Hey, what's up, guys? Welcome to Late Splaining the Interwebs. I'm your host, Nick Ricada of Ricada Law, a small law firm in central Minnesota. And whoo, baby, I'm cutting it way closer than I wanted to. My sincerest and humblest apologies. Let's get this show started. I am going to get the trial pulled up. Man. Oh. You know, when you sleep for like 3 hours and you wake up like 3 times in that time, you know something's wrong. You know you didn't get a good night's sleep. Okay. All right. How are you guys this morning? Hope you're doing well. I am doing. I don't even know how I'm doing, actually. I seriously have no idea. You mods need to drink some milk, I think. They need some milk. That's true. That's true. The mods here need some milk. Very much. All right, we're going into day 21. Amber Heard is expected to rest today. I would think actually that Amber Heard will probably come in and rest right away. But the question is, will they call Johnny Depp to the stand first? I mean, they can't be that dumb. They can't do it. They can be, but they can't be. And they kind of need to. But they really, like, that analysis hasn't changed. It didn't change yesterday by who they called to the stand. So they really need to call Johnny Depp. Damn it. They have to call Johnny Depp, probably, because they haven't gotten the testimony out of him that they need to keep Adam Waldman's statements at issue if the judge goes strict on it. Now, I don't think the judge is actually going to back down from it, but we'll see. Okay, so what I'm talking about there is they always have to put a fact question to a jury. So they have to find some question for a jury to answer. A jury is not a decider of law. A jury is a finder of fact. And so they need to give the jury a question to decide. And that question is on each element of the case effectively. Do they have to resolve anything? So to do that, each claimant has to put forward, generally speaking, each claimant has to put forward the elements of each claim. So in this case, defamation. Statement was published by the defendant, or in this case, Johnny Depp. He's not the defendant, but it's a counterclaim. Published by the defendant to the public. That is false. To the public, to another person. That is false with the requisite degree of intent and that it causes damage. So right now, they don't have the publication. There's not a fact question there. Adam Waldman published the statements. We know that, but we don't know that Adam Waldman is connected to Johnny Depp, specifically authorized to act as his agent. Okay. Sending out some links. My bad. So if they come in and rest, then it's just, it'll go straight to Johnny Depp's team. My news source does not have it pulled up yet. All right, they're just getting there on the Independent. Okay, please be seated. Where are you, Sky News? Defense is resting and they're going to motions. Hold on one second. Here we go. Sorry. I'm getting it pulled up here.
Just to take them back in. So when after we finish our motions and they come out, I'll let you say that, yeah, okay, let's just do it that way. All right. So based on them resting, you have a motion? And I did receive your memo ahead of time, so I have reviewed that. Okay, I have that. Okay. Yes, sir.
I haven't received anything from them. I don't know whether they filed.
I think it's just gonna be oral arguments. Yes, sir.
Good morning, Your Honor. May it please the court.
Here we go.
Ben
Is that
Chu
motion
for
to
plaintiff
dismiss?
Johnny Depp. Mr. Depp hereby moves to strike defendant Amber Heard's counterclaims because Ms. Heard has not proven by clear and convincing evidence that Mr. Waldman made the 3 allegedly defamatory statements with actual malice.
Right.
Wait, no.
Clear and convincing is not my motion to strike standard.
Understood, Your Honor.
Okay.
And we have cited the
Okay.
standard in our brief.
Thank you.
Moreover, Your Honor, the court should also strike defendant's claim for immunity and attorney's fees based on Virginia's anti-SLAPP statute, as she is not entitled to immunity under the statute. Because we know that the court has carefully reviewed our motion papers, I will just hit some of the salient points.
Thank you, sir.
Thank you, Your Honor. I would mention, however, Your Honor, that because this is not included in our brief, that there is no record evidence whatsoever that Mr. Depp even saw any of the 3 statements that Mr. Waldman made prior to being served with the counterclaims in this action, which we believe is relevant to many of the legal standards. And as Your Honor is aware, Ms. Heard had signaled for the past week that she was planning to call Mr. Depp in her case in chief. And it was our anticipation that she would try to fill what we believe is a gaping hole with respect to the elements of her proof. Again, there's no record evidence whatsoever that Mr. Depp ever saw any of the 3 statements about which Ms. Heard is purportedly suing him for $100 million.
Morning.
As Your Honor is aware, the elements of defamation are as follows. 1, publication of 2, an actionable statement with 3, the requisite intent. See Thorpe versus Sanders, 285 Virginia 476 at 2013. The requisite intent for defamation against a public figure is actual malice. That is, the statement must be made with knowledge that it was false or with reckless disregard of whether it was false or not. See Sanders v. Harris, 213 Virginia 369 at 372, a 1972 case. See also Jackson v. Hartig, 274 Virginia at 2019. Reckless disregard, as Your Honor is aware, quote, is not measured by whether a reasonably prudent person would have published or would have investigated before publishing, ellipsis. There must be sufficient evidence to permit the conclusion that the defendant, in fact, entertained serious doubts as to the truth of his publication, unquote. St. Amant versus Thompson, 390 U.S. Supreme Court, 727 at 731. Your Honor, the evidence shows that Ms. Heard cannot prevail on her claim because she cannot and did not establish that Mr. Waldman made the statements with actual malice. Mr. Waldman testified that he conducted extensive investigation and reasonably believed that the three statements he made were true. Ms. Heard presented nothing to contradict that undisputed fact. Ms. Heard has
You're
no
really
evidence
quiet.
of direct liability, because obviously, Your Honor, we need to talk about direct and vicarious liability, but it bears noting that she has no evidence of direct liability and cannot prove actual malice by Mr.
Let me
Waldman
turn you up
when
on this
making
side.
the three statements at issue. It is undisputed that Mr. Depp did not make any of the three statements at issue in Ms. Heard's counterclaim. Moreover, in order for Mr. Depp to be liable for the conduct of one of his attorneys, there must be some showing that he directed, participated, or otherwise authorized Mr. Waldman to make the statements at issue. There is no such evidence on the record that Mr. Depp directed or otherwise authorized Mr. Waldman to make the three allegedly defamatory statements at issue in the counterclaims. Indeed, there is no evidence of any communication or coordination between Mr. Depp and Mr. Waldman regarding the counterclaim statements or anything else.
Good.
For this reason as well, Your Honor, Ms. Heard cannot meet her burden of proving that Mr. Waldman was acting within the scope of his employment as our agency on behalf of Mr. Depp. Again, it bears noting that there's no evidence that Mr. Depp even saw the statements by Mr. Waldman until he was served with the counterclaims well into this case. It was more than a year after Mr. Depp filed his complaint, and Ms. Heard lost a series of motions to dismiss that she finally asserted her counterclaims, most of which have already been dismissed by opinion letter of this court. Whereas here, there is no evidence of direct liability.
Jury is not present.
Ms. Heard must rely on a theory of vicarious liability to hold Mr. Depp liable for the actions or statements, rather, of his purported agent, Mr. Waldman. Vicarious liability is by definition, quote, liability for the tort of another person, unquote. So to hold Mr. Depp liable for Mr. Waldman's statements, Ms. Heard must establish that Mr. Waldman himself committed all the elements of defamation. I know the court's familiar with this, so I'll try to run through it quickly. C. Parker versus Carillon Clinic, 296 Virginia 319 at 332, a 2018 case. Quote, vicarious liability is liability for the tort of another person. It necessarily follows
neutral
that a
for
claimant
time, guys.
cannot make out a case for vicarious liability against an employer without first proving.
Sounds like a law school argument, but it ought to.
Within the scope of his employment.
This is pure technical stuff.
Also, Route and Pontiac Corp versus
They're likely to
Alston,
lose on this.
236 Virginia 152 at page 156.
But they should
Which
win.
standard Ms.
frankly.
Heard has not met. And Your Honor, we cite a string citation to cases from other jurisdictions, which we obviously are not binding on the court, but we believe are influential. We presented those to the court for its review. It is Ms. Heard's burden to prove by clear.
His tone is that of a lawyer who's not going to win this motion, which is unfortunate.
Ultimately, to prove actual malice by Mr. Waldman, not Mr. Depp. And while it is well settled law in
You don't
Virginia,
need to pretend you have an expectation of winning.
that an agent's knowledge can be imputed to a principal, and this is the Allen Realty Corp versus Colber case, 227 Virginia 441 at 446. Ms. Heard's counsel cannot cite any case law stating that a principal's knowledge is imputed to an agent. In other words, Mr. Waldman must have made the statements knowing that they were false or with reckless disregard as to whether they were false. And Mr. Depp's knowledge cannot be imputed to him. There is no evidence in the record that Mr. Waldman knew the counterclaim statements were false. Indeed, Mr. Waldman did not even know Mr. Depp or Ms. Heard at the
This is a
time
weak
of
theory
any of the alleged
from Ben
incidents at issue, and thus had no personal knowledge of what transpired. And this is reflected in the trial transcript that Mr. Waldman met Mr. Depp first in October of 2016, long after the fact. Nor is there
The
any
idea that an
evidence in the
agent
record
doesn't
that
have
Mr.
the knowledge
Waldman
of the
subjectively
principal is
entertained
silly.
any serious doubts about the falsity of the counterclaim statements. Quite the opposite. The evidence shows, and it's unrebutted, that Mr. Waldman had very reasonable grounds to believe, and he did believe, and will to his dying day, that Ms. Heard's claim of abuse were patently false. Mr. Waldman testified at length about 29 witnesses he believed disproved Ms. Heard's false claims of abuse. See the transcript at page 6008 through 6012, and I won't run through all of that. But his testimony that 2 trained police officers, Officer Science and Haddon, were called to the penthouse on May 21, 2016, and saw no signs of injury.
The problem
Ms.
is
Heard's face,
he's making an
as
argument
well as,
on a
quote,
fact
Ms. Heard's
question
own
right now that
witnesses who
does
have
exist.
testified in various forms at various
If there's a
times
fact
that
question,
there
it goes
were
to
no
the jury.
injuries to her face
Period.
whatsoever between May 21st and May 27th, 2016, when she walked in to court with her publicist, her lawyer, her former best friend who no longer speaks with her, for a no-notice ex parte TRO. Some of the witnesses whom Mr. Waldman has cited, they include Laura DeVenier, Melanie Iglesias, who, as Your Honor recalls, was Ms. Heard's makeup artist, who decided to end any professional or personal association with Ms. Heard. Samantha McMillan, Hilda Vargas, Isaac Baruch, Trinity Esparza, Cornelius Harrell, Alejandro Romero, and Brandon Patterson, just to name a few. No reasonable jury could find that Mr. Waldman acted with actual malice in making the allegedly defamatory statements. He was not present for the alleged incidents. He has no personal knowledge of any of the alleged incidents. What Mr. Waldman knows is a product of the legal work he did, the sleuthing he did on behalf of Mr. Depp. Ms. Heard cannot possibly show that Mr. Waldman acted with actual malice, and her defamation claim must fail. 2, Mr. Waldman is an independent contractor, not an employee. It is axiomatic, Your Honor, that a person who hires an independent contractor is not liable for the independent contractor's actions. See Sanchez versus Medicorp Health System, 270 Virginia, 299 at 344. An independent contractor is a person who is engaged to produce a specific result, but who is not subject to the control of the employer principal as to the way to bring about that result. See Atkinson versus Sachno, 261 Virginia, 378 at 284. That's a 2001 case. An outside lawyer retained by a client in connection with litigation is an independent contractor. See King versus Dalton, 895 F. Sup. 831, Eastern District of Virginia, 1995, where Judge Ellis, a legendary jurist known by all Virginia practitioners, held that, quote, a law firm attorney working with a client is nonetheless an independent contractor and is not an employee of the client corporation. In that case, the employer was a corporation, but the same logic applies when it's an individual like Mr. Depp. That was Mr. Waldman's role. Indeed, clients hire lawyers to obtain specific results or to try to obtain specific results, but they do not control the means by which the results are accomplished. Lawyers, as Your Honor has reminded us, are subject to professional obligations to exercise independent professional judgment. We are not at the whim of our clients as much as we want to serve them. See Virginia State Bar Professional Guidelines, Rule 1:2 and 2.1. And just to quote 2.1, in representing a client, a lawyer shall exercise independent professional judgment, unquote. Mr. Waldman is, as a matter of law, an independent contractor, and Mr. Depp cannot be held responsible for any alleged tort by his attorney, particularly for statements about which he was unaware until he was sued for them. Mr. Waldman testified, and it's unrebutted, that he has his own law firm. He's not an employee of Mr. Depp. Mr. Depp or none of his loan out companies have issued him a W-2. And Mr. Waldman provides legal services to clients other than and in addition to Mr. Depp. And that's found at the transcript, page 6020 through 21. All of that is unrebutted by Ms. Heard. Mr. Waldman's statements, the third reason for which we respectfully submit the counterclaim should be stricken, is that Mr. Waldman's statements were protected opinion. And I won't run through all of that, but very briefly, taken in their proper context, the counterclaim statements are non-actionable expressions of opinion entitled to protection under the First Amendment. See Gertz versus Robert Welchink, 418 U.S. 323 at 339. That's a 1974 case from the United States Supreme Court. See also Shacker v. Bufault, a Virginia Supreme Court case found at 290 Virginia 83, a 2015 case, noting that where, quote, all sides of the issue, as well as the rationale for the speaker's view were exposed, the assertion of deceit reasonably could be understood only as the speaker's personal conclusion, unquote, and finding an accusation of deceit to be opinion. In context, Your Honor, any reporter or any reasonable reader would understand and expect a lawyer associated with Mr. Depp, as Mr. Waldman was, to challenge Ms. Heard's version of the inherently controversial events of the party's marriage. Just as Ms. Heard's lawyers were quoted challenging Mr. Depp, and Your Honor will remember the context of these quotes that were in a British tabloid where Mr. Waldman's statements were buried well into article in which both points of view were clearly expressed. And Mr. Waldman was clearly identified not as an independent expert on the US Constitution, but as one of Mr. Depp's attorneys. C. Chavez, 230 Virginia 112 at page 119, quote, the most unsophisticated recipient of such a claim, i.e. any reader of the British tabloid, made by a competitor against another could only regard it as a relative statement of opinion grounded upon the speaker's obvious bias, unquote. Mr. Waldman has never did anything to hide his support and belief in Mr. Depp. Finally, Your Honor, and for the rest, ultimately, Mr. Waldman's statements reflect the existence of two competing narratives and are merely his subjective view about events that he never claims to have witnessed. And there was no doubt about that. Turning to the second part of the argument, which will be more abridged, Ms. Heard is not entitled to anti-SLAPP immunity. As a threshold matter, Virginia Code Section 8.01-223.2, which is, as Your Honor well knows, is the Virginia anti-SLAPP statute amended most recently in 2019, provides in relevant part, quote, the immunity provided by this section shall not apply to any statements made with actual or constructive knowledge that they are false or with reckless disregard for whether they are false. Here, in addition to Mr. Depp's testimony, several witnesses have testified that A, they never witnessed Mr. Depp abuse Ms. Heard, and B, that they observed Ms. Heard without any injuries, marks, bruising, swelling, etc., during periods when Ms. Heard claimed to have injuries, marks, bruises, etc. Such witnesses include, but are not limited to, Isaac Baruch, Kate James, Dr. David Kipper, Nurse Debbie Lloyd, Officer Sines and Haddon, Officer William Gatlin, and former U.S. Marine Starling Jenkins. Ms. Heard's request for anti-SLAPP immunity should be stricken, and even if there were disputed facts as to that, the anti-SLAPP immunity does not apply because the defamatory implication of Ms. Heard's statements are not solely relating to a matter of public concern, as is required under the statute. As has become quite clear, Your Honor, Mr. Depp is not suing about any of the public policy commentary made by the ACLU when it drafted the op-ed, and Ms. Heard put her name to it.
This is a failing argument
What he is
because
suing about
issues of
here
spousal abuse
the
are
three statements
always
that were
considered matters of
directed at
public
him.
opinion.
He has no issue with women's rights. He supports women's rights. In fact, he was the one, Your Honor, as Your Honor knows, who made that first $100,000 contribution to the ACLU, and he made it also to the CHLA.
Your Honor, at this point, I'm going to object. Mr. Chu has largely just read his brief and confined his arguments to those directed in the motion. But like we saw with the last motion to strike, he's now directing his arguments to something other than what's at issue here. And I would object because I think making an argument not to you, but to the cameras, it's disrespectful to the court and to everyone's time. And it also threatens to undermine the integrity of this process and risk the jury being influenced by outside factors.
Well, it's his argument. I'll allow him to do his
Thank you.
Yeah.
Thank you, Your Honor.
Hey, Rottenborn,
As I
don't
was
be
trying
such
to
a
say,
cunt.
What Mr. Depp is suing
Your
about
Honor, I don't like this argument. It's harmful to my client.
very clear, despite the pious opening statement that about the First Amendment,
I'll allow it.
that with the testimony of Terrence Doherty and the emails that were admitted as exhibits, that the ACLU and Ms. Heard were conspiring to make it very clear that those three statements were related to Mr. Depp, because otherwise nobody had any interest in the article. And it's crystal clear from that. They wanted to time this thing with the release of Aquaman, which was her first film of any significance in terms of popularity, and to do that. That's very clear. So the charade that this had something to do with public policy is risible, and that is not why the anti-SLAPP protections were enacted. They were enacted to protect the rest of the article, not what Mr. Depp is suing about. As generally analyzed by the courts, a matter of public concern is one which relates to, quote, a matter of political, social, or other concern to the community, unquote, as opposed to a matter of only, quote, personal interest, unquote. That's Connick versus Myers, 461 U.S. 138 at page 146. Instead, the defamatory implication at issue in each of the three statements at bar relate to the personal grievances between Mr. Depp and Ms. Heard, which does not rise to the level of a matter of public concern with broader implications for society beyond the two litigants in this action any more than Mr. Waldman's statements. I mean, adding the gloss of public policy might immunize the statements that relate to public policy, but those are not at issue here. Mr. Depp agrees with those statements. We're talking about the three statements that they very intentionally and very cleverly put in to make it clear the implication that it was about Mr. Depp. They had lawyers from the ACLU working around the clock with Eric George to be as clever about this as possible. And Your Honor,
What's the point of this? They're allowed to be clever.
About the consternation of the ACLU when they
argument he's
realized
trying to make,
that USA Today
so
and
that
everybody else who
to get anti-SLAPP protection has to be a matter of public concern.
Oh, I see.
This cannot be protected by the anti-SLAPP statute. It
again,
is a cynical
issues of spousal
runaround.
abuse,
And I think
always a
now
matter
that
of
we
public
have
concern.
the undisputed evidence from
You can't have a
from the
private issue of
ACLU
spousal
in the form
abuse.
of the testimony of Terrence Doherty, who is not only their corporate representative, he was their general counsel. He is a brainiac lawyer. They knew exactly what they were doing, Your Honor. And he referred to testimony of a woman at the ACLU who said she had nightmares about Ms. Heard, and he expressed no concern about that. Now, that was either because they knew about, that was either a reference to this game they were playing with the op-ed, or the conspiracy they had to cover up her failure to make the donations. The donations became pledges, but we have evidence that she refused to sign the pledge card. So she's caught either way. Simply stated, Your Honor, Mr. Depp is not suing Ms. Heard for making statements about society in general. I think that's very clear from the record evidence. Mr. Depp is suing her for publicly naming him as an abuser by implication and forever tarnishing his good name, an act that, coming from an ex-spouse, is fundamentally personal in nature. For that reason as well, Your Honor, Virginia's anti-SLAPP statute is not applicable. And based on the foregoing, Your Honor, Mr. Depp respectfully submits that the court should grant plaintiff's motion to strike the counterclaims and also strike her claim that she is immune under the anti-SLAPP statute. Thank you very much, Your Honor.
Thank you, sir. Yes, sir.
I mean, he did what he could with the argument.
Thank you, Your Honor.
There's a
As
point
Your
I
Honor
would've
knows,
made
the trial
differently.
court is required to accept as true all the evidence favorable to Amber at this point, as well as any reasonable inference a jury might draw therefrom, which would sustain the counterclaim. That's the correct standard here. I'll address the actual malice
Little
argument
snippy.
first, the agency argument. Your Honor, there's plenty of evidence in the record from which the jury could determine that Mr. Waldman was Mr. Depp's agent. He made those statements. The statements referred to him as Mr. Depp's attorney. As Your Honor ruled on Friday with respect to the jury instruction conference, an attorney is an agent of his client. Mr. Waldman testified that he's been Mr. Depp's attorney since 2016. He freely admitted speaking to the press on Mr. Depp's behalf, and he refused to answer question after question about that agency, so we can't use that as a sword now. Mr. Chu puts a lot of emphasis on the fact that Mr. Depp allegedly
can.
didn't see
He absolutely
the comments
can.
that were made that are the subject of the counterclaim. But as Your Honor well knows, whether he saw them or not is not the standard for agency. There's also evidence that Mr. Depp met with the Daily Mail with Mr. Waldman prior to the defamatory statements being made and released. I believe that was in February of 2020, just 2 months prior. Mr. Waldman also concocted a story that Amber was being investigated for perjury by filing a perjury complaint against her with the LAPD. He disregarded any evidence that he didn't believe would fit in his narrative, that would fit in this story that he was speaking about on behalf of Mr. Depp. And after Mr. Depp lost the UK proceeding, after Mr. Depp was ruled to be a wife beater by the court in the UK proceeding, the court there found him to be a wife beater. Mr. Waldman then got an overseas tabloid to run a story claiming that Amber was being investigated for perjury, which simply wasn't true. He walked into the LAPD, filed a complaint for perjury against Ms. Heard, found a media outlet that doesn't follow the two-source rule, and then he had let the world believe that the LAPD was investigating Ms. Heard for perjury. That's a shameful and a sickening example, Your Honor, of the links that Mr. Depp, through his agent, Mr. Waldman, would go to smear and to defame Amber Heard, and that continued in the 3 statements in the counterclaim. Your Honor has heard evidence, I won't go through all the evidence, but Your Honor's heard evidence from Ron Schnell, who's traced the negative hashtags toward Amber Heard online associated with those defamatory statements, and noted the staggeringly high number of them that were associated with Mr. Waldman. Under the principles of the agent-principal relationship in Virginia, Your Honor, when Mr. Waldman made those statements, he was standing in the shoes of Mr. Depp. They are one and the same for the purposes of those statements. As Your Honor discussed at length on Friday, Mr. Waldman made these statements with actual malice. There's plenty of evidence from which the jury could infer that, and his own, both from the actual malice from Mr. Depp and Mr. Waldman's own reckless disregard of facts that didn't support Mr. Depp, and his attempts to manufacture false evidence that did. As Your Honor found in the hearing, I believe it was on March 24th, after Your Honor denied Mr. Depp's motion for summary judgment, Your Honor said, as to malice, a fact finder could reasonably conclude that Mr. Waldman made the statements with malice because Mr. Waldman has no personal knowledge of the party's marriage and still made the statements at issue. Nothing in this case has changed that. If anything, the evidence has only made it more clear that that is an inference that the jury can and we believe will find. So, Your Honor, there's no basis to grant a motion to strike on this agency argument. On the actual malice argument, the evidence shows that not only was Mr. Waldman Mr. Depp's agent, but that the two of them conspired to falsely accuse Amber of creating a hoax and falsify evidence that they believed supported their theory and what they wanted to achieve. As Your Honor well knows too, I won't go through all the law, but both agency and malice can be inferred through circumstantial evidence. There's plenty of evidence in the record from which the jury could infer those. Moving on, Your Honor, to the independent contractor, the court's
I disagree on the agency, but
ruled that an attorney client have a principal agent relationship. And as Your Honor said on Friday, there's no evidence in this case of anything otherwise. As to the argument that the
question is whether they have the relationship,
statements of opinion,
whether they have the
court
relationship
has already found twice
relative
that
to
they
the
are
statement.
not statements of opinion, both on January 4th, 2021, in its opinion letter denying Mr. Depp's demur as to the counterclaim statements, and at the motion for summary judgment hearing in March of this year. As to the anti-SLAPP argument, the court again has already ruled at the March 24th, 2021 opinion that the statements are as a matter of law regarding matters of public opinion. The court has already ruled that. Therefore, the only remaining issue for anti-SLAPP is whether the intent element of immunity is met. As we discussed on Friday, the intent element of immunity is substantially the same as the actual malice standard, which the evidence in this case easily allows a jury to find in favor of Ms. Heard on that. I won't go through the litany of evidence that supports that Mr. Depp is an abuser here, but I'll touch on a few things that relate to Mr. Chu's argument. One, Mr. Chu was totally misrepresenting Mr. Doherty's testimony. There's not a single piece of evidence, Your Honor, in this case suggesting that Ms. Heard and the ACLU were somehow conspiring to achieve a defamatory implication to Mr. Depp. That's simply not what Mr. Doherty said. Mr. Chu's feel free to argue that to the jury, but that's not what his testimony reflects.
Yeah, but the jury can determine
Your Honor,
that.
there's also
That's a fact question.
plenty of evidence that's been adduced both in Mr. Depp's claim and in Ms. Heard's counterclaim that show that absolutely that the counterclaim statements are 100% false. There was no hoax perpetrated. Mr. Depp is an abuser who abused Ms. Heard. She did not conspire with her friends to create a hoax. She did not create a hoax herself. And just very briefly, some of the evidence that's come up since the last motion to strike, Your Honor, that Mr. Chu conveniently disregards in this brief are the testimony of Rocky Pennington, testimony of Josh Drew,
That lady
testimony of
back
Elizabeth
is looking at Rottenborn like he's a day-old Subway sandwich.
Account of the events of May 21st, 2016.
Like,
Testimony
maybe,
Lacey,
maybe,
who
could be.
testified that she covered Ms. Heard.
I left it in the car.
With makeup
A little
on
warm.
right after the December 15th incident that provided ample testimony to support that Ms. Heard often would cover her bruises that were caused by the plaintiff, in this case, by Mr. Depp, with makeup. He ignores the evidence of Christy Sexton. He ignores the evidence of Io Tillett Wright. He ignores the evidence of Whitney Enriquez. All of these witnesses and others have testified extensively about Mr. Depp's abusive behavior toward Ms. Heard. Physical abuse, emotional abuse, psychological abuse, verbal abuse, Your Honor. Mr. Depp's own writings, recordings, pictures, and videos confirm that. The list goes on. There's abundant evidence in the record, Your Honor, from which the jury could, and again, we believe will find that Ms. Heard is not liable for defamation to Mr. Depp, and therefore, by definition, she has not acted with actual malice, and based on the court's rulings on March 24th, 2021, she would be entitled to anti-SLAPP immunity, which would permit her to ask the court to award attorney's fees against Mr. Depp. So with that, Your Honor, I'm happy to answer any questions the court has.
That's
but
fine.
that
Thank you,
covers it.
sir.
Thank you.
Yes, sir.
Rebuttal?
Your Honor, I will be brief in deference to the court's time and the jury's time. What Mr. Rottenborn said
It's
about
100% bullshit.
Mr.
Yep.
Waldman's allegedly going to the LAPD about perjury is a complete non sequitur. If they thought that that were somehow improper conduct, they could have included it in their counterclaims. They included everything else but the kitchen sink, and most of it was thrown out. There was nothing in there about Mr. Waldman going to the LAPD. So that is a very clear non sequitur red herring distraction. Number two,
an argument they should have made right away.
On summary judgment on the issue of the counterclaims, Your Honor was dealing with a different standard and a different evidentiary record. At that time, Mr. Waldman had not testified, which is material. Mr. Waldman has now testified for purposes of trial. We have his trial testimony. It's very clear that he did not act with actual malice. They didn't even argue that. So that's pretty clear.
Absolutely clear. Don't say pretty clear.
And again, this is consistent. The third point is that it's all about games. They didn't sue Mr. Waldman on the 3 statements. They didn't try to fill the hole. They've been telling us for a week that they're going to call Mr. Depp to try to fill the hole in their counterclaims. They didn't do that.
That's the biggest one right there.
It's very consistent with the game playing. Let's go into court after the police have found no problem and after witness who had no relationship with each other said there are no visible marks. Let's not give Mr. Depp's lawyer the required 24-hour notice before the TRO. Let's march into court with our publicist, with our lawyer, with our best friend who no longer talks to her. Let's get a TRO. And when the Me Too folks say, why are you taking $7 million from an abuser? They said, I didn't take money from the abuser. I gave it all to charity. Well, they didn't. I don't think anybody should feel bad about them stiffing the ACLU, given what the ACLU did in this case, which is a monstrosity. But she did stiff the sick and dying children. It is gamesmanship. And that's what she's doing here today. But the law is the law, and they have not fulfilled their burden with respect to the counterclaims. There is
you brought in the sick and dying children
between Mr. Depp and Mr. Waldman as to these statements at issue, except for the fact that he is an attorney, and that is not sufficient in a case where they have not even established that Mr. Depp was aware of these statements. And they knew that they couldn't do it, and they didn't even try. And it's more
looks like that sick and dying children line really bothered Amber. She started passing notes around.
When Ms. Heard plays word games with Mr. Depp about, oh, I didn't punch you, Johnny. I just hit you. Imagine if the shoe were on the other foot and Mr. Depp, a man, was saying to a woman, oh, woman up. I only hit you. I didn't punch you. And when it was chilling when she warned him on the tape, you go tell a judge, you go tell a jury that you, a man, were abused.
This is all closing argument.
Believe that.
Yeah.
He's just practicing. Opportunity for rehearsal, dress rehearsal.
And it's for the cameras. Rottenborn was right.
Finally,
it is
Your
for the
Honor,
cameras,
and
but he
Mr.
still gets to make it.
Rottenborn makes an excellent point with which I agree, which was that with respect to each of the 3 statements, Mr. Waldman was clearly identified, even by the tabloid that printed these, well within articles that had both sides represented, that he was Mr. Waldman's attorney. Even the reader of a tabloid understands that when you're getting statements from attorneys, it's going to be forwarding their client's point of view. Mr. Waldman is not the only attorney who has spoken.
You're hurting your agency argument.
Robbie Kaplan, who was Ms. Heard's second attorney. So Ms. Heard started out with Eric George. He made comments to the press.
Objection, Your Honor. Again, this is so much further beyond what Your Honor is addressing.
I'm finishing up, Your Honor.
Okay.
I'm finishing up. My point, Your Honor, and it's on point, is that Mr. George made statements supporting Ms. Heard's position. Ms. Kaplan made very clear statements supporting her client's position on the merits, and so did Mr. Waldman. But everybody knows when reading those that those are statements by partisans. So for the reasons that we've stated and the reasons set forth in the brief, we respectfully submit that the court should grant the motion to strike, or in light of the fact that Mr. Depp may reappear, at the very least, take these motions under advisement until the close of all evidence. Thank you, Your Honor.
All right. Thank you, sir. All right. In this matter, I've reviewed all the defendant's evidence as to her counterclaim.
Denying the motion to strike.
the arguments of her counsel and plaintiff's counsel.
Tell by
First, to
tone.
address a few issues that I believe are outside the motion to strike, and that's as to the SLAPP defense. The SLAPP defense is just that, it's a defense, so it's really not considered in a motion to strike. Having said that, we went down that legal road on Friday as far as the SLAPP defense goes, as far as the jury instructions. In this particular case, if the plaintiff prevails, it must be with actual malice. Therefore, if it's with actual malice, immunity does not apply under that statute. So we will deal with that with jury instructions, and we have. As to independent contractor, again, I think it's outside the motion to strike. However, Mr. Waldman was plaintiff's attorney since 2016. Before the initiation of litigation, there is evidence that Mr. Waldman had a certain role during the prior divorce proceedings in the UK case. Additionally, there is evidence that shows his legal representation was broader than just a limited litigation, as outlined in all the cases presenting an attorney as an independent contractor. So the only evidence in this case to this point is that Mr. Waldman was an agent to Mr. Depp, and that is the basis to weigh the motion to strike. As far as the opinions argument, again, I think that is outside the motion to strike. The opinions argument, the court has already ruled on this matter as to the three statements that are issued in the counterclaim, ruled that they were not opinion at the demur and at summary judgment. So that argument will not be part of the motion to strike. So when assessing a motion to strike, the court accepts the favorable evidence adduced as true towards the non-moving party. The court cannot reject any inference from the evidence favorable to the non-moving party unless it would defy logic and common sense. When there is any doubt and question, the court should overrule a motion to strike. Agency may be inferred from the conduct of the parties and from surrounding facts and circumstances. When there is no direct evidence, circumstances may and usually are relied upon to determine whether an agency relationship exists. A principal is liable for the tortious acts of his agent if the agent was performing his principal's business and acting within the scope of his agency. If an agent's tortious act arises from their agency relationship, is enacted in part to service the principal can be held liable for the tort. Here, the alleged tort is defamation. Besides demonstrating the agency relationship, the defendant must prove Mr. Waldman published an actionable statement, meaning a statement that is both false and defamatory with the requisite intent. As to agency, Mr. Waldman was plaintiff's attorney at the time of the alleged defamatory statements were made. Mr. Waldman does not deny this, and neither does the plaintiff. Moreover, Mr. Waldman made the allegedly defamatory statements about the defendant during the proceedings of this action and interacted with the defendant once the statements were made while still representing the plaintiff. Taking the surrounding circumstances as a whole, an agency relationship can be inferred, and thus a scintilla of evidence regarding agency must be turned over to the jury. In addition, the jury may infer that Mr. Waldman made these specific statements to a third party to serve as plaintiff by portraying defendant as an opposing litigant in a negative light. It is not disputed that Mr. Waldman published statements and that there is a question as to whether statements are false, and both parties disagree and have presented conflicting evidence as such. As to actual malice, Mr. Waldman made the counterclaim statements after he met with his client. In addition, there is evidence the plaintiff was with Mr. Waldman at a meeting in February 2020 with the Daily Mail online. Further, defendant claimed that she met with Mr. Waldman where he threw the paper containing the counterclaim statements within them. Consequently, there is more than a scintilla of evidence that a reasonable juror may infer Mr. Waldman made the counterclaim statements while realizing they were false or with a reckless disregard for their truth. It is not my role to measure the veracity or weight of the evidence. The Fourth Circuit and the Virginia Supreme Court have made it crystal clear that actual malice is a question for the fact finder. So therefore, the plaintiff's motion to strike is denied. Okay?
Boom.
Is there any
As
other
it's-
preliminary matters before the jury?
Expected outcome.
Okay.
I think they should have focused heavier on the agency relationship. They maybe should have dealt with that with Adam Waldman on cross in their deposition. But, you know, I would have argued, and maybe they did in their brief, that they did not establish an agency relationship or raise a fact question of the agency relationship specifically. They merely said he's his lawyer. And I do think that there's an argument to be made that they need to establish the role of the agent with particularity, because mind you, the judge still would have struck this, because there's no way this judge is going to let this thing do anything other than go to jury. If the judge makes a legal ruling on this, it gets appealed immediately. If a jury ruling, much harder to overturn on appeal. So
it got this far. I mean, that alone, the judge believed it was appropriate for it to get this far. She's not going to blow it up now unless there's damn good reason. And, like unfortunately, like Kurt's team said, the jury can rely on circumstantial evidence. They can make inferences from circumstantial evidence. That's a pretty open door, folks.
Yep. And while I personally think that a perfect argument could be made that in an academic setting would, like done by an algorithmic robot, would come out and say, yes, this should be stricken. I don't think that was happening here. And I don't think that this judge is going to rule in any other way. She was clearly reading the ruling that she wrote last night on the matter. So that should be no surprise. This thing's going to jury. It's going all the way to jury, but you shouldn't be worried about that, because if Johnny Depp is going to win this case, he's not going to lose Amber's claim. Like Amber's not going to also win. That's a hard thing for a jury to do. No, they're both lying against each other. They're either both going to lose or one of them will win. That's, in my opinion, that's the outcome that's most likely. Or the outcome list, I should say, that's most likely.
Hey, I'm going to grab more coffee while we got to pause here.
Yep. All right. So real quick, people are asking what an anti-SLAPP was throughout all of this, throughout all of that argument. So a SLAPP, an SLAPP, is a strategic lawsuit against public participation. Whitney Hurd has resting unfortunate face. I won't call it resting bitch face. I'll call it resting unfortunate face. Oh my gosh. DUI guys back there chatting up the people around him. Okay, but SLAPP is a strategic lawsuit against public participation. That means it's a lawsuit designed to prevent someone from speaking on a matter that is within the public concern. That does not mean that the particulars of the matter are public, right? A marital relationship is a private relationship. What happens in the marital home is private, except questions of spousal abuse, especially contextualized within the Me Too movement, as these are clearly a matter of public concern. The public is concerned about spousal abuse. The public is concerned about Me Too. Even if the public were in favor of spousal abuse, that would still be a matter of public concern. So you don't get to conceal and stop people from speaking out about alleged criminal actions because they're within a private type of context. Fraud is a matter of public concern. So if someone is committing fraud, even though fraud often happens in private communications, it's still a matter of public concern because someone being defrauded is against the public interest. So that's what they're claiming, is that strategic lawsuit against that public participation. Johnny Depp is suing Amber Heard to stop her from speaking. Or in this case, Amber Heard is suing Johnny Depp to stop him from speaking. Now, what the judge laid out that is really important here is that for either party to win in this instance, they have to meet a heightened standard because of their public figure status, their public celebrity. And that is one of actual malice, which means that they acted with knowledge of the falsity or reckless disregard for the truth, such that a reasonable person would, upon basically any investigation, be able to discern the falsity of the statement. So you can't just say, well, I didn't know it was false. If anybody could have easily found out it was true, found out it was false, then you don't get to use that as a shield. There's all sorts of ways to figure that out. We won't go into those right now, but basically the idea is they acted with intent to harm the other person, disregarding truth or knowing that it was false.
Is that Dennison in the gallery there? Why is he sitting there?
He just got there a few minutes ago. All right. He's probably not needed since it's going to be all cross exams today, or it's going to be all directs today. And I don't think that they're going to have him run. Maybe they will, but we'll see. But yeah, so with that said, if either party prevails, the other party is not entitled to SLAPP immunity because the parties prevailing necessarily means a finding of actual malice in this case. If they were two nobodies screaming at each other and defaming each other, then they would have to get to the heightened standard to overcome the anti-SLAPP protections. I hope that explained it for the audience. It's the anti-SLAPP stuff gets highly technical on defamation, and it's why you want a jury, because in the legal arguments around a SLAPP are make things very hard as a plaintiff. So it's
They're
why
complex for the legal professionals. They're complex. I mean, you'll see these SLAPP cases drag out for years and years and years. It's awful.
And you'll see judges consistently overturned on SLAPP decisions because the SLAPP statutes are written with very broad, sort of vague standards. Then they're applying federal Supreme Court jurisprudence to them. And oftentimes, the question is, well, who is a public figure? It's hard to discern, except when it's Johnny Depp or a government agent or like Tom Cruise. But when it's like, let's say hypothetically, I sue someone for defamation. I have 400,000 YouTube subscribers. Am I a public figure? Maybe. But am I Johnny Depp? No way. Right? So what's the balance there? And where does that fall down? That's a complicated question. There's no guidance on what that is really. Nothing that's concrete and simple to follow. So people have to make decisions. So yeah, the anti-SLAPPs, I'm not a big fan of them. I think they take the opportunity to get redress away from people. I get the intention. The problem with the reason anti-SLAPPs exist is because rich litigants would sue people who could not defend themselves in a lawsuit because they can't afford it. And they would suppress speech. Typically, like if you know that one rich family in town, you say anything about their stupid snot-nosed kid, and they'll sue for defamation, stop you from speaking. They'll drag you to the courts, make you pay $100,000 in legal fees because you said that their stupid kid can't read or was cross-eyed or whatever. And they know they would lose those on the merits, but it doesn't matter because you don't want to pay $100,000. So instead you'll retract your statements. You'll get bullied into submission. This is a purpose of the anti-SLAPP. Personally, I don't think it serves the purpose, even though the purpose is one of court efficiency and nobility. I don't think they actually get there. Like Mr. Branca just said, oftentimes these things will drag out for years. They'll end up costing the parties hundreds of thousands of dollars in motion paperwork, in appellate costs, and all of that could have been resolved much more quickly by a jury as it ends up happening. So there we go. That's my tirade on anti-SLAPPs. With that, let me get some of these super chats while we wait. How are you this morning, Andrew?
I'm good. Hanging in there.
Nice. Whew. These like 2 and 3 hour sleep nights there's something.
Oh,
Like
you're
I'm
crazy.
Yeah. Nappy soldier neuropunk something says Dr. Gatorade was more like drinking the Haterade. The cross came with a hard face like a can of Twister. Better yet, #Faderade. Yeah, that doctor. There were a bunch of people who thought that doctor did okay on the stand and that Dennison didn't do well on that cross, which I disagree with thoroughly.
Well, yeah.
I mean, that doctor came across horrendously, in my opinion.
Some people believe Amber. There's crazy people everywhere.
There you go. Marta Joy, does the 4 hours and 9 minutes include closing statements? No, I don't see how they can manage this at all. No, it does not. And that's why they rested today. I mean, they wanted to call Johnny because they came into this hearing. They knew this was going to happen, this motion to dismiss. First of all, it was emailed, but they knew it was going to happen anyway at the close of a case in chief. So a motion to dismiss gets filed. They know that's coming. They have to have like a 10% fear that the judge is going to rule against them. They know that the judge probably isn't, but they have to have that fear. That's why they've been talking about bringing Johnny Depp the whole time. Is he has to, well, they needed him to fill some holes in their argument. And under a purely academic look at it, I think that would still be true. And I don't think they filled those holes. But this isn't purely academic. This is a case involving people with a human judge that also has millions of people watching at home. And this judge making a ruling against one of the parties could be highly prejudicial. In fact, this judge may be concerned that that ruling would affect the jury's decision in favor of Johnny Depp as well. If the judge ruled as a matter of law that Amber Heard was, or that Johnny Depp did not defame Amber Heard, then that tells the jury that there's one party with clean hands.
Right.
I mean, that's the risk here. So, but yeah, they didn't call Johnny Depp though, because they only have 4 hours left. They have to deal with cross-examination on these rebuttal witnesses. The rebuttal witness list is beautiful, by the way. Someone sent it to me. Johnny Depp is the last witness that they're planning on calling. So Johnny Depp's own team is going to recall him at the end. I think that's a brilliant move, personally, because I think it leaves the jury with the reminder of who this is all about. And he's also, I think he plays pretty well. Let me see. I'm trying to find that witness list. I don't have it handy. It doesn't matter. So the witness list includes the flight attendant that Johnny Depp allegedly grabbed their wrist on the plane, includes someone who is a witness to the other incident. Kate Moss will be teleconferencing in, I think, tomorrow. The Jennifer Howell, who is there to refute Whitney Heard's recount of the staircase incident, is testifying. The chief executive of DC Pictures at Warner Brothers is going to be testifying by video deposition. He's the one who's going to say that Johnny Depp's statements had no impact on DC's decisions around Miss Heard in their contracts on Aquaman, and also that they would not have renegotiated her contract under any circumstances. So that's good. They've got a damages expert. They've got his treating physician on the hand who's going to come in. That's, I think, great testimony. The guy who actually treated the wound is going to come in and presumably say, yeah, this is caused by a bottle smashing into Johnny Depp. They've got someone else as well. They actually have a lot to get through, even with their 15 hours or 15 hours and 51 minutes. But if they hammer through some of these really quickly on the issues, it'll be brutal.
And Heard still has 4 hours.
Yes. 4 hours and 9 minutes.
Well, you know, they're bringing Johnny last, so they have to reserve a chunk of that for him.
Mm-hmm. Or maybe they're playing a game and they won't call Johnny. Because, hey, Heard's team did it.
Turnaround is fair play.
We got to the end. We decided we didn't need him. Oh, they had 2 hours left. Well, that's too fucking bad. So that'll be great. I really wish Kate Moss was going to be there in person, because I think Kate Moss on the stand would piss off Amber Heard so much.
Johnny's true love.
Just having a supermodel on the stand.
Yeah.
Anyone more attractive than her pisses her off. Oh, and Dr. Muffins is coming back as well.
So awesome.
And if they play that right, having her come back when they don't have sufficient time to cross could be absolutely devastating. Okay, here we go. Marta Joy, read that one. Matt Lewis, why has it never been mentioned with all the crazy audio recordings? There isn't a single one with Amber screaming for help while Johnny Depp is allegedly beating her. Yeah, there's no audio recording of physical violence or any sign of it. It's always some vague after mention. We got into a fight. You get like this.
Just reverse the genders.
Yeah.
If we reverse the genders, there'd be no question that Depp would be found to be an abuser.
Yep. And if we reverse the genders, we'd be asking for a whole lot more evidence that Johnny Depp as a woman was beating Amber Heard, right? Like we'd be the amount of evidence that it would take to show that he was beating her. They'd be like, where's the video? Where's the video? Where's the boxing ring built in their house that this must have occurred in for a woman to hit a man. Like that. I love that Ben Chu called that out. That was clearly for the public, wasn't for the judge at all, but he called that out. If you reverse these genders, there's no way that this would be treated the same. Tom Grawl, let me know when you do the whiskey review on the Bardstown. I sent an email as well. Have a great day. Oh yeah, I owe you, Tom. I heard that Tug's internet went down. That sucks for Tug. Hopefully he'll get that thing back up pretty quickly. Grishnock 414. Let's all take a shot every time we hear what, if any. No. Heel versus Babyface says late and questionable sexuality. Yes. Who barely made it in before they got to court today. That was nuts. Thrashifus, late and gay, but I still platonically love you. Lurkmore, 10,000 people watching dead air. You shyster lawyer. Karen took the kids. This timekeeping is why you'll never run a big law firm in central Minnesota. You shyster lawyer. I don't want to run a big law firm in central Minnesota. The headaches. Oh my God. Ugh. The amount of work you have to do until you can hire enough people to do the work for you is really a lot for running a big law firm.
Yep.
Braden Nelson, late and heteroflexible. The Pie Baker, YouTube shadow ban you, Nick. I had to get the link from Locals. Pitch your Locals as unbreaded Elmo. No, my voice is way too shot to do an Elmo voice in the morning, probably even right now in the afternoon. It's going to be a bit before I can do that effectively, but you can follow me on recadalaw.locals.com. You can get access to some exclusive content, not as much while the Depp trial is running, because I just literally don't have the time during the day when I'm streaming 15 hours every day. But we do all sorts of Locals exclusive live streams where I sit around, smoke cigars, drink whiskey, talk with the chat, and it's way different, way more intimate. There's no super chatting or anything like that. There are more personal posts on there from time to time. You can see what I'm up to. Also, it's its own community. It's like its own private Facebook group, essentially, and you can post things, have discussions with people. And there's more features coming, like live chats that run on different subjects. We'll be hammering those out when this trial's over, as well as access to the Discord. If you are a masochistic monster who wants to have access to a community rooted in toxicity and fat kids, that's how you join the Discord. If you want to be around that smelly kid that was always rude, that's every single person in the Discord. They're a horrific bunch of miscreants. I do not recommend anyone join the Discord ever. It is full of the worst people on earth. Matthew Perkins, how long do you think defense will take to rest? No time at all. Are we ready for the bloodbath Johnny's team is going to unleash with their witnesses? I am. My body is ready. My body is ready. John Myers, Amber's defamation expert should have used Terrence Howard from Iron Man 1 comparison. Yeah. Someone brought up the best comparison last night. The lead in Avatar, the highest grossing film of all time, has no career to effectively speak of. Like he gets basically nothing. I mean, you wouldn't know the movies he's in. He's in 1 to 3 productions of some sort a year, and they're nothing burgers. And yet that's a movie that's grossed $2.8 billion across the globe. It almost, basically 2.5 times, 2 2/3 the times of what Aquaman made.
And that guy's still a successful actor.
Yeah.
I mean, most actors are waiters in restaurants.
Yeah, Sam Worthington is the guy. He led Clash of the Titans movies. Yeah, the Clash of the Titans remakes, those were great. And those were the first one he got, by the way, at the same time, the same release year as Avatar was the release of the first Clash of the Titans movie. So he played Perseus in 2009. He played the Avatar character in 2009. And then, you know, he would go on to do the sequel to Clash of the Titans. I think Terminator Salvation, which God, oh, please, horrific movies. Yeah. And then after that, it's like nothing. It's nothing at all. And that was 2009. I mean, so we're talking, it's been now 13 years and he still just has not gotten anywhere. So again, I think he would have been a good comparison. Terrence Howard had a long acting career before Iron Man 1. I mean, Terrence Howard's been in quite a few movies and he's regarded as a very good character actor. Whereas Amber Heard, I've never seen her praised for her acting skills anywhere. Whereas Terrence Howard would go on to do Empire and make a fortune on Empire.
But not in movies, right? I mean, didn't he? I only remember him from one movie before Iron Man. I think he got an Oscar for it. But
that's a pretty good showing.
But what after that? I mean, in movies, of course, he had that whole Empire series. So I guess that's a huge professional success. A bunch of stuff on Law and Order.
Okay, so he's in Crash before Iron Man. He's in Hustle and Flow before Iron Man.
That's the one I'm thinking of, Hustle and Flow.
Yeah. So he's let's see. He's got 100 credit filmography. Iron Man's 2009. Or 2008. So before that, he's in August Rush. Very good movie. He's not a main character in that, but he's got a decent role. The Brave One, Pride, Idlewild, which is a weird kind of niche film. Get Rich or Die Trying, Four Brothers, which that's a Mark Wahlberg film. Hustle and Flow was a big one for him.
You're right. Looking at IMDb, he has a long, extensive acting career well before Iron Man. For a long time. Jesus.
Yeah, he's fairly old.
15 years.
He's a character actor. So I mean that's the big thing.
Are we ready for the jury then?
Okay. He was one of those Hollywood mainstays you're talking about where it's the rest of Hollywood, all the people who actually do struggle to eat and pay a mortgage in LA, which is near impossible. But yeah,
the journeyman actors. I mean, you see him in tons of stuff, and
yeah, they're the people who grind out the work. Tina AA sent me a sticker that says super effective. Daphne Lansborough, thank you for the donation. Nick Tucker, welcome to lawyer status. Raven Pro, welcome to paralegal status. James Shobani, good. Where'd it go? Shoot, where'd that go? Good morning to the man. Got introduced to your channel because of this trial, and I can say I won't stop watching when it's over. Oh, I will find a way. Keep up the good work and don't die in the back of a Honda Civic. If I do die in the back of a Honda Civic, please defile my corpse to make sure I'm dead.
All right. Good morning, ladies and gentlemen. I apologize. We had a few housekeeping matters to take care of, but thank you. You can have your seat. All right, your next witness.
Your Honor, on behalf of defendant and counterclaimant Amber Heard, we rest.
All right, thank you. All right, rebuttal evidence?
Yes, Your Honor, Mr. Depp calls Walter Hamada of Warner Brothers.
All right, Mr. Hamada.
Straight out the gate with Walter Hamada. This is going to be by video deposition.
Your Honor, just to clarify, this is by deposition, so we may need that.
Okay, well, okay.
I apologize, I should have provided notice.
That's all right.
Thank you, Your Honor.
If we could skip this, yeah.
Warner Brothers. Exec in charge of DC films. This testimony will be bad for Heard's damages claim. He's also going to, I believe, make fun of Amber Heard's lack of chemistry with Jason Momoa. The hell is beeping? Oh, that's what it is. Okay, sorry. I should have that fixed by now.
Hamada, what Do you work for Warner Brothers Entertainment, Inc.?
Yes, I do.
In what capacity?
My title is President of DC-based film productions for Warner Brothers.
What, if anything, you did to prepare to testify for Warner Brothers as to topics 2 through 18?
I did not do anything to prepare for this, other than the meeting that I had with the attorneys.
Did Warner Brothers have a contract with Amber Heard to perform in Aquaman 2?
Yes, there was we had an option agreement for her for Aquaman 2.
Do you know what it is?
It looks like a standard contract between an actor and the studio.
And which actor was involved in this? Which actor was a party to this contract?
Amber Heard. It's a contract for Amber Heard for the role of Mara in Aquaman and its sequels.
Which studio contracted with Amber Heard?
Warner Brothers.
When did you come to be the president of DC?
At the beginning of 2018.
Mr. Hamada, was Ms. Heard ever released by Warner Brothers from the Aquaman 2 contract, or what you call the option agreement?
No.
Was she released from her Aquaman 2 contract on or about February 22, 2021?
No.
Was Ms. Heard ever rehired for Aquaman 2 by Warner Brothers?
No.
Why is this not edited out?
Did Ms. Heard receive a pay increase for Aquaman 2?
No.
Why not?
As a rule, as a company, we go through a lot of trouble when we make our deals with our actors. We get options on them for subsequent movies. And I think traditionally, prior to me joining the company, every option was renegotiated. And one of the things that we were trying to put a rein in on was not renegotiating every deal, with the understanding that people come in and make these deals and they have an understanding that there will be options and that there is a deal in place. And it was a big part of our philosophy that we were going to hold people to their options moving forward.
But did Warner Brothers at any point in time reduce Ms. Heard's role in Aquaman 2?
The role in the film the size of the role in the film that she has was determined in the early development of the script, which would have happened in 2018, I would say.
Well,
So, and from there, beyond normal development, the role sort of, the character's involvement in the story was sort of what it was from the beginning.
Was her role ever reduced for any reason?
No, I mean, again, from the early stages of the development of the script, the movie was built around the character of Arthur and the character of Orm, Arthur being Jason Momoa and Orm being Patrick Wilson. So they were always the two co-leads of the movie.
Did Warner Brothers ever plan to portray Ms. Heard as the co-lead in Aquaman 2?
No, it was the movie was always pitched as a buddy comedy between Jason Momoa and Patrick Wilson.
Was Ms. Heard cast in Aquaman?
Yes, she was.
Was Ms. Heard cast in Aquaman 2?
Yes, she was.
Was Ms. Heard paid for her services in Aquaman 1?
Yes.
Was Ms. Heard paid for her services in Aquaman 2?
Yes.
Was her compensation for Aquaman 2
Was it pledged?
affected in any way by anything said by Johnny Depp?
No.
Was her compensation for Aquaman Stu affected by anything said by Adam Waldman?
No.
Was her compensation for Aquaman 2 affected by anything said by anybody representing Johnny Depp?
No.
Was there any delay in Warner Brothers exercising the option to cast Ms. Heard in Aquaman 2?
Yes, there was.
How long a delay was there?
So interestingly, they had an option contract,
I don't know, it probably
not an
weeks.
actual contract.
Yeah.
What was the cause of the delay?
There were conversations about potentially recasting.
Ooh.
Who was the producer?
Peter Safran,
Who was the director?
James Wan.
Did Warner Brothers believe that those concerns were legitimate?
Yeah, I mean, I had no reason not to believe the director and the producer of the movie.
And you are testifying today as a representative of Warner, correct?
Yes, I am.
What, if any, creative concerns did Warner Brothers have about casting Amber Heard as Mira in Aquaman 2?
It was the concerns that were brought up at the wrap of the first movie, production of the first movie, which is the issue of chemistry. Did the two have chemistry? I think editorially they were able to make that relationship work in the first movie, but there was a concern that it took a lot of effort to get there. And would we be better off recasting, finding someone who had better, more natural chemistry with Jason Momoa and move forward that way?
Oof.
Did Warner Brothers take any steps affirmatively to audition other actresses for the role of Mira in Aquaman 2?
No, we did not.
Other than the creative concerns and concerns about chemistry you testified about, was there any other reason Warner Brothers delayed in picking up Ms. Heard's option for Aquaman 2?
No, it was all concerns about whether she was the right bit of casting for the movie.
What role, if any, did Ms. Heard's dispute with Johnny Depp have in Warner Brothers' delay picking up Ms. Heard's option for Aquaman 2?
None.
There was none from our end.
At any point in time, was Warner Brothers considering paying Ms. Heard more money for Aquaman 2 than is set forth in the option contract you previously identified?
Never.
No, as I said, we were determined to hold our actors to their option agreements.
Would Warner Brothers have paid Ms. Heard more money on Aquaman 2 if it had picked up her option earlier?
No.
At any time from the beginning of history through today, did Warner Brothers ever release Ms. Heard from the Aquaman 2 contract?
No.
At any point in time from the beginning of history to today, did Warner Brothers
Back to the
rehire
dinosaurs.
Ms.
Look at that pen going.
for Aquaman 2?
No, because we just
Amber
picked
Heard
it.
scribbling away like crazy.
And when is the last time you spoke with Rob Cohen relating in
9
any
minutes.
to whether to exercise the option on Amber Heard? for
Took them
Aquaman
9
2?
minutes to
No, it
destroy
would've
her
been
claim.
the same time that I was having those conversations with Peter Safran
So
in 2020.
did you speak with Zack Snyder at all relating to whether to exercise the option for Amber Heard on Aquaman 2?
No, I've not had any conversations with Zack Snyder.
Did you speak at all with Jason Momoa in preparation for your deposition today?
No.
Have you
Why
ever
would- why
spoken
would he
with
talk to
Jason
him?
Momoa about any issues relating to chemistry between he and Amber Heard?
Yes.
Did you
Oh,
speak to
no.
Jason Momoa about chemistry issues between he and Amber Heard?
That would have been in that same time period where we were prior to.
Obviously, Momoa didn't say the chemistry was
Yeah.
awesome.
You were asked some questions about scripts. Did you review any of the drafts of the script for Aquaman 2?
Yes.
That literally took
When?
Depp's team 9 minutes.
Part of my role is I read all the drafts to the scripts as they come in.
When was the first script for Aquaman 2?
Oh boy. I cannot tell you. Probably in 2018, the latter part of 2018 would be my guess.
By the way, if she
And
wasn't getting
how
recast for
many
Aquaman 3, she
versions
is
of the
now.
Script had been written by the beginning of 2021 for Aquaman 2.
Oh, there were probably half dozen drafts of the script.
All right. What, if anything, did Rob Cowan say to you about chemistry? What specifically about the chemistry between Amber Heard and Jason Momoa?
Just the fact that they didn't really have a lot of chemistry together. You know, the reality is it's not uncommon on movies for two leads to not have chemistry, and that it's sort of movie magic and editorial, the ability to sort of put performances together, and with the magic of, you know, a great score and how you put the pieces together, you can fabricate sort of that chemistry. And so I think in at the end of the day, I think if you watch the movie, they look like they had great chemistry. But I just know that through the course of the post-production that it took a lot of effort to get there. Sometimes you don't. Sometimes it's very easy. You just put the, you know, characters on the screen together and they work. And sometimes it's harder. And so...
Can you give me anything more specific about what it was with Amber Heard and Jason Momoa that
Didn't like
she's a
the-
bitch.
difficult for the chemistry?
No, because it's like what makes a movie star a movie star. Like you
Oh,
you know,
Oh, no.
the chemistry wasn't
Oh.
there.
Now, you've used the term fabricated a number of times. What did you do to fabricate the chemistry between Amber Heard and Jason Momoa?
editing.
Well, those are just it's editorial. You know, a good editor and a good filmmaker can pick the right takes, can pick the right moments, and put scenes together. Again, score is a big, you know, the music in a scene makes a big difference. You can
All
make
the
a
tricks.
happy scene feel sadder or a sad scene feel happier.
It's like
So
Amica cream, but an
it's-
editorial.
It's just the magic of post-production, editing, sound design, music, etc.
And what do you mean by fabricating, though? I mean, were they literally falsifying, or were they just picking the best
No.
music? Let me finish my question. Were they picking the best music and picking the best looks because that's their job and that's what you do on every scene?
That is what we do in post-production. That's what filmmakers do. This is on any production. You're doing that. You're
Movies
putting
are
performances together.
manipulative.
Sometimes it's easier than others.
You have 2
this
hours
one,
to get someone into very complex
more
emotional
difficult,
states.
because of the
It's
lack
a
of chemistry
production.
between the two.
There's production that
we were able to-
happened.
James Wan and the editor were able to get it to a place where the end result actually works, and it's great.
And in fact, that's the job of every filmmaker, right? Is to put all
Of
the
course.
combinations together to make the most successful production.
Absolutely.
Tell you what has been marked as exhibit number 5. It's ALH 18247. And this is a text message exchange between James Wan and Amber Heard. And you mentioned James Wan was the director of Aquaman 2. Is that correct? And
That's
Aquaman, the first one, correct?
That's correct.
All right. And James is texting to Amber on August 25, 2018. You rated really high with the audience, exclamation mark, exclamation mark. Do you see that?
Yes.
This is August 25, 2018. What's going on August 25, 2018 that would cause the director to send a text message to Amber saying,
That'd be a test screening. So during our post-production of the movie, we test the movie with an audience, and the audience tells us what they liked and what they didn't like. And so that's what he's referring to there.
and they really liked Amber Heard, correct?
Yes, she did. She tested well.
hit $1 billion. Is that correct?
Yeah.
And more specifically, did you play any role in the determination to communicate to Amber's representatives that Warner Brothers was considering not exercising her option?
Yeah, probably in the sense of we had the conversations, and I believe, if I recall, we had that's where Peter Safran offered to reach out to the agent and express which direction we were leaning.
Have you seen any document that says there was any chemistry issues between Amber Heard and Jason Momoa in Aquaman 1?
Just say yes.
Documents? No, I mean, those were all conversations.
But if Jason came back and James
Just
Wan
many conversations.
that Amber Heard would play Mira, correct?
That's correct.
Okay. And Jason Momoa was able to negotiate a different compensation structure, was he not, for Aquaman 2?
That's true. He did renegotiate.
Now, Aquaman was the highest grossing DC film ever for Warner Brothers, was it not?
Yes, it was.
And what, if any, issues did you have with Amber Heard in Aquaman 2?
She's
My understanding
unlikable.
is actually the production went very smoothly.
They have to head off
Your next
the
witness.
fact that she injured Jason Momoa's eye and delayed production. That they have to leave that out.
Your Honor, we call Dr. Colber next, but I know we have a preliminary matter that we need to deal with briefly.
Hey,
If we
do
may
you-
approach.
Sure.
To those in the chat who are here from Tug, that Umbrella Guy's channel, it got his stream was shut down briefly. It is back up, and while I love having you here, Tug is a very good friend of mine, and I would not want to take away viewers who would love to see his show but may not be aware that he's back. So if you are here from Tug's channel, I bid you all the good grace to head back over there and know that his stream is up and running. So it always sucks when we get shut down by an internet issue or some other thing. I don't know what the deal was with Tug's stream, but it's very frustrating as a streamer. So if you're here, welcome. You're welcome to stay, of course. But if you're a Tug fan, you may want to pop back over. Okay. Next, Zyphon. Ave to the nose, hashtag me poo, hashtag Amber Turd. I appreciate what you do so much. Thanks for being a shining example of being yourself while being successful. It's making me want to produce videos for YouTube to a brighter future, brother. Back at you, buddy. Look, if you want to do it, do it. Do it as a hobby. Do it because you love it. And then if you ever happen to grab the wave, grab it by the balls and don't let go and ride it as hard as you can. I can tell you, I've never worked as hard on anything in my entire life. So, but it's all good work and all rewarding work for me. Waleed Al-Gamadi, when a jury hopefully says Johnny is on the right, what different sentences can the judge make to that effect? We'll get that in a minute. I think there's an issue with maybe some understanding of the U.S. legal system and what's going on here, but we'll do that in a second. Also, if the jury says he's not on the right, what about Amber's counterclaim? Is that a separate ruling? Okay, so the second one first. Yes, they are two completely independent claims. They just have the same nexus of facts. They really don't have the same nexus of facts, but they involve a lot of the same characters. So for judicial efficiency, they have two claims going at the same time because they can just get all these things at once. So second, if he is found to be the victor, it's not up to the judge. This isn't a criminal case, so there's no like sentencing that goes on. This is a civil case. What would happen is the jury would determine what award would go in Johnny Depp's favor if he wins, or in Amber Heard's favor if she wins. So in civil cases, it comes down to money. Money is a representation of the court's ability to resolve a conflict or an issue. And if an issue or conflict cannot be resolved by money, it's presumptively not a matter for the court. They're not allowed to force people to like make statements or apologize or whatever. Those can be done in settlements, but they can't be awarded by jury or judge. So this is just about how much money do you win if you win. I hope that answers your questions. Darren Haviland, why is Barney the dinosaur there? Oh, come on now. Sir J-Dog 21 with a huge chat. Thank you so much. Started reading the Irregular at Magic High School light novel, and it has big anti-communism and capitalistic sentiment in the first arc. As Richards explained what Doc Spiegel explain what Doc Spiegel did with his face and mouth with a reenactment as well, please. We saw that doctor, and he was either maybe having the drip from cocaine hit the back of his tongue, which looks a little bit like this, or he was remembering the first time he had a popsicle as a child, which was probably also used as a bludgeon against him by all of the other kids who were noticeably larger. Jay Lama, can you do a LawTube screening of Aquaman, please? I watched it last night. It was so bad that it would probably make great content. The only way to do that and not like die from copyright and all of the lawsuits would be to watch it but not display it to the audience, which we could do. It'd be like a riff tracks type thing, but getting everybody together to spend 2.5 hours of their wonderful time enduring the Aquaman movie is a hard sell. Hey guys, come watch this average film.
You could pull it off, Nick.
Yeah. You in? Are you in for watching Aquaman?
Well, not at 2:00 in the morning when you would do it.
That's the other hard part. If I do it in the middle of the day, my kids will be coming into the room all the time. The Dragon's Treasure. Why is no one talking about how ugly Amber Heard's hair is today? This ponytail braid thing doesn't work. As a ponytail simp, this offends me. Also, buy my tea. That's at thedragonstreasure.com. Guys, he really does look, I joke about him being a piece of garbage, but he's actually a really good dude, and he makes really great blends of tea. It's hand-picked, loose leaf tea, hand-selected and blended. And it's honestly phenomenal. It's best teas I've ever had, which may not be saying much, but it's better than Lipton by a clear mile. And he has some really great blends. Elixir of the Gods being my absolute favorite. Phenomenal. Rayona 1868. Whitney Heard looks like if Kristen Stewart and Amber Heard had an accident baby. Oh God. All right, Satan the Sir gaming and stuff. It's quite unfortunate that just because the trial is so high profile, the judge has to bend away from striking an obviously bad counterclaim. Yeah, I mean, I have no question that the counterclaim was made in bad faith. I don't think that they've constructively proven damages or even tangibly linked the damages to the sentiment. I think the much bigger thing is hashtag justice for Johnny Depp. I think that's a much bigger factor in any potential or perceived damages that she has. But realistically, they haven't shown that she lost anything. I mean, and that's what's going to be on close. What did she lose? She has her contract. She's getting paid for Aquaman 2. She has her L'Oreal contract. Oh, and also maybe the reason she didn't get roles between 2019 and now is what was it? It was, a global pandemic called Corona, in which a lot of people didn't get roles. Hollywood slowed to a crawl, and there was just not much happening. And Amber Heard, she's a wonderful actress, and I'm sure will land on her feet going far into the future, right? Like that's the argument. But yeah, this judge was not going to knock out the counterclaim. It would carry a heavy implication of perceived bias. Not appropriate, but it would. Megan Davis, look for Small Munchkin in your Twitter messages for that screenshot. I think it's really funny and you'll get a good chuckle out of it. I messaged you again to try and get it to the top. Again, keep it up. Small Munchkin. Oh, there it is. This is pretty good. I'll bring this over. This is YouTube subtitling. The subtitling algorithm is a troll on this. Notice we got the subtitle from the doctor yesterday, which I peed. Good job. Good job to that guy. Mick123 Mick. I missed yesterday, but the psychiatrist yesterday talked about gabapentin. It's used for one pain disorder, fibromyalgia, which is caused by PTSD. Does not affect normal pain, as he implied.
Ladies and gentlemen, I apologize again. We have a few things to take care of. We're just going to go ahead and take our morning recess now for 15 minutes. Do not discuss
Oh
the
my
case.
God, man, the pace is.
Doing the outside research. Sorry, that was the same thing.
The source is this person takes it for fibromyalgia. It's also for restless leg syndrome. I don't know what else it's used for. But yeah, I know people who take gabapentin as well. Yeah, so those preliminary matters are not that brief, apparently. So Dr. Colber,
If the doctor testifies, then is that WebEx? Okay, so I'll get that set up too while we take the break as well.
WebEx. What next? AOL.com?
Let's make it 10:50 to give him time to look at everything, okay?
All right.
I believe, is Dr. Colber the hand doctor? Surgeon, Johnny Depp's severed finger story has flaws. From Manistee News. I love finding the like talking points that came out or that come out from testimony. I don't know who Dr. Culver is specifically. Hey, what's up? Adam Krigler is in the chat. How you doing, buddy? Look forward to talking soon. Okay, here we go. We'll just get rid of that while we wait. All right. Tara Rayner, Johnny Depp rebuttal list that I sent you last night is bound to demolish the smidgen of credibility she thought he had. Okay, so it was you who sent me that. Okay, now I know what to look for. Very helpful. It was on a completely different app. No wonder I couldn't find it.
I see someone in the comments asking me what I think of USCCA, which is one of those self-defense insurance companies. Folks, I've written about it extensively. It's at lawofselfdefense.com/USCCA. You'll find everything I have to say about it.
Okay. Dr. David Colber is, yes, the hand doctor of Mr. Johnny Depp. That's who will be testifying next. So he's going to come in and annihilate yesterday's witness. That's the whole purpose of that. Here's the rebuttal witness list. Dr. Richard Shaw. I don't know who that is. Kimberly Collins, who is a forensic pathologist. Candle Davidson Goldbrun, representative for the Children's Hospital of Los Angeles. Walter Hamada, who we already had. Richard Marks, the entertainment lawyer who testified earlier. Mike Spindler, an economic damages expert. Doug Bania, social media and internet analytics expert. That guy would be there to counter the Q-score arguments of the previous witness and the Poindexter guy. Spindler, the economic damages expert, would be for yesterday's final witness. Morgan Knight, witness of the Hicksville incident. Dr. David Colber, which is hand doctor for Johnny Depp. Jennifer Howell, that'll be by deposition. That's the former friend and boss of Whitney Heard, Henriquez. And then tomorrow's witness list, I mean, these are interchangeable still, but the rest of the list is Kate Moss, the supermodel, Brian Neumeister, a metadata expert, Morgan Tremaine, doesn't say who they are. Lydia Phillip, who is the flight attendant, presumably the one who Johnny Depp allegedly threatened to break the wrist of after giving her drugs, which would be so many federal crimes. Dr. Shannon Curry, forensic psychologist, coming back, and then Johnny Depp himself. So that's
a hell of a lineup.
Yeah. Whether or not they have time for all of it will be a matter to be determined by the pacing of things, but they have 3 days. That's not too many witnesses for 3 days.
And they've been quick on this. I mean, his last video deposition was fast.
10 minutes of Johnny Depp's time, about 10 to 11 minutes of Amber Heard's time. So that'll be great. There's a Dr. Richard Shaw at Stanford who specializes in child psychiatry. Maybe he'd come in to testify about Johnny's lingering effects of Johnny's abuse as a child or something. I don't know. Who knows? Who knows? We'll see when they call him. And Tara Rayner followed up that it's in her Facebook DMs. Thank you. B Sport 48. Can you provide some BTS on how these parts of the trial work? Behind the scenes. Oh, if judges already ruled, had she already written arguments, seen written arguments? If she saw Johnny Depp's written arguments, if so, why bother with hearing oral arguments? Big time noob here. Thank you so much. One, you're entitled to an oral argument on a lot of these issues. Two, you may be able to articulate something that the judge had a question on from your written argument that gets resolved by an oral argument. Or three, you may come up with something in the interim time between the oral argument and or between the written argument and the oral argument that you need to include. And finally, in this case, the written arguments were submitted prior to the close of evidence in Amber Heard's case, because that only happened today. So at any point, they could have resolved some issues, or some evidentiary issue could have come up that they needed to speak to at oral argument. So they let oral arguments happen as they are timely. They're done at the appropriate time, and they resolve those issues. I hope that helps. The judge had already ruled, because the judge had made a determination based on the the strong preference to let these things go to jury trial at this stage, or go to the jury at this stage in the trial. And we're talking about an 11th hour removal of a thing that jurors have been sitting there for weeks for. That might just piss off the jury too. These people have been listening as diligently as possible for all this time. And then to suddenly say, oh yeah, by the way, this one issue, we just wasted your time on it. Not really great. So they, their presumption is to let it go to trial if any scintilla of evidence is entered. And that's in the interest of justice. So hope that helps answer your questions. Timothy Reaper, if you've ever dealt with the brain witches before, you've seen doctors like Smeagol, they're always right. And how dare you question their word? Then they prescribe medicine that, when taken together, will cause seizures. Sometimes that's how it goes. Really quickly, guys, if just to let people know on the super chat thing, during these shows with the trials, so many chats come in that it's often impossible for me to address them all on the stream. So I have a system that I've had in place for 3 years, a little over 3 years. And that is that I read all $20 and up super chats as fast as I can in the order that they come in. I obviously don't want to be reading chats over the trial discussions, but I do that as trial management, or as time management for these things. And then I try to get to the rest of them as I'm able. So I appreciate all super chats very much, but if you really want your thing read, unfortunately, there's economics at play with time. For example, yesterday, 831 chats came in. If I spent 30 seconds on each chat, on average, reading it out and going through it, it would have been 7 hours straight of talking. So to give you an idea of why I can't possibly get to all of them. So I know some of you have questions about like the legal processes. That's the best way. If that doesn't work for you and you don't have not everybody has $20 to throw at somebody, and I fully understand that. There are other ways to get in contact with me, and I try to answer things as I'm able. Some of the best ways are to participate in a locals live stream or something like that, or to catch me on Twitch. If you catch me on a Twitch stream, I tend to try and interact with the chat, and there's not 50,000 people watching. There's like, a couple hundred. So it becomes a little bit more manageable. Lancelot, they didn't bring up the Avatar lead because they forgot he existed to even bring him up. Yes, I agree. Because I forgot he didn't even occur to me that there was an actor playing in that movie. And I think Sigourney Weaver was in that too, if I remember right. Yeah, Rick Nikitas' live chat, BTFO. By the way, we'll be doing a lot of live chats when this trial's over in the Discord. Again, these trials put a strain on that type of content, unfortunately, but that's the way it goes. Deccan, Johnny had Slim tattooed on the 4 fingers of his right hand. He had it covered and changed to Scum. Thought you in the chat might appreciate that.
Wow.
Ouch. He did the same thing with Winona Forever. Like he changed Winona Forever to Wino Forever. So that's good. Good stuff. He should stop tattooing women's names and monikers on his body. Just a
Or just
general
keep
rule.
dating women with the same name.
Yeah, that's the handy way. You've got a list. Look, you've got 3 options for names if we're going to enter into a relationship. Well into
I know
art.
your name is Winona, but can I call you Karen?
Well in art, welcome to paralegal status. Ms. Bell, welcome to paralegal status. Thank you for joining as members. Ola Kyle, could Johnny's team just play a bunch of video depositions to run out Amber's time with the pre-recorded cross? If they did that, like if they front loaded all their video depositions and they had calculated out that it had 4 hours of cross, which I don't think they have that many, but if they did, I'm pretty sure the judge would allow them some live cross time and see that as a dirty play sort of tactic. I just, unless they had really good reason, like, oh, none of your live witnesses can come in prior, can't break it up at all. Okay. Yeah. I don't think that would not sit well with the judge, in my opinion. Base Chica, that's solid of you to say that, Ricada. I came here from Tug for this one. Here's a tip for being a stand-up dude. Oh, thank you. Even though I spend most of my day sitting down. Patricia Nolan, thank you for hosting us temporarily. Oh, happy to do so. Johnny Rivers, you got any painting tips for minis? Oh, you don't want them from me, brother. I'm a novice. Have you ever thought of doing a tutorial vid for subs? The worst advice on the internet right there. I'm a perfectionist. I keep trying to paint, end up stripping them and repeat. It blows. Thanks for all the content. Go Pack Go. Well, yeah, I can say, stop trying to be perfect at painting because you won't. That's the best I can do. I'm not a great painter, but it doesn't matter. You put the paint down on the mini and you let it be done. And then you paint the next one. There's always another one. You don't have to strip the same one. That's silly. Paint another. Joey Big Play says Branka keeps dodging the G word or R word question.
What is that?
Would you rather be the G word or the R word? Gay or retarded?
Oh, well, I didn't know I was dodging it, but I'll take the dodge right now. Sure.
There you go. River Thill says Dr. Spiegel looks like Doc Brown mated with Jordan Peterson and took acting lessons from Jim Carrey. Tina Lewis, thanks for the clarification concerning Barney the dinosaur. I thought that was Grimace, the mascot from the old school McDonald's. Garrett Patrick, this entire court hearing reminds me of Bugs Bunny versus Daffy Duck. It's Depp's fault. It's Heard's fault. It's Depp's fault. It's Heard's fault. It's Heard's fault. Guilty. Lawyer Mommy versus Cat Lady. B.A. Krim, have you seen the video of former Broncos brawls in New York airport versus airline employee claim of self-defense? Someone sent that to me. I haven't watched it. Have you watched this thing?
I saw a little clip. Of course, when you only see a clip, you don't know the whole story. But the clip I saw was the airline employee punching some other dude in the face and then the other dude knocking him out cold, knocking out the airline employee cold. From what I saw, the airline employee was the initial aggressor there. But I don't know. I don't really know what preceded that.
There's always minutes before whatever happened that could change that. Was the football player as big as I imagine him to be, getting punched by a small airline employee?
No, he didn't look that big, and the airline employee was pretty husky. I mean, I wouldn't call him fit, but he was. There was poundage there.
Sure. I always love when I see like someone like little hit an athlete, and you're like, "What are you doing?" That person's like 3 of you and muscle.
Well, people are taught this lie that they can learn some fighting technique that lets them beat up bigger people. I mean, I guess that's true if the bigger person is completely inept. But if you have 2 people and both of them can throw a punch, the bigger dude. I mean, there's a reason we have weight classes in these sports.
Yeah. I mean, there is some level of skill that can overcome other levels of skill. Oftentimes there are rules involved in that. And in street fights, man, if you're not bigger than the other person, you should very strongly consider what you're doing. You should just also not get in street fights because you're older than that, no matter who you are listening. Just curious as he's being charged with simple assault. The Bronco, the former Bronco is getting charged with simple
A thrown punch is normally just going to be a simple battery.
Yeah. But they're
Happened in
saying
New York. New York tends to reverse the term, so they would call it a simple assault. I don't know why they do that, but
yeah, in Minnesota we call it assault too, which annoys me. But yeah, but if he's getting, you said he was the one throwing the punch back, so there must be, well, there may be some other context there that's missing. Right. Elite Neo, hey Andrew, we use WebEx at my workplace for all of our instant messaging and video conferencing needs. I feel attacked, although some of my teammates are lead included, which we had Microsoft Teams instead. Take that as you will.
Okay.
You did. You took it as you will. Perfect. Catherine Smith, Branka, been watching you pre-Chauvin and Nick. Pure intellectual gold, tie or no tie.
Well, that's very kind of.
No tie, Branka and Rackets is freaking magical. Watch it, peeps, and pledge that like button. Thank you very much, Catherine.
And for those who like what I do, you might sign up for one of our free self-defense law webinars at hardtoconvict.com, right there under my picture.
You do those for free?
Yeah. Just about every week. We canceled this week because I wanted to cover the trial, but just about every Wednesday we do one.
Is it like one of those like a timeshare thing? It's like, oh, come to this free thing. There's muffins. And then you get in there and they just lock the door.
No, you can leave anytime you want. We don't lock up your computer. It's about an hour and a half of what I think is useful content. And then, of course, we do pitch stuff at the end, but you don't have to stay for the pitch.
Don't worry about the gas hiss that you hear seeping into your office right now as you watch this.
It locks out your keyboard.
Lay fun. Thanks for your coverage and awesome streams. Love it. Take my money. I will. Thank you. Jordan Bolduc, with all due respect to the judge, she looks like Henry Winkler. Rick Moranis. Rick Moranis. I mean, man, that is an apt comparison. Adam Young, you think Depp's team will try to put Kate Moss on after Heard's time runs out? I saw Runkle and Rob talking about it. I mean, no doubt they're going to try and strategize, but the part you can't strategize around is no matter how you structure your witness order, they can reserve the time. Like they don't have to spend time crossing anybody if they don't want to. So if you try and put garbage witnesses up to soak up time and they see that they're garbage witnesses, they're just not going to, do anything. And you'll end up burning your own time. And for every hour that they want to bleed out of the other side, I would say they likely to reliably get them to burn time. They need to spend at least a 2-to-1 ratio of minutes, maybe 3-to-1, of getting direct testimony that they will have time countering. Cross-exam is necessarily shorter. You have these directed questions for a reason. You have leading questions, so you don't have to go through all the nonsense. The foundation about who the person is and why they're relevant to the case is already laid on direct. So again, trying to game it out is a strategy that could work, but it can also backfire on you. You could waste a bunch of time with frivolity. And then they could just reserve it if they recognize what's going on.
Of course, one benefit to putting people on the list, I mean, you don't have to call them. And if you put people on the list, then the other side has to spend time and resources preparing for that prospective witness. Just like the Heard people did by saying they were going to call Johnny Depp, right? And then never calling him.
When Amber's witness list, I think in general was something like 80 people long. They clearly did not call 80 people. They called like 9 or something. Sam Curry, ceiling fan, microwave, cars and coffee, door frame, bed bugs, 17 across minus 14.
Okay.
I don't know what the hell that is. What the hell is that? Bowie says all Karens from now on are Ambers. Ooh, that would be bad. That would actually be like the worst thing that could happen to someone is if, like, I don't know, a president or something renamed Karens into your name. In honor of so-and-so, Karens are now called nuclear codes, crossword puzzle, timekeeping. I'm now a spy, a riddle. What the hell was that? There you go. Oh, here we go.
Yes, sir. Okay, approach.
Zach Donnell, FYI, Morgan Tremaine on the witness list is an ex-TMZ reporter. Oh, okay. Well, then that would be, how'd you get the tapes? Miss Heard disclosed this to you? Okay, there you go. Were you tipped off about the divorce proceedings, all that stuff? Just going straight to the credibility of Amber Heard. And anything like that can be absolutely brutal. This case is about whether or not people told the truth. Like, that's ultimately what defamation is. Prove that you're telling the truth when you want to destroy my reputation. And so if you show someone to be a liar based on what they've represented to the jury is going to have a hard time being lied to by someone and then finding that they told the truth in a different place. So that's why it's such a critical thing to try and get that into the record. Rick Nikitas says, breaking news, Arby's now sells hamburgers. Why? Just eat a roast beef sandwich. Jason Grimm, if the law teams were swapped, how would you predict the trial would be perceived at this point? Due time in the trial. This point in time in the trial. I personally believe that one, I think Elaine would be trying to screw up Johnny's case. Not trying, would be effectively screwing up his case by being herself. I think she's just demonstrated that whatever competence she may have had in her career as an attorney, I don't think she has it anymore. And I think now she might be banking on reputation or marketing on reputation. But I don't see any reason I would ever hire Elaine to do any legal work at all.
I mean, I've never seen her in a case before, nor would I expect to. I presume you haven't either.
No, someone said that they've pulled transcripts of her and that she's atrocious, but I don't, I mean, who knows? But
I mean, I think it's hard, in some sense, it's hard to say, right? Because I think Depp has the legal merit in this case. And so it's an easier case to argue when you have the legal merit. That said, I mean, certainly Camille comes across as way better of an attorney than anything Elaine's doing here.
Yes. And one of the things I was going to say is I think the crippling thing for Amber Heard's team is Amber Heard. I honestly think this counterclaim was a very poor choice. I think it exposed way too much of Amber Heard's, I guess, issues to be brought in to the trial that otherwise would not be. We wouldn't have psychiatric testimony, most likely, if there was no counterclaim. Right. So that was court-ordered evaluations of Amber Heard by both sides, and nothing for Johnny Depp because he's not claiming emotional damage. Only she is. So, but yeah, I think the big hurdle on Amber's side is Amber Heard. And so I think you'd see a lot of the similar issues that are going on in the case because I think she's directing that. Rottenborn, as much as I don't like him, is a competent, he seems to be a pretty competent attorney. And, I don't think that he's the cause of many problems. He hasn't demonstrated anything to lead me to that conclusion.
He doesn't just shrug in front of the jury and say, "Oh, I'm trying."
Right. Yeah.
Sir, can you hear me?
Yes. Can you hear me?
Yes. Can you count to 5 for me?
1, 2, 3, 4, 5.
It's like a roadside sobriety test.
I'm just trying to get you on the big screen. We're waiting for the jury.
Say the alphabet backwards, sir.
Thank you.
Don Booz says, I'm paralyzed and I take gabapentin for my nerve pain. Hey, there you go. Thank you. Tara Rayner, here in Ontario, Canada, assault charges are usually laid against the least injured. Unsure if that's a factor with the Broncos dude, but let's talk about the guy that Tyson beat. How many can say I pissed off Mike Tyson and walked? Do you want to press charges? No.
Just gonna get a matching face tattoo.
Yeah. In the
be seated.
In the U.S.
witness,
we called Dr. Colber.
Charges
sir,
are.
if you could raise your right hand.
I have.
So this is the hand doctor. This is the guy who actually saw and treated Johnny Depp's hand, as opposed to the Heard expert who never even saw the injury.
Documents right in front of him.
All right, sir, you can put your hand down, and any documents you have, if you could put them away, and just testify from your memory. Okay, sir. Thank you.
Thank you, Your Honor.
All right, your question.
It's weird he wouldn't know that.
Could you please state your
Gosh,
full
she's
name for
quiet.
the record?
David Allen Colber.
And what is your profession?
I'm a plastic and hand surgeon.
And how long have you been a plastic and hand surgeon?
Been in practice for 26 years
Where do you currently work?
at Cedars-Sinai Medical Center
How long have you worked there?
for the past 26 years.
Do you know the plaintiff in this action, Johnny Depp?
I do.
And how do you know Mr. Depp?
I had taken care of him when he had injured his hand.
He injured his
When
hand.
did
There
Mr.
you go.
Depp become your patient?
Should have been. I put his finger back on when some bitch cut it off with a vodka
Sometime
bottle.
in March of 2015.
And what type of treatment did you provide to Mr. Depp?
He had a fracture of his finger with soft tissue loss. And so we reconstructed his finger.
When did you perform the first surgery on Mr. Depp's finger?
I believe it was around March 20th of 2015.
And what was involved in that surgery, just briefly?
Debriding the devitalized tissue, putting a hypothermic skin graft, restore some of the soft tissue loss that he had, and then also putting a pin in because he had a displaced distal phalanx fracture.
What was the state of Mr. Depp's hand immediately after that surgery?
It was post-surgical.
I'm sorry, I think the audio cut out a little bit. Could you please repeat your answer?
He didn't hear the question.
It was injured
Oh.
and he had soft tissue loss and a fracture of his distal phalanx.
And what type of cast was on Mr. Depp's hand after you performed that surgery?
Strong showing for WebEx here.
It was a plaster splint.
And can you please describe to the jury what a plaster splint would look like?
So it's like a cast, but you don't want to put everything circumferential on it because of swelling after surgery. So I believe in Mr. Depp's case, it was like the two fingers. I think the third finger was the one that was operated on. So these two fingers, the third and fourth finger together. And it's a splint with plaster on the top and on the bottom that goes around the hand to protect it.
How mobile was Mr. Depp's hand when it was in that cast?
Well, he couldn't move his third and fourth fingers because of the bulkiness of the splint. Typically, post-operatively, it's a more bulkier splint right after the surgery. So it's not very, it gets in the way.
Could Mr. Depp grab someone with that cast on his hand?
He could attempt to grab someone. I don't know how successful he would be. He had his index finger free and his thumb free, but the other fingers were probably not being able to move.
How long was the pin in Mr. Depp's finger?
About 11 or 12 days.
And how was the pin removed?
It was removed under local anesthesia in my office.
How long did you ultimately treat Mr. Depp for his hand injury?
For several months.
And why was that?
It was a bad injury.
Oh my God, someone's dying in the courtroom.
Little office procedures to clean up the tissue. He had an infection as a result of the injury. So he had to be on antibiotics for some time until it finally completely healed.
Do you recall when the infection developed?
It was a few weeks after the surgery, and that's when I took out the pin.
When was the last time that you saw Mr. Depp?
Sometime in 2015. I don't recall when.
And when was the last time that you spoke to Mr. Depp?
The same, around 2015.
Thank you, Dr. Colber.
All right, cross-examination.
There you go.
Quick.
No need to dwell on anything there.
Good morning, Dr. Colber. So you said that this plaster splint was put on after surgery on March 20th, 2015?
Yes.
And a plaster
Yeah.
a plaster splint, is that sometimes called half a cast?
Sometimes it's called half a cast or a soft cast, something like that. Yeah.
And it's made of plaster of Paris, right?
Correct.
And plaster of Paris hardens like a cast does, correct?
Yes.
So other than the fact that it's a little smaller than a cast that goes around your whole hand, it's just as hard as a cast that would be put on a broken arm or a broken hand, correct?
Well, it's softer on the side so the fingers can expand for swelling. So it's not fully, the plaster appears circumferential around everything. So there are areas that are softer to allow for swelling.
But the parts that are covered with plaster of Paris are just as hard as any other cast, correct?
Correct.
And regardless of whether Mr. Depp could have grabbed someone with the hand with the cast on, he could have grabbed someone with the hand without the cast on, correct?
No, that wouldn't work.
Correct.
Michelle, can you pull up Exhibit 400, please? This has been admitted, Your Honor.
So this is not his treating doctor from Australia. This is his U.S. plastic surgery doctor, which is a shame. I wish the Australian doctor would have been called.
Permission to publish?
Yes, sir.
Downside is this guy can't testify to what caused the injury.
Dr. Colber, I'm just going to ask Michelle here to just scroll through these pictures, and I'd ask you to take a look at them.
Your Honor, I'm going to object for lack of foundation for these photographs.
They're already in evidence.
With respect to the questions to the witness.
They're in evidence. Thank you.
Go back up to that. Stop right there. Is there anything about the cast that was put on Mr. Depp's hand on March 20th, 2015 that would have prevented him from doing this damage to Ms. Heard's closet on March 23rd, 2015?
Objection calls for speculation.
Overruled.
I mean, he had his other hand available. So
no
These
further questions. Thank you.
Okay, I was going to say, if you try to do anything with this, you're wasting time.
Yeah.
Dr. Colber, how many fingers were in the plaster portion of Mr. Depp's cast?
I believe 2 or 3, at least 2 were, and the third one and the fourth one.
And
Oh, it sounds
why,
like 4.
why did you call it a soft cast?
Because it's not fully, plaster doesn't go around the entire hand because you allow for swelling. So there's plaster to protect the fracture. So there's a little plaster on it, but it's on the top and the bottom, but it's not completely circumferential.
Dr. Colber,
there's
if you had to
soft
slap
spots
a
to it.
hoe, could you?
And where are those soft spots located again?
Usually we'd put a piece of plaster underneath the fingers and on top, and then the sides of the fingers, it's soft so that the fingers can swell after the surgery.
Could Mr. Depp have hit someone with the hand that had the cast on it?
He could have hit someone with it. It probably would have
Broken the cast.
injured, damaged the cast.
Did you ever notice any damage to Mr. Depp's cast when you treated him after the surgery?
Good question. Thank you for finally asking it.
I don't recall.
Mm.
Nothing that comes to mind.
Could Mr. Depp form a fist with the cast on?
No.
This is the stairway
No further
incident.
questions.
He was
Thank you,
alleged
Dr.
to have
Colber.
held her
All right,
and
thank you,
punched her
sir.
repeatedly.
That completes your testimony. Thank you.
by Whitney Hurd.
All right. Your next witness. Plaintiff calls Richard Marks, Your Honor.
Oh, everybody's getting a turn today.
Marks.
She may have been the one to question Richard
So
Marks
just a reminder that
before.
you're. Hold on.
Were you here for Richard Marks's
Skips a
testimony the
second
first
on
time?
TV. No, sir, you're
No.
right. Just a reminder that you're still
This
under
guy's
oath. Okay,
great.
sir.
He's a entertainment lawyer in LA, and he's like, so I negotiated this deal. You may have heard of it. It's called Star Wars. The guy, like everything he's done. He's like, yeah, I helped Jesus write the Bible one time. You know, like he's done everything. He's been around forever. He knows everybody, and he's worked on like every project. He's like the guy who decided that Indiana Jones should wear a hat and it should fall off, and he should have to grab it all the time.
The Magic Man.
Yeah. He's a deal maker. Like this is the powerhouse you want on your team in Hollywood if you're trying to get something made into something.
All right. Morning, sir.
It's got to cost a
Yes,
fortune.
ma'am. Thank you, Your Honor. Welcome back, Mr. Marks. You've testified in this case previously, but would you just briefly remind the jury who you are?
I'm Richard Marks.
I'm the guy.
I'm the full-time entertainment transactional attorney. I make deals every day for productions and for individuals. I'm in the trenches negotiating and then making sure the contracts reflect the deals. And I'm very much distinguished from the other side's expert who is not an attorney, who's not in the trenches making deals, is not in that day-to-day process.
It comes out swinging.
Are you
From the other side's bimbo.
Catherine Arnold in this matter?
Yes,
Have you been asked to analyze that testimony and provide opinions in response?
Oh,
Yes.
yeah.
And generally, what are those opinions?
It's hot garbage.
well, my opinions are that she's very slick and smooth.
Oh my
But
God.
she's not an expert in deal making. Her assessment of damages is built on nothing, and it's wildly speculative.
I concur,
Are you
sir.
familiar with Ms. Arnold's opinion that it's customary for an actor to renegotiate the fee for a subsequent picture option in a multi-picture contract when a film is successful?
Yes, I heard that opinion.
And are you also familiar with her testimony that under those circumstances, an actor will renegotiate a 50 to 100% increase in their salary for the next optional film?
Yes, I heard her say that.
Do you agree with those opinions?
Absolutely not.
Why not, sir?
Well, what we're dealing with in this case is a test option agreement. And that's an agreement. It's a multi-picture agreement. And it's the nightmare for people like me. The test is going to take place, let's say, for 10 actors the next morning at 9. And you have to fully negotiate a contract that might cover 4 movies and have it signed before they're allowed to test, so that if they're chosen for the part, we have the full contract. There's no renegotiation. So you've got a contract for a multi-picture deal. It's usually a franchise, and you negotiate the first movie. And normally, if they get the part, they're the chosen one. They're the Stars Born moment, if you will. They get the part. Normally, their salary is inflated from their normal salary, because now they're going to play a character that could go on for 4 movies. In this case, Ms. Hurd's first salary when she got the part was $450,000. If Warner Brothers and DC Comics decided to make a next movie, they could recast her. They had no obligation. All they had was an option. But if they did cast her up front, that they had agreed to more than double her salary, like 2.25 times to get to the $1 million. These are large bumps, if you will. They're if an actor is on a series, say, they go and they have 5 options. They go up in increments of 5%, 10%, 20%, not these multiples that you see in a test option agreement. And that's one of the reasons that they aren't renegotiated normally. They are in some instances, but not normally.
What's the significance of the test part in a test option agreement?
The test significance is that an established actor usually wouldn't test. They'd be offered the role. Ms. Heard was in a group of actors that needed to be tested to see if the studio wanted to hire them. And then if they hired them, they would be locked up for potentially 4 movies at very lucrative increases, because after Aquaman 1, she gets to $1 million. Aquaman 2, she gets to $2 million. And Aquaman 3, excuse me, you get to $4 million. These are unheard of bumps if you're going on a normal career and trying to increase your salary by increments.
In your experience, what is customary for negotiations of multi-picture deals?
Well, I think what happened in this case was customary for negotiation of multi-picture deals. And by that, I mean that you assume success. The reason you go from the first Justice League movie where Ms. Heard played Mira the first time, the reason you more than double her salary is you assume success. So you've already built in the bonus that Ms. Arnold was referring to, a renegotiation, if you will, for the 3rd movie. Instead of doubling her salary, Ms. Arnold said it would only be fair to quadruple her salary. And that's just not the way these idiosyncratic contracts work. They're a very small portion of the contracts we deal with.
Are you familiar with Ms. Arnold's opinion that Ms. Heard's salary for Aquaman 2 could have been renegotiated to around $4 million?
I am.
Do you agree with that opinion?
No.
Why not?
Well, as I said,
Watch
that would
Aquaman
now
1.
be after a healthy first payday. It's more than doubled, and now it would be quadrupled. That's not the way it happens. Walter Hamada, who is the president of that part of the studio, said it doesn't happen. They're not going to do it. Ms. Arnold, for some substance, says, well, Jason Momoa got to do it, but she doesn't give us any of the details. We know that Jason Momoa was in a movie before the Justice League. He played Aquaman in a movie not with Miss Mira in that movie. So he had a history before the first movie with Amber Heard. He played Aquaman. We don't know what his contract, the state of it was when you got to Aquaman 2, and she says, unsupported, that he renegotiated. We're not sure what he renegotiated to. But I can say that at the end of the option period, when you've only got one option left and you want that star in more movies, you may renegotiate, but it's not a gratuity. It's, we'll give you more for the last option if you'll give us 3 more options. It's a give and take. And unfortunately, Ms. Arnold didn't give us any of that background or those building blocks. And then I think yesterday she said, and the other actors renegotiated. And again, we don't know their salary history. We don't know their contracts. We don't know anything except
You don't even know if she
she's
knows
asking you
who
just
those
to
actors
believe
are.
her as what I refer to as a professional expert.
Are you aware that Ms. Arnold's opined that but for the alleged defamatory statements by Mr. Waldman, Ms. Heard would have earned $45 million in the last 18 months and then the next 3 to 5 years?
Yes, I am.
I'd like to address
And
some
that's bullshit.
components of that one by one with you, Mr. Marks. Are you familiar with her testimony that Ms. Heard would continue to make films for approximately $4 million each following Aquaman 2?
Yes.
Do you agree with that testimony?
No.
Why not?
Well, again, in Aquaman 2, Amber Heard has already had this huge increase. She worked on Aquaman 2 for $2 million. What Ms. Arnold is saying is, oh, she should have worked on it for $4 million, which I disagree with. And I think there is reasons to negotiate. They weren't here in this case. So the $4 million I have a disagreement with. But even if it was at $4 million, or if it was at $2 million, the 4 or 5 movies that Ms. Heard might get might be independent movies. They might be standalone studio movies. They might be passion projects. Every actor has a quiver full of quotes, and their highest quote is for the superhero fantasy journey. Their lowest quote might be for the independent passion project, where they'll defer their salary and almost take nothing to work, just SAG minimum. To assume that she'd get 4 or 5 more movies at her last fantasy quote would be to assume that those are also those type of movies, playing another character. And Ms. Arnold says that Ms. Heard's breakout moment, her Star is Born moment, is Christmas 2018. If that's true, and I don't think it's true, those moments don't normally happen to supporting cast. But if it's true, as a deal maker, you would expect, if you represented producers, production companies, to flock in to take advantage of this hot star and to sign them up. And we have, from Christmas 2018 to spring 20, where there is none of this activity. The Star is Born phenomena didn't happen. Ms. Heard starred in one series of 8 episodes, and she earned a healthy fee, $200,000 an episode. But that's 5 times less than the $1 million Ms. Arnold is tossing out, supposedly based on Jason Momoa's quote. She doesn't prove it or give us facts. And Jason Momoa is not a comparable actor. He's been in a series where they shot 78 episodes, 44 episodes, 21 episodes. He played Conan the Barbarian. He was in Game of Thrones.
Unresponsive to.
All right, I'll sustain the objection. Next question.
And Your Honor, this is
We'll get
damaging
to
to our
those
case.
issues in a moment, but I wanted to.
He's kicking our ass, Your Honor.
You
Save
testified a
us.
few minutes ago that your understanding is that the last option in a multi-picture deal might be renegotiated under some circumstances. Do you have an understanding of whether Aquaman 2 was the last option in Ms. Heard's contract with Warner Brothers?
Oh, no. Aquaman 2 has not even been released, and Warner Brothers has a 4th option for Aquaman 3 or another movies where Mira appears, that character, and they've agreed to double the salary again. So it's in success, and that assumes that they recast and that they make the movie.
Are you aware of Ms. Arnold's testimony that Ms. Heard would have made several $1 million on endorsement deals, such as the one she had with L'Oreal?
I'm aware of that testimony.
Do you agree with that opinion?
No.
Why not?
Again,
Her
this is a
brand
business
was
of
not
personalities.
Ooh.
We didn't, after the breakout moment that Ms. Arnold talked about, Christmas 2018, we didn't see endorsement deals flocking to Ms. Heard during that 16-month period before Adam Waldman made a few statements in the London Daily Mail, I believe it was. We didn't see those endorsements coming to her. We didn't, what Ms.
She
Arnold.
was already roadkill.
These non-comparable actors, they had endorsement deals. But she doesn't show you when she describes the breakout moment and why she's comparing Amber Heard to these, what I call uncomparable actors, that she's making the comparison. She's saying, well, they had all these deals. Why wouldn't she? But for the statements that happened 16 months later, and I guess my primary question is what happened in the 16 months, even if you believe 3 statements in the Daily Mail are the stake through the heart of this Stars Born moment.
Oh my gosh.
Do you have an opinion about Ms. Arnold's testimony that Ms. Heard would have made $1 million an episode in a couple of streaming series following her A Star is Born moment?
Yes, I heard it.
Yeah,
I have an opinion.
I got an opinion
What's
on
your
that.
opinion?
Well, after Aquaman 1, this is a major coup. Amber Heard got that role. She tested for it. She could have been the other 19 actresses or 10 or whoever else tested, didn't get it. She got the role and she got her salary doubled for Aquaman 1 to $1 million. Now, Ms. Arnold wants you to believe that that $1 million would translate into, she'd get that for each episode of a series. We know what she got for a series. She got a series in that period after Christmas 2018, before spring of 2020. She got a series. It was 8 episodes and it was $200,000 an episode. And Miss Arnold is from somewhere in a glib way saying she got a couple series and $1 million each. And I can tell you, as someone in the trenches, rarely does an actor get $1 million for a series episode.
It's like the cast of Friends.
And again, in
At
those
the end.
16 months, there were no offers for series at $1 million an episode. In fact, her only series is the 200,000. And if you look at her resume, the series that Ms. Heard were in, I think the longest one ran 8 episodes. Jason Momoa, if you were to believe Ms. Arnold, somehow Jason Momoa's agent broke their confidentiality in the agreement, and he had a series at $1 million an episode.
So you can't even believe what she's saying.
That, Jason Momoa has had a series with 78 episodes, with 44 episodes, with 21 episodes, with 18 episodes, with 21 episodes. He was in, again, there's not a comparableness there.
We spoke a few minutes ago about the test option agreement. What's the significance of the option part of that agreement?
We got an option, a dumper.
The option part of the agreement gives the employer, the studio, the option. They don't have to do anything. They have an option to either employ you at a very healthy salary to play this role or not. They can recast the superhero role. You just have to think of how many actors have played Batman or Superman. They can do what they want. And indeed, since there's no contract, they only have a choice to exercise their option or not. They might say, we're not exercising unless you reduce your compensation. Who knows what the negotiation would be? But it's not a contract until the studio exercises the option, and they don't have to.
Oh gosh, that's brutal.
What's the alternative to an option agreement?
Well, the alternative is most agreements in Hollywood, you're hired to play the role. Or once you exercise the option, then it becomes, for that picture, an agreement like others in Hollywood. You are now hired to play that role. So most contracts are guaranteed. You're hired to play the role. In an option agreement, once they exercise the option for that movie, it becomes a guaranteed contract.
Are you aware that Ms. Arnold testified that Ms. Heard was released from her Aquaman 2 contract and then subsequently rehired?
I heard that testimony.
Is that consistent with your experience of the film industry in connection with these
No.
multi-option contracts?
No.
Why not?
Again, studios don't do things they don't have to do. As we heard Mr. Hamada, the president of the studio, say, you either exercise your option or you don't. They exercise their option. He denied releasing and then rehiring. And in my experience, in almost 5 decades in the business, doing this type of work, not talking about it, not consulting, you know, I heard Ms. Arnold say she'd been an expert 100 times. I'm a transactional lawyer. I do this occasionally. Basically, you know, it's not a contract till they option it, and they pick up their option, and at that point, it's guaranteed contract, and then different rules apply to it.
In your experience in the industry, do studios typically comment on those types of actions that they're taking with respect to options?
No, just like Mr. Hamada said, they don't need to comment on it. They either exercise the option or they don't. In Hollywood, silence is the default. You play no card before it's time. And the cards there were exercise the option or not. And I was surprised by Mr. Hamada under oath, basically saying that there was this discussion of chemistry. That
Objection, Your Honor, hearsay.
I mean,
I think it was.
he's
Okay.
it was the in-court statement
Whatever.
hearing, I believe, Your Honor.
in court statement, and he's an
That's fine.
expert.
It's saying hearsay that you were
Ridiculous.
hearsay.
Ridiculous.
That hurt expert's going to wake up in the morning with a penis sharpied on her forehead.
Objection. Go ahead.
Hearsay is an out of court statement. Any statement made in court cannot be hearsay.
Overruled. You can continue, Mr. Rose.
Oh, I was surprised to hear Mr. Hamada say that they talked about chemistry. That would normally be behind closed doors because it can't help your relationship with the actor.
Ooh.
You're either going to exercise or not. And that was quite a bit of candor from someone at his level. And so therefore,
She's not getting Aquaman 3.
His value. I think he felt that he was under oath and he was telling the truth, but it wouldn't
Objection,
be.
Your Honor, is
I'll sustain the objection.
The big
Mr. Marks, are
smug
there
grin.
circumstances where a studio would be more likely to say something about not using an actor again in a franchise?
Yes,
What are those circumstances?
once they've exercised the option, once the contract is guaranteed, the studio still has the right to pay the actor, but not play them, pay or play them. And that is a rare condition because you've hired the actor, you've got to pay them, but you say, go home, we're recasting. In that situation, after you've exercised the option and the contract is guaranteed, if you pay off the actor, that's normally commented on. That becomes a bit of information because it's not normal.
Is that circumstance different from Ms. Heard's contract with Warner Brothers for the Aquaman movies?
Oh, yeah. Ms. Heard's contract, again, it was just an option. Either we exercise it or we don't. And if we exercise it, she's in the film. If we don't, she's not. Until we exercise it, we have our right to recast or not make the movie. And even after we exercise it, we'd still have a right to recast and not make the movie. We just have to pay her salary.
Do you understand that Ms. Arnold compares Ms. Heard's career trajectory with that of other actors, including
Laugh out loud.
Moa, Gal Gadot, Zendaya?
Oh my God.
Armis.
This guy should just guffaw here on the
I
witness
heard
stand.
that.
And what's your opinion
You heard
of
it.
actors as comparables for Ms. Heard?
Even Ms. Heard's agent, Jessica Kay, said that 4 of those actors weren't
Objection, Your Honor,
comparable.
hearsay.
And I believe same response, Your Honor, that it was in testimony that was played in court earlier this week.
I mean, that's not what she testified to. I mean, he's characterizing testimony that was from days ago, and I don't even think she testified to that, Your Honor.
You don't
Days
think
ago doesn't matter.
Days ago,
bro.
So what?
Overruled. You may continue, Mr. Rose.
Again,
Yeah, go eat it.
they are not comparable.
You
Jason
better be able to
Momoa
say
was
he
Aquaman.
didn't testify to that.
Chris Pine was Captain Kirk.
Boom.
Gal Gadot was Wonder Woman.
Yeah.
He knows the
Zendaya
actors.
working on Disney Channel since she was 13. She's in all the Spider-Man movies. She goes by one name. Anna
I would have liked to have seen more of these hits in Cross by Dennison. Of course, they would have had to be in question form, but
her breakout, it was as a nude poster. She's been an ensemble piece, Knives Out. These are not comparables.
Ooh.
Now, Miss Arnold stuck to Jason Momoa, who's the most non-comparable because of his history and his career. But she didn't give us the advantage of telling us what his contracts were, what he renegotiated to, what he earned. She didn't give us any of those building blocks. She just she set him up as a comparable and then said what Ms. Heard should earn, but she never gave us the salary of Jason Momoa or the other comparables. And she built like this house of cards on nothing.
Good.
Showed us with her words the beautiful clothing that the emperor was wearing. But we could see, if you know the business,
Objection, Your Honor.
that he wasn't.
Beyond the scope of the question.
All right, I'll sustain the objection. Next question. Okay. You were just speaking about Mr. Momoa as a comparable. Are you aware
This guy
that
is worth
Ms.
every
Arnold
dollar.
compares?
He reminds me of this partner I'll tell you about later.
Mr. Momoa as an actor with equivalent franchise experience who was able to renegotiate his salary for significant increases in bonus.
Yes.
What's your response to that opinion?
Again, he didn't have comparable franchise experience to Miss Heard. He was Conan the Barbarian. He played Aquaman in a movie that Amber Heard was not in. He played Aquaman, not a supporting character like Mira. It's just not comparable. And you can say the words, but I saw nothing from Miss Arnold to back it up, something to build on, which if she was a negotiator in the trench, the studio negotiator would say, okay, so show us, where's the comps? Let's talk numbers, because ultimately that's where we have to get to, not just because you say it so. We just don't believe you. You've got to show us.
Oh my gosh.
In your experience in the industry, what factors influence the negotiation of the terms of a film agreement with an actor?
Well, I mean, first, it depends on the film. If the film is $1 million movie and everybody's deferring their salaries, that's one thing. If it's a superhero movie, that's another. But for deal makers and negotiators, the best predictor of what the deal should be is past earnings, precedent, comps. You also look at the budget of the movie, what it can bear, because if Jason Momoa's comp is $10 million, but the budget's $10 million, obviously he has another price for that movie. But the best predictor of future earnings is past earnings. And I didn't see any Miss Arnold talk about past earnings at all, except the earnings in this rarefied superhero 4-picture deal, where instead of incremental increases, which you normally see, it was multiples increases. And then when you get on a series, the big renegotiation was when the network has no more options. Until then, the actors on the series get 5, 10, 15. small percentage raises. They don't get multiples. They get the multiples if it's a success and the studio wants to continue making the series and they want to keep these characters. That's when the renegotiation happens. Here, even if we believe Ms. Arnold, after Aquaman 2, there was still an option waiting at a big price, double the previous payday.
What's the significance of the timing of the Waldman statements to the opportunities Ms. Arnold claims Ms. Heard lost?
Well, the argument, as I understand it, is that Ms. Arnold says that Ms. Heard lost all these opportunities because of those losses were caused by Adam Waldman's statements 16 months later. So I think the timing.
Sure.
Your Honor, we're getting. Can we get some lube here?
He is chewing up their completely crappy witness in Catherine Arnold. This is glorious.
I mean, this is cruel and unusual punishment prohibited by the U.S. Constitution, Your Honor.
So I'll just say.
Go ahead,
Nick.
No, you.
I was going to say he reminds me of a partner. So I used to represent Universal. He reminds me dead on, like in terms of look, demeanor, knowledge, experience of the lead partner that was on all the Universal deals and just knows everything. Has been in the trenches. He's done the 24-hour negotiations, and like this is spot on for somebody.
He shared a hooker with Charlie Chaplin.
Seriously, seriously, they've got those jokes, right?
This guy has no problem going and swinging, and you can tell because he does this every day. Mm-hmm. So he comes out
Mr.
here.
Marks, what's your overall assessment?
I saw her testimony.
Swinging more than fists.
Yep. My overall assessment of her opinions is that they're not worth the paper they're not written on. She knows something
nice,
but not about negotiating deals. She may have gotten someone at the Endeavor office to
almost at the morgue
confidentiality, but she never laid out the building blocks.
Excuse me, Mr. Objection, you have to stop talking, Mr. Marks. Thank you. Beyond the scope.
Yeah, Mr. Marks, can you just limit your testimony to your opinion about
Okay.
Ms. Arnold's opinions, please?
My opinion, as someone who's made deals as a deal maker for almost 50 years, is that she calls herself an expert, but she's not. She doesn't have the background. She doesn't have the day-to-day knowledge. And her testimony that I heard did not back up her bottom line. If you want to get those figures, you have to show why they're deserved. And again, she was constructing a Jenga without the bottom pieces. It does not hold up under scrutiny by someone who makes
this case does not hold water.
No further questions.
All right, cross-examination.
No, that's it. That's all. You destroy them right there and you leave it.
Well, she
God,
did.
That's so good.
Yeah.
So good.
I mean,
Man, this guy better not find himself alone in an elevator with Amber Heard.
Good morning.
Good morning. How are you doing?
So you agree that studios use comps to negotiate deals, correct? With actors?
Sometimes they do.
And
his answers are so much better.
You have an issue with the comps that Ms. Arnold used, correct? As you testified to.
I have an issue with the comps that she says she used that she didn't disclose.
The comps being the actors that you just talked about. She did disclose, she disclosed the actors.
She disclosed the actors and budget figures from their movies. She never disclosed their salaries and salary history as comps.
You're not offering a different set of comparators that should be used, correct?
I'm saying if you are going to...
That's not my question. Are you offering a different set
He's
of
answering
than what Ms.
You asked him what he was saying.
I'm not here offering comparators. I'm saying what she offered are not comparators.
That was my question. You're not offering comparators, correct?
No, I would say that Ms.
That was my
comparisons are where you look.
That was my question. Motion to strike after.
All right, we'll strike after that. Just answer the questions, Mr. Marks. Thank you.
Yeah, you're a deal maker.
His grin
correct?
every time.
He's so
kills me.
awkward. You look at him
What
scratching.
actors have you negotiated for in superhero movies?
Well, he's worried about that rectal bleeding.
Well, recently I've negotiated for Chris Pratt in a superhero series for Amazon. I've negotiated a deal for Michael Douglas, not in a superhero movie, but a historical movie. I've negotiated recently a deal for Paul Rudd.
This is a bad question.
And Will Ferrell on an Apple series. Billy Crudup on
I did a deal with Jesus on a resurrection.
Recent talent deals.
What actors have you negotiated for in a superhero movie?
I said Chris Pratt.
As I sit here now, I can't remember a superhero movie that I've negotiated. I've certainly negotiated over my career franchise movies and fantasy movies.
Your Honor, so it's no, you haven't negotiated with for any actors for superhero movies, correct?
So you would define
define it.
I don't know.
Make him define it.
Isn't a superhero movie. It's more of a fantasy.
Okay, so no, correct. Your answer
Okay,
is no.
all right. So as I sit here, I can't think of a Marvel type superhero movie that I've negotiated. Although I know there's one or two in there.
Now, you testified and you agree that Mr. Momoa negotiated his multi-picture contract for Aquaman 2, correct?
I heard Mr. Hamada say there was a renegotiation, but no facts were pro-offered, such as he didn't have an option. His options were out. What he was earning and what he renegotiated to, and he is Aquaman man. So yes, I did hear there was a renegotiation.
And you understand that his salary went from $3 to $4 million to $15 million.
If
I don't
you
think that was
tell
in
me that,
evidence.
I haven't seen his contract, and I haven't heard any testimony under oath that that's where the leap was.
Now, Ms. Heard's contract.
Did he get more? Did they get more options for when they made that leap? Did they get more options?
Ms. Heard's contract was a talent contract, correct?
Yes.
And you agree that for if there's an Aquaman 3, Ms. Heard would have an option to receive $4 million, correct?
The studio would have an option.
Well, actually, you would language it. Warner Brothers would have the option to engage her.
He got it. That's a difference.
$4 million, correct?
Yeah. She doesn't have the option to refuse.
Yes.
They have the option to engage her.
And she would receive $4 million, correct?
Yes, $4 million.
Would you agree that the money Amber was
If they
making on Aquaman
choose.
2
If,
or
yes,
3
if.
would be her market rate for future studio movies?
I would think it would be her rate for future studio superhero movies, but not necessarily studio movies that aren't superheroes. That could be standalone. That could be other type of studio movies.
But for studio superhero movies, it would be $4 million, correct?
If I was Ms. Heard's agent, that's where I would start. Assuming everything was equal, the budget of the superhero movie, that she was in the ensemble. There's a lot of ifs to look at, but all things being equal.
You agree that Aquaman was a breakthrough role for Ms. Heard, wasn't it?
It's the first movie of that ilk that she makes, but she is not Aquaman. She is Mira.
But it was a breakthrough movie for Ms. Heard, correct?
For her, it's a breakthrough movie to be in that film and in the ensemble. Absolutely.
And she was the female star of that movie, correct?
I believe so.
You would agree that for all of the
Keep saying
actors Ms. Arnold listed
ensemble,
as
you know she hates
comparables,
it.
their career trajectory went up after their breakthrough, correct?
She didn't give us the raw materials to look at, but I'll take your word that all those unrelated actors in unrelated films, except for Jason Momoa, they went up. as did Miss Arnold's when she went from 1 to 2.
In your experience, can you identify an actor or an actress who's not been able to get a new studio movie after a breakthrough performance in a superhero movie?
As I sit here now, I haven't been asked to opine on that, but there are lots of supporting characters.
Very conditional question.
That
Colby Smulders
don't appear in the next movie.
But a female star in a breakthrough movie in a superhero movie, can you identify any actress who's not gotten another studio movie after that?
Well, after Miss Heard's breakthrough in 2018, she
Miss
did
Heard.
get Aquaman 2.
Aquaman 2 was already, she already had the option for Aquaman 2.
All right.
Correct?
So she did. Miss Heard did not get any movies after 2018, long before the Adam Waldman statement.
Yeah, the example is your client.
By any actor or actress who's not gotten another studio movie after their breakthrough in a superhero movie.
Yes, Amber Heard.
As I sit here now, I haven't been asked to research that, and I can't. That would be a normal thing.
And you're not providing an alternative number for Miss Heard's damages, correct? For the jury.
Correct. I'm not providing an alternate number. I think, she's been more than adequately paid.
More than
her number. That's all. I mean, my question was, you're not providing another number.
I think
Asked and answered.
And the full answer of the question, Your Honor.
It was a yes or no question. He said his answer was no.
I'm not going to strike it.
Okay.
Oh God. Your Honor, it was non-responsive to my question. It's the way you do that. Oh, they're done on that?
That's all you got, buddy?
Oh, come on, man.
Mr. Marks, in response to some questions from Mr. Lederhaft, you were discussing some franchise and fantasy movie agreements that you've negotiated with actors. Could you just describe some of those for us?
Yeah, let him opine on any of them.
I've had such a long career that I mainly forget what I've done, but I negotiated all the contracts for Pinocchio, if you will, that was produced.
Pinocchio.
The original.
Is Coming to America, the original, is that a fantasy movie? The Golden Child, is that a fantasy movie?
Maltese Falcon.
By the way, I may have
examples after
negotiated
1986.
contracts,
North by Northwest.
The film wasn't made, but as I sit here now, those are the only ones that come to pass. If I was
The
looking
Great Train Robbery.
my resume or going through my files, I might think of others, but there isn't a deal that I haven't made.
And I think you also testified in response to Mr. Nadelhaft's questions that you have negotiated some deals for Chris Pratt and Paul Rudd. Do you recall that testimony?
Yes, these are for a streaming series.
Do you happen to know if both of those actors have played Marvel superheroes?
I believe they have, but don't quote me because that's not my genre.
No further questions, Your Honor.
All right. Thank you, Mr. Marks. You can, you're free to stay in the courtroom or you can leave, okay?
Thank you very much.
Thank you. All right. Your next witness.
Unflappable. They were not going to get it.
Plaintiff calls Michael Spindler.
Michael Spindler.
Michael Spindler.
You testified previously, correct, Mr. Spindler? All right. Just a reminder that you're still under oath. Okay, sir? Yes. All right. Thank you.
Isn't a deal I haven't done. Oh, this is the forensic accountant guy. Hopefully he's got something better than a bar napkin.
Good morning, Mr. Spindler.
Good morning.
Can you remind the jury who you are and what you do?
Yes, I'm Michael Spindler. I'm a forensic accountant. I'm a CPA, a certified fraud examiner, amongst some other certifications. I'm with B. Riley Advisory Services, a national firm that does forensic accounting, bankruptcy and restructuring work, and business valuations and appraisals. I've got over 40 years of experience.
Are you familiar with the testimony rendered by Ms. Arnold in this matter?
Yes, I am.
Do you understand that Ms. Arnold testified that Ms. Heard has suffered economic damages resulting from 3 statements made by Mr. Wall?
Yes, I do.
Do you have an opinion of that claim?
I do.
Oh.
All right.
Oh, they're already concerned.
Jeez.
Oh my God.
Your Honor, can we get a rape kit brought in?
I mean, when your theory of damages is so speculative that it's based on an if, you need to expect that you're going to get literally spit roasted on rebuttal.
Yeah. Just absolutely. Everything about her damages claim was based on a series of circumstances that has yet to manifest. And I think it was really bad. I wish they would have asked a few more questions about those option contracts and just like re-emphasize to the jury. So wait, if the studio doesn't execute the option, then they're not in the movie and the studio has no obligation to do so. And Amber Heard can't take an option contract and enforce it against the studio in any way, right?
Exactly.
Right.
And what instances have you seen in your long fucking history of studios not exercising options? What is the probability that a studio may never exercise that option, may choose to never exercise that option? Oh, is it pretty high? Oh, okay. And that's regardless of the fact that, you know, there's any drama going on. Okay, great. No further questions.
In 9 months, I think Amber Heard is going to be bearing Marx's child.
I would say Rottenborn would be burying the child.
Now, you indicated that you would listen to Ms. Arnold, and she testified on behalf of Ms. Heard relative to economic damages. Have you formed an opinion as to the testimony and opinion rendered by Ms. Arnold?
Yes, I have. It is not adequately supported and it is unreasonable.
Oh.
There were multiple elements to that analysis, both damages related to her film career and to endorsements. Have you analyzed both those issues?
Yes, I have.
What is your opinion of the claims that have been asserted relative to the film career and endorsements?
Okay, well, first of all, with respect to her damages calculation, there was no
You should use scare quotes.
She initially looked at these comparable actors and seemed to use that as a basis for numbers. She didn't provide the underlying calculation. She didn't provide underlying support. And then it appeared as though in her testimony, she backed away a little bit from that, but she still suffers from the issues of not providing detailed calculations or support for where those numbers come from. And she still, to some extent, appears to be using some kind of comparable analysis.
All right.
We all know where she's
What is
pulling them from.
the type of analysis that you think is appropriate here?
Well, I think, and as you heard from the last witness, I think that something that is anchored in facts, taking a look at historical compensation as a basis for anticipating future compensation.
Had you looked at Ms. Heard's prior compensation?
Yes, I have. I've looked at tax returns that were provided for the period of 2013 through 2019.
Why do you want to use historical earnings?
Well, once again, you want an analysis is anchored in fact. I don't believe that Ms. Arnold has done that in her analysis.
Oh.
So here we've got some actual data. We've got some historical compensation. And as the last witness mentioned, that often provides somewhat of a basis for future anticipated earnings. In addition, I believe that Ms. Arnold herself said that she had hoped to be able to look at a renegotiated salary for Aquaman 2 and then use that as a basis for future compensation, that being the new kind of base, if you will.
All right. Were there any years in particular that you focused on in your analysis as to Ms. Arnold's testimony?
In terms of the historical compensation?
Yes.
Well, for 2013 through 2019 in total, her compensation was around $10 million. for all those years combined. In 2019, the last of those years, her compensation was somewhere between about $2.6 million and $3 million. Now, that's a good year. That's known as a clean year.
What do you mean by a clean year?
Well, for example, 2019, you had Aquaman was released in December of 2018, and that was a successful film. So in 2019, you've got the benefit of that kind of success, and you also don't have any potential impact from the alleged defamatory Waldman statements that occurred in April of 2020. So 2019 is clean of all that.
What did you understand Ms. Arnold's methodology to be?
Her methodology initially appeared to be based on these comparable actors that she had identified, and theoretically, the compensation that they earned, although she doesn't identify what that compensation is or provide any support for it or any calculations.
What is your opinion of that methodology from an accounting perspective?
That methodology was unsound. It's just unsupported. There are no numbers. There's no data that she provided and support for that.
What methodology did you understand Ms. Arnold to adopt at trial?
Okay, well, it looked like somewhat of a mix and match approach. She used different approaches, I believe, for different elements of the damages, although it's still a little bit unclear to me, a little bit vague. But there are 4 basic components that she was looking at, and we can go through those in any order you wish.
All right. With respect to the television series portion of her analysis, what do you understand that methodology to be?
Okay.
Objection, Your Honor. May we approach?
All right.
They're very scared of any of these experts on damages because they've actually looked at numbers. I mean, the lady yesterday, her testimony was, well, I've been around a bit and I've seen some of these deals. And that was honestly it. Not very useful.
So one question for you guys, because
gossip and speculation.
I missed this part. I heard them arguing on the motion, but is the judge holding out her ruling? Is she with kind of?
No.
Okay.
No, the ruling was rather predictably denied.
Yeah.
I wasn't super impressed with the oral argument. They left out some stuff that I would have liked to see gone into, like no evidence of the agency relationship related to the statements, particularly while Mr. Waldman had been Johnny Depp's counsel at the beginning or before the statements were made, and he had consulted with Johnny Depp after the statements were made. We don't know the nature of the relationship when the statements were made. That's not been offered into evidence. They were not able to get that into evidence. They've offered no expert testimony that says that his statements would be automatically imputed to Johnny Depp or they'd be understood in that way. So those are the things I would like to see them do. But I think ultimately this judge is going to take this thing to the jury since they've had a jury seated for 6 weeks.
Yeah, I agree with that. She would have eliminated it
Hard
already.
to do just a never mind at the end. Never mind. Yeah.
And I also, I mentioned this before, but I think that the judge has to be conscious that if she did dismiss the case on a technical argument, it would potentially prejudice the jury. And on anything even remotely close, she was not going to do that, because if she says that Johnny Depp comes in here with clean hands, but Amber Heard doesn't, potentially that could make a jury decision right there. So yeah,
she's not gonna create an appellate issue. It's just like with the time, I heard the argument that I guess Rob had said that there's a courtesy 3 minutes that he's seen given in other times in other cases where, because there's this fundamental right to a cross-examination, they get some sort of courtesy time. Right. So I'm sure if the judge realizes it's a fundamental issue, they're not going to rule on it to create an appellate issue.
Yeah. I'll be curious what to see what if anything the judge will do with the time. If they run out, does she just say, look, you got 5 minutes on cross, 10 minutes on cross? I mean, maybe she does, but it'll be weird to see if those things come into conflict.
Yeah, I mean, and those are giving them some time. I mean, you can give them, like I said, 3 minutes, I think, and make them do it just like this, right? You know, they can do it. They have the ability to do a quick cross. So
Yep. And they're doing fairly quick stuff today. I wonder what this argument is about.
Yeah.
It's animated.
Innocent's getting animated.
Let's see who came out on top.
I have a feeling Rottenborn's a habitual bottom.
Oh, yeah.
Come on. Unmute it.
Unmute it.
It's not me who's muted it, guys. It's the court. Oh, there we go.
From television shows. Did you analyze what historical earning Ms. Heard had during the period that you were concerned with relative to television shows?
Well, yes, during 2019, she entered into a contract in July of 2019 to appear in a television series at $200,000 per episode.
All right. What about endorsement deals? Did you look at what she had made on endorsement deals during that period?
She did have a contract with L'Oreal at $1,625,000.
All right. With respect to her movie roles, what were her historical earnings during that period?
Well, certainly for the most recent years, you had the Warner Brothers deal, which was a 4-picture deal. The first film was $450,000. Then the first Aquaman was $1 million base fee. Then $2 million for Aquaman 2. And presuming that there was an Aquaman 3, that would have been $4 million.
Okay. Why do you look at historical earnings as part of your analysis?
Because you want your analysis to be anchored in facts. You want it to have a sound methodology, and you want to come up with a reasonable result. So if you take a look at, for example, the analysis that Ms. Arnold did, it didn't appear to be.
Let's just look at the analysis that you're doing.
Wait, why can't he comment on her analysis?
What you said, I think, is you wanted them anchored in facts. Why?
Because that provides a sound basis for coming up with something with reasonable certainty. There's AICPA, or American Institute of Certified Public Accountant, guidance with respect to reasonable certainty. And those are the basic elements of it.
Thank you. No further questions.
All right, cross-examination.
So tight.
I guess he was told by the judge not to keep bringing up the crazy lady's projections.
Yeah, but why? He's an expert. He's allowed to.
Hello,
He's allowed to
Mr.
review
Spindler.
them.
Good morning.
I'm going to ask you a few questions that may refer to the statements in Amber's counterclaim against Mr. Depp. When I refer to those statements, I'm going to refer to them as the Depp-Waldman statements. Do you agree that we can both be on the same page what I'm referring to when I say that?
That's fine. You can use your
I
terminology.
think you need to object to this.
Yeah.
Yes.
Can we approach?
Yep.
Okay.
Yep.
Good job.
Whether or
Why
not
don't I
these
just
statements,
call them the Johnny Depp is libel statements? I mean, it's ridiculous.
yeah, the fact that they let them go yesterday was actually embarrassing. These should be objected to. They're the Waldman statements.
Waldman statements, not that.
There's no reason to add Depp. If I just add Depp to them, would you understand that? I'd know what they mean if they were just Waldman. If I, you'd want this guy, he's not a lawyer, but you'd want him to say, actually, I understood that Adam Waldman made those statements, so why don't we just call him the Waldman statements? But yeah, this whole like, whoa, I want to characterize him as, yeah, the Johnny Depp did a libel statement.
the Johnny Depp is guilty statements. Let's do that. Let's do that.
Dennison was smiling there.
So, Mr. Spindler, when I refer to the Depp-Waldman statements, you understand me to be referring to the statements in
Oh
Ms.
my
Hurd's
gosh.
counterclaim against Mr.
How do
Depp,
you lose that?
correct?
I'll understand that, yes.
Now, you're here to provide
Say
a
no.
rebuttal.
You lose it by arguing that, well, we've been referring to them in front of the jury by that name, Your Honor. It would confuse the jurors to change it. now.
Correct.
You're not providing an opinion on whether Ms. Hurd suffered defamation by Mr. Depp, correct?
That is true.
You're not offering an opinion as to what any of the underlying facts relating to whether Mr. Depp abused Amber, correct?
That's correct.
You're not offering an opinion as to the magnitude of damages that you believe Ms. Hurd may be entitled to if she proves defamation by Mr. Depp. You're just reviewing what Ms. Arnold has said, correct?
That's correct.
And you said that you want your analysis to be accurate in the facts, right?
Anchored in facts.
Anchored in facts. You'd agree that what an actor earns in one period isn't necessarily reflective of what he or she may earn in future periods, correct?
Correct.
And that's because
there can
an
be some
increase in the
variability.
number of roles,
Yes.
an increase in the number of roles may lead to greater income, correct?
I'm sorry. Could you repeat that? I was speaking. I didn't hear.
One of the reasons that what you earn in one period may not be reflective of what an actress may earn.
Could go
in
up or
periods,
down.
because an increase in the number of roles may lead to greater income, correct?
The number of roles or the particular project itself. Yes.
Sure, getting better roles may lead to greater income, correct?
Correct.
And the same is true for an endorsement. As an actress's profile grows, the amount of money that she may be able to earn from endorsements grows as well, correct?
It can.
So
It depends.
what Ms. Hurd earned
If
from
that actress falsely defames her husband.
19 that you testified to isn't necessarily reflective of what she might earn over the next 5 years, correct?
Not necessarily. It is a good indicator, though.
And you'd agree that from 2013 to 2019, in terms of earnings and star power, that Ms. Hurd's career trajectory was on the upswing, correct?
There was a slight increase during that period of time in her earnings from 2013 through 2019.
And you'd agree that that was as a result of getting more lucrative roles, right?
Yes.
Now, you're not a causation expert.
Oh, look, she's got bruises on her eyes.
That's correct.
You're not testifying as to whether the Depp-Waldman statements caused her to lose any roles, correct?
That's correct.
And you're not offering any opinion as to whether the Depp-Waldman statements kept her from being considered for roles that she otherwise would have been considered for, correct?
That's correct. I'm not testifying on causation issues.
And you can't speak to what opportunities may never have materialized for Amber as a result of the Depp-Waldman.
Imaginary opportunities.
Correct?
Yeah, I've not done those calculations.
And you don't have an opinion about whether or not Ms. Hurd could have renegotiated a contract for Aquaman 2, correct?
That was not part of my work.
And you don't have an opinion on the impact that additional exposure or press coverage or magazine
This is a good
covers or
cross by
interviews would
Rottenborn.
have had on Ms. Hurd's career, correct?
Correct. I'm just looking at Ms. Arnold's calculations.
You've never served as an expert witness before to calculate damages based on lost roles by an actress resulting from defamation against that person, correct?
I've been involved in defamation cases, but I've not done the calculations as an expert witness and testified there too.
You got to give
And there's
Rottenborn
never
credit.
been an
I think he's the most
instance
competent guy on
in
that
which
bench.
you have served as an expert witness.
That's true.
In a case to calculate damages based on alleged defamation against an actress, correct?
Correct.
And you're not offering any expert opinion on what impact the alleged defamation by Mr. Depp has had on Ms. Hurd's career, correct?
I'm sorry, one more time?
You're not offering any expert opinion on what impact the Depp-Waldman statements by Mr. Depp has had on Ms. Hurd's career, correct?
The Depp-Waldman
I have
statements
been
by
taking a
Mr.
look at
Depp.
Ms. Arnold's calculations.
And you're not offering any expert opinion about what impact, if any, social media coverage of this case or of Ms. Hurd may have had on Ms. Hurd's career, correct?
You're correct. That's other experts.
Can we approach
No
her?
further questions. Thank you.
All right.
Turn the mic back on.
Okay.
All right, thank you, Mr. Spindler. You can have a seat in the courtroom, or
Thank you,
you're free to
everyone.
go. Thank you.
No, they had
All right,
some
your next
quick
witness.
question on cross, it looks like, but it was muted by the court.
Plaintiff calls Doug Bania, Your Honor.
Okay. Can you spell the last name for me?
Gloomy Fox says it's literally bottom of the barrel tactics. What are you smoking? He just cross-examined a witness, got him to admit to no facts. He won on the argument clearly on the Depp-Waldman statements, and they shut down his entire line of testimony. I mean, what do you want out of that? He got him to say, you're not testifying about any of the stuff pertinent to Amber Heard's case. Like,
but that's
without
a
letting
nothing
him
burger.
yeah, I mean, but what do you do with this guy other than that? I mean, if you let him testify, he's going to rip you apart. And he effectively shut down the testimony. Yeah, again, you don't have to like Amber Heard's team to recognize that Rottenborn did an effective cross-examination right there of a dangerous witness.
Okay, sir? Thank you.
Good afternoon, Mr. Bania.
Good afternoon.
Can you briefly reintroduce yourself to the jury, please?
Yes, hi, Doug Bania. I am from Nevium Intellectual Property Consultants based in San Diego. I value intellectual property. I provide litigation support in infringement and defamation cases, as I'm doing today. And I use internet and social media analytics in both of those services.
Since you last testified in this case, the jury has heard testimony from Ronald Schnell and Catherine Arnold. Are you familiar with their testimony?
Yes,
Were you asked to analyze their testimony and provide opinions in response?
yes, I was.
Have you formed opinions in response to the testimony of Mr. Schnell and Ms. Arnold?
I have.
Generally, what are those opinions?
Generally, Mr. Schnell provided no evidence of a correlation between the Waldman statements and the hashtags and the spikes of those hashtags on Twitter. Second, based on my internet and social media analytics investigation, I've concluded that the alleged comparable actors that Ms. Arnold came up with are not comparable with Ms. Heard. And then thirdly, Mr. Schnell and Ms. Arnold both failed to provide any evidence of a causation as it relates to the Waldman statements causing any economic harm to Ms. Heard.
Let's dig into those opinions a little bit. You're familiar with the
It's nice that this guy defaults to the Waldman statements.
2.7 million alleged negative tweets related to Ms. Heard between January 2018 and June 2021?
Yes.
And what's your understanding of how Mr. Schnell identified those particular 2.7 million tweets?
Yeah, so essentially Mr. Schnell chose hashtags that he felt were negative towards Ms. Heard. Those hashtags range from justice for Johnny Depp, Amber Heard is an abuser, Amber Turd, and the hashtag we just don't like Amber. So then he used those hashtags and he searched.
Say it as many times as you
using
can.
the Twitter API, searched through various tweets, and then came up with any tweets that were using those hashtags.
Did you conduct an analysis of those tweets?
Yes, I was given that exact the data that Mr. Schnell used on a hard drive. So yes, I dug into that data as well.
And what was the purpose of your analysis?
So what I'm trying to do, and what's at issue of the case today at this point is, were these tweets, did they contain the Waldman statements? That's what where we're at right now, are the Waldman statements. So I wanted to analyze those tweets to determine which ones, and if any, contain the Waldman statements.
And what's your understanding of what the
How many times can you say Waldman statements in one sentence?
So my understanding is there's three Waldman statements that were published.
Always one more.
In the Daily Mail. The Daily Mail is a UK tabloid, and Mr.
Nobody believes.
Arnold was quoted in three of those articles. and those dates were on April 8th, 2020, April 27th, 2020.
Came prepared.
On June 24th, 2020. And my understanding that those quotes, sorry, I think I said the wrong name, but those quotes are the only remaining in this case.
Did you analyze the timing of the tweets that we were talking about as compared to the timing of the Waldman statements?
And that's exactly what I did. So I wanted to look at the Waldman statements, look at the dates that they happened, and then analyze those as compared to the Twitter data that I had.
Have you prepared a demonstrative that reflects that aspect of your analysis?
Yes.
Your Honor, may
How
I approach?
convenient.
Yes. Did you show counsel?
We would show them, Your Honor, but they're dicks. So
This is how you ask non-leading questions, Elaine. You might want to take notes here.
Yeah, her questioning here is very good, very on point. It's really snappy, getting right to the details that she wants, not getting wrapped up in any extraneous stuff. And it's did you do this? Did you do that? Did you analyze this? Did you analyze that? Lay the foundation for what he's about to do. He's about to point out that the statements that are in there, and this is the claim, the statements that were made by Waldman were in the text. That's what the expert claimed, that they were in the text of the tweets, particularly in the text of the hashtags.
Well,
so he can go through and just show that they're not.
And I talked with a data analyst today on my channel, and one important thing that their data analyst did not say was whether or not the comments were negative or positive, which is material.
And can be published to the jury.
Mr. Bania, can you explain to the jury what this demonstrative shows?
Yes. So this shows the total hashtags and tweets that Mr. Schnell was analyzing. This is the summary data that their tweets that are running from January 2018 to June of 2021. And again, these are related to the four hashtags that I discussed. Whenever I get an assignment such as this, when I'm dealing with a defamatory statement that's allegedly gone viral online, where there's economic damages involved and there's a lot of data involved, I like to take the data and I like to do a 30,000-foot view of the data to see what I'm looking at, to see if there's anything interesting, odd, different about the data. And the first thing that I noticed is 35% of the tweets were prior to the Waldman statements. So again, remember, my assignment is to determine if the Waldman statements are part of the tweets.
No, it's more than
that
35.
Mr. Schnell analyzed.
Yeah,
So
those numbers don't seem right.
If these tweets were prior to the Waldman statements, in no way could they have anything to do with the Waldman statement. So that was the first issue that I noticed. Then I noticed what I like to call kind of the alleged defamatory time frame. And as I discussed, that's when the Waldman statements were published. That's the date down here. You know, the first one was in the beginning of April, and the last one, which is the third one, was at the end of June. But what I found interesting is only 2% of all of the tweets happened during this Waldman statement period. So really, these are just observations. And for me, there were red flags that I made note of. And then I just continued with my analysis.
Whether the work could be performed in connection with forming your opinions about the purportedly negative tweets.
Yeah, so now I realize that 35% are irrelevant and 2%, only happened during this important period. I just continued to dig into the 2.79 million tweets that Mr. Schnell provided.
And Tom, can we take that one down? And Mr. Bania, have you prepared another demonstrative that depicts that analysis that you were just describing?
Yes.
Your Honor, may I?
Okay, yes. All right. Okay, we'll just see if he has an objection. No, I'll give you time to look at it, sir.
No demonstrative evidence from the Heard expert on
plaintiffs-
comparables, right?
You can turn your
None.
microphone, sorry.
No
Zero.
numbers.
Objection as a demonstrative.
Okay. All
No
right.
demonstratives
Plaintiffs
from
Exhibit 1294
any of
will
their
be marked
experts, I don't think.
for identification as a demonstrative.
Well, except for the tweets.
Yeah.
Thank you, Your Honor.
Oh, yeah, there was the one
the
tweet
graph.
analysis with the
Right.
graph.
Mr. Bania,
Four, yeah, there were 4 graphs.
This demonstrative shows.
Yes, this is showing the various spikes as it relates to the hashtags that Mr. Schnell testified about. This is actually an exhibit or a demonstrative that he used in his testimony. What this is showing are the largest spikes related to the hashtag Justice for Johnny Depp. I don't know if you remember his testimony or any of his demonstratives. The other 3 hashtags did spike at the same time, but a very small spike. So what I'm showing you here are the 6 top spikes in Mr. Schnell's analysis. And what's important here again is the very first spike and the largest spike again happened before the Waldman statements. So what I'm trying to figure out is what tweets were related to the Waldman statements. So this number 1 spike, which is the biggest spike, was prior to the Waldman statements. So it's irrelevant to the case. And then the second thing I noticed that was interesting.
Well, I mean, it's still relevant
here are the dates
because the subsequent
in
spikes are
gray
based on
right
those.
Here. This is the time in which the Waldman statements happened. And you're going to notice, as we discussed before, only 2% of the tweets happened during that time. But I found it very interesting for such a viral event that has potentially caused such economic harm. There's no spikes in this area. And actually, you're going to see that Mr. Waldman, his statement came out here in the first April 2020 article. Then the second one came out here. And then the third one came out in June. There's actually a downward use of the spike, downward use of the hashtags. So I'm not seeing any correlation as it relates to the Waldman statements and any spikes here as it relates to the hashtags Mr. Schnell chose.
Did you analyze each of the spikes that are depicted here?
Yeah, so what I did is I looked at the 6 different spikes, and you're going to notice that each spike represents a month. So the second spike, is July of 2020, and so on to the 6th spike going to April 2021. And what I did is, I don't know if you remember my last testimony when I went into Google search, and I'm able to go into Google search. I went in and I typed in Amber Heard. And then after you hit search, you can use the tool and you can go back in time. And I chose each 6 of these dates to go back in time to see what was the media talking about back then. What was the general public being fed as it relates to Amber Heard back during those spikes. And what I found is none of them. Well, actually, I analyzed the top 3 search results because they represent 50 to 70% of what people click on. And I realized that none of them had anything to do with Waldman statements.
Are you aware of Mr. Schnell's testimony that the tweets using the 4 hashtags he looked at were mathematically correlated?
Yes.
What does that mean?
Nothing.
So what Mr. Schnell is saying, which is irrelevant to this case, is the 4 hashtags that he randomly chose, they tend to go up and down together. And that's why he had these spikes here. So the correlation there is how those 4 hashtags work or dance together going up and down. But first of all, the hashtags have nothing to do with the Waldman statements. And the fact that there's a correlation with the hashtags is irrelevant to this case because we're dealing with the Waldman statements, which none of that correlation analysis he did had to do with.
How do you know that the correlation doesn't have anything to do with the Waldman statements?
Can I clear this at all? No. Oh, yeah. Well, first of all, I know because that would happen right here. If when Mr. Waldman, one of his quotes was published, you would see a big spike right here. And then you would see maybe a little noise down here. And then the third time you might see second time a big spike, and the third time a big spike. That's not here. So that's telling me there's no correlation between the Waldman statements and this hashtag use. And then I've actually provided evidence that there's no correlation because I analyze each of these spikes and none of them had to do with the Waldman statements.
Is mathematical correlation the same as causation?
I love it.
Why not?
I mean, correlation is simply a relationship between two or more variables or two or more things. In this case, the correlation question is, when the Waldman statements were published, at the same time, did you see a correlation with spikes in these hashtags? And again, can we clear this? You see none of that right here. It's actually a downward trend. There's no spikes, there's no correlation. So, again, Mr. Schnell provided no evidence of any correlation.
What correlation opinion did he provide during his testimony?
Well, he provided the correlation that the four hashtags, spike together. But again, the hashtags have nothing to do with the Waldman statements, and the facts that they're correlating or moving together is irrelevant to the case because the case is about the Waldman statements.
So what is causation then?
So causation is where one thing causes a change in the other. So as it relates to this case, did the Waldman statements cause Ms. Heard to have economic harm? In other words, did the Waldman statements cause Ms. Heard not to make as much money in her career? And again, Mr. Schnell provided no evidence of this. Ms. Arnold provided no evidence of this. And as a matter of fact, during Ms. Arnold's testimony yesterday, she didn't even know what causation was. She was asked, causation and correlation, and she said that she's not a semantics expert. We're not talking about the words.
That's such a bad answer.
When it comes to damages, you have to prove causation prior to calculating damages. So there is no causation that's proven here. Therefore, a damages analysis is not appropriate.
Did you hear Mr. Schnell testify that he
Dang.
agreed with your opinion in this case?
Yes.
And what's your understanding of the opinion that he agreed with?
Well, he agreed that he failed to link the spikes and the hashtags on Twitter to the Waldman statements.
Did he try to do that?
He tried to do that. But
Did
again, his analysis was looking at the word Waldman and looking at the word Waldmanian, and then trying to say that 25% of the tweets included those two terms. But first of all, Waldman isn't the issue here. It's the Waldman statements. And Waldmanian, I don't even know what that is, but it's not relevant to this case.
We can, I think, take that one down, please, Tom. Mr. Bania, what other work have you done in connection with forming your opinions about Mr. Schnell's testimony?
Again, the assignment was to determine if the Waldman statements were part of the tweet. So I continued to dig in, to the data. I believe the next step is, now that I've excluded, the 35% that was before the Waldman statements because they were irrelevant, I wanted to really analyze from
this guy is perfectly cast as a numbers nerd.
See if any of those tweets, were.
He's got the pocket protector.
Did you prepare a demonstrative that reflects that analysis that you did?
I sure did.
You know it.
Do I look like someone who didn't prepare an analysis?
And I was asked, that is the pronunciation of demonstrative we use in court. Like that, it's specific. It's a specific term, but that is the correct pronunciation.
No objection as a demonstrative.
All right, we'll mark it for identification as plaintiffs 1295 as demonstrative.
Marnie Coffee says, no question, just popping in to say I grab a bowl of popcorn and open your live. Anytime I get a break during my day, love the coverage and commentary. I'll be hooked
of the
long after
statements
the
made by
trial's
Waldman
over.
as part of the work that you did?
Yes. Yeah, so here I reviewed the Waldman statements again. And what I wanted to do is I wanted to determine what, if any, tweets included the Waldman statements. So what I went back to the Waldman statements.
Oh my God!
And
Look at those
I came
percentages.
up with key terms and key themes for those Waldman statements, which are listed here. The Waldman statements were about abuse hoax, sexual violence hoax, and fake sexual violence. So what I did is we're now dealing with a 1.2 million tweets because we're starting in April 2020 because that's when the Waldman statements started. And what I did is I searched the 1.2 million tweets, for these three phrases. And I determined that there were 751 tweets that included those key terms.
Out of 1.2 million.
0.06% of the 1.2 million. And then as I was sifting and sorting and analyzing this data, I realized that a
random
lot of these
sample of
tweets have the
1,000?
exact same language. It was interesting to see it was the exact same tweet because I'm analyzing the language to see if it matches one of these three. I realized that a lot of these tweets were retweets, likes, or shares. So therefore I eliminated any of those and it came down with 95 unique tweets. And then what I did from there is I analyzed those to determine if any of these terms were in there. And I identified 5 tweets that were related to the Waldman statements.
Do any of the hashtags Mr. Schnell analyzed include the words from the Waldman statements?
No, they don't. And, because I am rebutting Ms. Arnold, her testimony yesterday, she was saying that the Waldman statements caused these hashtags. Then throughout her testimony, she walked that back and admitted, no, none of these tweets have anything to do with the Waldman statements. They don't include the Waldman statements. These hashtags are only hashtags
brutal.
that Schnell, in his opinion, felt that they were negative towards Ms. Heard.
Based on your expertise, what are your overall opinions about Mr. Schnell's testimony and the Twitter hashtag data?
Mr. Schnell provided no evidence that any of the tweets were related to the Waldman statements. Mr. Schnell, there's no correlation there. He also provided no evidence that there's any causation that, the Waldman statements caused any economic harm towards Ms. Heard.
Your Honor, I'm about to switch to a different topic. I don't know if you want to break now or push.
All right, it's going to be a little while, I assume?
A little bit more, yes.
Okay.
Yeah.
Let's go ahead and break for lunch, ladies and gentlemen, okay? Do not discuss the case and do not do any outside research, okay?
The Heard team's going to get transfusions for lunch.
I mean, this guy's laying pipe on the argument here, on the analysis. He's like, well, I like that Rob Schnell agreed with me. I mean, that's bad that you have the other expert
All right,
agreeing
we'll
with
come
your
back at
expert.
1:40 then, is that right? All right, thank you, Your Honor.
What do you agree with you on? Well, that he failed to do the thing that he was supposed to do. I mean, he agreed with me that he failed on that. Oh, God. That's terrible. And then have 5 tweets out of 1.2 million come back with some sort of thing linked to Waldman shows that that's not the defamatory issue, unless those tweets were from Vin Diesel or something, which purportedly they're not.
Well, Nick, I think we're going to have another lawsuit to cover, and it's going to be the lawsuit that Catherine Arnold brings against Marks and the accountant for ending her career. Like RIP.
Yeah, well, except the problem is she doesn't have any career to speak of outside of being an expert witness. So she's.
Have you seen her website?
No.
Oh, I'm gonna send it to you real quick. Hold on. I'm gonna get this for you.
let's-
This is gold. This is so gold. You're gonna love this. She's also got a dating type page on here, which is great.
Of course she does.
Yeah.
Well, she loves talking about those male superheroes.
Private chat.
She gave a happy little smirk every time one of them was mentioned.
TheEntertainmentExpert.com.
Oh, yes. Oh, yes. Oh, yes.
Here we go. Look at this. So here, Catherine Arnold, the entertainment expert. Here's her cases. Sampling of cases, Koziak, Tropin, and Throckmorton. David Boys Schiller Firm Group versus Impala Partners for the defendant's unfair trade practices, promissory estoppel. Okay. Jenner and Block for Waverly Kafanga and the estate of John Steinbeck versus Thomas Steinbeck, Gail Steinbeck, and the Paladin Group. So they were against Steinbeck's kids. She was for the plaintiff. Let's see. Attorneys for Arco Films. What else do we have? So services.
Go to About real quick, though. Go to About real quick. This is the one that's like the dating profile page, you know?
Oh, there you go.
Yeah.
I've had the pleasure of pursuing a very interesting and diverse career that has straddled the studio and independent film worlds, as well as corporate sponsorship and fundraising programs. Starting out as an executive at the Maltese companies, I worked on television and feature film projects financed by Wall Street ad agencies. In that capacity, I oversaw the production of Pound Puppies, The Legend of Big Paw, an animated feature produced with Kushner Locke, and was the associate producer on Manhunt Live, The Search for the Green River Serial Murderer, a live television special with Patrick Duffy. At the Goober Peters Entertainment Co., I was involved in the development of feature films with the company that produced Rain Man, Batman, Tango, and Cash. Wait. Notice how that's worded.
Yeah, the company that produced.
The company, yes.
Involved with the development of films with the company that produced those, among others.
No, but she comes back strong, Nick. I mean, because she was the associate producer on Pizza Man.
Pizza Man.
Well, you know what's funny too? Didn't they ask her about Batman, and didn't she like not even know who was like starring in Batman and who was anything about Batman? Didn't they?
She knew George Clooney. She knew George Clooney was Batman. She said, "Oh yeah, I know that one."
Yeah, she had that poster.
I know George. Yeah.
So Pizza Man, written and directed by John Lawton of Pretty Woman fame. So is John Lawton like just a one-hit wonder, then wrote the illustrious and inimitable Pizza Man? What's pizza? If I type in Pizza Man movie, I'm getting a bunch of porn hits. I bet
you're gonna get porn. You're gonna get porn. Yes.
Oh, Pizza Man, starring Bill Maher from 1991.
Was that before or after Religulous? I think that's before, actually.
4.4 out of 10 on IMDb. Pizza Man is on a quest to get $15.23 when someone orders one. He uncovers a plot to rule the world and stops at nothing to get his pay. Oh, God. What's the budget on this thing? Not to be confused with the 2015 film from India, Pizza Man. 87 minutes. Critical reception. The Los Angeles Times wrote a review of the film. Lawton has a real winner in Marr, a hairy-chested macho guy with a great sense of humor, and with also the femme fatale of his plot, Annabelle Gurwitch, who has no trouble being glamorous and funny at the same time. Hey, there you go. That's a good review. Movie review is Pizza Man has the right ingredients.
Between Pizza Man and Pound Puppies, that
No
also sounds
pineapple.
like a porn. I'm sorry, like both of those do not sound good.
Let's see.
Pound Puppies definitely sounds like porn.
Yeah.
Oh, here we go. Here we go. This is a Rick and Morty movie. It's too off the wall, too artless in style, and just plain too smart for the mainstream. But it has all the ingredients for accruing a cult following. I just never did, though. Pretty sure. So she did Pizza Man. A big shift in my career occurred with my partnership with Louis Venosta. Wrote and co-produced the Mel Gibson romantic comedy Bird on a Wire, as well as this TriStar release of The Last Dragon. Great movie.
It's all things other people did.
We launched Venosta's directing career with the highly acclaimed feature short film The Coriolis Effect, which won the 1994 Venice Film Festival in its category. Well, where does career go after that? Nevada. Cowboys and Angels. Oh, I thought it was Cowboys and Aliens. That movie was trash.
That was funny.
I hated that movie so much.
It was, but it Nick, it's one of those that's so bad it's funny.
Yeah. Okay. So here's that. What's her services?
Oh, you know what she does.
Economic damage and
Whatever you
loss,
want.
film finance, film. So she's just an expert witness.
Yeah.
That's
Yeah.
all she does.
That's all she does.
I've served on over 6 dozen matters involving loss of wages and economic damage claims ranging from 200,000 to 250 million. Have provided expert testimony, reporting, consultation, financial forecasting, and referrals for clients in both federal and state courts on cases regarding copyright infringement, breach of contract, yada, yada, yada. Media, Chinese cash promises to evaporate from Hollywood. 2018.
Oh no, we got to simp for China again, guys.
That's her last thing was 2018. Okay. Articles. How Hollywood joined the global movement to isolate Russia within hours. Okay. There you go.
Oh my God. She's got, I mean, go down that list. You get to the third or fourth one and it's 2014 already.
Yeah, here we go.
That's about it.
Yeah, you're right.
2014 was quite some time ago, folks.
A case study, Guild Residual Calculations, Studio versus Independent Film Finance Models. Okay, well there you go. That's Catherine Arnold, the entertainment expert.
And look at our articles. It's not even one a year.
Are they even about her, or is she incidentally mentioned?
She's
not the author of the articles, is she?
Yeah,
so
looks
anyway.
like it. Looks like it.
Oh, she is the author?
The one I clicked, anyway.
Okay. I wouldn't recommend clicking on more than one. It could be very dangerous to your health. Okay, let me since we have some lunchtime. Well, I guess impressions on the beginning of the day from the panel here.
I mean, all the witnesses they've called so far have been good. I mean, I think that, everything from Hamada to Marks to everybody else. Oh, what's up to you, I guy?
Hey, boys. How are you?
Hey, good man. How are you?
Pretty good, man. What a fucking day, huh?
Yeah. What's the buzz in the jury room? Are people, I've been really curious if jurors were going to start perking up on Johnny Depp's rebuttal.
So I was actually surprised that they rested this morning rather than resting yesterday, but I guess to not give the plaintiffs time to prepare is my only understanding of the matter. I've never seen the defense resting like at 9 o'clock in the morning on the following day, so that was new to me. But after Johnny Depp's team started putting on their witnesses, I mean, every single witness had something valuable to provide, and the jurors, if I can just summarize, because I'll go into detail later on my stream later tonight, but to summarize, the jurors are very perked up, especially number 8 and number 7, and even number 9 to an extent. Those are the most visibly, noticeably perked up. They're paying attention. They're taking notes. They're leaning forward. I mean, that is usually a very huge indicator. They were not doing the same when when Amber Heard's witnesses were testifying. They were more leaning back and kind of apathetically observing. And today they're very alert. They're paying attention. They are showing interest, and not surprisingly.
Yeah, I was wondering if they were in, oh my gosh, if they were entirely checked out for the trial, or if they were just kind of checked out for Amber Heard. I think it's very telling that they're basically checked out during Amber Heard's witnesses and her case in chief. Now that rebuttal's on, Johnny Depp's people are back in the stand. They seem to be more interested. I think that indicates that maybe they're, I hate to make any prediction, but that tends to indicate, in my opinion, that they're at least listening and maybe empathetic to the claims of Johnny Depp's case more than Amber Heard's case.
Yeah, and we have the privilege, like I said, in a majority of my cases, they usually last no more than a day, on extremely rare occasion, 2 days. And any trial lawyer worth their salt will say that it is very difficult, even if you look at the jury, stare at them, if you have like somebody staring at them the entire time, that may not necessarily be an indicator of where their minds are as to how they're sitting, who they're listening to. But because of the length of this trial, because of our ability I mean, this is my second week, my fourth day total observing this jury. So I'm in a unique position to report a little bit more intimately on it. I can tell you that there is definitely a noticeable difference. And I know I'm biased. Obviously, I'm Team Johnny Depp. Let me just say that right now. I am a biased observer, okay? I have an opinion of who I want to win. But at the same time, I'm trying to remain as unbiased as possible as to what I'm seeing and observing. But here's the problem. Jurors are people too. And just like we are people observing this, they're on the inside, we're on the outside looking in. And it's very possible that we may just be of the same opinion. And so far, it's showing that their levels of interest peak more towards testimony that is bolstering Johnny's case and hurting Amber's case. Although I will say this, there was one moment, this is a very notable moment, when it was the accountant. The accountant said, it is possible to receive roles. I have it written down, something about receiving roles, like Rottenborn tried to like interrupt him, and he just kept going. But his statement was very, very, very good for the defense, right? It was like supporting actresses like can receive follow-up roles or whatever the hell he said going forward. And I looked at Amber Heard's table and she was just like, she was like cheering, like, oh my God, like looking at Elaine, like, woohoo, like we got what we wanted. And I'm like, you do realize that's like 1% of the case, right? I don't know. That statement did help. So I can understand her excitement. She was visibly cheerful, but here's the follow-up, right? This is what you didn't see. If you didn't see that, this is what you definitely didn't see. The jury, when she did that, they just kind of looked at her like, and then they moved on back to the witness. Like they were not impressed. And especially showing that kind of emotion in a courtroom as the defendant. So where's her fucking PR team? That's my question.
They've been absent for, I mean, to be fair to her PR team, David grab-ass Shane may be looking for asses to grab. I mean, that might be what's going on.
He's got his own legal problems.
Yeah.
I'm not privy to that information. I've been stuck in this courtroom basically, so I live and breathe this trial right now.
Yeah, no, I'm just making
as long as you're not on Rhea, DUI guy. If you're on Rhea, be careful. You know, I'm just saying, don't come over to David.
On Rhea, what's on Rhea?
That's an exclusive dating app for celebrities.
Really?
Yes, it's like the League, but
I had no idea.
Exclusive.
Yeah, you could meet Amber Heard. Think about it.
Her PR guy, David Shane, has some hashtag Me Too allegations of his own that he's been dealing with ever since being hired. That's the joke. That's why I call him David the Grab Ass Shane. It's just a joke.
Although here's another.
He hasn't grabbed my ass technically.
Yeah. Here's another fun fact. So I apparently was wrong. I tweeted, I think it was yesterday, where I looked over and it was Farron actually who pointed it out, because I wasn't even thinking in that direction. But Farron, being a reporter, she was sitting right behind me. She's a staple on Joe Logic's channel. Farron said she pointed to the seat where the court TV reporter is supposed to sit, Ms. Painter. And she was like, look, it's 11 o'clock and she's not there. And on Twitter last night, I called her out. I was like, how the hell is she? Can she report on this trial if she's not here? I even made a crack about the sketch artist. There's a sketch artist in the courtroom next to the photographer. I'm like, the sketch artist is doing a better job than her because she's there for 100% of the trial. I made that joke. And this morning, last night in the stream, I was told, and I understand now, that Ms. Painter watches this trial remotely, and she's actually working very, very hard. So I tweeted the retraction that this is before I had a chance to talk to her. This morning, I tweeted a retraction of my statement, last night's statement, and because she did kind of try to talk to me, and today she was very, very standoffish for all the rightful reasons. And I said, look, I apologize. I already tweeted about it. I did not mean any harm. And now we
we kind of started chatting a little bit, and she really is. She's actually pretty cool. So maybe we'll have a chance to coordinate. I'll find out what Court TV is doing on all this.
She seems cool. I imagine she's probably mad at me because I called her out for being a pawn of the defense when she was, because the Court TV exclusive reporting was that they were bringing Johnny Depp, and then they didn't bring Johnny Depp, of course, on the defense's case in chief. And I think that was gamesmanship that they played, and I think they played the PR angle on that to get eyes on their experts specifically. Oh, we're gonna call Johnny Depp right away Monday morning. Then suddenly it's not him, but 3 experts, and probably their 3 best ones. So they got a lot of eyes drawn in and attention, and then didn't have to call him. And I think that maybe Chanley got played a little bit by their team.
And for the first time in my life, you guys, I can tell you, I have intel that I possess right now that I can't even share with the world. And that is a very unique feeling. I've never been in such a position before. It will be revealed later, but I cannot reveal it at this time.
No, well, that's very, very cryptic, you Fed.
Information. It's really not DUI guy, it's the FBI guy.
Yeah.
It's the FBI guy. That's right.
Did anybody
CIA
else
guy.
make it? Did anybody else make it into court with you today? I know James from court did not. Did Farron make it in?
Well, Farron didn't even drive. We only had 1 line holder. Well, we were supposed to have 2. We had Jamie, who's a local, and then we had Carla from New Zealand.
Okay.
All right.
And when we reached out, we were like, hey, so wait, what is going on here? Are you going to be coming? And she's like, yeah, I'm in New Zealand. Basically, like, what do I need to do? And we're like, I don't think this is happening. So we have 1 person, but nobody else was there. I know Rob can't. I can't do it because I already talked to him a few days ago. I know Joe left. I don't think Nate's coming because he indicated at one point. I know that Ian is coming tomorrow, but not for the trial. He'll be there in the trial Thursday and Friday because he's flying in tomorrow morning. And so James was supposed to make it in, but somehow he got bumped from 91 or 93 to like 103 or some bullshit. So he barely missed the cutoff. Scott was sleeping. We didn't have a spot for Scott either. So unfortunately, it's just me again. I'm on the front lines.
There you go. You're in the trenches. But you're Richard Marx. The rest of them are Kathleen Arnold.
Let me just get this shout out real quick. So tomorrow, as according to my last conversation with Rob, which is a few days old now, Rob said he was planning on being there tomorrow. Do you guys have confirmation of this?
I haven't talked to Rob.
Okay. I'll text him later. We'll see if what he's up to and if he is able to make it so we can save a spot for him. And then I know Ian is going to be flying in tomorrow. Like I said, that's all but confirmed because he tweeted about it. And though it's true. If he tweeted about it, of course.
Yeah.
So
if it's
Thursday,
it's the fact if it's tweeted.
Exactly. Thursday, Friday, he should join us. And ideally, if this is gonna work out the way I hope it will, Friday is basically gonna be getting the band back together because the first day was the 3 of us, and now the last day is gonna be the 3 of us back together again, which is gonna be a statement in and of itself.
Yes, with your Triforce powers combined, all of law nerdery will congeal inside the courtroom and create like a pink dome, like in Ghostbusters 2, preventing all the heathen Karens from entering the courthouse. There'll be a
whoa! I wouldn't go that far, Nick. I would not go that far. The heated Karens are there.
Well, hold on though.
Let me tell
DUI
you,
guy.
it is a sight to behold. Sorry, let me just finish on this real quick because
Yeah.
this is another thing you guys don't see. It is a sight to behold when Johnny Depp stands. So after the judge leaves, everybody remains standing like a statue. You can't even get out. Even if you wanted to, you can't get out because everybody's still blocking the exit, nobody moves from their pews. And Johnny, as soon as like Johnny starts walking towards the back door, he turns around, he gives this little wave to everybody, and everybody, of course, reacts. And it sounds like a hen, like a what do you call that? Where you hold chickens. What's that thing called?
A roost.
A coop?
A coop?
Coop.
Like a chicken coop?
A coop. It sounds like a coop of clucking hen. I swear to God. It's like a like every girl in the room is just going gaga over him. And I wish you guys could see it. I've never seen anything like it.
It's got to be a little bit weird. It's got to be a little bit weird. So what was the were there any major points today that really stuck with you? Not like from a jury perspective, but in the case itself. You mentioned the one with the accountant, but anything else like really stand out to you about any particular witness or any testimony, or in the alternative, if there's no particular moment, what witness do you think has been the most engaging and effective so far?
Marks, hands down. Marks. They were absolutely enamored with Marks. They enjoyed listening to the whole spiel of well, hold on. I'm sorry. I have so much information in my head. It's hard to sort it out at this time. I need to time to process it all.
I got you.
Marks was talking about, he's the one who helps coordinate getting gigs. Yeah. And when he started basically annulling, well, I mean, both of them, Marks and the other guy, they were both basically calling Arnold a hack, and the fact that her testimony is not substantiated by any evidence, is not based on any facts or data. I mean, the jury was just eating it up by the spoonful. I mean, you could see they were just like, this was interesting to them. They were, like I said, they were leaning forward. They seemed engaged. Whereas with Arnold yesterday, my notes did say that they were a little bit more aloof. They were a little bit more distant to Arnold, and it comes as no surprise. So I think, whereas yesterday Arnold and Spiegel and Moore, they were all detrimental to Amber Heard's case. Well, today is the complete opposite. Marks and the accountant and the other guy, the tweets guy, they were all very not only just helpful for Johnny. The jury seems to find them interesting. They're engaged. Right. They're paying attention. They're listening. So I think today so far has been a good day, and I'm looking forward to seeing what's going to happen later.
What's been the low point of the day? For me, it was the hand doctor. I thought that was a complete letdown on testimony. It was very forgettable. He didn't testify to how the injury might have occurred or anything like that. It was just like, oh, I put a cast on him and he had a cast. And I was like, oh, okay.
It's funny you say that, Nick, because as soon as you brought it up, I was like, oh, yeah, we had a cast doctor who testified today.
I forgot about him too.
So yeah. If that tells you anything.
Yeah, that's so I'm glad I'm in good company there, because that was like, I was like, man, I was excited for that guy. I'm like, here's the treating physician. He can talk about what his opinion of the injuries were. And it was just like nothing. It was nothing at all. So I thought that was a letdown. Do you have any indication of what's coming next? I mean, they're still on cross of they're still on direct of this the statistics guy. Yeah, how does Captain Nerd play out in court? Like this guy who's on there right now, because this guy like is the he's the leader of the math team and the chess team, and he wrote a computer algorithm to have both those
my
clubs
homeboy,
fight.
he's on the chess team. What the fuck? I need to like hook up with this guy and then play some chess. He'd probably whoop my ass though.
Yeah,
he would. Yeah, he would.
That guy would beat you with math.
He's beaten Deep Blue blindfolded.
He wrote Deep Blue and then beat it. So yeah, how's he coming across? What are you getting out of him?
I can tell you right now, juror number 7 is a nerd, almost all but guaranteed, because he is absolutely in love with the demonstratives.
Okay.
Wait,
anything
hold on.
Out?
Can I ask whether that juror is Asian?
No, he's not.
Oh, okay. Just clear. Just want to
Number 7 is our Irish boy, our redhead Irish boy.
Got it.
Okay.
He seems cool. Like, he's the kind of guy you would grab a beer with. I'm not even joking.
Is there anything you're looking for out of today? Like what for the rest of the day? Is there anything you're excited for that you've heard about, or are you hoping happens today?
Sorry, you're getting cut out, and I heard, what am I expecting the rest of the day?
Are you excited for anything for the rest of the day? Is there any buzz around there about what might happen?
I don't think so. Not particularly today, but maybe tomorrow or Thursday. Time will have to tell.
If Johnny takes a stand. I mean, that's the big thing, because
Right. If
he's
Johnny
the
takes a
last
stand, I mean, that's going to be the biggest hype of all.
he's the last guy on their rebuttal witness list. If they call him back as the last witness and Heard's team's out of time, I think it'll be the mic drop of mic drops on the case.
Well, hold up. So we have new information from Kurt, who has been doing some research on Virginia law. Have you talked to Kurt about this?
No.
So Kurt said that the rules of procedure in Virginia state that even if one of the sides runs out of time, the judge is under obligation. Otherwise, it could potentially be reversible error if the judge does not permit the opposing side, who has 0 minutes and 0 seconds and 0 hours left on the clock, to at least some reasonable amount of time, basically, to utilize for cross-examination. They can't just leave a witness hanging. That even just logically thinking about it, it smells like reversible error. And there's Virginia case law on it, apparently, according to that's uncivil law for all of you guys who don't know Kurt.
Yeah, I haven't talked to Kurt about it, but I believe Rob has addressed that and said that I think a reasonable amount of time is something like 3 to 5 minutes.
Courtesy, 3 to 5 minutes, yeah.
But 3 to 5 minutes. Okay, so does it matter if the witness has been on the stand for 3 hours or 10 minutes? Because 3 minutes is okay on a 10-minute testimony. What if somebody's been up there for half a day? I don't know.
We don't
Is
know.
that still reasonable? Yeah.
Very, very curious. I mean, if you ask me, the time limits are presumptively unreasonable in general. So, could you imagine doing the O.J. Simpson case in 6 weeks with time limits? Like, no, it's one witness for some of these.
Well, no, they could. I mean, the reason they won that trial, I think, is because they drug it out and the jury was so exhausted. They were like, anything to get out of here.
Yeah, I think so. But that's the way they did that. The same thing with Jody Arias. I mean, the case was months long, and so I think sometimes you need significant amount of times. The Jody Arias trial, I was just reading about it, and like several of the people, their testimony was 8-9 days of testimony from one witness.
Yeah.
And it's kind of crazy to think about how much time that is.
The other side deserves the ability to present the exact same amount of information, right? And we've seen some of these cases where it's been clearly unbalanced between defense and prosecution, particularly some of the trials we've seen where the prosecution has just been able to ramrod information through, even in Rittenhouse. We saw, essentially their closing, the substance of their main closing and their rebuttal was almost 2x of the defense. So it's really manifestly unjust if there's not some sort of parity in the amount of time that's given to both sides.
Yeah, I agree. But I just think time limits in general are unreasonable presumptively, and that time limit should be imposed when someone appears to be violating some sort of when their testimony gets cumulative and such. I think there are other controls. So I would be surprised at seeing the time limit strictly enforced, but Rob has said it's pretty strictly enforced. So we'll see maybe how that goes. All right, DUI guy. Anything else you want to hit before heading out? I want to give you 10.
Let me ask one question. I got one thing for you. So DUI guy, I've heard some people ask this, and I don't know if it was yesterday or today, but did anyone get kicked out of the courtroom today?
Yesterday, not today.
Nothing today. Okay, somebody mentioned it in my chat, and I just wanted to get it and sent me a message about somebody getting kicked out. Nobody today. Okay.
No, that was yesterday. There was these two really, really awkward ladies. They look like a mother and daughter who are sitting at the end of my row. They have spent a grand total of what feels like 15 minutes. But the problem is, it's not the 15 minutes. I don't really care about that. It's the fact that they keep walking in and out and in and out and in and out and in and like they're walking past me 500 times. And I'm like, what is your deal? They keep either getting water or snacks. Or are they that hungry? I mean, do they need to eat every 15 minutes? I don't know. But it's very annoying.
Yeah. That would drive me nuts. Sit down.
Well, by the way, though, that Amber is annoyed by the opening and closing of doors. So
Amber's annoyed by what?
The opening and closing of doors. There's an interview, a famous interview, where Amber hears doors closing in the background and she flips the fuck out. She just goes crazy.
She just could not concentrate or maintain it. If I were Johnny Depp's team, all during cross, I would have had my frontline people just getting up like every 5 to 10 minutes and going out, standing up noticeably, walking out, and then have a different person do it, every time, coordinate it with Morse code. I have no idea, but just, just to piss her off. But they didn't really need any help, I think, on Amber Heard's testimony. She destroyed herself pretty effectively. Okay, I guess final question. What was your opinion of the oral argument this morning related to the dismissal?
Oh, before it even started, I looked at the girl next to me and I was like, watch, he's gonna lose the motion before he Chu even opened his mouth, because it's obvious. It's one of these things like where, again, judges are afraid of getting ruled against. They understand that the standard is very, very low, and the evidence has to be like so insurmountable for them to rule on a motion like that. Just like an emotion it's basically like a motion for summary judgment, just like a hiding for one of the claims for the other party. She wants to submit it to the jury. I think even the judge, based on what I've seen, even the judge suspects like who has the better chance of winning here, which is Johnny, of course. But she has to rule properly. She has to rule, and she has to let the jury decide. Which reminds me, by the way, there's this girl that is sitting next to me. I don't know if I'm visible on the stream at all ever.
Yeah, we can see you.
You can see me. So there's this girl sitting next to me, and did you notice what it says on her shirt? Is it visible?
That's not visible.
It says, "I stand with her," or "I'm with her" in capital letters. And I didn't see that shirt at first. And I started looking, and I don't know if it's a Hillary Clinton or is it an Amber Heard reference? I don't know. But
is it a big blue H?
No, it's not.
Okay.
Well, either way, it should be banned.
No, I started like kind of talking to her, and she was very aloof and like very unfriendly and off-putting and kind of like, "Why are you talking to me?" I was just like making comments about the trial, like, "Watch this." Or her dad's an attorney from Minnesota, by the way. She's from your neck of the woods, Nick.
Oh God.
Her dad is a real estate lawyer in Minnesota. And so I chatted her up a little bit, but then like I noticed the more I talked to her, the more she was like trying to like, I don't.
Well, when you start every sentence with "Hey, baby."
Oh no, I should have started every sentence with "Let's go, Johnny Depp's team," and then she would have run out of that courthouse.
Yeah, so you found an Amber supporter. I hear
And
they're
she's
rare
seated next to me, so pay attention to her. But she's just so devoid of emotion. It's really scary. She's devoid of like the human element. Does that remind you of anybody? I can't think. No one comes to mind.
Well, here, let me quote what was it? Richard Marx when here, I'm pulling up the line. Do you agree that Amber Heard would have obtained endorsement deals? No. Why not? This is a business of personalities. Oh my God. That was so mean.
When I heard that, I was like, oh, yeah.
When he kept referring to her as ensemble cast, like that too, I know that just
triggered,
burn her up. No, I was a very important role. I'm Mira. All right, DUI guy, let me get you out of here. Court should be starting back up before too terribly long, and that way you can eat. And if you have,
did you hear what the judge said? What time we're resuming? Because I missed it.
I probably did, but I don't remember.
Okay, well, it doesn't matter. We took a break at like 12:35, so I'd say
you probably got 20 minutes.
1:30, yeah.
Yeah.
All right.
So
thanks for having me, guys.
Good luck, man. Thanks for reporting
Thank
in,
you.
and hope everything goes well. By the way, chat, DUI guy in the description. Make sure you check out his channel. Oh, we're hearing 140 is what people are saying in the chat pretty uniformly. So.
140. Thank you, chat. Chat is never wrong. Did you know that, Nick?
I do know, especially mine.
Yeah.
Yes.
Yeah,
they've never ever messed with Nick before, ever.
If you want more what's it called? Follow-ups on the happenings and ins and goings of what's inside the courtroom, follow me on Twitter, follow me on YouTube and TikTok. Those are my 3.
There you go. And your YouTube channel is linked in the description. People can just click on your name. It'll take you right there. All right, buddy. Catch you soon.
Yep. I'll see you soon, guys.
Take care.
Peace.
Bye bye.
Okay, so there's our in courtroom
That's great.
reporting. He's the only guy there today that
Yeah.
that we know. So that's very cool that he popped on here and was able to give us the inside scoop on what's going on. Yeah, I had messaged James from court, and he said he was not in the courtroom today. So I told him to get some rest. He mentioned the line shenanigans, and I'm sure everybody who's been standing in those lines all week has got to be exhausted. So hopefully he gets a little bit of shut eye during the trial today, so he's pumped up and ready to go for tomorrow. With that, let me hit the super chats that are here. Sheepsidian says, that confusing super chat you got, the one that mentioned bed bugs, it activated the Winter Soldier. I'm now hobbling away from him as he put Ridge wallets in my pockets to use as target practice. Thanks and send help. Tails says, I heard Amber is an acronym for a mega bitch empty of rectitude.
Wow.
Or of rectum. I think that would work too. She's now empty of rectum as well. RZEQDW, ping me on Discord before you read this so I know when to tune in. Well, I failed that. Actual message. Your boy Soban has found a promising cutie. Third date on Thursday. And if things go well, she's coming to Matsuri. Awesome. That'd be great. Go get it, brother. He won't have even seen this, and that makes it funnier. Abyssal Structures, love the coverage. Here's my first ever super chat. Hey, thank you. I play techno DJ sets on Twitch. You've inspired me to make subtle nods to this trial by playing tracks named Don't Trust Her Speeches and Fake Tears. Very good, Abyssal Structures. And remember, you better count your dub lengths before you touch the turntables, because if you run out of big tunes, that means your sound is done. KW, op-ed stated that reporting abuse by a powerful man hurt her career. Predictably, and like other victims she knew, isn't that evidence that the vicarious liability for the decline in her career is demonstrably hers/the industry's? That's an interesting potential admission. Sure. They might include something like that on close. We'll see. I think they're going to stick to the Adam Waldman made the statements. Johnny Depp's not responsible for those statements. And even in the event that you found that there is some relationship between Adam Waldman and Johnny Depp, those statements didn't have any impact on Amber Heard because nobody put forth any effort that they could have. In fact, the negativity to Amber Heard predates those statements by a good amount. And this guy, the data guy who's on there right now, he's killing it right now.
I mean, literally every link in the legal chain is broken.
Yeah.
They only need one to be broken.
And I know someone in the chat he put speed lines on that bar graph. People were like, oh, speed lines. That's not actually speed lines. That's the trajectory of Amber Heard's career visualized. Just straight plummet downwards. Let's see. Medical grade whiskey, shameless shill for physicians for patient protection. Ivory Tower academics like Heard's experts are selling out our profession, lack integrity, and harm medicine. I suggest patients at risk for more information. Great book. Thank you, medical grade whiskey. Look, people who are just experts, I know they pretend to be experts and purport to be experts, but they lose their expertise very quickly. Expertise that's not matched with some level of experience isn't expertise.
It's not credible. You can't view somebody as credible unless they've actually done the thing, right? The whole point is you're supposed to have done the thing. If you're just literally LARPing as it, or you're read about it, or you're, somebody who has maybe done it once or twice, you're not as credible as a guy who literally has done the thing for decades and years. And that's the difference between Catherine Arnold and Richard Marks. It was very clear, especially with the minutia. You can tell when he's talking specific numbers. You can tell by the way he talks, with the confidence of his voice, that he knew exactly what he was talking about. And by the way, yes, he gave kind of longer answers, but he didn't really evade the questions like all of the witnesses on Amber Heard's side, where they were just completely evading the question, or in the case of Dr. Nosferatu, Dr. Spiegel, trying to answer a different question altogether.
Right. And I understand the irony of speaking this way. The one thing that you will never find me claiming is to be an expert at trial practice or anything like that. Before any non-ribbing criticism comes in, all the ribbing criticism you want, but you won't actually find me overinflating or overvaluing my courtroom experience or anything like that. I'm a guy giving opinions based on what I observe, and I have the ability to translate the legal stuff that's going on because I have the education for it. But I prefer to defer to people with lots of trial experience on these trial questions because I don't have that background, and that's fine there. I'm not selling myself as an expert. Now, if you want someone who's an expert at streaming on social media about trials, I may be a preeminent scholar in the field.
I was going to say, you may be a preeminent internet grifter. Like, if you want to do that, Nick Rekieta is top tier grift.
Yeah. I found out yesterday that I'm the all-time #2 super chat earner in the United States. So
you didn't know that?
I didn't know I would hit #2 because I used
okay,
to be #6. So I'm right behind Tim Pool. I'm coming for you, Timmy boy. I'm coming for
Count
you.
your chickens before they're
bloodbath.
cooped.
You better play guitar for those chickens, because when I come there, it's gonna be breasts and thighs for days.
And that chicken city of his, it's insane. It's like a chicken metropolis.
Yeah, it's I've been in it. It's the size of a small house. It's pretty crazy, but yeah. So I could maybe qualify as an expert on something like that, but yeah, these people are. This lady is charging $650 an hour. She's made $60,000 in her representation so far.
From this one case.
What did she produce out of it? And I was marveling at this yesterday on my night stream. This woman has been in this case for 3 years. She testified that she's been working on this for 3 years and has been paid $60,000. And you can presume the bulk of that is recent. As you get ready for the trial prep coming up, she's going to be doing the majority of her work recently. So I would imagine something like $35,000+ has been paid in relation to this year's work. And she doesn't even know her own side's CV. She couldn't tell you Amber Heard's movies. One of her most recent films, she couldn't tell you that she was in it. It's like, how do you not know this? I mean, you've been looking at this for 3 years. I know you're doing other stuff and you're hearing other cases, but any long-term projects, like for me at least, I tend to grab a lot of those details as you hit them over and over and over again.
Roughly 100 hours. 100 hours. I mean, when I do a legal consult, I typically spend something on the order of 10 hours, and I have that case memorized.
Right. Yeah, I mean, you'd put at least 1 or 2 hours of trial prep in, which is all it would take to go over your comps, right? You think, okay, I cited these as my comps. I need to know about them. I need to know some facts about them, not just know, I have no idea who they are. All of them, the only thing I did was pick them based on attractiveness, super subjective, and age, which, by the way, some of them weren't even close. I mean, like I said, Zendaya, like 10 years out, some of the men were almost 10 years older, really not comparable actors and actresses. So really ridiculous presentation.
And age is far less relevant than time spent in meaningful production in Hollywood and television. I mean, Zendaya, yeah, she's 10 years younger than Amber Heard, but her resume is much more impressive starting when she's 13 years old. She starts significantly younger than Amber Heard does, and on more meaningful productions.
But age is another factor here too for an actress. I mean, I mentioned this yesterday. Nobody in court seems to want to talk about it, but let's face it, an actress at 35 is not the same as an actor at 35.
But Andrew, that's exactly what I was going to say, because the point is about Zendaya, it's a double whammy. So it is very relevant. It is very relevant for a female actress, very relevant for a romantic lead. But Zendaya is way ahead because she's already gotten there, and she's got 10 more years, 10 years on Amber Heard, who's already at her zenith, and her star is falling rapidly.
Yeah, and look, I talked about this a little bit yesterday. Hollywood's a lot like court in this way, though. It's not fair that like younger, more attractive women have a better prospect at getting a role, but that's the way it is, because
reality isn't fair, Nick.
Right. You got millions to hundreds of millions of dollars on the line, and you go with what you think is the best option to capitalize on that investment. So with Hollywood women, the trajectory of their career is a high arc and then oftentimes a big fall off when they hit those mid 30s to early to late 30s years.
There's
And
not a lot of Helen Mirrens out there.
Right.
But they exist, but they're
They
outliers.
exist, but there's not many. Right.
And when they exist, a lot of them have taken that high arc and during that high arc capitalized on refining their acting craft to transition into a completely different style of career. I mean, you go with someone like not Sigourney Weaver, the Jamie Lee Curtis, for example,
Yes, Jamie Lee Curtis.
who is in Halloween. You know, she's presented as young and attractive, and then her career progresses through attractiveness, and now she's older and she's an attractive older lady. But Jamie Lee Curtis is being cast because of her acting acumen. She draws people to the screen. She's very good at her performance art, and that's what they need to do. Amber Heard hasn't done that. She hasn't had the roles to do that, and I don't think she has the talent to do it.
It's too late. I mean, frankly, it's too late. She should have started doing that already, and she hasn't done any of the work. And because of that, she's done what most people do, like the Colin Kaepernicks of the world. They work on the different grift, right? They haven't worked on their craft, so they work on the grift. She clearly has picked a gender identity-based violence sort of grift. That's going to be her grift. She's going to work that. She's not going to give it up because that is all she's got, because her acting chops are, chopped.
Now, the analogy to Kaepernick is well put.
Yeah. People are saying True Lies, though. True Lies is like 19 years ago. Yeah. And Jamie Lee Curtis is looking bad in True Lies, bad in the good way. But that was a long time ago.
Almost 30 years, folks. 1994 was True
is
Lies.
that? Oh my gosh. Yeah, that's
wow.
Insane. Okay. Next. Tails says Richard Marx should permanently have the meme sunglasses on and a joint. He's more based than Geddy Lee. Every time Richard Marx speaks, na. Marnie Coffee. So Amber's witness testified she would make $45 million over the last 18 months. No, I think she said, in fairness, over the next 5 years or something like that. Which is the reason she picks 5 years is because it's right in this nice gray zone for presumptive economic damages that courts, like, you project damages 10 years out and they go, yeah, what if you get hit with by a bus though? Like you can't predict economic damages going forward too far, but you can do some speculation on damages so long as you have a history to back it up. Her history of backing it up is very short, and it's related to one deal. And Richard Marx's testimony today was very effective at pointing out how attenuated a Marvel or DC superhero movie role is from the regular roles that people are getting. You know, you show up as Mira in DC. That's not translating to these individual standalone studio pieces. You're not even getting into other franchise films necessarily, because you're now in some ways branded in that particular role. The actors who have been able to transition either between those types of roles and get repeats, Chris Evans comes to mind, starring first as the Human Torch in the god-awful Fantastic Four movie, and then becoming the much better role of Captain America. Much better produced movie, much more fleshed out role, much more important role. Like, he was able to do that. I think Chris Pratt, maybe. No, I don't think
Chris Pratt had Parks and Rec, and he had other things that were going on before he became.
I feel like he was in another superhero fantasy style movie before Guardians of the Galaxy. But there aren't a lot of them. There are not a lot of people who have moved into a subsequent separate contract for one of these big productions.
Had Pratt done the Jurassic Park movies already? Like Guardians of the Galaxy?
Those came later.
Okay.
The Jurassic Park movies were after Captain America.
But the point is that negotiating those contracts, Marx has experience negotiating for Chris Pratt, who already has chops as a superhero. So the fact that that Marx has not specifically negotiated his Marvel contract is really irrelevant, right? Those negotiations are just as tense for any of these movies. It's just numbers on a paper that are different, right? The actual process and the procedure, that those negotiations are all the same. From my world of like commercial real estate, it was the same for $1 million, like for a hotel, versus we were negotiating for Epic Universe, the new Universal Studios theme park. Same process, just different numbers.
Right. But in his testimony today, Ryan Reynolds, yes, I saw people are pointing out Ryan Reynolds is Deadpool and Green Lantern. And there's some gap there because Deadpool is largely in a mask. So you're not looking at Green, in a full body mask. And when he's not, he looks like Freddy Krueger had a bad day with an omelet pan. But so you've got some difference, but you're not seeing a lot of those transitions. But my point is that Richard Marx testified specifically that these are anomaly contracts, these long-term multi-film option franchise superhero movie contracts, and that just because you get a superhero movie contract does not mean that any of your next films are going to be like that at all. And someone pointed out Brie Larson is actually a very good example of someone who has pulled in Captain Marvel, and she shows up in all these Marvel movies as Captain Marvel. And outside of that, she's got no irons in the fire that seem to make any sense, probably because she's unlikable. Okay. Next, B Sport 48. What are the chances this whole thing is settled between the parties before the jury verdict? Almost zero. Why would you settle as Johnny Depp at this point? You've gotten the public opinion, and if you settle, you mitigate the public opinion.
No, right. No way.
So,
well, I shouldn't say no way. I guess there's a theoretical set of circumstances in which it would be smart to settle. But first of all, I don't see Amber Heard buying into those circumstances. So
if Amber Heard is indemnified by Elon Musk to the tune of $500 million, Johnny could settle for $500 million. There you go.
By Long Island.
Right. But really first of all, I'm not sure the judge will let them dismiss the case. I think they can, with both parties' consent, dismiss the case. There is no unilateral withdrawal. So Amber Heard cannot retract her counterclaim. Johnny Depp cannot retract his claim at this point. They're in it. I would assume they could settle at any point. The likelihood of that is so low.
Zero. I think it's zero at this point.
Yeah. Tank Commando, are you going to read the leftover Rittenhouse chats during your 24-hour stream? Redemption is only a day of suffering away. No, that would be horrible television. Lord Weeble, DSP is just David Spiegel in a fat suit. Changed my mind. They sound the same and both fold under being called out for disingenuous behavior. Same lukewarm IQ as well. Dang. Scarvy the Strange. I tried to get in, but was put in the overflow room next to some hipster broad that told a story of how her car broke down in the middle of nowhere. So she thought she was about to get jumped by hot MAGA people. What? I actually believe that very much. Penny Whitbrot, I notice Andrew keeps sneezing. There's an excellent supplement, All Clear with a Q instead of a C, made from quail eggs that suppresses histamine in minutes. No drowsiness, from Nurse Penny. So there you go, Andrew.
Well, I have a combination of bronchitis and COVID at the moment, folks. So a little under the weather.
Maybe you should take some All Clear, and you wouldn't. The government doesn't want you to know that works on bronchitis, but it does. So there. Okay, where was this one? Here we go. Next is the Sod Monster. I heard that Hollywood Trump guy negotiated 30 pieces of silver for Judas. Oh, yeah, Richard Marx. Yeah, I got Judas a deal. No big deal. It's fine. We worked it out. You get these transactions, they come in, you got to go in aggressively. And sometimes you get a good one. And we got what we were after. Dark Dick's Power Hour says, love your channel. Shout out to Dick's Power Hour on iTunes. Well, there you go, guys. You can check out Dick's Power Hour on iTunes for all your dick power needs in 1 hour. Etienne de Gaulle, if you want to have a little nerdy fun, Google weird correlations, which will show you the correlation between eating organic and autism, or how the divorce rate in Maine correlates to margarine consumption. Yeah, I've seen that. That website's pretty great. They just lay they lay line graphs over each other. It's like these should have no connection. B.A. Krim, doesn't this witness look like Chandler from Friends? A little bit, but not as much as the hand doctor yesterday did. That guy looked a lot like Chandler. Chryson, if he dug any deeper, he will soon find a damn mummy. No guard, 5 people were mean to me on Twitter. Pledge me $100 trillion. Again, that 5 out of 1.2 million testimony was really golden, I think, for
crushing
for Johnny Depp. Chuz Nacho, the others expert looked at 1,000 random tweets. This Chad looked in essence at all of them since he reached the 95 unique and original tweets and analyzed them. Paragon, Amber Heard really should try to cut a deal at this point. Everything just keeps mounting against her. Johnny just wants his reputation cleared. He won't get his reputation cleared with a deal unless that deal was her going on like every news station in history, broadcasting to the world that she lied intentionally.
And what kind of deal would she settle for? I mean, she has, some theoretical, a low, but theoretical prospect of winning.
Yep.
If she doesn't win, she's done. Right? I mean, it's not like she's going to have an acting career.
She's doubled and tripled down too far to back down at this point. She's put too much on the table. She didn't need to do this. And by the way, Amber, this is a self-own. All of this is her going a place she didn't need to go. She had $7 million she could have walked away with. As she said, her pledge was just an empty promise, right? So, I mean, she could have walked away with that $7 million, which is, more than she's made in most of her film career. We heard she's made 10 million total. So almost the amount she's made for the total of her acting just from divorce. If you guys are surprised by that, you should look up how most of the wealthiest women in the world have gotten wealthy. But that aside, she could have walked away with that money, but no, she wanted to fight Johnny Depp, and she wanted to double down by, saying that she was, abused in ways that are horrible.
I suspect she knew she was not going to be making a good living in the lifestyle to which she'd become accustomed with her acting skills, and she was looking for another ticket. Depp was gone. It was going to be the ACLU and whatever this other thing was she was going to do, being an ambassador of domestic violence.
Yeah. And I mean, I think she gets paid 33 grand per speaking engagement on domestic violence. So
that's a good grift. That's a very good, profitable grift.
I'll take it all day. You want me to speak whatever your event is, 33 grand. I'm there twice. I'll speak for twice as long as she will. 33 grand.
And I guess Daddy Elon didn't work out in the end, right? For whatever reason, one way or another, right? For all this talk we have, the scuttlebutt of, Elon's sugar dadding her, clearly that didn't work out as expected.
No,
that's why
crap.
That's why a lot of people talk about him paying her fees, and I don't think that's likely to be the case. I can't see why Elon would be paying her fees at this point. Maybe he paid early on, like an initial retainer check or something, because it's literally just play money to him. But I can't imagine him maintaining payment for the publicity portion of it, like, because if we get to damages, it'll probably come out what she's paid, and if she's paid nothing, where the money's come from. Although she's already testified this has cost her $7 million or something already.
No, I think Elon launched SpaceX simply to have a means to escape rods like this.
Yeah. I will maintain that the only Tesla that's in space has a hooker in the trunk. I mean, I can't see why else you launch a Tesla into space, but I can definitely see if you have a dead hooker problem, you put her in the trunk of the Tesla and you launch it into space. Be like, look at what we did. It's awesome.
Speaking of dead hookers, I see Drex in the chat, so just wanted to say what's up to him.
No one will ever hear from Astelin again. She was a great dancer, though. What's up, Drex? I think Drex is coming out of the closet. Well, also to my house though, this weekend.
Awesome.
I think he's coming out. So that should be fun. Which means that when we're outside of closing arguments on the 24-hour stream, he'll be welcome to rescue me at any point. So that'll be crazy. I can't believe I'm basically decided to do a 24-hour stream on Friday. It's going to be such a disaster. Okay, but following up with that chat, everything just keeps mounting against her. Johnny just wants his reputation cleared. However, it is more satisfying for us to see this case go all the way. I would say it's critical for Johnny, even if he loses, to take the case all the way to jury trial or to the jury verdict. I think if he were to settle now and equivocate on his very strong public stance against Amber Heard and the allegations, it would look dishonest. And I think he would lose a ton of goodwill with his supporters and fan base who have been out there championing him this whole time. For a small scale version of this, I'll point to the Comicsgate issue of Richard Meyer, who was, I believe, fully defamed by what's his name? Comic book writer, super crazy shit. Mark Waid. Mark Waid defamed Richard Meyer. Richard Meyer sued Mark Waid. They had a long fight over jurisdiction, which is a nightmare. And then they got past jurisdiction. We're going to jury trial. And then Richard Meyer settled with Mark Waid. And undisclosed, NDA on the settlement agreement. But everybody was pissed. Everybody was mad about it. And it's like, well, these are people who stood by you for a year to 2 years, and now they're feeling like you have capitulated in some way. Johnny Depp would see a massive blowback in his fan base, and his fan base is how he will monetize his future, whether that's through Hollywood or some other means. If it's the Daily Wire and you suddenly have 10 million Johnny Depp fans joining the Daily Wire to see his next movie, I mean, great for the Daily Wire, great for Johnny Depp. That may be the case. If it's back in traditional Hollywood, that would be ideal for him.
Maybe he'll become an ambassador for domestic abuse.
That would be
Great.
the ultimate move.
Yeah.
The judge sanctions the ACLU and demands that they name Johnny Depp the ambassador that Amber Heard was holding. Lancelot, Richard has amazing charisma. I was hooked on everything he was talking about and could just listen to him talk about the industry. Yeah, that guy sounds like he's got a trillion stories that are all great. Jeff Exodus, I guess according to Dr. Spiegel, every trauma surgeon is an IPV expert as well, right? Yes, that's true. They deal with trauma, and intimate partner violence is trauma. Therefore, the last moron Heekin says, I choke the chicken twice a day, unbreaded. Can I qualify as
Are
an
we ready
expert?
for the jury? Oh,
Yes.
okay, sure.
Maybe Amber Heard could launch an MMA career.
It's getting old for that too. Sergeant Schultz, numbers nerd, looks like Cameron from Ferris Bueller's Day Off. I can see it. Yeah, a little fuller with the glasses. Felipe Move says, Rackets should have known better. This wasn't the right Richard Marx. Don't mean nothing to hold on to these endless summer nights right here waiting for his appearance today.
Look at that. There's nobody between Depp and Heard. There's no human barrier.
Yeah, he won't look at her though.
No.
Did you hear that testimony?
Yeah, I did. Good for him.
You'll never see my eyes again. Well, that's there you go. Penny Whitbrot, by the way, followed up on that all clear, says the all clear Alkalar would still help since COVID triggers mast cells, leukotrienes, and type 1 and 2 histamine. Get well soon, Andrew. So sorry you're not feeling well. Way to tough it out.
I'm not too bad. I'm at 90%.
Here we go. What's up, Legal Vices? How you doing, buddy?
I'm good. I've been extremely breaded for the past 5 hours, so I need to be released. I need to be freed from my shackles to speak.
What? How have you been breaded?
Oh, I've been visiting Legal Bites, grifting for subscribers. So
You've been cheating on me?
I've been slightly tethered.
Oh, it's just too bad. Its connection dropped. Weird.
Hey, we can only have one Korean lawyer out at a time, so let's get rid of this. Let's get rid of the shady guy down here.
Bye, Andrew. It was nice seeing you. See you later. Bye.
I
up,
love
Jeff?
that my two Korean lawyers are in whiteface. That's
Yeah.
fantastic. It just shows how based and red-pilled Korea is.
All the yellow is left on that court reporter. So.
Oh my god, that was a bit much. I love it. So what's up, Legal Vices? What's the good word on today's coverage? I mean, coming from the other stream plus your own opinions, what's going on?
Wow, I was surprised to see Miss. I've never seen a movie in my life being taken to task by our rebuttal witness. That was awesome. That was great, and show you how repentant I am. I'm dipping into the cigar malt with you.
Oh, nice, very good. I'm drinking this. Well, I haven't had any today, but
I think it's soju time.
This Kilkaman
Is
Seneg.
That's the Seneg. Oh yeah, that's good
Yeah.
stuff. That sherry cask. Oh
Yeah, you're a man who knows his whiskey. Okay. And by the way, Felipe Move, I did get your litany of Richard Marx song titles. So yes, I did understand.
He did so well today. I mean, he was a different witness today.
I thought he did well the first time too, personally, but he was great today for sure.
All right, you may be seated. All right. Do you need to approach for a moment? Okay.
That's my takeaway today. Not worth the paper it's not written on.
That's a good line. True and honest Shabbat, bad pressure, bad calf care says the Andrews. How dare you say women have a shorter window of relevance in Hollywood? The truth is so offensive. Really, though, if she was actually a good actress that uses talent instead of looks, she might have more time. But the best part about this is that women who smartly market themselves through Hollywood know that they have both.
Your next question.
You have the looks and the
Mr.
talent.
Bania, before lunch, we were talking about your
And you-
opinions
you
in response
exploit
to the
both of
testimony
them.
Mr. Schnell.
Yep.
Did you
Meryl
also
Streep, Helen Mirren.
testimony
The
of
list
Ms.
is
Arnold in this
lengthy.
Young Helen Mirren was hot.
And
Excalibur,
and you her opinion that Ms. Heard's career would have followed the same trajectory as that of Jason Momoa, Gal Gadot, Zendaya, Ana de Armas, and Chris Pine, if not for the Waldman statements?
Yes.
What's your understanding of Ms. Arnold's basis for her opinion that Ms. Heard's
There was
career
none.
similar to that those identified actors?
Ms. Arnold stated that when producers or her industry is looking to hire talent and actors, that it's important to best understand the public's perception of the actors that they're considering, and that it's important to look into social media to see what is happening with the actors they're considering for either a movie or even an endorsement opportunity with companies. So that was her approach.
And is that the process she followed in providing her analysis of those purportedly comparable actors?
No, although she stated that, she went in and brought in these alleged comparable actors, and without really reasoning behind that.
Did you conduct an analysis based on your expertise in social media and internet analytics of Ms. Heard compared to the actors to whom Ms. Arnold compares her?
Oh, it's going to be brutal.
I did.
And what did you find?
Well, since Ms. Arnold stated that the proper approach is looking at the public perspective, looking into social media, and she did not do that, I felt that was the best approach to do this based on her words. So yes, I did go into best.
I actually applied the methodology she merely claimed.
Ms. Heard and the alleged comparable actors using Q scores. Then I also went and did some analysis online and on social media as well.
Can you briefly remind the jury what Q scores are?
Yeah, again, Q scores measure how well a celebrity, it could be a cartoon character, it could be a sports person, how well they're known, how well they're liked, and how much they're disliked. And it's an industry standard tool that's used. It's not just focused on the movies that they're in, but it's focused on them as actors, but also what's happening in their personal lives come to play as well. So that's how Q scores are typically used.
Did you prepare a demonstrative that reflects the Q score analysis you completed?
Yes, I did.
Your Honor, may I approach again? All right, thank you.
Let's see. Waffles McGallagher. Nick, when mentioning Chris Evans, you failed to mention his starring in the American classic, Not Another Teen Movie in 2001. The man was destined for the stars. That movie's so great.
No objection to the demonstrative.
All right, we'll identify plaintiffs 1296 for identification and publish to the jury.
Mr. Bania, what point in time do these Q scores represent that are reflected on your demonstrative?
So these are the winter 2019 Q scores that are reflected here. And what was important for me is I wanted to find Q scores that represented Miss Heard after Aquaman. And remember, Aquaman is December 2018. These Q scores were gathered January and February of 19, but before the Waldman statements.
And what did you find based on the Q scores that you looked at?
So as you see here on the left are positive Q scores, and the higher the number, the better. As you can see, Ms. Godot has the highest Q score out of the group of actors here at a 28. But you're
for good reason.
Ms. Heard has the lowest positive Q score. She has a
Also
9.
for good reason.
So I find that very interesting that she doesn't appear to fit in as a comparable with these alleged comparable.
He's got 1/3 the Q score of
I
Gal
think
Gadot.
what's also interesting is the average Q score for all actors being scored at that time, which include all the alleged comparable actors here.
You should have the average line there on the
at
chart.
an average of 17, and you can see again she is 9, well below that. And then on the right side, you're going to see the negative Q scores. So this is how much people dislike.
Winner, chicken dip.
So the lower the score is better. You can see Mr. Momoa is over here with the lowest at an 8.
This is the only woman on earth who can't even fake being attracted to Jason Momoa.
A 20-point difference from Mr. Momoa, and also a 10-point difference.
Where's the chart of Momoa's Q score of Amber Heard? Need a logarithmic scale.
Her positive score is very
Negative
low,
Q score.
and her negative score is very high, which tells me that she does not fit in as a comparable as it relates to these alleged comparable actors.
Bad chart design, by the way. He should have had the negative bars going down below the x-axis.
My opinions as it relates to these Q scores is, Miss Arnold used these actors as allegedly comparable actors. But really listening to her testimony yesterday, it appears that she's abandoned this approach. I don't think she's using these comparable actors or these alleged comparable actors anymore. She's more relying on her experience, and I agree with that.
Did Ms. Arnold offer a criticism of your use of the Q scores here?
She did, yes.
And what's your understanding what that criticism is?
Well, what I believe she was saying is that I should have ran Q scores for these allegedly comparable actors after each of their breakout films, which I disagree. First of all, Q scores doesn't work like that. Q scores are available twice a year. So it's not that I could pick a month or a different month for each of the Q score actors. So I feel that, what was important for me, and this doesn't always happen when I'm using Q scores, you can get this perfect moment in time, as Miss Heard said, but as Miss Arnold said, that, Aquaman was Miss Heard's breakout moment. So these scores reflect that breakout moment, and they're terrible Q scores.
How would your analysis change if you had used Ms.
Not to
Arnold
beat around the bush.
with respect to the timing of the Q scores that you looked at?
I mean, if you really think about what Miss Arnold was saying, is she's saying that she thinks Q scores are the highest for each actor right after their breakout moment. So I would think, if anything, these Q scores could have been a bit lower because it's not right after their breakout moment. But what's important for me is the fact that these scores reflect, who Amber Heard was at the time before the Waldman statements, but after the Aquaman release.
We can take that one down, Tom. Thank you. What other work have you done in connection with forming your opinions in this case?
Look at that narcissist.
Again, taking the advice from Ms. Arnold, it's important. She says the industry looks into social media, what their followings are like, with the numbers as it relates to their followers. Again, what is the public perception of them? So I analyzed their social media accounts, but prior to the Waldman statement. So.
And how did you do that?
Yeah, so what I did, I don't know if you're all familiar with the archive.org. They have a tool called the Wayback Machine. What archive.org does is it archives the internet. So you can go back in time to see what websites and web pages used to look like in the past. Not all the time can you actually get a celebrity's social media accounts to have been archived, but we were fortunate that each of the alleged comparable actors' social media accounts were in archive.org. So I was able to go back in time prior to the Waldman statements to see what the following activity was for each of the alleged comparable actors.
Mr. Bania, did you prepare a demonstrative that reflects your social media analysis?
Yes.
Oh, no.
Yes, ma'am.
Again,
You know,
when
that Amber
it,
Heard scribbling, she's playing hangman with herself, and the answer is always Johnny Depp.
when one expert comes in with numbers and the other expert comes in with nothing, I mean, the statement is powerful.
No objection to the demonstration.
All right, we'll mark it for identification purposes. Plaintiffs 1297 and publish.
He's going to show their Twitter followers.
Mr. Bania, could you tell the jury what you found when you looked at the social media?
There we
That's
go.
what I found. Again, this is prior to the Waldman statements. First thing you're going to notice here is not all actors use social media. You're going to see Mr. Pine doesn't have Facebook, Twitter, or Instagram, and Momoa and Darmus don't use Facebook or Twitter. But what's important to look at is you have Ms. Heard prior to the Waldman statements with 3.8 Instagram followers and 142,500 Twitter followers. And then you move down to Gal Gadot with 37 million Instagram followers compared to her 3.8 million. And 2.3 million Twitter followers compared to Ms. Heard's 142,000. And you can then even go down to Zendaya with 65.9 and 17.2 million Twitter followers. What this is telling me
Sounds
is
like Anna
really
Armas is
more people
criminally
are interested
undersubbed
in
on
Ms.
Instagram.
Gadot and Zendaya and even Mr. Momoa than Ms. Heard on social media. It just tells me a lot. People are interested in these actors as opposed to Ms. Heard, more of a following. Q scores, well-liked, less disliked. So it kind of fits into the analysis of determining whether or not these.
Amber should be making 20% of what Zendaya is making.
Based on your expertise, what are your overall opinions about Ms. Arnold's analysis of the so-called comparable actors?
Yes, again, it appears that she's abandoned this approach, and I agree with that. I feel that, through the Q score analysis and the social media analysis, that they're just not comparable.
We can take that one down.
Someone asked if Amber
Mr.
Heard
Bania,
gets
based on all the analysis you did in this
Just
case,
a second.
what are your overall opinions?
Yes, my overall opinions are that Mr. Schnell failed to prove any causal connection with the Waldman statements and the search or the hashtag activity, those spikes as it relates to Twitter. There's no causal connection there. My second opinion is, based on my social media and Q score analysis, Miss Arnold's alleged comparable actors are not comparable. And then third, Miss Arnold and Mr. Schnell both failed to prove any causation as it relates to the Waldman statements causing economic harm to Ms. Heard. So, you know, as a damages expert, which Ms. Arnold is, you need to take into consideration causation before you can calculate damages. You look at damages and you look at this allegedly damaging event, and not only do you have to prove that 100% of the damages because of these Waldman statements, she didn't even consider COVID. It happened at the same time.
There it is.
You know, a lot of actors probably made a lot less money because of COVID. Maybe films didn't get made. And, you know, when you do an analysis of damages, you prove causation, but you also have to look at everything else that might have caused this alleged economic harm. And she didn't look into any of that. She didn't even
And the
know
less proven actors would be
So
the
I
most
don't think
damaged by that,
damages
right?
is the appropriate
Studios would run to safety.
No further questions, Your Honor.
All right, cross-examination.
brutal.
Look at how quick and clean that was.
People are asking if Amber Heard can call rebuttal. I don't believe she gets a Sir rebuttal in this case. So no, these will be the last words.
Good afternoon, Mr. Bania.
Hi.
Yeah, you're not a damages expert, correct?
She wouldn't get one
I
because
am
of
a
her
damages
younger, you
expert,
think?
but not providing any quantitative damages opinions in this case.
In this case, okay. And is it your testimony that only if a person repeats the Waldman-Depp statements could they be related to the defamation?
No, that was your
Say that one
expert's
more time.
testimony.
Are you saying that a person literally has to repeat the Waldman-Depp statements in a tweet for them to be related to the defamation?
Just say yes.
No, if you looked at my analysis, I did pick the 3 themes as it relates to the tweets, and I analyzed those themes, and I came up with 5 examples of when those themes were used.
And you ran searches for, quote, abuse hoax, sexual violence hoax, and fake sexual violence. And you ran all those in quotes, correct?
I did.
So only if a person used a tweet with those words in that order and with that spacing would they hit on your searches, correct?
Objection, compound.
Overruled.
Yeah, so I used them in quotes because, you know, hoax could be used in many other contexts. So I wanted to make sure I was fitting my search with the theme of the Waldman statements.
So if someone tweeted misheard faked sexual violence, that wouldn't appear in your searches, correct? Faked with an ED.
It would not.
Okay. And if they use 2 spaces between abuse and hoax, that wouldn't fit in your search.
That's correct.
Okay. Did you? And a tweet can only be 280 characters, correct?
That's correct.
All right. So certain of the Waldman-Depp statements, a person could not tweet.
Now it's Waldman Depp.
In one tweet, correct? The whole statement in one tweet.
The Waldman statements?
Correct.
No, you could not tweet those entire quotes.
Did you make any determination if there was an online bullying campaign against Mr. Depp after Ms. Heard's op-ed?
I didn't look into any online bullying campaign for Ms. Heard nor Mr. Depp.
Did you determine if there were tweets harassing Mr. Depp that quoted from Ms. Heard's op-ed?
No, my assignment was to determine if the Waldman statements were part of the tweets that Mr. Schnell provided. I was rebutting him.
And in your analysis of when you testified before, you never looked to see if the op-ed was quoted anywhere, correct?
Objection, Your Honor. May we approach?
It's outside the scope of his expert testimony.
All right, questions withdrawn. Next question.
Now, you have no objection to Ms. Arnold's use of comparables, correct? Just the use of comparables in general.
I listened to her testimony and my understanding that she abandoned that approach. But as it relates to my testimony today, my opinion was related to those specific alleged comparable actors, that they were not comparable.
You're not offering an opinion as to who the appropriate comparables should be to Ms. Heard, correct?
Just not those.
Yeah.
And you testified just before about the Q scores of Ms. Heard and the comparables. That was plaintiff's exhibit 1296, correct?
Such a waste.
I don't know what 1296 means.
Okay. The demonstrative in front of you.
Mine? Yes, that's correct.
And you said that those were all for the winter of 2019?
I said Ms. Heard's were from the winter of 2019.
Because isn't it true that none of the rest of these people were from the winter of 2019, correct?
That's correct.
In fact, Mr. Momoa's was from the summer of
2020.
Of 2020?
That's correct. Not
So
all
lacking
alleged
confidence.
comparable actors had Q scores for that date. What was important for me is to get Ms. Heard's Q scores right after Aquaman, but before the Waldman statements.
So you weren't comparing apples to apples, correct?
I wouldn't say that. I'm saying that it's not the exact same years.
Well, so in the winter of 2019, that Q score comes out, that the field work dates for that is from January 22nd, 2019 to February 7th, 2019, correct?
That is correct.
So that would be so the field work would be starting almost immediately after Aquaman just came out, correct?
Yeah, in her Star is Born moment, yes.
You'd agree that for the winter of 2020, where you took Jason Momoa's Q score, would have more time to account for the rise in popularity of the film Aquaman, correct?
Well, actually, if I use Miss Arnold's suggestion, the celebrities tend to have, the celebrity moment right after they have their breakout film. So I disagree with that. I think maybe his Q scores could be lower as it relates to when I use them.
You'd agree that for the winter of 2020, Mr. Momoa's Q score would have more time to account for the rise in popularity of the film Aquaman?
No.
I don't know if it accounts for the rise of popularity again.
Winter 19, winter 2020, the world was a much different place.
Usually a Q score will be the highest right after the film, like I did measure Ms. Heard.
All right. Do you show?
Yeah, it's why that opening day of a movie release is bigger than every other weekend. That it's at the peak popularity outside of real aberrations that sometimes happen. But so are you going to show his Q score being higher at a different point?
If you look on page 177 of your deposition transcript, you see that?
I don't see a page. Is that what you handed me?
You don't see page 177? I think 4 pages per.
Oh, yes, thank you.
And I asked you at lines 6 through 10.
Yeah, he's struggling
For
here.
the winter of 2020, Jason
awkward.
Momoa's
Scratches himself
more
all the
time
time.
to account for the rise of popularity in the film Aquaman. And you answered
Collar
yes.
pull.
At that time, as I am a rebuttal expert to Ms. Arnold, based on her testimony, I've learned something new from her.
You didn't look at Miss Heard's Q score for summer of 2020, correct?
She doesn't have any.
And Miss De Armas had a lower familiarity score than Miss Heard, correct?
If I don't have that in front of me, but if you're saying that, yes.
Okay. And Miss De Armas's career trajectory has gone up since the summer of
Why do they say that all the time? I would just say, I don't know.
I don't know. I didn't analyze her.
There you go. There you go, Andrew. You called it.
Don't say if you say it, it must be true. I don't know.
Yeah, you put up plaintiff's trial exhibit 1297. That was the demonstrative. Miss De Armas has less Instagram followers than Miss Heard, correct?
Correct.
And Miss Heard has more than double the Instagram followers of Miss De Armas, correct?
Yes.
Okay. And isn't it true that you get more social media followers the longer you're on social media?
Not for everybody.
Not necessarily. It doesn't work that way. It depends on many other
Just look at my YouTube subscribers.
Miss Armas had a lower familiarity with Instagram followers, yet your testimony is that she would not be a proper comparable to Miss Heard?
That's correct.
And you're not offering a different set of people who should be comparables, correct?
That's correct.
Okay, thank you. You can take that down.
Oh, I thought he was done.
Already asked that question.
Now, you understand that Mr. Waldman has been banned from Twitter for life for harassing Amber Heard, correct?
I don't know that, but if that's the case,
And you understand that Mr. Waldman appealed the decision to Twitter and they have confirmed his ban for life?
Objection, Your Honor. May we approach on this one?
Okay.
Yeah, come on.
So Adam Waldman would be an example of someone who, the longer he was on the social media platform, in fact, the less followers he would have, because now he has zero. But I guarantee you, he still used Twitter in some capacity.
Right. I mean, Twitter's the moral authority, depending on who they ban or don't ban.
And it's outside this expert's scope. Adam Waldman's
You
Twitter
agree
social
that in
media accounts aren't
looking
at
at
issue
Mr.
here.
Schnell's data, 65% of the uses of negative hashtags relating to Ms. Heard occurred between April 1st, 2020 and June 15th, 2021, correct?
correct.
And you would agree that 5 of the 6 highest spikes of the negative hashtags were after the Depp Waldman statements, correct?
Correct.
Okay. And where you talked about the February 2020 spike, and the 65%, by the way, even includes the February 2020 spike of tweets, correct?
That's correct. Well, there was no spike in Feb 2020 during the Waldman statements.
Well, the spike in February 2020 was before the Waldman statements, right?
Before the Waldman statements.
I would have you. Can we pull up the chart again if you want to talk about the spikes?
Sure. Can you put up 1294?
Why'd you agree to that? You're the lawyer.
Number
You
one.
run the show.
Number one.
You don't remember
that
your own
spike
chart?
happened before the Waldman statements.
Okay. And there was hardly any activity in negative hashtags until February 2020, correct?
Still before
That's
the statements.
And you understand that the spike in February 2020 was related to the partial tape that Mr. Waldman and Mr. Depp leaked to the Daily Mail, right?
Objection, Your
I'm
Honor.
aware
I don't
that
know
the
that.
articles were related to Heard admitting to hitting Depp.
And you understand that Mr. Waldman testified that Mr. Depp and Mr. Waldman met with the Daily Mail in person to provide the partial tape to the Daily Mail.
Objection, Your Honor.
And he talked about what the number one related to.
What's the objection?
Sorry, lack of foundation and
I'm asking if he knows or he
You're on
doesn't.
the scope.
All right, we'll rule.
So what's important to me is the fact that this spike is
I-
prior to the
Sir,
Waldman
sir,
statements.
do you know if Mr. Waldman testified that Mr. Depp and he met with the
Just
Daily
say
Mail in
no.
person to
Just
provide
say
the partial
no.
tape
I don't know.
in February of 2020? You don't know one way or the
It's
other.
irrelevant to my opinion.
Okay.
Thank you.
And the spike in July of 2020 came right after the last defamatory statement by Mr. Depp and Mr. Waldman, correct?
No.
The July spike, which is number 2, is not related to the Waldman statements, and there are articles related to abuse between Heard and Depp and feces found in Depp's bed.
And that's based on Google searches you did?
That's correct.
Okay. And the July spike in time came after the June 27th, 2020 defamatory statement by Mr. Depp and Mr. Waldman, correct?
That's correct.
Okay. And 5 of the 6 spikes came after the defamatory statements, correct?
After the Waldman statements, yes.
Okay. Now, you testified before that you eliminated shares and likes of the Depp Waldman statements from your analysis, right?
Repeat that, please.
Did you say that you eliminated shares and likes of
Retweets.
tweets that included the Depp Waldman statements?
That's correct. When I was doing my analysis, I noticed the exact same text was a part of many of these tweets.
Don't shares and likes disseminate the negative information?
That's quite possible.
Okay. And you agree, right, that use of the term Waldman or Waldmanian occurred over 25% of the time in the negative tweets toward Ms. Heard from April 2020 through January 2021, correct?
Although it's irrelevant to this case, it has nothing to do with the Waldman statements. That's what Mr. Schnell says.
You don't disagree with the search results, correct?
Although has nothing to do with this case or the Waldman statements, I do not disagree.
So if people are tweeting about Adam Waldman or Waldminian at the same time as tweeting negative hashtags about Amber Heard, it's your testimony that they have nothing to do with this case?
The hashtags have nothing to do with this case.
That's what you're saying?
Yes.
Okay.
Yeah.
Okay. And even if they include the negative hashtags with Mr. Waldman's name and Waldminian, you're saying they have nothing to do with the defamatory statements?
All
Yes.
4 hashtags that Snell used had nothing to do with the Waldman statements.
Yeah.
Waldman himself has nothing to do with the Waldman statements. We're talking about the Waldman statements here. Waldminian, I don't even know what that is, but again, it has nothing to do with this case, and it's not related to the Waldman statements. That's what's important.
And the reason you're saying they're not related to the Waldman statements is because someone didn't literally copy what Adam Waldman said in the Daily Mail and tweet it out?
That's what your
Well, I looked
expert
at
said.
enough tweets that included the name Waldman that have nothing to do with anything negative or the Waldman statement.
No, they must have, had,
Mr.
they must have had to have the negative hashtags toward Ms. Heard, because the only way that those would have been in the data you looked at would have had the negative hashtags towards Ms. Heard. He wasn't looking, it was looking at that universe, correct?
Well, first of all, I don't agree that justice for Johnny Depp is a negative hashtag towards Amber Heard. So listen, the assignment was to determine if the tweets that Mr. Schnell presented were related or included the Waldman statements.
In your review of the tweets related to Ms. Heard, you cannot point to any that were positive toward Ms. Heard, correct?
Again, I was not looking for that.
And you did not review the hashtag Justice for Johnny Depp during the time frame from April 1st, 2020 to January 1st, 2020 to see if there were any that were not negative toward Ms. Heard.
Boy, this guy's really off stride.
I did not look into anything as it relates to anything other than what relates to the Waldman statements. That's what's at issue here today.
How are you going to say that those statements had a significant
And you didn't
impact
form any
on points
statistical analysis
4,
to
5,
the
and
Waldman
6?
statements impact on the hashtags, correct?
Correct.
You did not analyze whether media and press coverage other than the Waldman statements affected Ms. Heard's career, correct?
Correct.
Okay. Looking at the exhibit that's in front of you, where you have the numbers here, those you said are related to Google searches?
The 1 through 6?
Correct.
Yes.
Okay. And can we put up plaintiffs 888?
I just got a note from the gallery.
And we could just start at 1. Do you understand that your... Okay. Oh, thanks. And 888, it's page 76. These are the documents you relied upon for your opinion today?
Yes.
And are these the search, where it has the different letters? These are the searches that you ran for the various time frames and the articles that came up for numbers 1 through 6, correct?
No, I mean, obviously document 1A is the Heard supplemental expert witness disclosure. These are documents that I used throughout the time I've been working on this project. So these aren't related to those 1 through 6 numbers.
Okay. These are documents you relied upon for your opinion today?
These are documents that I relied upon when I presented my designation.
For your opinion today, that you're offering today?
Yeah, these are the documents that, yes, I've relied on throughout this case.
Okay. And actually, Michelle, could you turn in this designation to...
This guy's driving me to drink.
Cheers. I decided to join you, by the way. We're doing the Kilhoman too.
Oh, nice.
Can you just scroll down? Yeah, keep scrolling.
Oh, this guy's burning time.
Yeah. Yep.
Like it's free.
Keep going.
We've made his point.
Okay, stop. This was the chart you provided with your designation for your opinions in this case, correct?
Yes.
Okay. And it's similar to the chart that we had before with the 1 through 6, correct?
That's correct.
And where it has the various boxes, it's talking about documents 6E through 6H, for instance, related to Depp wanting to have Heard replaced on Aquaman.
Yes.
And you prepared this chart, correct?
Yeah, this was part of my designation.
I'd like to have this page.
What does it have to do with the Waldman statements? The
Your
petition
Honor,
to
I do
remove.
have an objection, if I might be heard.
All right, if you want to come forward. Page 99.
Yeah, I know my camera occasionally blanks. Thank you. It's an issue I'm working on. It happened with the installation of a new graphics card that's PCIe 4.0, and apparently Elgato does not, which is my Camlink capture card, does not play nice with that. So I'm trying out different settings, but I don't have a ton of time to just tweak it endlessly, unfortunately. Seho, look at Dr. Spiegel and Dr. Heinz Doofenshmirtz and tell me I'm not high for thinking they are brothers. Tails says, which would you cast as a female supervillain first? Jada Pinkett Smith, Amber Heard, or Hillary Clinton? The only one with demonstrated body count is Hillary Clinton. So that's the one I would pick. Let's see. Cosplays, cons, and cuisine, etc. What would the chances be that Turd goes full re in the courtroom when and if Depp wins? Leaning for a Depp win. I mean, I don't know. She made storm out of the courtroom. Like
She'll have a reaction. She'll have some reaction.
Yeah, but what that reaction is, I mean, that can literally go either way.
Yeah, I don't think you're gonna see like I don't think you're gonna see like a full on like crazy screaming a thing like when Trump won or whatever. Like I don't think she'll fall to the ground. I want her to do that, but I don't think that's gonna happen.
Will she rise to the Twiggly Poof level? Or the
the
Triggly Poofer.
Gosh, that was gross. Adam Trapp. If Amber starts an MMA career, there will be a line of people starving themselves to get into her weight class. An emaciated Johnny Depp enters the octagon. I'm here, Slim. Johnny Arbor 007 got you some Black Bush for Houston. That's Bushmills Irish whiskey. Take your mind out of the gutter.
Black Bush is really good.
Bushmills is a Protestant whiskey.
It is. It is. Bushmills 10 is a fantastic Irish whiskey, by the way.
The last one I had. Do I have that bottle still down here? My wife makes me keep all these freaking liquor bottles because she wants them, quote unquote, for projects. Drives me nuts.
She's going to show you just how many you've had to drink in the past few years.
Yeah, it's like
significant.
Yeah. Where is it? Nope. Yeah, I must not have it down here. Oh, wait.
No,
Ha!
perfect timing.
Bushmills 21-year triple distill.
Oh. Ooh. Wow.
Matured in 3 woods.
Topo Chico 2022.
That Bushmills 2021 that's just a sweet appley goodness. I'm jealous.
Bania.
I'm not fit to unlatch your bootlaces.
Other than
he lost that objection.
Humana.
Yeah, actually, drinking doesn't lead to intimate partner
so as I
violence.
understand it,
It's the wife's insistence on
your-
keeping the bottles that does.
the way you determined that the tweets were not related to the Waldman statements was that you looked at time and then you ran certain Google searches, correct?
Correct.
And then the top 3 hits came up.
Correct.
And then you looked through the article to see if the Waldman statements were there.
So as it relates to any trending event, any defamation that's happened online, any allegations of economic loss because something went viral, going to Google, looking at the spikes in time and going back in time to see what was happening on those top 3 sites will give you an indication of the best results that were being served at that time. So something viral that's happening would appear most likely in those top 3 results.
And just so the record's clear, if we could go back to page 76 of this document. Numbers 6A through 6N, going to the next page, those are the headlines of the searches that you found?
Correct.
And you don't disagree that that negative tweets toward Ms. Heard have continued throughout the analysis of the tweets, correct?
I'm not looking at whether they're negative tweets or those hashtags are negative. I'm determining if those tweets are related to the Waldman statements.
Well, okay, and you
Which
haven't.
they're not.
You have no opinion whether the tweets were positive or negative towards Ms. Heard. That's what you're saying.
Yes, I'm just analyzing whether or not they're related to the Waldman statements.
Okay. Thank you. Nothing further.
All right, redirect.
Oh man, I don't think he realizes how poorly that went for
I have
him.
no further questions for this witness, Your Honor. Thank you, Mr. Bania.
And now he does.
Thank you.
Ladies and gentlemen, we're going to take a brief recess for you at this point. Hopefully within 15 minutes, we'll get right back to you, okay? Do not discuss the case and don't do any outside research. Sorry. Do not discuss the case and don't do any outside
0
research.
points.
Sorry, we'll just take a short break.
Be funny if Camille starts getting makeup endorsements.
All right. So just so that we're on the same page, you can have a seat. Keep standing the whole time.
Gonna give
All right.
time.
Just so we're on the same page with Mr. Knight's testimony. Actually, could Mr. Knight go back out, please?
Get out.
Get
We
out.
might or might not be talking about you.
GTFO.
All right. All right. So we're on the same page with Mr. Knight's testimony. There is a rule on witnesses. However, Mr. Knight's a rebuttal witness. The purpose of excluding witnesses from the courtroom, usually it's a courtroom, is to deprive a later witness of the opportunity to shape testimony to correspond with that of an earlier witness. The issue we have here, obviously, if it was a direct witness in the direct testimony, you had time to do a rule on witnesses, let them know about the rule on witnesses. With a rebuttal witness, it's a little different because they didn't know they were going to be a witness. You didn't know they were going to be a witness. I understand that part. The problem is the courtroom in this particular case appears to be the world. So what we have to do here is I'm going to do a voir dire, and I'll allow both sides to ask questions as well of Mr. Knight to see what he has seen of the case. And I'm just going to use the factors that the case law in Virginia uses, which the factors to consider, because the court does have broad discretion to permit or prohibit a witness to testify in this particular circumstance. So the factors I'm going to consider is if the impropriety was intentional, which we'll find out, the prejudice attached to it. Also, if the excluded witness learned about substantive aspects of the case from an earlier testifying witness, and whether that knowledge had any effect on his or her testimony. So those
Was that the note?
we're going to look at in weighing this decision. So keep that in mind when you do your voir dire. And it's my understanding that the evidence that Mr. Knight will testify only relates to Hicksville. Is that correct? Okay. All right. Now we can have Mr. Knight.
This is Morgan Knight, the witness of the Hicksville incident. So they didn't know that he would be called for rebuttal, but now he's here to testify about this incident, but he wasn't noticed as a witness before. So he may have been observing social
All right, sir,
media
Mr. Knight, if you could come
about
forward.
this.
He may have been watching Rakita Law.
That'd be so funny.
Hilarious.
Soviet California says, what grinds my gears are network TV shows like 911 on Fox that my wife watches. They make a huge deal about one character and alcoholism, but are too cheap to pay licensing and have a Scotch named Glenn Callan. I'm just waiting for McLovin.
Sir,
What
we're doing is I'm just going to ask you a few questions outside the presence of the jury. Then the attorneys are going to ask you a few questions, okay? Then I'm going to have you step back outside after that, okay?
No problem.
All right, what's your full name, sir?
Morgan Higby Knight,
Okay, you don't have to be that close. All right. All right, what's your last name?
NIGHT.
Okay. All right, and sir, before I can allow you to testify, I just want to ask you a few questions. Have you seen any of the trial that's been going on for the past 6 weeks?
Approximately 5 weeks ago, a friend of mine texted me that Hicksville was mentioned, and I watched a little clip where
Okay.
it was mentioned.
Which clip did you watch?
I believe it was somebody testifying about, I think it was the security guard testifying maybe about Hicksville or.
Well, if he's seen anything, how do you keep him in and
exactly
then
who
still
was
justify
testifying.
booting the
There
woman
was something
earlier
where
on in the
Hicksville was
trial?
mentioned, and it was about something about a wrist or something like that.
All right, and what did you do after that? At some point, did you get in contact with attorneys?
So I didn't reach out to them. I didn't really care.
Okay.
The innkeepers that worked at Hicksville before reached out to them and said, we saw some stuff that wasn't true. And then they asked, is it okay if I give the attorneys your phone number? So the attorneys reached out to me.
Okay, and when did the attorneys reach out to you?
May 3rd.
May 3rd. And you talked to the attorneys at that time?
Yeah.
I'm
Okay.
becoming
Not
a
Camille, but,
vegetarian
Geraldine.
with every word this guy
Okay,
speaks.
and then have you seen any other parts of the trial?
No, she instructed me not to watch anything about it, regardless of if it was about Hicksville or not. So I've been
Since May
keeping
3rd.
off the internet and turning off anything that seems to be like it's on social media. So I just don't watch any of that.
Okay, all right. And questions, Ms. Prater?
Oh, good. Elaine's
So,
doing this.
Mr.
This will be
Knight,
competent.
you were contacted Mr. Depp on May 3rd?
Yes,
Okay, and you said it was Carolyn?
Geraldine.
Geraldine. Oh, Yerlin, I got it. Okay, and
No, you don't.
I think it's pronounced Geraldine.
okay, can you tell us the conversation you had with her at that time?
Yeah, she just asked me my recollection of the evening, and I told her, and she said, okay, would you mind testifying? And I said, sure. And she said, okay, well then we're not sure if we're going to call you or not, but just in case, please don't watch anything having to do with the case. And I said, I will do.
Now, how is it that, to your best knowledge, how is it that Geraldine was able to get hold of you? How did she know that you knew something?
So, like I said, two of my innkeepers, my innkeeper and my manager, had reached out to her team, I think through email. And one of them texted me and said, hey, do you mind if we give Geraldine your phone number?
Now, you also communicated on Twitter, did you not, about this case?
Yeah, 2 weeks prior to Geraldine reaching out to me, someone had made a comment about something that happened by the fire pit, and I said, that's not my recollection. I didn't see, that's not what I saw.
So who was it that made a comment about something that happened at the fire pit?
So once I was told about the fact that Hicksville was mentioned, I went and did a Twitter search of Hicksville trailer. So it was, I don't know who it was, but I was just like, what are they saying about Hicksville? And so that was why I did a search, just to see, because it was weird and fascinating, because the night to me wasn't that remarkable in the context of all the different experiences I've had at the trailer palace.
So explain to me, please, what you mean by.
Did he just say? Yeah, he said trailer palace.
Trailer
So
palace.
if you go to Twitter and you put in keywords and do a search, all the tweets regarding that subject come up, or anything with those keywords in it. So that is how I found the tweet that I replied to.
Okay. And how many tweets did you find that mentioned Hicksville when you did that trailer search?
Probably like 5 or 6. I only replied to one of them.
Okay. And what do you recall those tweets saying about Hicksville?
The one that I replied to said that there was some incident by the fire pit, and Johnny was yelling at Amber, and I replied that I didn't see that. I was there all night, and I was working that night, so I didn't see anything like that.
They're going to move to exclude this guy.
So
yeah, but on what grounds?
And that one was that somebody said somebody was testifying that Johnny was yelling at Amber?
Yeah, and I believe grabbed her or something along those lines.
Do you recall who said Johnny was yelling at Amber and grabbed her?
I have no idea. It was a stranger, so I didn't really pay attention to who was writing it.
All right. And you said that you responded to it. How did you respond to it?
I said, that's not what happened. I was there all night.
On Twitter, Elaine.
Yeah, basically. I'm
That-
paraphrasing. It was a
Did
few
you
months
say
ago.
anything about what you thought happened?
I just said that didn't happen. I didn't say what. I believe I said maybe something along the lines of, from what I saw, Amber was the one acting jealous, not Johnny.
Oh, shit.
And you said this to one of the tweets.
Yes.
Do you recall whether that was the Umbrella Man?
I don't recall. That's ridiculous.
Okay. So tell me about the other 5.
Would that be in the umbrella?
Tug.
You recall seeing when you ran your trailer search.
I think they were similar in nature, but I don't specifically remember the details of them. That was pretty much the only one I remembered, and that's the only one I replied to.
Do you remember anything about the other 5 and what was said?
No.
When you said that somebody told you about a security guard, what was your understanding of what the security guard said?
I got a text that somebody in the trial had said
She looks like a concentration camp prison guard supposed to be hired.
during the trial. And so
Frau
that's what I
Blucher.
go on Twitter and do a search.
And did you have any communications with the 2 innkeepers about what you knew or what you thought?
No, I haven't talked to them in years, and
So-
still haven't regarding the case.
So how is it that the innkeepers then contacted you and said, do you mind if we give you the telephone number to the attorneys?
Because they still have me in their phone, and Christy, who was the manager at the time, is the one that texted me and said, hey, do you mind if we pass this along? Mr. Depp's attorneys want to talk to you.
Do you mind if we pass what along?
Your phone number.
Right, but how is it that, what is the communication you had with the innkeepers
Email.
that even led them to understand that you believed you had knowledge about the Hicksville incident?
There was no conversation. They knew because they were both working that same night. Jenna was the innkeeper, and she was there along with me that night. Christy was the one who texted me, and she had come in the following morning for her shift. And I slept over. I was live-in innkeeper that night.
So I'm trying to understand. So just based on the
You're
fact
trying
that
to find a basis to
7 years
exclude.
ago, they happened to know that you were working that night.
9 years ago, and it's because I was there
Okay.
with them.
My math, well, it's 2022.
My brain no work so good.
What year? Oh, that was
2013.
You're right. Okay.
I'll love him
So
and hug him. And
how is
squeeze
it
his
that
pet
out
him
of the
and call
blue
him
they
George.
remembered 9 years ago that
Out of the
that
blue.
you worked there?
Because
that
they have
night?
working memories, Elaine. They're not all
To be
Chardonnay
honest, like,
idiots.
to get celebrity sometimes, but it was
It's the night that
it's
Johnny
not that
Depp was there.
unmemorable. It's not like it's any other night of the week. So I'm sure they remembered the specifics of that night.
Had Mr. Depp's attorneys ever attempted to contact you before?
No,
Had you ever attempted to contact Mr. Depp's attorneys before?
no, I had no interest.
All right. Have you had any conversations with Mr. Depp's attorneys other than the one you described with Geraldine?
Since
Yes.
well, I met with Camille last night.
All right. And what was that conversation? Please describe.
I just went through, the story again that I had told Geraldine.
And let's hear what that story was.
You want me to go through
Yes.
the whole story?
Your Honor, we would object to attorney work product.
No attorney work product.
No, I'll overrule that.
All right.
objection. That's okay.
It was worth a shot,
ahead.
but he's not. They're
ahead,
not
sir.
his
Yeah,
attorney.
That I described like them getting to the trailer palace.
Should have objected on hearsay.
Me showing them around, the interactions I had when I was on duty with Mr. Depp and Miss Heard, how the evening progressed.
I think the judge wants to hear what he's going to say.
Levels of drinking and drug use that I witnessed.
I mean, the jury's not present.
What the state of the damaged trailer the next morning, and basically just the details that I had only spent total 45 minutes to an hour with Mr. Depp and Miss Heard throughout the entire course of the night. So it was my recollection of those events during that time.
And what did Ms. Vasquez say to you?
Your Honor, this is beyond, we object on the grounds that it's beyond the scope of the voir dire,
No,
which is
I think
limited to the
whatever
three
she said to
criteria.
him
But
is
may I
very
please finish
critical.
stating my objection, Your Honor?
Go ahead. Yes, sir.
The objection is that it's beyond the scope of the voir dire. Your Honor enumerated the three criteria which are relevant here. And this is a rebuttal witness, so.
Your Honor, whatever Ms. Vasquez shared with him is going to be very important here because they knew by this time he was going to be a witness. So
That's
what-
last night. So how
Right.
does that fit into one of the three factors of deciding whether or not he's going to testify?
Well, one of the
Articulate it,
three
Elaine.
factors, Your Honor, may I approach?
Oh, may I
Your Honor,
approach
may I
because I'm going to
approach?
sound freaking
You sound like an
retarded
idiot.
on television?
Camera, yep.
She knows she's going to get creamed on this because this is the problem. One thing, what Camille Vasquez says to the witness is irrelevant,
right?
Unless Camille Vasquez told this guy how to testify, but he just testified to what he told her. It seems consistent with the statement he made on Twitter, and with the events of the night.
Well, that was fast.
Mr. Knight, did
Yes.
Ms. Vasquez provide you with any information that anyone
Probing,
had testified
probing question
to
compromise.
or,
Here you go.
said at any point?
No, she didn't talk about anything except for asking me my experience and just getting a clear understanding of
Camille's not going to jack things up like that.
side of scope of what I saw, and just asked me for the facts and told me just tell the truth and let me know,
Just tell the
Do
truth.
you know what any of the witnesses said in this trial?
about, outside of what I described earlier with the, a friend of mine texting that someone was talking about Trailer Palace, I do not.
Do you know whether any of the witnesses testified about any jealousy?
Other than the tweet that I replied to, no.
All right. Thank you. Your Honor, may we approach?
All right. Well, do you have any questions? All right. Sir, if you could have a seat back outside the courtroom.
Sure.
Thank you.
Can I leave my water?
Yes, you can leave your water.
Oh, that indicates that he's probably coming back.
That's the tell.
The only thing worse than vocal fry is male vocal fry.
Oh God,
it's so bad. This is cringe. He is cringe with his speech pattern.
This is a genuine man ish.
Who is that masked man?
Cripesies says, I'm still waiting for Karen to object to a question with what, if any, as an argument. It's even rubbing off on Rottenborn. Cheers from Swedistan, former Sweden. Oh, ever tried Macmira or box whiskey, Nick? No, I've not. Mel D, welcome to Lawyer Status. Lancelot 652. Richard has amazing charisma. I was hooked on everything he was talking about and could just listen to him talk about the industry. Jeff Exodus, I guess according to Dr. Spiegel, every trauma surgeon is an expert IPV expert as well. Oh, wait, I read some of these. Sergeant Schultz, numbers nerd, looks like an old Cameron from Ferris Bueller's. Hold on. Where the hell were we? I think we're here. Here we go. The scriptic. It now makes sense why Cross was lacking yesterday. They had Hollywood Marks and Super Nerd warming up in the bullpen, ready to hurl fireballs at Herd's experts. Yeah, I mean, some of the stuff, now that they don't get off that easy. There were some misses yesterday, for sure. But some of the stuff you don't want to ask the expert who's going to just disagree with you. You want to ask the expert who's going to agree with you that you're going to call later.
Yeah.
Yep. So yeah, Gary Herman, is Johnny's team going to recall Dr. Curry? She's on the list. Sean Vermillion says, "Rip Miss Arnold's career." Jeff Exodus, Christina Everhart of Iron Man was the comparable of Mira. They were in one first and second movie and did a spread on the lead character. Dean K, I wonder if she has more followers because of the see-through clothing. Well, Anna de Armas has eclipsed now Amber Heard in Instagram followers. And it's well deserved. Maria Espinoza, do you think Depp's team is bringing in experts to somewhat force Amber Heard's team to cross, thus eating up their little time left? I mean, yeah, I think the volume of rebuttal witnesses has something to do with the time limit. Because again, if the ideal situation would be to bring Johnny Depp as the final witness and not leave them with much, if any, time to cross-examine him. And then their redirect can be a couple minutes and Johnny Depp gets the final word, and that's great for everybody.
Yep. Make him beg for time. Boy, Elaine is trying so hard. I wonder what garbage is coming out of that mouth.
Yeah, there's the grounds for dismissal of this guy. I mean, I know they definitely want to, obviously, especially if he's going to testify that Amber Heard was the jealous one, because it'll be another instance of where she projected her behavior upon Johnny Depp, seemingly in like an Uno reverse card. But he didn't reach out to the lawyers. He doesn't seem interested in the case. He didn't respond to that umbrella man or whatever, the umbrella man.
God, whatever.
So it's, he didn't even reach out to the lawyers. Like he's this passive person who happened to be watching, and this is a public courtroom. And the crazy thing is the judge is talking about, well, the world is the courtroom. This guy talks about 5 weeks ago. That's at the minimum amount of engagement on this trial. It's before Johnny Depp takes a stand, I believe, at that time, or maybe he had just taken the stand
5 weeks ago. So this trial's lasted longer than CNN Plus.
Yes.
Rip.
And any individual stream has more viewers than CNN Plus had concurrent subscribers. So yeah. But yeah, what grounds do you come after this guy? Where's the prejudice? Where's the unfairness? Where's the bias? None of those seem to exist here. No undue influence from Camille, it appears. Soviet California, if Amber is bold enough, she could now try to sue Walden, regardless of the outcomes of the case. What are the intricacies of that being entered into this record? Oh, Adam Waldman, you're beyond the statute of limitations.
Right.
So no, she
based on
wouldn't.
weighing the factors, I'm going to allow Mr. Knight to testify. We could get Mr. Knight back in.
Yep.
And if I knew you were going to do a sidebar, I wouldn't have made him leave. I never know.
But the second she told him he could keep his water there, it was over.
Yeah. Yep. Oh, man, look at his demeanor. What a sad sack.
All right, are we ready for the jury? Okay.
John.
Thank you.
Will the trial end today? No. Friday is closing argument.
Not to beat around the bush or anything, but no.
No. We got a full week of Griffin. Come on, guys.
Yeah. I mean, Friday's closing arguments. They have enough people on their witness list that there's no way they're letting this thing go to, I mean, they're going to get through all of tomorrow for sure. Thursday may be a short day. We could see that. We could see a shorter Thursday, but
they could just have a trial by champions and have a sumo match right there in the middle of the courtroom.
I think
know
Elaine.
my
Elaine
two
would be the
contenders.
contestant.
Nah, I got to go with the girl in purple.
No, I think Elaine's fierce though.
Yeah, the other one has like mass though. And you're like,
If you put a box of Malbec behind the other sumo competitor, I think Elaine wins every time.
There's a backflip right over.
Yeah.
She could square off against Ludo from Labyrinth on Depp's team.
You're going to notice as we get closer to the end of the testimony, you're probably going to have some more interruptions, and I apologize for that, but there's just some matters we have to take up outside your presence, okay? All right, thank you. All right, your next witness. All right, Mr. Knight, if you could come forward to be sworn.
Do I have enough time to put my hands in my pockets?
Testify truthfully in this case.
That's the true Giga Chad move.
Sir, if you have a seat.
Let me take my mask off.
I've got one hand in my pocket and the other one is eating some tofu.
I'm sorry, I did the wrong way. Let me take my mask off.
He's drinking organic water.
Would you please state your full name for the record?
Morgan Higby Knight.
Mr. Knight, where are you from?
I live in Los Angeles, California.
And what do you do for a living?
So I currently own and run Hicksville Pines Bud and Breakfast in Idlewild, California. And I created and ran Hicksville Trailer Palace in Joshua Tree, California, starting in 2009.
And how is
someone from my neck of the woods?
Bud and Breakfast.
Hicksville Trailer Palace Fire Pit is just
So
my
Hicksville
hometown.
Pines Bud and Breakfast is up in the mountains of Idlewild, which is a beautiful like snow town above Palm Springs. And all the units are A-frames instead of trailers, which we have. It's obviously a very different climate than Joshua Tree, which is a desert area. The rooms, which are themed at both places, are trailers, vintage trailers from the 50s through the 70s at Hicksville Trailer Palace. So there's also different kind of amenities. There's a pool in Joshua Tree. There's a rec room up at Hicksville Pines.
When did you first become the owner of the Trailer Palace?
Trailer Palace, I started building it in 2009. It took about a year with my collaborator, Stephen Butcher, and on the trailers. And we got done and opened in 2010.
Did there come a time that you sold the Hicksville Trailer Palace?
Yeah, I did at the beginning of 2020. I had some health issues and just it was too much to run both at the same time. So I chose Idlewild because it was newer and shinier.
There's a Trailer Palace.
And just
looks
for
fun.
my sake.
Yeah, it does look
how long
fun.
did you
I
own
kind of
it?
want to hang out now.
So 10 years.
It does not look like
That's
the Trailer
opening,
Palace
11
in my
years total.
hometown.
And what was the Hicksville Trailer Palace?
So it started out as a artist retreat. I was a filmmaker at the time and wanted a place to get away and work on film projects outside of Los Angeles. I also put in a recording studio so musicians could record records there. I had lived in New Orleans for 5 years, and there's an amazing recording studio there called Kingsway, where all the musicians would come and they'd live in this big mansion and record their records. And I just thought that was a really neat thing for artists to be able to get away and create their create whatever they were working on. Over the course of the build out of all the trailers, themed trailers, which I'm a huge fan of this hotel called Madonna Inn. And so I wanted to do really detailed themed trailers. It became too expensive to just make a living off of an artist retreat. So I decided before I was done to make it a hotel as well.
And what were your job responsibilities, generally speaking, when you owned the Hicksville Trailer Palace?
So I would be live-in manager some nights, a couple nights a week. I would also drive out from Los Angeles twice a week and bring supplies that you can't get out in the Yucca Valley area and Joshua Tree. There's just a lot of things like, smart
Cocaine
and stuff. So I would drive that stuff out. There's also no USPS. So sometimes I'd have to get things shipped to my house and drive them out as well. I would also just do constantly building and creating new stuff at Trailer Palace, whether it's new trailers or amenities. So I would be working on that stuff as well. I'm a big fan of the fact that Disneyland is always making it better and better.
He's the Disneyland of Joshua.
Does that mean that you spend the night at the Hicksville Trailer Palace?
Yeah, we have a house on site where the recording studio was, and there's a bedroom in there. So whoever is live-in manager those nights stays in the house and basically lives there. There's a kitchen and everything.
Have you ever met the plaintiff in this case, Mr. Depp?
I had met him really briefly at the Viper Room in the late 90s. I worked with some of the people that performed there.
Elaine hadn't drawn that out.
This girl Robin from the Pussycat Dolls and some other friends in this band, The Imposters. So I was there and I met him once.
How about Miss Heard? Ever met her?
I had never met her before. They were guests at the hotel.
When was the first time that you met Mr. Depp and Miss Heard together?
In late May 2013, when they were guests, Mr. Depp's assistant Nathan had rented out the entire place so they could have a night there in privacy.
And what do you recall, if anything, about Mr. Depp and Miss Heard's arrival to the Hicksville Trailer Palace?
Mr. Depp got lost. His security guard who arrived early asked me if I could go fetch them because he had an old car that didn't really fare on the dirt roads out there, which are pretty horrible. So I went out and made sure that they got themselves and the car back to Hicksville safely.
Do you remember approximately at what time that was?
It was 3 to 4 in the afternoon.
What was Mr. Depp's demeanor when they first arrived?
At Trailer Palace, he was super excited about the place, really complimentary, just had a lot of questions and seemed like he was in a really great mood.
And how about Miss Heard's demeanor? Anything stick out?
She was pretty quiet. She just kind of didn't say that much when I was giving them the tour of the grounds and the trailer.
And was anyone else with Mr. Depp and Miss Heard when they first arrived?
There's people that are arriving throughout the afternoon. So there was, I think 10 to 12 people total ended up staying. The security guard had gotten there earlier and just to check out the place. But yeah.
And did I understand your testimony previously that the entire trailer park was rented out by Mr. Depp and Miss Heard?
Yeah, the whole place slept, I believe at the time, about 25 people, but there was only 10 to 12 in this party.
And who was part of that party besides Mr. Depp and Miss Heard?
I'm really horrible with names, but I remember one of them was Miss Heard's sister and the security guard I mentioned before, but I honestly forgot his name too.
What happened when Mr. Depp and Miss Heard first came onto the property?
So I gave them a tour of, we give all guests a tour of their specific trailer and the grounds and show them around the, when someone rents the whole place, they get another trailer called the bar trailer, which is basically a place to set up their alcohol and stuff. And some people in the group were just putting their beverages in that area.
And where were you when Mr. Depp and Miss Heard, did there come a time when Mr. Depp and Miss Heard went to the bar trailer?
I didn't notice most of the time that my interactions with them, everything's kind of centrally located. So there's a fire pit, bar trailer, and picnic tables all right in the same area. So they were generally around that area the entire evening that I saw them.
And what did you observe of Mr. Depp and Miss Heard as the evening progressed?
So Mr. Depp was super, just super curious and really nice. He was also really interested in my innkeeper because she was a musician. So they would talk about music a lot. At one point, the innkeeper who lived at the next door property went home and grabbed her guitar, and they had sung a song or two around the campfire in the early evening. There's another instance where Mr. Depp, the innkeeper, her name is Jenna, and myself were talking about books and music, and Ms. Heard came over and kind of interjected. She seemed a little annoyed that Mr. Depp wasn't spending time with her.
What about Ms. Heard's demeanor made you think that she was annoyed?
I think just generally she, it's hard. Like I think, I don't know. It was just like a gut reaction. Like I can't describe it, but you know.
How long were you with Mr. Depp and Ms. Heard that evening, generally?
So throughout the course of the evening, I was probably mostly with Mr. Depp, but 45 minutes to an hour total. So it was, that's over the whole course until the end of the night after the check-in.
Okay. And did you have an opportunity to observe Mr. Depp interact with other people, guests on the property that evening?
Yes, I saw him hanging out with a security guard at one point, and outside of the time that him and Jenna were singing around the campfire, he was off by himself a lot of the time, and Miss Heard was over at the campfire with her friends and seemed to have a good time.
And if you haven't already, can you generally describe for the jury your observations of Ms. Heard that evening?
Yeah, she seemed to be having a really nice time with her friends around the campfire. And
I think Legal Vice is
yeah,
passed
everyone
out.
was in a pretty
Did
good.
he? Oh, no.
Did there come a time in the evening that you observed Mr. Depp and Ms. Heard have a disagreement or an argument?
Yes. I was speaking with Mr. Depp, just one-on-one.
Paint a couple eyes on the top of his head.
And Ms. Heard came over and she said that I want to talk to you, and seemed really upset about something. So I went and back in the house because it was really, they went off on their own, and she started, honestly, it was really triggering because I've been in emotionally abusive relationship before.
Objections. Move to strike.
What's the objection?
You're up. May we approach?
Okay, sure.
They don't want him talking about being in an emotionally abusive relationship. I see.
Hey, Legal Vices, you there, buddy?
Yep, I'm here.
Oh, were you sleeping, or are you looking down at something?
I'm just looking down at something.
Oh, okay. I was like, I muted you because I thought you were passed out, and I was like, I don't want him to start like telling bedtime stories. Like,
Everyone here in the chat is about to have me take a train to Busan to save you.
Yeah, full of zombies.
Yeah, I like this objection. Objection. What's the objection? Not quite sure yet.
Mr. Knight, will you please just explain for us what you observed when you saw Mr. Depp and Ms. Heard having an argument?
Yes. So Ms. Heard asked him to go talk off to the side, and she was upset at him and she was yelling at him. And I personally had been in
Objection.
All right, I'll sustain the objection.
Okay.
If you could just explain to the jury what you observed when you saw Mr. Depp and Ms. Heard having an argument.
Okay.
Yeah, don't testify about your own victimization.
He was kind of cowering and seemed almost afraid, and it was really like odd to see because he was older than her, obviously. So, but I just went back in the house because I didn't want to.
Objection. To what he did.
All right, I'll sustain us too.
Understood. So after you observed the argument, fair to say you went back to to your house on site?
Yes, I did. Yeah.
What happened after that?
So when I saw Mr. Depp on my next rounds, he apologized profusely and said, "I'm really sorry about that." She was upset. because-
Objection, Your Honor, hearsay.
Sustained. Next question.
What, if any, type of reaction did Mr. Depp have?
He was just really
Objection, Your Honor, hearsay. He's going to say it again.
It's
No, he can describe the reaction.
a statement.
All right, if you could make that clear, that's
Yeah.
fine.
Just what type of physical reaction did Mr. Depp have after the argument between Mr. Depp and Ms. Heard?
What was your
he
impression about
honestly
his
throughout
state
the
of
rest of the
mind?
night became a lot more quiet and was just very more petulant. In the beginning of the night, he was a lot more outgoing and extroverted, and throughout, as the course of the night went on, he was less and less so and more quiet.
Did you observe any of the guests consuming alcohol while on the property?
I assume they were. I mean, people had cups and there was alcohol set up in the bar trailer, but I didn't physically see them pour alcohol into their cup and cup go into the mouth per se.
Did you witness Mr. Depp drink any alcohol that evening?
I couldn't say.
Anything about Mr. Depp's demeanor that made you think he was perhaps intoxicated?
Yes, as the night went on, I am a former bar owner, so even though I wasn't drinking that night, I'm very familiar with the signs. So just as the night went on, like I said, he became more and more quiet, but he also, as we would have conversations, his head would kind of sway a little bit back and forth, which was a little, he was much less sharp than he was earlier in
Be
the
right
night.
back.
Just like the chat thought
Ms.
I would.
Heard appear intoxicated to you?
She did. She seemed, I think when she was angry at him, it seemed like she was intoxicated, but that's just based on my experience and my own personal trauma dealing with abuse.
They snuck it in.
All right, I'll sustain the objection. We'll strike it from the record. Please disregard that testimony.
Unring that bell.
Sure they will.
Anyone
Uh-huh.
do take drugs?
I did not.
Did you witness Mr. Depp and Ms. Heard interact other than the argument that you previously described for the jury?
At the end of the night, I heard a commotion. I was inside the house and came out. I couldn't tell what was going on. And Mr. Depp and Ms. Heard were having a discussion about I'm not sure what, but then they went to their trailer. At that point, a lot of people had already gone to bed. So it just kind of petered out. Everyone went to bed, including myself, and I didn't hear anything else the rest of the night.
What time did the evening come to an end?
I'd say it was almost around 3 a.m.
Did you ever see Mr. Depp grab anyone?
Objection, leading.
Sustain.
Did you ever see Mr. Depp become physical with anyone?
Objection, leading.
Sustain. Next question.
Did you ever witness Mr. Depp get angry that evening?
Objection, leading.
Sustain.
What, if anything, happened the next morning?
What if anything?
Next morning, we were out at noon at the time before COVID. And so around 11 o'clock, one of my innkeepers let me know that there was some damage.
Objection, hearsay.
Did something happen that caused you to go to Mr. Depp and Ms. Heard's trailer?
Yes, I was informed that.
Objection, hearsay.
It's not being offered for the truth, Your Honor. I mean, may we approach on this one
Okay,
topic?
sure.
Thank you.
What if anything?
Yeah, Camille's gonna own her on this one.
No, I was just deep diving these places. It's kind of a nice little thing. I was just kind of looking at they have it's like about $160, $170 like 2-person Airstreams. It's got a little pool. Lana Del Rey apparently frequents the place. We've got surprisingly they have a cornhole game set up in the one corner of the place and shuffleboard.
So it's a luxury. So it's like glamping.
It's
Yeah,
glamping. Yeah.
Yeah.
The trailers are all tiny.
Yeah, they're very, very like 1-2-person little tiny things. They're like the
What
massive.
happened the next morning, Mr. Knight?
The innkeepers let me know that there was some damage in one of the trailers, and it happened to be Mr. Depp and Ms. Heard's trailer. So I wanted to inspect the trailer because I was extremely worried. All those trailers that Steve and I worked on were like my babies, and the one they were staying in was the only one that was mostly original and restored 1950s style, and so I was very concerned.
So what did you observe when you went to the trailer?
I observed that there was a light sconce by the bathroom in the bedroom that had been broken off the wall, and a couple pieces were on the floor, and they were, and yeah, it was basically just broken. The light fixture was hanging on the wall still, and except for the pieces that were on the floor.
Did you come to understand how that happened?
Objection, foundation, and
All right,
light.
foundation, also seen as the foundation, how you knew.
Did you ask how the sconce was broken?
Objection, hearsay.
Sustained.
It is a foundational question. Did you come to understand if the
How
sconce
often
is
do light
broken?
fixtures in the trailers break?
They break pretty often. I mean, it's not like a usual thing, but things in the trailers generally get broken because it's all vintage trailers. And I would say as much as every couple weeks, there's some incident of damage in one of the trailers. In this case, Mr. Depp had told me that.
Objection, hearsay.
Objection.
So anyway, yes.
Beyond the light fixture, was anything else in the trailer damaged?
No, everything else looks fine. In fact, we have something we call a piggy fee that we address to guests, that if there's anything what we call inconsiderate or unusually large messes, we charge them extra
Like
for
a turd.
$25 an hour cleaning fee, but they did not receive one of those because everything outside of the light fixture looks fine.
And what was your reaction to seeing the damaged light
Very
fixture?
violent encounter then.
To be honest, I was relieved because it was not a big deal. I just tucked, there was
Why
already
is she
light
smiling?
in the room. So I just tucked the wires in the wall until I had a few months later time to buy, it was matching sconce with another one in the room. So I had to, on eBay, find a matching pair that would fit there. And when I finally got around to it, I was able to get that and charge it to Nathan, whose credit card I had.
And what was your understanding of who Nathan was?
Mr. Depp's assistant.
Okay. And what did you charge Nathan or Mr. Depp for replacing that pair of light fixtures?
The pair came out to $62.
A literal nothing burger. 62 bucks?
While you were on site, Mr. Knight, did you ever wear a mesh shirt?
Of course he did.
At any time during Mr. Depp and Mr.
He said I would absolutely never wear that.
see Mr. Depp become physical with anyone?
Objection, leading.
Overruled.
I'm sorry, that answer was,
I never saw Mr. Depp get physical with anyone when I saw him.
thank you,
All
Your
right,
Honor. Nothing further.
cross-examination.
Thank you, Your Honor.
When I go
The
back
way-
to the States, I'm
The way they
still-
told
Knight,
that story
you are
initially,
a pretty big fan of Johnny
that was a
Depp,
big
aren't
deal.
you?
I am not. To be honest, throughout the evening,
Sorry, I just asked you one question.
Oh, I
didn't ask you
apologize.
the rest of that.
I
You
apologize.
wanted to participate in this trial, didn't you?
I did not. I
You
was
knew-
asked by the attorney, and I wanted to. They asked
Yeah,
me. And I said,
Elaine
"I'll
is
have to tell
pissed.
the truth."
You knew this was on camera, that it was being broadcast to a lot of people, and you saw testimony, did you not, in this case? And you
Treading a thin line
seized
here,
the moment
Elaine.
and responded to the umbrella guy, the lead person for Mr. Depp's Twitters. Did you not?
Wait,
Objection.
what?
Twitter? The
Argumentative
lead man?
question.
Overruled.
Facts not in evidence.
Mr. Umbrella Guy is the lead. The lead.
You
what?
know that he is
The lead what?
one of the most predominant pro-Depp Twitters out there.
I have no idea. I don't care or follow the Umbrella Guy.
In fact, you do follow
I follow the umbrella
Twitter
guy. How
called
cool
Johnny
am I?
Depp fan, don't you?
Absolutely not.
You don't? That's your
No.
testimony under oath?
It is my testimony under oath.
All right. And on April
Bad
21st,
question, Elaine.
testified in this case about Hicksville, didn't he?
I wasn't here.
And in fact, you tweeted in response to the umbrella guy on April 21, 22, quote, "That never happened. I was with them all night. Amber was the one acting all jealous and crazy." Do you
Yes,
recall writing that?
I do recall writing that.
Michelle, can you
Well,
bring that up, please? We're going to call it Defendants 1903.
Is it a reply to Tug or is it a reply to a retweet?
I reply to tweets all the time. I don't know who they're from.
Show his Twitter follows. You say he's
And
following
I'm gonna
Tug.
go ahead and ask you to redact, leave in the umbrella guy and the date and the bringing in the Hicksville. Your Honor, I'm sorry.
But redact everything harmful to our case.
Let me
let's
just tell you what we're redacting in front of the jury.
So it's about 200 miles southwest of Las Vegas, and I'm going to be in Vegas at the end of July. So I'm seriously going to try to carve out a night just to go here.
Oh, is it?
I'll bring-
I'll be in Vegas next month. Maybe I'll try to swing by.
While she's working on that, did you write and direct a piece called Matters of Consequence back in 1999?
What?
I did.
Digging deep.
Didn't Mr. Depp's first wife,
Relevant.
Lorianne Allison, work as a makeup artist on that?
She absolutely did.
That's 6 degrees of separation.
And while
Isn't
we're
that 5 wives ago?
that, 4 days after you tweeted to Umbrella Man,
Where's
That
all
was
this on your
umbrella guy.
Owned.
We have this up. I'm going to ask you to take a look. What is Defendant's Exhibit 1903? Do you see that?
I
Where
do.
was all this on
Okay,
voir dire?
And that's from that umbrella guy on 4/21/22, correct?
Correct.
And it says bringing in the Hicksville incident accusations. Do you see that?
I do.
And there's clearly Mr. Depp testifying there, likely a video, right?
Okay.
And you respond, "That never happened. I was with them all night. Amber was the one acting all jealous and crazy." Do you see that?
I do.
Your Honor, I'm going to move the admission of Defendants 1903.
Any
Uh,
objection?
Did Elaine just 4D
Yeah, Your
chess
Honor,
herself into
We
admitting
believe
that
the first
testimony?
part of the that umbrella guy's tweet
Yeah.
should
Doctrine of
be
completeness.
unredacted for
Read-
context.
Oh,
She has owned herself.
Uh,
Yep.
No idea what
It's hearsay. It's rank hearsay.
Nope.
Your Honor, not
Nope.
necessary.
You're gonna approach.
She opened the door.
If it's hearsay,
Yeah.
how are you introducing it, you dummy?
You just played yourself.
Oh,
First of all, she just walked herself into this guy saying it wasn't Johnny, it was Amber Heard the entire time.
She had him confirm his own hearsay.
it's a trap.
Did he make that admission on testimony on direct that it was Amber Heard being was that while I was gone? Did I miss that?
That she was being the jealous aggressor.
Yeah,
or
he
whatever
said
it
that
was.
when Camille was on direct. Yep.
Oh, okay. I didn't hear that. I think I was upstairs.
Oh, she's marching. She's upset.
Yeah.
With that redaction, any objection?
No, Your Honor, thank you.
Okay, 1903 will be in evidence with as redacted.
Oh,
Well, might
as
be a different
redacted.
redaction. Yeah.
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 So they included the first part of Tug's tweet, apparently. Quick reply to the tweet, get your name in.
Now, so you reached out to the umbrella guy in this
Reached out
text,
to.
this Twitter, right?
No.
I wouldn't call it reaching out.
And in fact, the umbrella guy is in Mr. Adam Waldman. Do you know who Adam Waldman is?
I have no idea.
Well, he's testified earlier that he talks to the umbrella guy.
That he what? He talks to the umbrella guy?
Yeah. Were you aware of that?
I honestly, this sounds like schizophrenia.
This. Exactly, you tested, Your Honor. Yeah, it's in. Okay, good. 4 days after that, you tweeted something pretty nasty about Elon Musk, didn't you?
So
did.
what is that?
Yes.
How is that relevant?
Thank you. So
I
you don't like
did.
Elon Musk, right?
Objection,
Well-
relevance.
Oh,
I don't
I
think
know.
he's trying to steal Amber away
So
from
that
Elon.
was the context of that is that he
I
had,
didn't ask you for the context.
I apologize.
Okay. But you texted something that had swear words in it. Would you agree
Oh my God.
about Elon Musk?
Swear words.
Yes.
Okay. Now let's talk about your
Under the doctrine of completeness, what's his tweet about Elon
recollections
Musk?
here. 45 minutes to an hour. Your recollection is that Mr. Depp actually drove there?
Yes.
What type of car was he driving?
An old one that was a convertible.
An old convertible?
I'm not a car guy, so I couldn't express the model.
All right. And your recollection was this was May of 2013?
Yes.
Okay. Do you recall when in May?
Late May.
Okay. Now, you said that you spent a total of 45 minutes to an hour with Mr. Depp and Ms. Heard. Is that correct?
After mostly Mr. Depp, but that's after the tour and after they were checked in throughout the course of the night.
Okay. And you don't recall any of the people that were there other than Ms. Heard's sister and the security guard, correct?
I don't recall any of their names.
Do you remember how many of them were female?
I believe it was predominantly female.
Do you remember how many males were there?
I don't, outside of the security guard.
Do you remember what any of the other people looked like?
They honestly just seemed like youngish hipsters, like for lack of a better term. I know that previously a couple of them had stayed at Hicksville Trailer Palace. That's how they knew about the place.
Okay. So you don't recall seeing how much anybody had to drink that night, correct?
I did not witness that.
And do you recall the use of drugs at all?
I did not witness that.
Okay. Were you sitting at any point with these people at the campfire?
I was not.
And when you said that that you saw Ms. Heard and Mr. Depp and
Look at that
Ms.
face.
Heard was yelling at Mr. Depp, where were they?
She pulled him for a chat, and it was off towards their trailer, like a little bit off towards the dirt.
How many feet were there between the campfire?
Like the insurance
and
person trying to decide if your kid's going to get that chemo.
Campfire in their trailer?
Yes.
Approximately 75.
Okay. So where in that 75 feet did Ms. Heard pull Mr. Depp and yell at him and he cowered?
20.
Okay. 20
From the campfire.
From
not
the
trailer.
campfire.
Yeah.
So your testimony is that Ms. Heard grabbed Mr. Heard, pulled him 20 feet over, yelled at him and he cowered.
Yes, that's what I witnessed.
And then did they go back?
I went inside the house.
So you don't know whether they returned to the campfire or they returned to their trailer?
I do not.
Okay. And do you know whether there were any disagreements or physical communications?
I wonder if this guy's story is going to appear in Depp's closing.
I do not.
Do you know whether Mr. Depp did anything to anybody else at the campfire?
I didn't see anything.
Okay. Do you know whether Mr. Depp grabbed anybody's wrist and asked them if they knew how many pounds of pressure it took to break their wrists?
I wasn't there the whole time.
Okay. Is it your testimony that Mr. Depp and Ms. Heard went last to their trailer? Everybody else went before them?
The rest of the people, I think about half of them had already gone to bed, and it was all around the same time at the end of the night that the rest kind of scattered. There might have been a couple of people that went right after them or right before, but it was all around the same time.
Okay, so your recollection is that when Amber and Johnny Depp went back to their trailer, that dissipated. Everybody then left at that point.
Yes.
Okay. Now, how far away was your house that you were staying in from the trailer that Amber and Johnny Depp were staying in?
I'd say it was about 75 feet away.
Okay. And the next time that you saw or heard anything was when you went there in the morning and saw the broken sconce. Is that
Yes,
correct?
I didn't hear anything after went to bed.
Okay. And that's the extent of your knowledge.
Yes.
Okay. I have no further questions.
All right, redirect.
Elon Musk tweet.
Mr.
Do
Knight,
it.
how did you get involved in this trial?
I got a text from one of our old employees who I didn't talk to for
Objection,
years.
hearsay.
No, it's not.
Don't tell us what the text said. Just how did you
Okay.
get involved?
I got a text from. I got a.
That's still hearsay. You're under objection.
Overruled.
Thank you.
Overruled.
I was asked if it was.
No.
Objection, hearsay.
Apologize.
What did you?
I got a
What
text.
did you receive a text? Okay.
Yes.
From
and
whom?
From a former employee.
And how long had it been since you had heard from this former employee?
Approximately 5 years.
And did you contact Mr. Depp or any of his attorneys?
Objection, leading.
Overruled.
That's not a leading
I did
question.
not.
How did you get in touch with Mr. Depp's attorneys?
They got in touch with me.
Objection, hearsay.
Overruled.
Go on, Mr. Knight.
They reached out to me.
Okay, sorry. Objection right now.
Thank
you. Only if he talks more.
It's like Camille is this is your lawyer and Elaine's this,
How do you
this
feel
is your
about
lawyer on
those things?
toxoplasmosis.
Objection, relevance.
Extremely relevant considering that they have accused him of being.
Overruled.
Thank you.
Yeah.
How do I feel about it?
Yeah.
I'm happy to tell what I saw, and that's the extent of it. I really don't care outside of that.
Thank you very much, Mr. Knight. Nothing
All
further.
right. I assume this witness is not subject to recall. Is that correct? All right. Sir, you're free to go. Thank you.
Thank you.
All right. Your
Wow.
next witness. Or is it gonna be a
Powerful
deposition?
surprise witness for Depp.
Apologies, Your Honor. Thank you. Dr. Shaw.
Okay,
Plaintiff
Dr.
calls
Shaw.
Dr. Shaw.
Okay. Dr. Shaw.
You think so? Or are you being sarcastic?
You asking me?
Yeah.
Oh, I thought it was good for Depp.
Okay. I was like, I thought he was fine. Why are you saying terrible? Am I?
Oh, did I say
No, it's-
terrible?
Yeah, you said terrible surprise witness for Depp. I was very confused.
Oh, sorry. If I said terrible, I misspoke or meant terrible for the for Heard's team. No, that was a good witness for Depp.
Yeah. I thought so too. Who's this guy?
Thank you, sir.
Dr. Shaw.
All right. Yes, ma'am.
Good afternoon, Dr. Shaw. Can you please state your name for the record?
My name is Richard John Shaw.
Dr. Shaw, can you please describe your educational background?
I'm a psychiatrist. I went to medical school at the University of London in England. I went straight after high school. That's actually the system in the British medical system. I did 2 years of preclinical training and then 3 years of clinical work with patients. Following that, I moved to New Zealand to do an internship. It was an internship in neurology, medicine, surgery, and psychiatry. I spent 3 years in New Zealand and I did a year of psychiatry residency training. Excuse me. And
Like the British doctor version of the trailer guy.
following that, excuse me. Following that, I moved here to the United States for the first time and did a residency in adult psychiatry at the Albert Einstein College of Medicine, which is in New York.
Isn't it
was
true that you
4
have
years of
tuberculosis?
training in the Bronx. And I also did some subspecialty training in family therapy, couples and family therapy as in my 4th year. And after that, I moved to California, and I've worked at Stanford. I studied at Stanford. I did a fellowship in child and adolescent psychiatry, and I've been at Stanford pretty much since then.
Dr. Shaw, what is your current position?
I'm a professor of psychiatry in the Department of Psychiatry at Stanford.
I'm a destroyer of
I also,
expert witnesses.
Run what's called the Psychiatry Consult Service at the Children's Hospital at Stanford.
What, if any, professional certifications have you received?
I have what's called board certification in adults and general psychiatry. I obtained that from the American Board of Psychiatry and Neurology in 1991. And then I obtained subspecialty board certification in child and adolescent psychiatry in 1993.
Are you a member of any professional organizations in the field of psychiatry?
Yes, I am. I'm a
Do you
member
follow
of
that
the
umbrella guy on
American
Twitter?
Academy of Child and Adolescent Psychiatry. I'm also a member of the Academy of Consultation Liaison Psychiatry.
How long have you been practicing psychiatry?
If you include my training in psychiatry residency in the US, that would be since 1985.
Is that approximately 35 years?
Yeah, I think so.
What percentage of your practice involves treating patients?
Yeah, approximately 3/4 of my time is working with patients. I work in the pediatric hospital, treating a combination of mainly children and adolescents with severe medical conditions, but also working with parents of children who have severe medical conditions. I also consult to the pediatric emergency room, and we evaluate patients who show up with suicide attempts and other serious situations.
What does the remaining quarter of your practice entail?
Well, as a professor, I have to do a number of academic activities. So I do research, I do a lot of teaching, I give lectures, I supervise residents, medical students, and fellows in psychiatry. I do some administrative work. Yeah, so it's a pretty diverse, varied day and week.
Can you tell the jury a little bit about your research and academic work?
Yeah, a lot of my research has involved looking at the issue of trauma and PTSD in parents who have medically fragile children. A lot of these parents are naturally really affected by their child's illness and develop trauma symptoms. So I've developed some interventions to try to help parents, provide support and treatment to reduce their symptoms of trauma.
Have you published articles or books in your area of expertise?
Yes, I have. I've published approximately 70 or probably closer to 80 peer-reviewed manuscripts in different scientific journals. I've also published a number of book chapters on various topics, approximately 30. And I have published 3 textbooks, one of which has gone into a second edition on topics that are related to my area of expertise. And one of them actually is about the treatment of PTSD in parents of premature infants.
And one of them is a cookbook of children.
Have you published a book through the APA?
Actually, all of those books were published through the APA, the American Psychiatric Association. They have a publishing house, and that's been my publishing company.
What is the APA?
The APA, the American Psychiatric Association, not to be confused
It's
with
4:30 a.m. here. I need to get at least 2 hours of sleep before I have to go to work.
Professional organization that represents
See ya.
psychiatrists
We'll see y'all
in the
soon.
US.
Thanks a
Take
lot.
care.
The last time I looked at this, I think there's about 37 or 38,000.
And we'll hear more about the Goldwater rule.
The APA has many different roles. One of it is advocacy in psychiatry in the US, but it also has an important role in terms of education. So they host an annual scientific meeting every year in which psychiatrists will present their research. It publishes a number of journals in the field, and from time, fairly frequently, it publishes guidelines for professional practice or about ethical guidelines that they hope that members will follow as part of their practice.
What ways are you involved with the APA?
Well, I mentioned my publishing. I also present at the scientific meetings. I last
Hey,
presented
Francois, this is a commentary
in
channel. Don't tell us to shut up. I'll tell you to
during
shut
COVID,
up.
was
Fuck off.
virtually, but on the topic of group therapy for parents with trauma symptoms. I follow the APA and their various guidelines. I think it's a really influential and important institution.
Going back to your credentials, what, if any, professional awards have you received?
I've been given several teaching awards at Stanford University, and the American Academy of Child and Adolescent Psychiatry that I mentioned honored me with an award for service to my specialty several years ago. I don't remember exactly when.
Have you given any public presentations in the field of psychiatry?
Yes, that's part of our work as an academic psychiatrist, is to lecture, to give presentations. So I present fairly frequently at annual scientific meetings, as I mentioned. I've been invited to give grand round presentations at different medical centers, including University of Pennsylvania and Harvard. So that's just part of I think our role is to try to educate our colleagues about our work.
Have you testified as an expert in the field of psychiatry before?
Yes, I have.
On how many occasions?
I would estimate, in terms of deposition and trial testimony, approximately 50 times in the past 15, 20 years.
What type of cases did you testify as an expert in?
They're pretty varied. So some of them have been medical malpractice. I've also done
Curious why he's
a number
here.
of cases evaluating victims who've been subject to physical or sexual assault or trauma.
What work were you asked to do in this case?
My role in this case was to give my opinions about the
Could it be to rebut all those indications of abuse victim that the Heard psychiatrist starts talking about, and basically saying,
And
well,
what
all
were
those
the
symptoms are in
judges in your
depth?
opinion?
I was present yesterday in court listening to his testimony. I have viewed his depositions. He had 2 depositions earlier this year, and I watched those depositions. I've also read a lot of deposition testimony. For example, testimony by Mr. Depp's psychiatrist, Dr. Blaustein, by his physician, Dr. Kipper.
Yeah, he's just here to evaluate
Davey
the other
Lloyd.
side.
I've reviewed depositions by many of the therapists involved in this case, including Dr. Banks, the relationship consultant, Dr. Cohen, who was Ms. Heard's therapist, and I think Dr. Anderson, who I think provided some couples therapy. I've also reviewed the medical records of Dr. Kipper and Dr. Blaustein, and some various email communications. I think a lot of the information that has been talked about here.
Thank you. Your Honor, at this time, we'd like to offer Dr. Shaw as an expert in the field of psychiatry.
Any objection?
Okay. He's a child psychiatrist. It's his specialty, so he doesn't know anything about adults.
Well, he said he was providing therapy to parents of sick children who were traumatized by their child's illness.
Yeah, that's true. I mean, frankly, like, you're not going to disqualify this guy as a witness, but I think you can ask him some interesting questions if you want to waste a bunch of time. You know, how much of your practice, like what actual number of parents are you treating? Do you treat, how does that interact with intimate partner violence, as opposed to, are there differences between intimate partner violence? Or maybe you would ask, intimate partner violence isn't the same as child abuse from a parent, or trauma of a sick child, like the different indicators for post-traumatic stress. I don't know. I feel like there are questions you could ask to raise some issues here. And to me as a juror, I don't know that they're actually thinking this, but to me as a juror, I immediately want to know why they've got a guy who predominantly specializes in child psychology on to talk about Johnny Depp. Like that's one of my opening questions. Like, well, in the world of experts, you can
So
call
any objection?
No objection, Your Honor.
All right, so
anybody else.
He'll be moved as an expert. Thank you.
Dr. Shaw, you testified that you observed Dr. Spiegel's testimony yesterday.
Yes, that's correct.
What'd you think of it?
And to reorient the jury, can you please generally describe the main areas in which Dr. Spiegel testified?
Yes, he.
Objection, Your Honor. They heard what he testified to. What's his opinion?
All right.
about?
Foundation to reorient them.
That's okay. We can move on.
Okay. Do you have an opinion of Dr. Spiegel's testimony?
Yes, I do.
And what is your opinion?
I have a couple of primary opinions. The first is that my opinion is that he violated the ethical principles that are outlined in the Goldwater Rule when he gave his opinions about.
I guessed it.
Yeah, specifically with relationship to personality traits and his cognitive abilities. My second primary opinion would be that that Dr. Spiegel's opinions were unreliable and that he had insufficient information.
Objection, Your Honor.
All right. You're going to approach?
Yeah.
Man, that came, he just came in hot, right? Yeah, he violated his ethical rules and his opinions are unreliable. Oh, that's nasty. That's exactly what you don't want to hear about your expert witness.
And may God have mercy on his soul.
So to people who are talking to me in chat about what I was saying about this guy, again, I said you're not going to disqualify him as an expert. But if you wanted to spend some time on voir dire to raise questions for the jury about why he's here, ask some questions. Try to raise some doubt. Now, the first impression that these guys get is this guy's CV and then him saying this other guy's testimony is unreliable and he violated his ethical obligations. Maybe, strategy question here. Do you want to try and raise a specter of doubt as to why he's the guy who's on the stand before that? Maybe not. Maybe they don't have time. Maybe they think they'll get him on cross. But the first testimony elicited that's not about this guy's rather immaculate qualifications that they left unchallenged is that, yeah, the other guy's testimony is unreliable and he's unethical. I mean, shit, it's a bad start. They could just say no further questions and leave it if they really wanted to. I mean, obviously they're going to want him to tell the jury why it was unethical, why his opinions are unreliable. But oof. When Amber's side cross-examines, it counts against Amber's time. I don't have a time counter for today. I don't know. We actually had some pretty significant pauses in the time or well, I should say neutral time. The, the argument for the motion to dismiss took up a good amount of time. There's the voir dire. I think those things might have been neutral on time. Not quite sure how the judge is counting those. So it's hard to even get an estimate as to what each party's timeline is. But Hurd's team came into this with 4 hours and 9 minutes. So I'm sure they've burned at least, I would say at least 2 hours of that today, but I don't know. But yeah, I mean, professor of psychology at Stanford. Did he say he was like a higher level, like a supervisory professor too, of some sort?
I didn't catch that. Albert Einstein School of Medicine. Went to medical school right out of high school.
Yeah. Went to New Zealand, trained there, came back to the US, did all the licensing shit here.
Doesn't come across like Doc Brown.
Yeah, wrote 3 full textbooks, over 30 chapters, contributed to other textbooks, and some ludicrous amount of publications of peer-reviewed manuscripts. Was like 70 or something. That's a lot of writing. And I have a feeling this guy could actually recite them, whereas the other guy, I'm not sure he could recite his address. So, okay, let me hit some of these super chats. HB, how does performing as badly as Amber's team have in such a high-profile case affect the lawyer's career? Their final witnesses were a fangirl for damages and a clinically insane Dr. Doofenshmirtz cosplayer. Well, I mean, this is one of the most televised trials in most people watching's lifetime. If you were around for OJ, that was probably comparable. But outside of that, I mean, legitimately, and this is a million people minimum watching just on YouTube every single day. Once about 2 weeks of the trial had gone by. And that's crazy to think about how many eyes are on them. So would you hire Amber Heard's team or anyone on it? That's the question. Maybe Rottenborn. I wouldn't hire Elaine. I don't know that I'd hire Shaky Voice Guy, who's done a couple crosses today. I'm not impressed with him at all.
Dr. Shaw, you mentioned the Goldwater rule. What led up to the publication of the Goldwater rule?
The Goldwater rule came about in response to an incident that occurred during the 1964 presidential election when Senator Barry Goldwater was running as a Republican candidate. And there was a magazine called Fact Magazine that started a campaign to discredit Senator Goldwater. And they obtained a mailing list from the AMA and sent out a single survey questionnaire to about 12,000 psychiatrists in the US, asking if they felt that Senator Goldwater was fit to run for office. And about 2,000 psychiatrists responded, 1,000 of whom expressed very negative opinions about Senator Goldwater and made comments such as, for example, he was a megalomaniac, he was a paranoid schizophrenic, that he had narcissistic personality disorder. And as a result of that, he was replaced as a candidate and then went on to sue Fact Magazine for defamation of character. And he was successful in that lawsuit. And in response to this incident, the American Psychiatric Association, that I think was really concerned about how psychiatry was being represented and statements psychiatrists were making about someone they had never met or evaluated, issued the Goldwater rule. And the main premise of the Goldwater rule was that it was improper for a psychiatrist to render a professional opinion about a public figure unless they had personally and closely evaluated them.
What justifications did the APA provide, other than the ones you mentioned, for enacting the Goldwater rule?
They wanted to make sure that psychiatric illness wasn't being stigmatized. They wanted to ensure that individuals weren't defamed by statements made by a psychiatrist that weren't backed up by medical evidence. And they also wanted to preserve the integrity of the psychiatric profession, since I think the public in general, when a psychiatrist speaks out publicly and expresses an opinion, a psychiatric opinion, people generally like to take that seriously. And the APA wanted to make sure that those opinions were credible and could be relied upon.
Have there been any updates to the Goldwater rule?
Yeah, since 1973, which is when the Goldwater rule first came out, there have been a number of revisions and publications by the APA. They're called annotations in psychiatry, in which the Goldwater rule has been better defined and expanded to some degree. So, for example, in 2017, in this publication, the APA reasserted that it was not ethical to provide a psychiatric or professional opinion about someone who had not been evaluated personally by that psychiatrist, that it was unethical to provide an evaluation without obtaining consent from that individual. They also sort of really kind of defined what a professional opinion is. And and how they defined it is that an opinion that a psychiatrist expresses about someone's speech, behavior, or any characteristic about that person, if that opinion is made using the expertise, experience, and knowledge inherent in the practice of psychiatry, that is considered a professional opinion. So it might include making a diagnosis or not making a diagnosis. And the other, I think, a couple of important things about that 2017 document were that the APA specified that if a psychiatrist is to give an opinion about someone, about the diagnosis or personality characteristics, whatever, that they have to follow an appropriate methodology. They have to do an evaluation that follows the standard practice of a psychiatrist here in the US. And if they don't do that, they are considered to be, affecting the integrity of both the psychiatrist and the psychiatric profession. And this revision of the Goldwater rule definitely received a lot of support. The president of the APA at the time stated that breaking the Goldwater rule was irresponsible, stigmatizing, and definitely unethical. So that was a very strong statement from the president of the APA.
What other medical organizations have weighed in on this issue?
Yeah, the number of organizations have their own sort of version of the Goldwater rule. The American Medical Association, that represents physicians in the US, has an annual meeting, and they have what's called a Council of Ethical and Judicial Affairs, and they had a meeting in 2017 in Honolulu, and they came up with their own statement about the issue of whether physicians can provide opinions without directly evaluating somebody.
Doctors would have their meeting in
opinion was that
Honolulu, wouldn't they?
physicians should refrain from giving a psychiatric diagnosis about any public figure, including celebrities and people in the media.
Are there exceptions to the Goldwater rule?
There are exceptions, yeah. And I think Dr. Spiegel had a lot to say about this yesterday when he was saying that if you couldn't express an opinion without evaluating someone, it sort of made the whole specialty or role of experts in the court sort of null and void. But there are exceptions in situations in which an expert can give testimony in court. So one good example would be if there was a medical malpractice case, or if there was a case that involved a patient who'd committed suicide and the courts wanted to find out whether the psychiatrist had followed appropriate practice, the expert can review medical records and can give an opinion based on those records, provided those records have sufficient information, for example, about the diagnoses, about the treatment, about how the patient was responding or not responding to treatment.
Did you form an opinion about whether Dr. Spiegel complied with the Goldwater rule?
Well, my opinion is that he did not. He expressed a number of professional opinions about Mr. Depp that we heard about yesterday. And again, he did so without an evaluation, without consent. He did not follow the guidelines of the APA in the 2017 revision, where it was considered important that there be sufficient information obtained by that expert to give an opinion. So I would definitely felt that his conduct, unfortunately, did violate the Goldwater rule.
And specifically, what opinions of that Dr. Spiegel gave yesterday do you feel violated the Goldwater rule?
Yeah, I think that, well, there were sort of two primary ones. The first that you heard about was that Dr. Spiegel had professional opinions about Mr. Depp's personality. And he talked a lot about how he believed that Mr. Depp had narcissistic personality traits. So, and he also, talked a lot about narcissistic personality disorder. So narcissistic personality disorder is a diagnosis in the Diagnostic and Statistical Manual. It's called the DSM-5 for short. It's a diagnostic manual published by the APA.
Objection, Your Honor.
Okay.
They're going to object to the DSM?
I mean, aside from narration and not having a recent question, what's the objection that you need to approach? You just say, objection, can we get a question? What's the DSM is the question. So, yeah, this guy, look at him. Look at that look on his face. That's a cobra who's spotted a mouse. Why is it every time they show the gallery, someone is getting up and walking around? Every single time someone is up, walking around, leaving their seat, coming back in. But yeah, this guy's here. He's here to lay down devastation on the testimony from yesterday. That's his whole purpose. He's already eviscerated it. He comes across as eminently credible. I mean, what's the argument against this guy at this point?
Go ahead, Dr. Shaw, please continue.
Sure. So I was just talking about narcissistic personality disorder in the DSM-5. So the diagnostic criteria for that are, I'm not going to remember every word about this, but essentially it's a pattern of grandiosity, a need for admiration, a lack of empathy that's demonstrated by that person since young adulthood. And the DSM-5 has 9 specific criteria. And for someone to meet the diagnosis, you have to meet 5 of those criteria. And so when, as a psychiatrist, we're trying to make a diagnosis of any personality disorder or any diagnosis in general, the normal professional guidelines would dictate that we would do a very careful diagnostic interview. And there are actually interviews specifically written to assess personality disorders. It's also possible to have the individual fill out questionnaires. There's something called the Narcissistic Personality Inventory. This is a 40-item checklist that taps into various components of narcissistic personality disorder. And it's also possible to get psychological testing, like the MMPI that I think you heard about in reference to one of the other experts here. So with all of this information, including collateral information from family members, work colleagues, information of that sort, it is possible to come up with a diagnosis of narcissistic personality disorder. So in the case of Dr. Spiegel, he had none of this information, even though he came out and stated with what he described as a degree of medical certainty that Mr. Depp had narcissistic personality traits. And if you remember somewhat towards the end of his testimony yesterday, he was asked to, since he couldn't provide any documentation from the medical record about narcissistic personality disorder or narcissistic personality traits, he was asked about what is referred to a lot in his testimony as record evidence. So information that he obtained from depositions.
Yeah, that was Elaine.
From text messages.
It's record evidence, Your Honor.
Emails, whatever. And so he was asked to give, I think, 5 examples of record evidence that would make it seem like Mr. Depp met criteria for narcissistic personality traits.
Make it seem like was
and I'll just mention a
well-worded.
couple of them.
I think Elaine did all 9.
My opinion is that testimony did not really hold together. So he stated, for example, that one of the criteria for narcissism is narcissistic personality disorder is a sense of entitlement. And the example Dr. Spiegel gave is that he believed that Miss Heard married him for his money. So clearly, sense of entitlement is from a psychiatry perspective, that's very different from a belief that someone wanted you for your money. A second example that was given was that he was asked to give an example of how Mr. Depp had shown that he was envious of others, which is another criterion for narcissistic personality disorder. And the example that Dr. Spiegel gave is that Mr. Depp was jealous of Miss Heard because he believed she was having an affair with Mr. Franco. Now, if we look at these two terms as a psychiatrist, there's a big difference between being envious and being jealous. As a psychiatrist, when I think about envy, I think about somebody wants something that someone else has, and it makes them feel bad.
I think this is going beyond his
All right. He's giving his opinion as to how Dr. Spiegel violated the Goldwater rule with respect to his testimony about narcissistic personality traits.
He did, but now sustain the objection. Next question.
Okay. Okay, and you mentioned two major examples. What was the second one?
The second one was confusing being envious with being jealous.
Oh, sorry, Dr. Shaw. I mean, you mentioned two major examples of ways Dr. Spiegel violated the Goldwater rule. What is the second?
Oh, sure. So the other big category had to do with Dr. Spiegel's evaluation of Mr. Depp's cognitive abilities. And his general opinion was that Mr. Depp had
It's a Captain Sparrow baseline.
deficits in his memory, in his attention, in his processing speed, that he had word finding difficulties. Again, Dr. Spiegel did not evaluate Mr. Depp, and the information that he relied upon, there were two pieces of information. The first was that he watched a very long deposition that Mr. Depp gave the day after I think he had flown back from London to the East Coast. And he made observations about Mr. Depp's behavior in that deposition, and felt that he could opine or give an opinion about processing speed and other cognitive aspects. He also made reference to something you heard about yesterday, this thing called the mini mental status examination. This is a brief screen for memory and cognitive functioning that is often done. And he testified that Dr. Blaustein had administered the mini mental status examination. And although, from the records, all we know is that—
Objection, Your Honor.
Sustain the objection.
Dr. Shaw, without going into Dr. Blaustein's record, what information does a mini mental exam provide?
Objection, Your Honor. It's beyond the scope of his designation.
Overruled as to that limited question.
Yeah, so the mini mental status is it's a
Wonder why he's not allowed to go into Blaustein's stuff. The other guy did.
Questions and tasks that someone completes, and you get a score out of 30. What Dr. Spiegel testified was that Mr. Depp could not recall 3 words after 5 minutes. And he used that as an example of Mr. Depp having cognitive deficits that he specifically attributed to Mr. Depp's alcohol and substance abuse. And he really did not have sufficient information. I liken a mini mental status exam it's like taking someone's temperature. If it's elevated—
Objection, Your Honor, and I think it's going beyond.
No, I'll sustain the objection.
Okay. Now it's probably a good time for a break.
Okay, sure. All right, ladies and gentlemen, I know you had a break, but we didn't. So we're going to go ahead and take our afternoon break for 15 minutes. Do not discuss the case and do not do any outside research, okay? You can stay right there, Doctor.
You can tell how scared they are of this guy. I mean, if he goes anywhere beyond what they think the line is, and I'm not quite clear on where the line is drawn or why it's drawn there. If the other doctor relied on Blaustein's reports, as he testified that he did, this guy should be able to similarly
Your excuse
rebut
was 15 minutes too, sir.
on
Doctor. Okay, we'll come back
Blaustein's
at
reports.
4:17 then, finish the day? Okay.
So I just wish I knew what his line was, but that was resolved at sidebar. But this guy, this is kind of the difference that we were talking about, and I talked about a little bit last night when I kind of ranted. Some people were saying we were being too mean to the doctor, and without them opening their mouths, which doctor do you prefer? This guy who looks put together, or the other guy whose hair's sticking up off the side of his head? Like, it just from looks alone, this guy's got nice posture. He's ramrod straight sitting in that chair. I don't think his back has ever made contact with a chair back before. And he comes in and he sits down. His presentation is clean, careful, collected. He's not getting angry. I mean, he hasn't been crossed yet. Maybe he'll get snippy on cross. I highly doubt it.
And he doesn't make those bizarre facial gestures that suggest he himself is a psychiatric patient.
Right. Yeah. It's so what's going to happen when they cross-examine this guy? It seems like he'll very politely answer every single question thoroughly within the scope of his expertise. I mean, that's what it seems like is going to happen. And that's just the surface level difference between them. So when this guy sits down and says, "Oh yeah, this guy's testimony is completely incredible, completely just not good," and he violated an ethical rule in doing so. He had no basis for any of these for any of these conclusions. He didn't draw them based off of conversations. He didn't do it with consent. I mean, it just sounds devastating to me. You got to wonder, is the jury paying attention? And I would think they probably are at this point, but who knows? But yeah, well, I mean, we'll see where they go. I don't know what they're going to do on cross to try and recover from this, but it's going to be messy for them. Mark 36 NGNT, we should all drink more beer. Maybe. BN says, I think he's going to highlight Johnny's childhood background of trauma, and if he seems like an abuser from that. I was kind of wondering if he was going to go that way, but it seems like, though his specialty is that he's chosen are in childcare, he is just a general psychiatry professor with some severe chops and lots of experience. So he's just going to, right now he's talking about the Goldwater rule and violating it. And frankly, any psychologist or psychiatrist should be able to do that, right? That who's a practicing licensed psychiatrist with the APA should be able to opine on the rule and talk about it. And then it becomes a credibility question within the scope of the two competing experts. But this guy comes across eminently more credible to me. I don't know. Am I crazy?
It's certainly my sense.
Carrie Pellicer. Most psychiatrists that treat drug and alcohol abusers have degrees in cold psychology. FYI, your personality is fully formed by the age of 7. You just don't really understand the psychology of drugs and alcohol. Well, I do, and did at 7. Jackson Kai, I grew up on MDMA. No, I'm just kidding. Jackson Kai, I feel like Dr. Victor von Frankenstein from yesterday is actually this guy's evil twin pretending to be a psychologist, and this guy has to keep begrudgingly telling people he's not actually an expert. Well, it's like that David Cronenberg film. What was it called? Where the two identical twin doctors
One
they would
good,
trade
one
off.
evil.
Yeah, and they would trade off. One was cool, and you say good and evil. I say cool and lame.
Mm.
One guy's like the ladies' man, and the other one's cleaning up the seconds. Beth says, "Here's to the British guy that knew more about Goldwater than Dr. Cryptkeeper." Restless Medic says, "No, Ms. Heard, I expect your case to die." Tina Lewis, Dr. Shaw looks like David Bowie. Yeah, I can see the David Bowie references. Timothy Reaper, Dr. Vision versus Dr. Smeagol. Oh yeah, he does seem like Paul Bettany, doesn't he? There was a look that he gave where do you remember that the cartoon Grinch, Andrew? Have you seen that?
An old cartoon?
Yeah, the old cartoon Grinch with the Dr. Seuss.
Yeah, sure. I think so. I mean, I've
Remember when
seen one.
Yeah, it's the only. I think there's only one. But remember when he smiles and his smile like goes
Yeah,
like,
right.
yeah,
To ear to ear. Yeah.
this guy looked like that for just a minute. It was during one of the sidebars, and his neck kind of comes back, and it looked like he smiled all the way to his ears, and I felt like his jaw was going to unhinge, and he was just going to eat someone whole in the courtroom. Dan Camacho says Dr. Spiegel's response to Dr. Shaw: homeless person sounds and yells. Skeleton, this guy is a great example of what a psychiatrist, please, should act like versus whatever the heck Doc Brown was doing yesterday. Antimatter, redneck, all those Amber Heard experts getting slaughtered by Johnny Depp's actual experts. I foresee a bunch of professional issues with each of the experts' careers. Forget get woke, go broke. It's go turd, get flushed. So there you go. I mean, I'm not sure how much professional, like if you're talking about disciplinary action, I'm not sure how much of that any of them will face, but I mean, certainly any of these experts, but again, I have to stress a lot of these people are professional experts. They're mercenaries. I mean, they're who you hire to just go to say the thing. I mean, that the Hollywood.
I certainly get that sense from Heard's experts.
That's what I'm talking about.
Yeah.
Yeah.
Oh, they're clearly just hired guns. I mean, they become resistant, petulant when they're asked any questions that might be negative towards the client that's paying their bill.
Right. Dr. Hughes from the very first testimony. She was clearly someone who does not believe that men can be victims of intimate partner violence at the hands of a female. I mean, she all but testified to that. And it's how her practice is run and it's how her presentations are. So, yeah, I mean, no matter how bad she looks or how bad her Google reviews get bombed, if someone's got a domestic violence issue tomorrow and they need their female to be a domestic violence victim, guess who they're going to call? That lady. Call her up right away, whether the person's a victim or not, and then she's going to come in and make the testimony. The Doofenshmirtz psychology guy, I mean, that guy's a hammer. You just swing him. You swing him at whatever needs hitting. And that seems pretty clear. His evaluation of Johnny Depp was based on nothing, but he was comfortable saying it. He argued that the Goldwater rule invalidates his entire profession of expert witnessing. So, you know, but yeah, they're hatchet men and they come across that way to me. And I think the contrast is probably resonating with the jury, but I can't tell, of course. Let's see, here we go. We've got, I think I just, GJ says you were talking about Raising Cain by De Palma. I was. Raising Cain by Brian De Palma?
No, you had the movie, right? They're talking about the twin doctors.
Oh, no. That's not the movie. It's a Cronenberg film.
Yeah.
It's not Raising Cain. It's hold on.
Dead Ringers.
Yes, Dead Ringers. It's not, well, my internet broke halfway through watching it and I had no desire to go finish. That's what it was. I did not think it was that great. He did Nightbreed. Oh yeah. So he did Nightbreed, which is the Clive Barker movie. I liked that one quite a bit. But yeah, Dead Ringers was weird.
Is Cronenberg still alive? That was a weird dude.
I think he's got to be dead. Says he's still alive. He's old.
Oh my God, he looks like this expert witness.
He kind of
He looks exactly like him.
I I've never seen The Naked Lunch, but The Simpsons did a bit on it, and it's when all of the
Right.
kids, yeah, they faked IDs, and then they like rented a car and were driving it around.
It's
and
one of
they
the
all went,
creepiest movies you'll ever see.
well, they all went to the Naked Lunch, and they come out of it because it's rated R, and so they come out of it, and Nelson looks up at the marquee, says Naked Lunch, and he goes, "I can think of 2 problems with that title." Yeah, so Cronenberg is a weird guy, but yeah, this guy has Cronenberg vibes. Either he is Cronenberg or he's in his movie. By the way, we're at about 60,000 people. A little bit ago, we peaked around 70,000 people. If you like the show, you like the coverage, click that like button. It really helps out. I haven't shilled it too much today, but it is very helpful to the stream if you do like it. If you don't like it, don't click it and screw you. S. Hyder, Amber's case looks nearly worse than Dr. Creepy Gross Hands from yesterday. Verdict is expected when? I think the judge has subtly put it in the minds of the jury that they should be rendering a decision before Memorial Day. They're going to get the case on Friday after closing arguments. I don't know if the judge is going to keep them until they decide or if she's going to let them go home or go to hotels. I'm really opposed to letting juries go home during deliberations, especially, or even to hotels. Like, just deliberate the case. If they could just go to a comfy hotel room and they know there's a bell, that, or maybe that's the problem. When they know that at 5:00 they're all going to the hotel and they get to recharge for tomorrow, that seems like that keeps people entrenched.
Yep.
So we'll see how that goes. Yeah, as Sonia Collette says, Dr. Smeagol reminds me of Gargamel, who hunted the Smurfs. Creepy AF. Yeah, that I would not hire Dr. Spiegel for anything. I wouldn't hire him as an expert witness, because though that's, one of his jobs and he to some extent did it, I think he may have torched her case, or he's certainly a contributing flame if her case goes down. That's not the guy you want testifying.
But the thing is, we're surprised by how wacky he is. We're seeing him for the first time when he shows up to testify. Heard's legal team had met with him.
Yeah.
They'd seen his hair. They'd spoken with him. They'd observed his demeanor. And they still chose him.
Well, when you need did you watch Game of Thrones?
Yeah, unfortunately I did.
Well, okay, but the first like season or 2 is okay, right?
Yeah, it was good.
Okay, when Tyrion meets Bronn, right?
Yeah. Okay, yeah.
That's Bronn, right?
And
like
Bronn
you see
is yeah, right. Bronn is that they have trial by combat, right?
Yeah, he's the
Bronn wins for
sellsword.
him. Kicks that guy through the moon window or whatever that thing was called.
Right, and the lady says that wasn't you didn't fight honorably. He says, "Nope, he did though." That's who you're hiring. You're hiring an older senile psychiatrist version of Bronn.
Well, except Bronn got the job done.
Right, yeah. But that's what they thought. Okay, correction. That's what they thought they were hiring. To me, it doesn't pass the sniff test that they're innocently stumbling upon all of these hatchet men. All of these witnesses who come in with these overbloated opinions, clearly designed to cause damage, to try and they're wrecking balls swinging into building walls. That's what they're doing, and they're hoping to hit a beam and knock it over. All of their experts are like this. The lady expert from last night, who was their best expert, she didn't bring anything. Well, I still can't discern what she prepared or what she's done in the case, but she did come and sit down and talk about how great Amber Heard's non-real career was going to be.
Right.
And so,
absolutely zero figures from anybody except about Amber Heard. And those, of course, are speculative. Those are like options figures and things that might happen and things that might be negotiated, a movie she might do.
Right. And so, it's not a coincidence when it's witness after witness. And more watching this trial for, 5 weeks and a couple days now, it just seems more and more clear that Amber Heard's team knows they don't have a strong case here. They know that the facts, when they come out, are against them, and they're desperately trying to keep whatever factual record as clean for them as possible, which, yes, it is a lawyer's job to do so. But at some point, your client has done the thing. And I'm getting strong vibes that they're very concerned about any jury decision. And they shouldn't be in a defamation case of a public figure. They should not be very concerned. They should be thinking they have a massive advantage just by the nature of the claim. But I'm getting so many flipping messages. Why?
The next superhero franchise from Marvel will be Umbrella Man.
Yeah, the Umbrella Man. It's that umbrella guy. You almost got it entirely wrong, Elaine. Be like, if she would have said the Raincoat Man,
Right.
that would have been the only way to get it
The
worse.
Parasol Man. Yeah, I mean, how many damages experts did they talk to before they found that woman who would talk for 2 hours without any actual data? Played by Johnny Depp. That would be funny.
Is this guy's Dr. Shaw, right?
Thank you.
Yeah. Yep.
Dr. Shaw, is the Goldwater rule limited to diagnoses?
It's not. It's includes all professional opinions.
Do you agree with Dr. Spiegel that the Goldwater rule doesn't apply to expert witnesses?
I don't agree, no.
How could Dr. Spiegel express an opinion without violating the Goldwater rule?
This has actually been a topic that's been written and published about. So it is possible for someone to give testimony about a matter without interviewing someone. And there's certain sort of ways that it should be framed. So for example, when Dr. Spiegel was testifying about the report that Mr. Depp was unable to recall these 3 objects, what he could have done is said that I have not personally examined Mr. Depp, so I can't speculate about his cognitive state or ability to function cognitively. However, it is possible that someone who's not able to recall 3 objects could have issues related to substance use, which was what his opinion was. However, what he should have done in expressing his opinion is then have followed up to say that in order to really establish whether these were relevant and significant cognitive deficits, Mr. Depp should have had psychological testing to establish the nature of these deficits. And he should also have added that there are other potential explanations for these findings. So, for example, it's possible that Mr. Depp...
Objection, Your Honor. He's now going past the designation.
I think he's just opining as to, or is responding to Dr. Spiegel's testimony yesterday.
No, he's opining as to what Dr. Spiegel could have said, but it's past the...
No, they brought up it could have been lack of sleep. He could have been drunk.
If we can move on.
Okay. Who is qualified to give an opinion about cognitive deficits and processing speed?
It would have to be someone who could conduct the type of neuropsychological testing that I was mentioning. You can't establish the presence of cognitive deficits without a battery of tests.
Objection, again, this is beyond the Goldwater.
Overruled.
You can't establish cognitive deficits without appropriate neuropsychological testing. And that can only be done by a psychologist or neuropsychologist. So a psychiatrist like Dr. Spiegel would be giving an opinion outside of his area of expertise if he gave an opinion about cognitive deficits that required psychological testing to be further evaluated.
Dr. Spiegel yesterday testified about the practice of forensic psychiatry. Do you recall that testimony?
Yes, I do.
What is forensic psychiatry?
Forensic psychiatry is a specialty of psychiatry that relates to matters on the intersection between psychiatry and the law. So, for example, what we're doing today is forensic psychiatry, where a psychiatrist comes into court and gives an opinion about a matter to help the court come to an opinion.
Are there professional standards that govern the practice of forensic psychiatry?
Yes, there are.
And what organizations have issued those standards?
One of the primary organizations that has issued guidelines about the practice of forensic psychiatry is called the American Academy of Psychiatry and the Law. This is an organization that represents forensic psychiatrists. And it has published guidelines about what constitutes an ethical and sound practice of doing a forensic assessment and providing a psychiatric opinion. So this guideline, I think was published in 2015, actually contains many elements that are consistent with the Goldwater Rule. So, for example, it states that for a forensic assessment to be done, there has to be informed consent, and there should be a very thorough, comprehensive evaluation that would include reviewing past records, past psychiatric history. It would include doing what's called a mental status examination, which is a careful evaluation of someone's mood, cognition, things of that nature. And the guidelines do state that it is reasonable or permitted to provide an opinion without an evaluation. But if you're going to do that, there's some things that you have to really make clear in your opinion when you express that opinion. And the first is that you have to acknowledge the limitations of your opinion and not, like Dr. Spiegel, say that his opinion was held with a degree of medical certainty. You have to explain what's missing, what data you did not have that you were not able to rely upon in coming to that opinion. You also have to talk about what additional information
The truth, the whole truth, and nothing but the
that
truth.
opinion. And even though these guidelines say it's permissible to do this, the text is still, I think, not fully in support of psychiatrists doing this. So their statements are that opinions rendered without a proper database, which is what we as psychiatrists rely upon to make diagnoses and give opinions, professional opinions, is questionable and not generally recommended.
Did you form an opinion about Dr. Spiegel's testimony with respect to these practice guidelines?
Yes, I did.
And what is your opinion?
Well, my opinion is that he did not follow those guidelines. So, for example, he did not have consent.
Here comes the
He did
objection.
not do even a basic evaluation of Mr. Depp. When he gave his opinions, as I just mentioned, he said they were opinions that he had to a degree of medical certainty, and he did not make any statements about what other additional information he would have wanted to make that opinion. So, for example, when asked about should neuropsychological testing be performed, he said most patients don't have access to that, which is actually not at all true. I mean, every medical school has neuropsychologists that can do testing. So I think that was an unfortunate statement. So I think those are the primary ways in which the Goldwater Rule was violated, and the practice guidelines were not adhered to.
Dr. Shah, yesterday Dr. Spiegel was talking about correlation and causation. What is the difference between correlation and causation?
Objections. It's not in this designation.
It is. We can approach and I can show you.
All right.
Okay, so what's going on here? A Virginia lawyer reached out to help out with this. He says he's betting the hoorah objections to this rebuttal is due to the rebuttal expert designation that is generally required to be filed before trial, usually 45 days from trial. If they didn't disclose an opinion in the rebuttal designation, the judge can exclude it even if the opinion is based on observations of testimony at trial. That may be why Depp's lawyer was showing the judge the papers when the first objection happened. It's a surprisingly strict rule given it's about rebuttal evidence. And we do see that this is, they're now objecting to beyond the scope of the designation a little bit more specifically here. So that's what's going on. So this guy would have had to give his designation opinion, and they're trying to strictly hold him to that as the rule of evidence. So even though he's on rebuttal, it has to be about what's in his designation.
Go ahead, Dr. Shaw.
Yeah, so the difference between a correlation and causation, correlation is a statistical analysis of a relationship between two different factors. So in Dr. Spiegel's testimony, he talked about, there being a correlation between opinions he had about Mr. Depp, his narcissistic personality traits, his substance abuse, things of that nature. So a correlation doesn't say anything about whether or not these factors caused that, the behavior he was discussing. Perhaps one of the easiest ways I could describe this difference between correlation and causation is if we look at the issue of measles, if you bear with me. So there's a correlation between being young and catching measles. Now we know that measles is not caused by being young. Measles is caused by a virus. But young children have not been exposed to the virus. They don't have the immunity, so they have a higher rate of measles. So the difference statistically is, the difference is between causation and correlation is illustrated by that example. So another way I might put this is if we had 100 people in a room, just bringing it back to the issue of IPV that Dr. Spiegel was testifying about. Let's say we had 70 people who had all the risk factors for IPV and 30 people who had no risk factors for IPV. So what can we say about those 70 people? We can't say that any single one of those people has perpetrated IPV, even though they may have all the risk factors. And if we look at 30 people who have no risk factors, we also can't say whether or not they have perpetrated IPV. So the actual presence of risk factors for IPV that Dr. Spiegel was talking about, they say absolutely nothing about what happened in this case.
Thank you, Dr. Shaw. Nothing further.
All right, cross-examination.
Another good witness.
Yep. Very, very good.
Oh, look at that little blonde lawyer. So happy. Look.
You're not offering any opinion as to Mr. Depp's psychology.
Look how happy she is.
Yeah,
that's correct.
And
good for her. She did a good job.
Testified a lot about the Goldwater rule. You know of no case where an expert has been excluded from testifying based on the Goldwater rule, correct?
I don't know about the whole universe of cases. It's possible, but I don't know personally about one.
And you,
most of them are
you've
ethical.
never offered an opinion on the Goldwater rule before, correct?
That's correct.
And you've never written an article on the Goldwater rule, correct?
I have not.
And you've never given a presentation on the Goldwater rule, correct?
I have not.
And you've never been on any committees regarding the Goldwater rule, correct?
I have not.
And you agree that you've testified that there are exceptions to the Goldwater rule about having to interview the subject, right?
Yes.
And you understand that Dr. Spiegel requested to meet with Mr. Depp twice, but Mr. Depp declined, correct?
I'm aware of that.
And Dr. Spiegel stated in his designation and at trial yesterday that he did not meet with Mr. Depp, right?
Yes.
Okay. Can we put up Defendant's Exhibit 1904?
They keep going with this. Mr. Depp didn't
Dr.
submit.
Shaw, have you seen the opinions
I feel like they
of
should.
The Ethics Committee on the Principles of Medical Ethics?
Yes.
Okay. And if you could turn to 79 of the PDF, and it's actually, thank you. You see where it's highlighted here?
I mean, it can get
Yes.
ridiculous, right? You've
And
never
it's
tasted
a
poopy flavored ice
psychiatrist
cream, have
who
you?
argue that the gold
No.
model is not sound. The psychiatrist sometimes has to render
Objection,
opinions.
hearsay.
He's an expert. Without conducting an examination of an individual, examples occur in particular in certain forensic cases and consultative roles. This objection attempts to subsume the rule with its exceptions. What this objection misses, however, is that the rendering of expertise and or an opinion in these contexts is permissible because there is a court authorization for the examination or an opinion without examination. And this work is conducted within an evaluative framework, including parameters for how and where the information may be used or disseminated. You see
That hasn't happened here.
I do, yes.
And this court authorized Dr. Spiegel to testify in this case, correct?
That's not what the authorization means.
Thank you. I have nothing further.
Rebuttal.
Redirect?
Or redirect. The court didn't authorize Dr. Spiegel to evaluate, which is what the rule said.
Dr. Shaw, Mr. Nadelhoff just asked you about the court authorization of Mr. Depp's evaluation. Are you aware that the court has twice denied Ms. Heard's request for an evaluation of Mr. Depp?
I heard that yesterday in testimony, yes.
Thank you. Nothing further.
All right. Thank you, sir. You can either
Yeah, it was
have a seat
literally
or
the
you can leave.
opposite
Thank you.
of having
That was
a court
really
authorization.
intentionally deceptive by that attorney. That's the question is not whether or not the expert can testify. The question is whether or not the expert can violate the Goldwater rule. What the hell's going on now?
They're raising up a TV either for
Oh.
deposition testimony or for live WebEx. We'll see. I mean, that was just slimy. That authorization bit. Because that was clear deception. That's all that was. Kate Moss is scheduled for tomorrow. This could be Jennifer Howell. We'll see. We'll see who it is.
Yeah, that was a weak cross of a very, very powerful witness for Depp. I said powerful, Nick, not terrible.
Oh, yeah.
Powerful.
I got that. Okay, Jennifer Howell by deposition.
And what is your current occupation?
I run the Art of Elysium, CEO of the Art of Elysium.
Let me just go back. Now, you've indicated that Whitney lived with you from January 2015 to, I'm sorry, May 2015 to April 2016. Are you absolutely certain about those dates?
I'm certain, yes. She came and went at different periods, but all of her stuff moved out of my house April 2016.
And I'm sorry, did you say you were 100% certain of that? That's all. Could you answer my question?
Yes, she did go back to Amber and Johnny's at different points, but she was still living with me during that time.
The question I asked, because you were talking at the same time Ms. Vasquez was giving an objection, was I believe that you said you were 100% certain of those dates. Is that correct?
Same with me.
What?
Oh, you previously testified that you were the CEO for Art of Elysium. Is that correct?
That's it?
And are
Wow.
you still currently in that position?
Yes, I am.
And how long have you been the CEO for Art of Elysium?
I am the founder of the organization. So we did our first workshop in August of 1997, filed legal paperwork in February of 98 to set up a 501c3. So I guess since the beginning of the charity.
Ms. Howell, when did you first meet Amber Heard?
At the Pineapple Express premiere is where I met she and her sister Whitney.
And that was the shortest
Do
testimony.
you remember approximately what year that was?
Still reeling from it.
I believe it was around 2008. I'm sure that could be pulled. It was the LA premiere. I think there was probably multiple premieres, but it was the Los Angeles premiere of Pineapple Express.
Was Ms. Heard there with Mr. Depp?
No, this was long before. I was a guest of James Franco, and Amber was in the movie. And so I met she and her sister at the, to be specific, at the after party of the premiere.
Did Ms. Enriquez end up working for Art of Elysium at some point?
Yes, she did.
What year did Ms. Enriquez begin working with Art of Elysium?
I believe it was in 2014. I don't have those documents right in front of me. I believe it was leading into the year Amber was receiving the award.
And what was Ms. Enriquez's
To be fair,
position at Art
that
of
was Elaine's
Elysium?
best
Art
performance.
salon manager, director.
Does Ms. Enriquez still work for Art of Elysium?
No.
I hadn't realized she was in Pineapple Express. I have to say, she looks quite pretty there. Much better there than she looks here.
2015, I believe.
Each time you saw Mr. Depp, did you ever see him doing any illicit illegal drugs?
Never.
Of course, that was 2008. Man, that was quite
Did
some
you
time
ever
ago.
see him consuming excessive amounts of alcohol?
Objection.
Never. Did you ever see Mr. Depp appear intoxicated?
No.
Did Ms. Heard ever show you photographs of depicting injuries on her face or body?
No.
Did Ms. Heard ever tell you that Mr. Depp was abusive towards her?
No.
Mr. Depp paying your legal fees, Ms. Howell, for this deposition and the testimony you've provided in the UK action?
He is not.
Who is?
Myself.
Okay.
Do you feel any particular sense of loyalty towards Mr. Depp?
None at all.
Do you feel any sense of loyalty towards Ms. Heard?
None at all.
Ms. Howell, do you recognize
This letter?
this check as the check that the Art of Elysium received on behalf of Ms. Heard for a donation, an anonymous donation of $250,000?
Yes. Yes.
I believe you testified previously that you understood that the anonymous donor was Elon Musk. Is that true?
Yes.
If I could please have Exhibit 4 brought up. And for the
TMZ
record,
is
it's date stamp JH 22 through 29.
TMZ has filed an emergency motion to prevent their employee from testifying in this case tomorrow on First Amendment grounds and source protection. So a journalistic shield.
What for?
So what we're going to get out of Miss Howell in just a second, I believe, is her letter saying that Whitney Heard that basically.
Do you recognize this document, Ms. Howell? And if you need to scroll through the 8 pages, feel free.
That basically Miss Heard told her that that Whitney told her that what happened on the staircase was
Can you scroll down?
not like what she's testifying to.
Yeah, I recognize that.
And what is this?
That is an email, I believe, I sent to Whitney.
Scrolling up to the first page of this attachment, who is Marcel
Pariseau?
Sure, Pariseau.
He is one of my oldest friends in Los Angeles who has served as a board member of the Art of Elysium and is one of my biggest confidants here in LA, kind of for the course of my career.
And going down to the third page of this exhibit. Thank you. This is an email, Ms. Howell, that you sent to Whitney Henriquez on or about Tuesday, July 28th, 2020 at 11:02 a.m.
It is.
This is a true and accurate copy of an email exchange that you sent to Ms. Henriquez?
Yes, I believe I'm the one who gave that. Yes, it is.
And then did you forward this email exchange and the attachments to Marcel Parasau?
Yeah, I asked him to keep it for me.
Why did you send this email and letter to Ms. Henriquez?
Because I've struggled very much with what to do in a situation that I love someone who I know is doing something very wrong, and I know that they're doing it because they're trying to protect their sister. And
wow.
I'm trying to protect her, and I'm just trying to get her to wake up and do the right thing, which is tell the truth. It's the only thing that can help everybody involved in this case.
Ms.
Well,
Howell, do you
that's not
recall
good.
submitting a witness statement in the United Kingdom?
Yeah, they basically just called to verify the witness statement that was submitted previously.
And do you recognize this document to be the witness statement and the declaration that you submitted in the UK? And if you want to scroll down to look at it.
Yes, I recognize it.
And at the first page, do you see a date on this document?
January 13th, 2021.
And is this document a true and accurate copy of the declaration that you submitted in the UK proceeding on or about January 13th, 2021?
Yes.
And are all the statements in your UK declaration accurate and true?
I mean, yes, I signed it. Yes.
All right, let's pull up
I mean,
what
yes.
I believe was Depp Exhibit 9. It's been marked as Depp Exhibit 9.
I mean, again, this is going to come off very badly for Amber Heard here. She said she loved Whitney. Whitney lived with her forever. No manifest negativity towards
So,
her
Ms.
or
Howell,
Amber.
earlier you were shown this document. Scrolling to the end of it.
Can you go? Okay.
There. Did Mr. Waldman assist you in drafting this email?
Absolutely not.
Did you speak with Mr. Waldman at all about drafting this email?
About writing an email? No, I did that on my own accord.
Did you speak with Mr. Waldman at all about contacting the ACLU?
I do not recall having a conversation with him about that.
And Ms. Howell, you testified earlier that you received a check from Fidelity Charitable in January of 2018. Is that correct?
I don't know if I said the date, but yes, I received an anonymous donation from that check that was submitted. Whatever it's on there, I just don't know the date off the top of my head.
And you testified that there was a letter sent along with that that said that it was in honor of Amber Heard?
Yes. Richard, I was guaranteed 20 minutes with him after being attacked for 3.5 hours by your side the last time. So I am going to stick by what I was told before entering this and what your side agreed to.
Oh, was that?
All right, your next witness.
Your Honor, Mr. Depp calls Candy Davidson Goldbraun, who is the corporate designee of the Children's Hospital of Los Angeles.
All right, and that's by deposition, is that correct?
Yes, Your Honor.
Okay.
Oh, so I wonder when they're gonna highlight what's in the letter.
Is it your understanding that you're here to testify today on behalf of the Children's Hospital?
Ah.
Yeah. So as of
But this may just go to Amber not paying these people the money she promised, right?
made by Miss Heard
Well, also, I mean, they got that letter.
to the Children's Hospital in connection with the
This one, yes.
$3.5 million pledge, aside from the original $100,000 check from Mr. White in August of 2016.
Yes, there was a payment
Why is she wearing a mask on a web call?
January 9th of 2018.
And what amount is that gift?
Or he, I guess. I shouldn't assume.
$250,000.
Okay, and was that gift made by Miss Heard or on Miss Heard's behalf?
By Ms. Heard.
Okay, and what are you basing that statement on?
By the check that we received from Fidelity. Fidelity charity that came to Children's Hospital.
What is this document?
The letter to Mr. White from myself inquiring about further installments on the pledge that had not been fulfilled.
And why did you write this to Mr. White on June 14th, 2019?
I wanted my money.
Figure out if there were any other payments coming from Mr. White to fulfill the pledge, because Children's Hospital Los Angeles had not received any other correspondence from him.
And what is this document?
It is a letter to Ms. Gottlieb from myself on behalf of Children's Hospital Los Angeles, inquiring about additional gifts, pledge payment installments.
This letter appears to be directed to Miss Amber Heard, care of Jody Gottlieb. Is that correct?
Correct.
Who's Jody Gottlieb?
In the Children's Hospital Los Angeles record, Jody Gottlieb was our contact for Miss Amber Heard.
Ms. Goldbraun, why did you send this letter to Ms. Heard and Ms. Gottlieb?
I was trying to see if the pledge was going to be fulfilled or not.
In your experience, is it common practice for anonymous donors when making donations to, in one paragraph, state that they wish to remain anonymous, and in the very next paragraph, identify themselves?
Yes,
That is common?
it is common for donors to want to remain anonymous publicly, but allow the charity to know who they are.
Between June 2018 and the dates on which you sent the letters to Ms. Heard and Mr. White in June of 2019, were any additional funds received from Ms. Heard?
No.
Okay, so as of June 2018, a total of $250,000 had been received as far as the Children's Hospital is concerned from Ms. Heard. And that was the same amount that had been donated a year later in June of 2019. Is that accurate?
Correct.
As of the date of this deposition, March 30th, 2021, how much in total has Ms. Heard donated to the Children's Hospital?
$0.
For this particular gift, in her lifetime,
From 2016 to present.
$250,000.
Ms. Goldbraun, do you recall we were speaking about this letter a few minutes ago? All right, and this was a letter that you sent to Ms. Hurd, correct?
Correct.
Did you ever get a response to this letter?
No.
As of October of 2018, how much money had Ms. Hurd directly donated to the Children's Hospital?
$250,000.
As of March 30th.
I'm sorry, I didn't hear the end of that.
Sorry, I just realized. You said October 2018?
Correct.
Okay, yeah. $250,000.
Okay. As of March 30th, 2019, how much money had Ms. Hurd directly donated to the Children's Hospital?
$250,000.
What is your understanding of the length of time over which Ms. Hurd pledged the gift of $3.5 million to Children's Hospital?
There was no date arrangement with Ms. Hurd to have this pledge paid off in a particular time.
If Ms. Hurd were to pay this, the rest of the $3.5 million in 2 years or 5 years, would Children's Hospital welcome that?
CHLA welcomes every and any donation that comes its way.
Has Amber Heard's pledge of the $3.5 million to Children's Hospital expired, to your knowledge?
Not that I'm aware of, no. It has not expired.
All right, thank you. Your next witness, or?
Your Honor, I think we've concluded our witnesses for today. We will have more live witnesses tomorrow.
Okay, all right, ladies and gentlemen, that'll be the end of your day for today. Again, do not
Okay.
do any outside research. Do not discuss the case with anybody,
Nice.
and we'll see you tomorrow morning at 9 a.m., okay? Thank you.
So every day is not 5:30 day.
Yeah, no kidding. That was a big to do. Every day is 5:30 day. Well, except if you're done with witnesses. Yeah, I'm really curious about that Jennifer Howell testimony. I think they got the letter in. She authenticated it, the email, but
all right,
they didn't ask
You want
any
to have a seat for
questions
just a
about
moment
it.
because we do have a few proffers going to be done.
Maybe they're going to.
Just
proffer
for the
the
record,
letter.
we talked about it earlier. I will charge the 30 minutes extra time for today to the plaintiff's team so we can stay on time.
Understood, Your Honor.
Okay. All right. And I believe, Mr. Rodenborn, you had some proffers you wanted to do. Testimony.
They lost 30 minutes.
We did,
For the-
Your Honor,
for the record.
testimony in a few exhibits. Mr. Nadelhoff is actually.
Okay, Mr. Nadelhoff, if you want to proffer testimony for the record as to testimony that the court has sustained objections.
Okay. Why do you have a whole banker's box? What the hell are you about to do?
It's full of
Your
proof.
Honor, it's a box here, so I just.
Okay, that's fine. You can stay there as long as you stay close to the microphone. I appreciate it.
And Your Honor, what I will do is I'll explain what we're proffering the evidence for, and then we have copies.
Good.
Which I'll provide to you. We'll provide them to you electronically, or I don't have another copy for you right now, but I.
No, they're not going into
That's
closing
fine.
arguments,
Go ahead, yes,
guys.
sir.
They're just not
Okay,
calling another witness today.
Your Honor, for Laurel Anderson, on March 31st, 2022, the defendant attempted to designate certain portions of the deposition testimony for trial of Dr. Laurel Anderson, a clinical psychologist who worked with Ms. Hurd and Mr. Depp. Dr. Anderson testified in the therapy session. Ms. Hurd reported to her that she was slapped by Mr. Depp, that he hit her in the head, had her hair pulled by Mr. Depp, kicked her in the leg, and that Mr. Depp gave Ms. Hurd bruises. Ms. Hurd also reported that Mr. Depp was the first to initiate any violence.
Jesus, dude,
Ms.
take a
Hurd
shower
also
or something.
reported
What's
that
with all
she
this
was in the
scratching?
bathroom to
It's like a
protect
meth
herself
addict.
from Mr. Depp. Ms. Hurd also reported to Dr. Anderson that Mr. Depp threw a phone at her on May 21st, 2016, hit her and held her hair. Ms. Hurd also reported to Dr. Anderson that she was a victim.
Another
of
one.
That she was a victim to Mr. Depp's abuse. The testimony is contained in Dr. Anderson's deposition transcript.
It's like every 7 seconds.
The court
It's like a chronograph.
also excluded records of Dr. Anderson from Ms. Hurd's and Mr. Depp's therapy sessions and a treatment summary, which are exhibits B and C.
3,
Mr.
2,
Depp objected
1.
to Dr. Anderson's
testimony as described in medical records stating that they were hearsay and that they did not fall into any exceptions, including statements for purposes of medical treatment. The court sustained the objection on the grounds that the testimony and exhibits were hearsay. For Dr. Kipper, on August 31st, 2022, the defendant attempted to designate certain portions of the deposition testimony for trial of Dr. David Kipper, Mr. Depp's physician. Dr. Kipper testified Ms. Heard voiced concerns of
Asking
Mr.
her
Depp's
to
behavior while on drugs and
re-litigate
alcohol.
her objection
Mr. Depp tried to
rulings.
fight and push Ms. Heard while he was attempting detox on his island, and that she found lots of cocaine in February 2016. Dr. Kipper also testified he told Mr. Depp to, quote, bury the dragon, which referred to the bad feelings that Mr. Depp has inside him. This testimony is contained in Dr. Kipper's deposition transcript, which is Exhibit D. Dr. Kipper also testified about an email he wrote explaining Mr. Depp's detox treatment. In the email, Dr. Kipper wrote to Mr. Depp's sister that Mr. Depp had fundamental issues with anger, romanticized the drug culture, and had no patience if his needs were not met. This email is Exhibit C. Exhibit E. Mr. Depp objected to Dr. Kipper's testimony and the email stating it was hearsay.
There he goes again.
It did not fall into any exceptions, including statements for purposes.
Ms. Barney next to him is wondering what the hell he's doing.
Objection on the ground that the testimony and exhibits were hearsay. Deborah Lloyd. On March 31st, 2022, the defendant attempted to designate certain
The jury's
portions
not here, no.
of the deposition testimony for trial of Debbie Lloyd, Mr. Depp's nurse. Ms. Lloyd testified Ms. Heard voiced concerns about Mr. Depp's behavior while on drugs and alcohol, and that Mr. Depp worked himself up into a
This
rage
is all hearsay from Amber Heard. I mean,
Yeah, they're offering it as
testimony is
a
contained in
proffer,
Ms.
trying to get her
Lloyd's
to
deposition
reconsider her
transcript, which is
sustained
Exhibit F.
objections on it.
Also, Ms.
Oh, she's
Lloyd
not
had
gonna do
recent
that.
notes on these issues that she testified to, which is Exhibit G.
I guess just creating a record for
Ms.
appeal.
Lloyd's testimony and portions of the nursing notes stating it
Yeah,
was
I think
hearsay
so.
that did not fall into any exceptions, including statements for purposes of medical treatment. The court sustained the objection on the ground that the testimony and portions of the nursing notes were hearsay.
Yeah, well, this is all a bunch of uncorroborated
March
claims
31st,
by
April
opposing
1st,
party.
2022, the defendant attempted to
So what they're doing,
designate
guys,
certain
is
portions of the
we
deposition testimony
believe
for trial
they're trying to
of
preserve
Ms. Filati,
these matters
Ms.
for an
Heard, and
appeal.
Mr. Depp's nurse. Ms. Filati testified that Ms. Heard reported to her on December
These are already
16th,
ruled on.
2015, that Mr. Depp headbutted Ms. Heard in the forehead. This also was contained in Ms. Filati's nursing notes, which is Exhibit H. Ms. Filati further testified that Ms. Heard reported being freaked out after the December 2015 incident and
More
testified to
hearsay.
text messages between herself and Ms. Heard, where Ms. Heard reported the incident of abuse.
None of this is going to
These
lead
text
to a
messages
successful
are
appeal,
exhibits
folks. It's well
I, J,
within the
K, L,
judge's
M.
discretion to
Filati also
exclude this kind of
testified
evidence.
that on May 21st, 2016, Ms. Heard reported that Mr. Depp became completely delusional and crazed and hit Ms. Heard in the face while she was on the phone with IO Tillett Wright. Ms. Filati testified to text messages reporting this as well, which are contained in Exhibit N. The testimony is contained in Ms. Filati's deposition transcript, which is Exhibit O. Mr. Depp objected to Ms. Filati's testimony, portions of the nursing notes, and the text messages referenced stating it was hearsay that did not fall into any exceptions, including statements for purposes of medical treatment. The court sustained the objections on the grounds that the testimony and portions of the nursing notes and the text messages were hearsay. Amy Banks, Dr. Amy Banks. On April 29th, 2022, the defendant attempted to designate certain portions of the deposition testimony.
So maybe this is why Amber did all this, because she had seeded so much bullshit
Mr. Depp.
claims
Banks testified
into what she thought would be an admissible record that she thought she had a lock, that she'd rigged the game,
including by hitting
and she
her.
didn't realize none of this would be admitted.
Dr. Banks also testified that Ms. Heard
She thought she was going to have all these people testify in front of a jury.
cigarette. Dr. Banks also reported that Ms. Heard told her that Mr. Depp initiated the violence while in a session with Mr. Depp, and Mr. Depp did not object to the characterization of the violence. Finally, Dr. Banks testified that she believed Ms. Heard's accounts of the violence and that Ms. Heard was a victim of domestic abuse. This testimony is contained in Dr. Banks's deposition transcript, which is Exhibit P. Mr. Depp objected to Dr. Banks's testimony, stating it was hearsay that did not fall into any exceptions, including statements for purposes of medical treatment and for providing improper expert opinion. The court sustained the objections on the grounds that the testimony about the abuse was hearsay and that Dr. Banks's testimony that Ms. Heard was a victim of domestic abuse was improper expert opinion. Connell Cowan. On April 29th,
Man, this is going to be
2022,
forever.
the defendant attempted to designate certain portions of the deposition testimony for trial of Dr. Connell Cowan, a clinical psychologist who worked with Ms. Heard. Dr. Cowan testified that in the therapy session, Ms. Heard reported abuse by Mr. Depp, including text messages and medical notes, where Ms. Heard reported in December 2015 that, quote, Johnny did a number on me, end quote. This testimony is contained in Dr. Cowan's deposition transcript, which is Exhibit Q. It is also contained in Dr. Cowan's medical notes in Exhibit R at Depp 9122 through 23, and is contained in text messages that are Exhibits S and T. Mr. Depp objected to Dr. Cowan's testimony, stating it was hearsay that did not fall into any exceptions, including statements for purposes of medical treatment. The court sustained the objections on the ground that the testimony about the abuse was hearsay. Alan Blaustein. On April 29th,
This is not
2022,
taking
the
anyone's
defendant
time,
attempted to
guys.
designate certain portions of the deposition testimony for trial of Dr. Alan Blaustein.
Depp's team
a
forfeited
clinical
30 minutes
psychologist
of
who
time
worked with
today.
Mr. Depp. Dr. Blaustein testified that in the therapy session,
But this isn't taking
Mr.
time.
Depp reported that he had cut himself as a child and burned himself with cigarettes. Dr. Blaustein also testified about the drugs that Mr. Depp was on, as reported to him by Ms. Lloyd. This testimony is contained in Dr. Blaustein's deposition transcript, which is Exhibit U. This information was also contained in emails, which are Exhibits V, W, and X. Mr. Depp objected to Dr. Blaustein's testimony regarding the cutting and burning himself as speculation, and the testimony regarding the drugs Mr. Depp was taking as hearsay that did not fall into any exceptions, including statements for purposes of medical treatment. The court sustained the objections on these grounds. Bonnie Jacobs. On May 4th, 2022, the defendant attempted to introduce into evidence the treatment notes of Dr. Bonnie Jacobs, a clinical psychologist who worked with Ms. Heard. The treatment notes show Ms. Heard reporting abuse by Mr. Depp, including sexual violence. The treatment notes are Exhibit Y. And based on the court's ruling, the defendant did not call Bonnie Jacobs as a witness. Mr. Depp objected to Dr. Jacobs' notes as hearsay that did not fall into any exceptions, including statements for purposes of medical treatment. The court sustained the objections on those grounds. I have some more.
Oh, thank God.
As long as you don't just keep turning every page in that book.
No,
because
it
I'm
is
not
not.
staying for that.
It is not.
Okay.
Oh, he was in the
Elaine's so
Matrix for a
proud
second.
of him. Look,
That's my grandson.
that's my boy. Once we get that rash taken care of.
So yeah, again,
The
this
UK
is
judgment on April 29th, 2022.
just preserving
Ms.
the
Heard moved
record
to allow
for an
evidence
appeal.
and
But like
questioning
you said,
regarding the UK judgment,
even if the
and for
appeals court
admission
said
of the
all of
judgment itself,
these
which is Exhibit Z.
were
In
admissible,
support for a motion, Ms.
they're
Heard
not going to
argued
find an
that Mr.
abuse
Depp
of
had opened the door
discretion
to
on
the
them.
admission of the judgment by presenting evidence of damages after the date of the judgment on November 2nd, 2020. For example, Ms. Heard observed that Mr. Depp had sought damages for losing his role in Pirates of the Caribbean 6, a movie that has not yet been made. Ms. Heard further observed that Mr. Depp testified that the op-ed had caused him and his family irreparable harm, thereby suggesting that his reputational harm had continued to the present. Ms. Heard noted that Mr. Depp's expert designation indicated Michael Spindler relied on Mr. Depp's earnings from 2019 to 2021 when reaching his opinion, which resulted in an amendment to the designation. Ultimately, the court found that Mr. Depp had not opened the door to the admission of the UK judgment and overruled the motion, which the court did again today with Mr. Bania's opinions. Finally,
finally,
Adam Bercovici. On May 19th, 2022, Ms. Heard attempted to call Adam Bercovici, who is an expert in the policing and Los Angeles Police Department policing of domestic violence calls for service. Mr. Bercovici would have testified to his qualifications in the field of policing and LAPD policing of domestic violence calls for service as follows, and further outlined in Ms. Heard's fourth supplemental and rebuttal disclosures dated March 31st, 2022. Mr. Bercovici spent 30 years with the LAPD, retiring in 2012 at the rank of lieutenant. He has extensive experience as a patrol officer, field supervisor, uniformed watch commander, both as Sergeant Second and Lieutenant One, along with multiple assignments as an officer in charge, Lieutenant Second of specialized detective units. During his tenure with the LAPD, Mr. Bercovici held numerous positions directly responding to and overseeing subordinate officers' responses to the domestic violence calls for service, including as a patrol officer, supervisor, watch commander, and assistant watch commander. And actually, this, Your Honor, is a
what they had him excluded.
prepared a longer.
How'd you not
brief
get that
of what
guy
he's
in?
going to say. I can is it okay to submit it rather than
All right.
hearing me read it all?
Any objection to that? No objection. Okay.
Okay.
That's fine.
Please, for the love of God, make him stop.
You just scared me with the size of that.
No,
picture. Just wanna
I understand.
Okay. All right. That's fine. If you can get Jamie our copy of it, we'll make sure it becomes
course,
part
sir.
of the record as
Jamie,
well,
get a copy
okay?
of the record.
All right. Do you have any proffers, Mr. Chu, that you need to at this point?
Not at this time, Your Honor. Thank
Okay.
you.
All right.
No, we haven't tried to introduce any hearsay evidence, Your Honor, so we're good.
From you, like tomorrow, let me, by the end of the day tomorrow, if I could get clean
That's a
jury
confidence
instructions,
indicator, by
without
the way.
Sites on them for the ones that have been admitted, and also the verdict forms as well, if that's been worked out. Okay.
Your Honor, we sent revised jury instructions to them yesterday morning and a revised verdict form today. So just waiting to get
Okay,
back. But we'll
sure.
coordinate.
All right. Thank you. And you're working with Jamie about some exhibits. There's some that were, both sides noted that were in evidence that are not. So I want to make sure everybody gets everything cleared up. You're caught up?
No, they're not reading those for the public. They're reading them
Okay,
into the
good.
record.
All right, just keep that going so we can get that, make sure that's taken care of. As far as time left, Sammy, today, I can give you a rough estimate for two reasons. One, you had some depositions, so make sure you give the breakdowns to Sammy about those. And two, Sammy wasn't here today. He had a mandatory CLE that he had to do. So I just did a rough estimate, and I want to
A
qualify that as a
mandatory
rough
CLE?
estimate. But it looks like the plaintiff has used about 5 hours today, and the defendant used about an hour and 15 minutes. Is what I have.
So
Okay?
that
Again,
what?
it's rough estimate, so don't expect them to be the same. But Sammy's going to get to it this evening and send you an email this evening with the actual accurate times. Okay. Anything else?
No, thank you, Your Honor. Thank you.
All right.
No, Your Honor.
Okay.
Thank you.
Have a good evening. We'll see you in the morning.
You too. Thank you.
They had to use more than an hour 15.
So did she just read the time? I missed it.
I don't know if they read the time. The person who's the timekeeper is going to update the time by email for them tonight.
Okay.
But she said that she had the plaintiffs down using about 5 hours and the defense using an hour and 15 minutes. Which that seems like a more generous spread to the defense than I thought. I didn't think that they only used an hour and 15 minutes. I thought they used more. You love that mandatory CLE? You got to wonder what he did. Why do you have a mandatory CLE on a given date?
No, that is crazy. Yeah. One wonders what he did, how he got ordered. What the hell is that orange thing?
It's a very bad jacket.
Oh, that's the court reporter.
Yeah.
That's the lady who's been sitting there with those headphones. Jesus Christ. Who makes that chair?
A reliable company.
Steel case.
She's using a vinyl school bus wrap as a jacket. Okay. So what, I mean, that last part, just again, to clarify
Is
for
Elaine
everybody.
reassuring Amber here? Yeah, no. We're not fucked. It's okay. It's all good, man. It's all good.
Amber's pretty far to the side there.
Yeah, she's leaned over. She's got her arms crossed. That's not a very open body position.
Open your arms. Come on, open your arms.
Elaine's spewing that toxoplasmosis all over her.
Stop touching my elbows, you weirdo. You know, what's going on here? What is this? What is this?
What's that red-haired? Is she there to steal someone's child? Oh, I guess that's it.
Yeah. So she's she'd passed a note earlier in the day. I'm not entirely sure what her role is, but I would assume some sort of paralegal or research attorney, something like that for the team. Okay. So just to clarify for everybody, that last bit is probably a little bit confusing. And I see a lot of people, is this for the cameras? What are they doing? No. This is a list of objections that they lost, that they found for their opinion to be unfair. To take an issue to an appellate court, you have to have the preservation of that issue on the record. So a quick way to get anything on the record is to just frankly read it into the record. So what they did there is they have this list of objections, and rather than typing up a document, or they probably are submitting an accompanying document with it, they had a little bit of time today. So he proffered for the record their objections to preserve them for appeal, so they can go to an appeals court in the event that they lose and say, look, this was an abuse of discretion by the judge. This should not have been excluded, and therefore it prejudiced our client and made her case more difficult. I didn't hear anything in the record, nor have I seen anything in this trial on either side that would suggest that the judge has issued a ruling that would nullify a jury verdict in the case.
Right. It did feel a little weird, though. I mean, all these rulings should already be in the record. It seems weird they have to read it again here. I wonder if part of the motivation is not, for the cameras. They know the cameras are still running, or maybe in an effort to kind of preload bias the judge. You know what I mean? Because a lot of decisions are going to be made now in jury instructions and a variety of things. And they may want the judge to have in mind, man, listen, Your Honor, you just ruled against us on this entire binder of stuff. Give us a break.
Let's see. Here we go. I'm going to look up the proffer rule here.
We need Rob.
Yeah, no kidding. Okay. So admission or exclusion of evidence. Error may not be predicated upon admission or exclusion of evidence unless, one, as to evidence admitted, a contemporaneous objection is stated with reasonable certainty as required in Rule 525 and 5A.18, or in any continuing objection on the record to a related series of questions, answers, or exhibits if permitted by the trial court in order to avoid the necessity of repetitious objections, or as to evidence excluded, the substance of the evidence was made known to the court by proffer. So they have to, under the rules in Virginia, make a proffer of the substance of evidence that they objected to, that they find wrong. And it's probably to clarify, because a question can have can have a broader range than what the specific thing that they need to include is, especially if it's like a whole document and they just needed a section or whatever. So,
fair enough.
So that's the that's a rule there in the that's from the Virginia rules of the Supreme Court, which I would assume apply down to well, that's going to be for or Superior Court, not Supreme Court, Virginia Superior Court. So that would, let's see. Yeah, and I think one of the reasons they do that, and they do it outside of the jury's presence, of course, to prevent them from hearing the test or the evidence again that's excluded. But it does seem like they could proffer that by in writing. I don't know why there's a specific oral requirement, but if that Virginia lawyer is still watching and you want to, give me some insight, I'm happy to take it. Other than that, though,
someone mentioned earlier that Amber Heard had also been in Zombieland. She was the girl in apartment 406 in Zombieland.
Yeah, she gets clocked by like the, not the toilet seat lid, but the thing on the back of a toilet on the tank.
When she goes zombie.
Yeah, she like drags herself and the guy just.
So I had no idea who that chick was. I did remember whoever she was super hot. So I have to concede, I don't think much about Amber Heard's looks today, but in 2008, 2009, she was smoking hot.
Oh yeah. Yeah, she was very good looking back then. All right, let's see. People want me to read the TMZ motion. Let me take a look at it.
But having said she was smoking, she was also obviously completely forgettable as an actress, because I had no recollection she was either in that or Pineapple Express.
Okay, so this is 9 pages. I'm not going to read the whole thing here, but the substantive issue is TMZ submits an emergency motion to intervene for the limited purpose of asserting journalist privilege pursuant to Supreme Court Rule 314. According to a published report, TMZ's former employee, Morgan Tremaine, has been called to testify at trial imminently on behalf of plaintiff Johnny Depp regarding information provided to TMZ by a confidential source in violation of TMZ's and the source's rights under Virginia Rule of Evidence 2.508. So VA Rule Evidence 2.508. Protected information. So the rule says, where's the rule? Okay, except as provided in subpart C, no news person may be compelled by the Commonwealth or a locality in any criminal proceeding. That doesn't matter. A court may compel a news person to testify about, disclose, or produce protected information only if the court finds, after notice and opportunity to be heard by such news person, that the protected information is necessary to the proof of an issue material to an administrative or criminal proceeding. Protected information is not obtainable from any alternative source. Commonwealth or locality exhausted all reasonable methods for obtaining the information from all relevant sources. And there's an overriding public interest in the disclosure of protected information, including preventing the imminent threat of bodily harm to or death of the person, ending actual bodily harm being inflicted. That was, but that's for a criminal organization or criminal trial. Publication by a news organization or the dissemination of a news person by a news person of protected information obtained while engaging in journalism does not constitute a waiver of protection from compelled testimony, disclosure, and production provided by subpart B. But that doesn't say what they need it to say. They can't compel them in a criminal or administrative proceeding, but there's nothing to do with civil here. And we don't know that they're actually being compelled. Okay, let me see what else this stupid order says. According to a published report, Morgan Tremaine called to testify at trial. And Brown versus Commonwealth. I'm not going to read that. Recognizing privilege of confidentiality of information and identity of a source. With this motion, they seek a protective order precluding the plaintiff from eliciting or Mr. Tremaine from disclosing TMZ's privileged information during the testimony. TMZ is uncertain whether Mr. Tremaine is appearing pursuant to a trial subpoena. If he is, they likewise request that the court quash the subpoena. Journalists' promise of confidentiality are vital to reporting the news. That is why the law strongly protects the ability of journalists to keep their promises. The court should permit TMZ to keep the promise it made here. Okay, so that's the gist of it. I've got to read through the whole order, but effectively they believe that they are the rights holder, the holder of the privilege, or maybe that their source is the holder of the privilege and has not waived it. And so they're going to try and enforce that. The rule that they cited does not seem on point here. That's criminal or administrative proceedings. It's civil proceedings are not mentioned. So I guess in their absence, it goes this, they may compel them to testify if they meet this 4-part test. So protected information is necessary to the proof of an issue material to administrative or criminal proceeding. No. So that's all. It's all criminal. As far as I can tell. Let's see. Protected information means information identifying a source who provided information to a news person under a promise or agreement of confidentiality made by a news organization or news person while such news organization or news person was engaged in journalism. So there's something there.
I object to the whole privilege. I mean, listen, if a journalist wants to protect their source, that's up
to the journalist to assert it.
Yeah.
Yeah.
Then serve the contempt.
Our Supreme Court. So this is from the Virginia lawyer clarifying the question there. He says, our Supreme Court will readily bounce appeals for procedural reasons. Very strict about preserving issues at the trial court. Very common to lose appeals for not adequately objecting and proffering the proof. Okay. So they basically have to do it. So that's
fair enough.
That's what happened with that. And so, yeah, with this, I'll look into the journalistic shield thing. Maybe we can address it tomorrow or on a night stream. I I would love to know more about the TMZ thing. And maybe I might also just do it as a short video and trailer for tomorrow's show. I've been putting those up. Hope you guys have been enjoying those little trailer videos that I'm doing for the live streams. With that, there are super chats to read, of course. And
I think I'm going to leave those to you, Nick.
Yeah, I was going to just ask right before I get into them if you had any final thoughts for the day.
I do.
About
if
how
anybody
it went.
wants, for the day on that too. But the grift must go on. Anyone who would like a free copy of the Law of Self-Defense Principles, free, folks, at lawofselfdefense.com/free book. I thought the day was great for Depp's team. I thought that his witnesses were very good. I thought the cross of them was very weak. I don't know what the hell was going on with the Jennifer Howell witness. That seemed
very weird.
Rather pointless to me. I mean, I thought the whole point was going to be her impeachment of the sister's claim of the events on top of the stairs or whatever the hell that's all about. Instead of just mostly mention that letter, that email, and then spend about as much time on some check that she received. I'm not sure what that's about. And then, of course, the Children's Hospital thing was just about a check too, really.
I think the check is the implication of witness tampering. Elon Musk sent an anonymous donation on behalf of Amber Heard right before the testimony in the UK trial. Effectively, this is hush hush money. I think that's what the testimony was there, or it's meant to elicit that notion. I don't think they communicated that very effectively. The check was, you have to be kind of enmeshed in the lore, I think, to get that.
Yeah. So how does that get explained to the jury? And in terms of the letter, how do they get the letter in front of the jury now?
Yeah, because if the letter's in evidence, I guess they could ask someone about the letter on the rebuttal list. Maybe. I'm not sure who. I guess Johnny Depp.
But overall, I thought it was a great day for Depp. I thought Heard's legal team came across as stumbling, ill-prepared, off balance. Just not a good day for them.
Yeah, I agree. Largely, I think it's a decent day for Depp. The time deficit, I mean, an almost 5-to-1 time deficit is not where they need to be. They had 4 times the amount of time going into this. Of course, we'll get more precise numbers later, but a 5-to-1 time deficit for Depp is not good. You're going in with a big advantage, but don't waste it before you've got Johnny on the stand. I can't believe they wasted 30 minutes, frankly. I think they should have planned that out better. Use it for something. I'm not sure what, but get something going. I wouldn't be sacrificing a minute of my time if I could avoid it.
No, it seems, some sloppy planning there for sure. I mean, you'd think you'd have, a witness or two extra lined up just in case you ended up with some free time at the end of the day, just so it didn't go to waste. Or I guess maybe they just want to, maybe the witnesses they have left, they don't want to break them up and they can't do it in half an hour.
Right. That is possible. So if they're willing to sacrifice the time, that's on them. All right, man. Well, thanks for hanging out today, as always.
And my pleasure. Thanks for having me. And send me a link in the morning. I'll join you again.
Sounds good, buddy. See you
then. Take care, folks. Have a good night.
You too. All right. And Mr. Robert Barnes, I have sent you a DM with the link to the show. If you have a few minutes and want to pop in and talk about Journalistic Shield in Virginia or your thoughts on the case, welcome. You're welcome to do so, of course. With that, as we wait for it, I'm going to make sure we get through the larger chats for today. So we can wrap up. I'm not 100% sure about doing a night show tonight. I'm really, really tired. So I might need a sleeping night. We'll see, especially with Friday coming up, which is going to be a huge day. I can't go in with too big of a sleep deficit before doing a 24-hour show. Okay. Susanna Macgiola Fedrag, welcome to Paralegal Status. Very much appreciated. Thank you for joining the channel. Radioactive Llama Pajama says the chat demands an interview of Richard Marx in Mark Richards' voice and an interview of Mark Richards in Richard Marx' voice, and maybe throw in some 14-inch objections from Earl Grey. Don't be Tent Binger. be a boulder. Tin Weasel, welcome to paralegal status. Thank you for joining. Tarkina Meyer, aloha from Maui. Plan to catch up on the trial on the 8-hour flight home. Well, have fun with that. The worst part about going to Hawaii is flying back home. Kyle Bird says Dr. Spiegel looks like he still prescribes cigarettes. Yellow Flash 2, why does Amber Heard shop at Men's Warehouse? There was the one day where she wore a very nice feminine outfit, and she should be wearing it every day. I just don't get it. You should have said something to your guest about his comment about the court lady who is a human being. Nah. Nah, I'm good with it. Hey, what's up? Mr. Robert Barnes, welcome to the show.
Yeah, you can't be tired, Nick. You're the Energizer Bunny. Go boom, 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 boom. Just keep rolling. 24 hours, 18 hours, 16 hours. That is insane. You have an insane level of energy to survive this.
Yeah, it is. Today I'm feeling it, though.
I can imagine.
I was drifting just a hair at the end. I was like, okay, these proffers are killing me. All right. So first of all, welcome. Overall impressions of the case and how it's progressing.
I mean, I think the moral narrative overwhelmingly favors Johnny Depp. I think the court of public opinion overwhelmingly favors Johnny Depp. I think legally there's the allegations he's suing on. I don't think she has any chance of her claim, her counterclaim. But I think as to his claim, it's just a thin claim from that statement's really vague, saying I became the public figure of domestic abuse. Was that a true statement? I guess it could be, right? That doesn't mean domestic abuse allegations were true, but my own view is that most jurors don't get caught up in the legalese. And I think that the jury is going to come in favor of Johnny Depp. I think the money's almost inconsequential. It's not like he could ever collect it from her anyway. Her career's already was going nowhere.
Right.
And so that there's not, I think he wanted to do it for legacy as much as anything. And then secondarily to get back into the game. But it seems to me the way he's been very unusually engaged for especially a celebrity kind of plaintiff or client. I mean, it's just he's paying attention to everything, processing everything, reacting in live time to everything. I think she made a massive mistake by being here. I can't understand how she couldn't have settled this in ways that this disaster wouldn't unfold publicly in front of the whole world. People are going to use her as a verb. It's not like I went and an adjective. It's not like I went all Amber Heard on you. Obviously, right. Amber Turd is an unfortunate other nickname she'll be stuck with. But that's how I see it. I think a lot of it, I'm sure the jury probably has checked out. Like when they were doing the proffer, the jury wasn't there for. But some of today's witnesses, I just checked in here and there. I was like, I would have already checked out already myself if I was there. So I think that's my take on the legal aspect. Or at least, I mean, how the trial's gone as a whole. I thought her Depp's team's been solid, not spectacular, but solid. But if I'd been paid $6-7 million, I would expect a little more, to be honest with you. But they've been okay. Heard's team has not been very
considering good. Heard's team has also been paid $7 million, according to her.
But we know that might not. Maybe she's just pledged it to them.
That's true.
We'll see. But I mean, if that's the case, she really has not got her money worth. I think she does have a legal malpractice. If a lawyer advised her on the crafting of that defamation of that opinion piece to avoid a defamation suit specifically from Johnny Depp, they did a poor job of it. All she had to do was rephrase that one sentence and to say, because of public accusations, I became the poster girl for domestic abuse issues that went beyond whatever there's ways to phrase it that would have made it clear it was not re-raising the allegations against Depp. And that was so she might have a legal malpractice claim that it's probably under California law, so that may be non-assignable to Johnny as a means of collecting the debt. But on the legal side, the TMZ thing was interesting to me because that's a pure First Amendment issue, what they're raising.
Yeah, so real quick, welcome to Fair and Balanced.
Hello. The chat wants me to call you Nikki Poo. So hi, Nikki Poo from yesterday.
Well, I know who's getting banned from this chat first. No,
Mr.
welcome.
Barnes, good to see you again.
Good to see you.
And I can tell you exactly, I was going through the jury and I was like, I know exactly who's sleeping and when, because I was going through all of the testimony. I can tell you the only two they were awake for was the first witness, not just because it was the first day, but just because it was, the president of film production. There's about 5 guys that really like movies, and Joe can attest to it too. We were there yesterday. Juror 1, 2, 3, 7, and 9 love movies, love Zendaya, love Aquaman, or at least Jason Momoa. And the other one I think they were awake for was Morgan Knight, Mr. Hicksville, and that was probably about it. The rest of it was kind of a meh. If I knowing the jury and studying them yesterday.
And then for the people who are watching, who are expecting that great testimony from the friend of Amber Heard's
Jennifer
sister,
Howell.
that never went anywhere.
Yeah,
so disappointing.
Yeah, I'm trying to figure out where they plan on. I mean, so presumably, I was half spacing in and out of this thing by that time. But I can't. Did they actually get the letter in evidence? It kind of seems like they did, but it was never published.
I don't think so. I think it was referenced, but not an admitted exhibit, as far as I could tell. I mean, I do.
When you say letter, you mean the declaration? Is that what you're referring to?
Yeah.
No, her email.
Oh, but her declaration, I don't think got in either. I don't know what the hell happened. Why am I
So
hearing
it's
that
like
echo now? I didn't do
It must have been excluded, or they chose not to. I can't believe they chose not to call it, not to introduce it.
Now, arguably, I'm sorry. You go ahead, Nick. You want to talk, so.
Yeah. Check while I talk. Check the private chat.
Okay.
Real quick. I got a message for you in there. No,
that's what I said. That's what I said. The same thing.
It's just it's like you're calling her to rebut Whitney Heard's staircase story, and she doesn't end up doing anything. I mean, she testified that she was doing this because she saw someone she loved doing something so wrong. It's like, well, okay, well, let's get specific about what was wrong. She's lying. She's lying, and you know she's lying. You have a prior inconsistent statement. Where the hell is this? Where's the offer of this as evidence? Where's the testimony about it? And if this thing was excluded in limine, don't bother calling her, because it was just confusing as to why she's there.
Yes, that's what I think happened. I think they got brain locked, and this happens to attorneys sometimes, especially when you're this deep into a case. I think they were expecting that they were going to get her testimony in, which, in case you're unfamiliar with what the testimony we all are expecting from Jennifer Howell, it was that Whitney came running over there after the fight on the staircase between Amber and Johnny, and that Whitney told Jennifer Howell, her boss, when she moved into her place, that Amber tried to kill Johnny. Completely the opposite of the testimony that she provided when Whitney related the story from the stand, where Johnny's grabbing the back of Amber's head and punching her, one hand being in a cast, whatever. But whatever story she was telling, that it's completely different what she told a long time ago to Jennifer Howell compared to what she related on the stand. Now, as Nick pointed out, normally you would think this is hearsay. It sounds like classic hearsay. How can Jennifer Howell talk about a conversation she had with Whitney? It's not a statement from a party opponent. And the reason you would get it in is because there's an exception to hearsay for a prior inconsistent statement. For the purposes of impeaching testimony, you could say, well, this is what you told everyone on the stand, but this is not what you told people in the past. And you would think that that would be a valid exception and that the court would allow it. It seems like this morning, when they had the pre-trial conferences between all the attorneys, that they probably brought this up, and the defense knew it was coming, and they said this is hearsay, and I'm sure this argument was made as to whether or not it should be allowed in as a prior inconsistent statement, and apparently the judge said, no, it is hearsay, I'm not going to allow it in. This is our speculation. We didn't hear it, but this is our speculation as to how the conversation must have gone. So they sliced that out. But when you slice that out, that's the whole meat of the freaking testimony.
It's the only reason to call her.
Yeah, it's the only reason to call her. So in your brain, you're like, oh, we're calling her. She's part of the thing. But you just carved out the entire entree, and you're left with like 2/3 of an overcooked appetizer. And it's the end of the day, and everyone's bored. And you're like, why are we watching this? And the jury's confused as to what they get out of it. They get nothing from it. And you just wasted time for nothing. And when you're the counsel, it's hard to realize what's happening when you carve out such a major chunk of the testimony sometimes. Maybe that's why I got stuck in there. That's what I think you're saying. And that was my takeaway. The exact same thing when I was watching the testimony.
Well, It's the only thing I can think of that makes sense is that it was excluded, and they then called her anyway. I guess maybe to cast some shade on her truthfulness character, so to speak, without a chance for her to rehabilitate it. But it was completely that, and the cross exam from Elaine was completely pointless. So I don't even know what the hell that was. And then they had that testimony about the check, which is to implicate a payoff, but they didn't adequately ask questions to explain it to a jury. That what they needed to do was say, okay, so this anonymous check comes in from Elon Musk on this date. And what date were you noticed to appear or testify in the, the UK matter or whatever it is, like, and show that check came in like right at the same time. And that's what they needed to do, but they didn't do that. So it all just seemed very confusing and discombobulated. But Robert, can you talk about this TMZ thing a little bit? Are you familiar with how strong journalistic shield is in Virginia and who holds that privilege? Would it be TMZ, the reporter, the witness? What's going on here?
So Virginia state law has no shield law either. Statute. Most of the shield law today in America is passed legislatively by a statute.
Right.
So DC has a shield law, some other ones. Virginia, interestingly enough, does not, nor have the Virginia courts adopted one as a matter of common law. So it's all a straight, old-fashioned First Amendment question, which isn't unique to Virginia. So now there's been Virginia courts that have rather aggressively enforced First Amendment issues. And for those wondering, how is the First Amendment implicated? Anytime the court does anything, the court is a state actor. So that's why defamation can somehow gets caught up in the First Amendment, because it's about the court exercising judicial power of the state against a citizen or individual. And that is state power that the freedom of speech, freedom of press, et cetera, applies to. So in this context, the question is a court violating the First Amendment rights of freedom of the press by enforcing a court subpoena for either information, documentation, or testimony against a member of the press? And so it's a straightforward constitutional question. So while some people, like TMZ did it so misleadingly, now I can't be too critical of TMZ. They once compared me to Shakespeare, and you always have to reward a flatterer and a briber. So they referred to me as Shakespeare gone wild in a case some years ago.
Right.
There's a whole lot of backstory about TMZ for another day. It'd be for the late night version of Arcade Alive.
I would
love to know the backstory, because I know part of one backstory. I wonder what you know.
I would have compared you to Brad Pitt, so I don't know why they limited you to Shakespeare, Robert. So
exactly. But it was great. But I mean, there's a lot of let's just say if they really dug down the Epstein list, certain people at TMZ might have popped up at some point. There's a reasons why TMZ has the power it does in Hollywood. But putting that aside, they cite the Virginia Supreme Court rule. The Supreme Court rule they cite is the right of intervening. It has nothing to do with journalistic shield or anything else. But the way they phrase it sounds like that. Well, according to the Virginia Supreme Court rule 3.14, that all that is the right to file an intervention when your interests are implicated. So nothing to do with the First Amendment.
The other rule that they cited is 2508, which I was reading through, which is an evidence rule, but it looks like it's limited to criminal and administrative courts, so not civil.
Yeah, the only Virginia decision that's ever been issued on journalistic privilege is a 1974 Virginia Supreme Court case in a criminal case. So now there are state and federal cases that have dealt with the First Amendment challenge in Virginia. And basically it comes down to, you really have to show it's harassment. In other words, if you're subpoenaing a journalist and it's not really that material, it's not really necessary, it just lifts the discovery standard from it could lead to discoverable evidence to it's guaranteed to lead to critical evidence. That's all it is in the end. I think they meet that here. But you get some judges that are more sympathetic than others and expanding, because there's a lot of discretion in how you define relevance, how you define necessity. That's where you get a broad range of applications of the rule across the entire federal and state judicial landscape, even though all they're applying is, am I as a judge violating the freedom of press of this individual by enforcing this subpoena in this case for these documents or this information? I don't think TMZ should win.
I don't think so either.
And with that, I mean, with with that as the standard, if we look at it from like a strict scrutiny lens, so here you have a compelling government purpose, which is to discern facts within a particular civil case. It's exclusively in the realm of the government to do so. You have a question of whether or not this would be I guess, like a least restrictive means test, and limiting that to this one particular subpoena that is made with particularity about a specific subject with a specific target of a fact. I think it's got to be hard to
It's
argue
not a
that-
fishing expedition.
Yeah,
you're right. The journalistic test is an application of strict scrutiny in the First Amendment context, and what you've laid out is exactly what it is. And is it relevant? Is it material? Is it necessary? Because if it is, then it's a narrowly tailored remedy for a compelling public state interest, which is accuracy in trials for the truth of the matter that is at issue in trial. And clearly, I think here they meet all of that, unless I've missed something. I haven't followed the trial anywhere near as much as you guys have, but just my understanding is it would, right?
The allegations probably around two specific disclosures to TMZ. One, I would think, would be the source of a video of Johnny Depp slamming some cupboards that appears to have been recorded without his consent, and was TMZ claims the rights. If you play that video we played it at trial, they claim the copyright to it, which would imply that TMZ has purchased the rights to it from somebody. So who is it? Did they have the authorization to sell the rights, since it was a work created by Amber Heard? Presumably she's the copyright holder, unless she has transferred those rights in some express manner, because copyrights cannot be transferred by mere implication. They don't fade like a trademark. There's no genericide to it. So copyright has to be transferred expressly. So where's the express transfer going from her to whatever to TMZ? And then the other disclosure that is at issue in this case is when she filed her initial restraining order and divorce paperwork against Johnny Depp. She showed up to the courthouse with a publicist. She was met by paparazzi outside, presumably including TMZ. And at her deposition, which was played before the jury and entered in trial, this video, she said, because TMZ had been informed.
She leaks emotion worse than
Smile,
almost
bitch,
any
you're
witness.
on camera.
Yeah.
Should have told her.
It was so bad. So now, okay, you're saying she's representing that she was doing this to protect Johnny Depp and to keep him from being in the news and all of that stuff, and that she did it in the most protective way. And at the same time, it seems very likely that she was responsible for the informing, or she knew of the informing. So we need to discern that fact for the jury, I would think, because it goes straight to her credibility.
I will point this out. So two things on what you just mentioned. I'll go last first. On that disclosure to TMZ, she made the most inconsistent statement possible, which has not really come out in this trial. On the one hand, she said, "I wanted to reach Johnny to let him know that TMZ had found out about it, so he wouldn't learn of our divorce from TMZ." And later on, when she's questioned by Elaine and speculating, well, how did TMZ know about it? You know, who would be able to know about this information to leak it to TMZ? So she points the finger basically at Laura Wasser, Johnny's attorney. Well, if you think Laura Wasser is the one who gave the scoop to TMZ, why are you trying to alert Johnny to it? Johnny's own lawyer is the one who's telling TMZ. So, of course, it doesn't make any sense to have you try to reach it so that he would learn from you rather than TMZ if his lawyer is the one releasing TMZ. There's completely inconsistent statement. The other thing is a follow-up what you were talking about with the copyright on that slamming cabinets videos. This is something Nate mentioned earlier, and that is that TMZ is notoriously very scrupulous and careful about not violating copyrights, and that they're going to want like the provenance of that copyright. So it's almost impossible for the creator of that video, which was Amber Heard, to not be aware as to who had the authority. If she didn't do it herself, to not be aware as to who it was that had the authority, because TMZ wouldn't have aired it or paid money for it unless they knew that the creator of the video was okay with it, so that they wouldn't get a copyright claim themselves, and they don't walk into copyright claim issues. So it must be that Amber knows. Amber must know what happened there.
Because if you think logically about this, if Amber Heard records Johnny Depp in what should be actually a two-party consent recording state. They're in California. So that recording has to, and it's within the privacy of their home. That recording has to be consented to by both of them. But even so, it's clearly evident from the video that the rights holder is Amber Heard. She's making the recording. She's turning on the video. She's the one turning off the video. She's looking directly at it. She's asking questions in it. So they know that Amber Heard is the presumptive rights holder. If Joe shows up at TMZ with a video of Amber Heard and Johnny Depp in their private home, Johnny Depp smashing things and Amber Heard's doing stuff, and he says, "Hey, TMZ, I'm going to sell you this. I'm going to sell you this video. I need 10 grand for it." They go, "Well, do you have the right to it?" Because if they don't, the claim from Amber Heard is big. Like it's a large claim. It's an easy copyright win if they air that, and they're moneyed, and there may be punitive damages involved for what they do, and they're going up against celebrities who might have their lawyers paid for by studios, and it will look bad for their business model, which is to take grainy pictures of celebrities getting into and out of SUVs. Like, so that would interfere with it greatly, and they're already close to being litigated on any given day by a celebrity or by a production studio. So they don't want to give them an easy win because somebody got pissed off. So I'm very curious about that. And it'll be interesting to see how the motion plays out.
Like, it's interesting is in a federal court system, I could not issue this subpoena if I didn't do it during the discovery process. It would be considered a violation of the discovery rules, that I have to go through the discovery process to get this. I won't mention the case, but there might have been a case where recently I was threatening to do that and led to, let's just say, a resolution. But because I was going to test the limits of it. But it's, if like in that case, I inherited a case where things weren't as done as well as they could have. But that's the other part I thought of, but I don't see any objections on those grounds. So Virginia state rules must allow you to subpoena third-party information even if you didn't subpoena it during the discovery process. Now, maybe their grounds is they didn't know she was going to lie about this, but I think she lied in the deposition about this. But maybe they didn't ask her specifically in the deposition. You guys might know that better than I.
They didn't know the deposition testimony was going to come in. It had to come in by impeachment.
Right.
So it had
Is that
she
the
not
case in Virginia? Because like a bunch of states now are liberalizing their rules so that if it's a party, you can introduce video depositions for anything. It's just totally wacky to me, but I don't know if that's the California rule now in state court.
Okay, well, I'm not positive on the rule, but my understanding is effectively they had to wait for her to testify in some way, because that's what it appeared in the course of the testimony.
That's more normal.
Yeah, once she opened the door to be impeached with her deposition testimony, then they were able to introduce it, and so that could be what got
perjury,
this.
would it? I mean, didn't she say specifically she neither sold nor gave anything to right on the stand in this trial to TMZ?
The only thing that she has said is that, and it wasn't from her, it was from her friend Io, who said that Amber had sent her the video. That's the only testimony that we've heard, and she said that she never gave it to TMZ. But to me,
I feel like Amber may have also said that, though.
I think she thought she didn't give it to TMZ. No.
Right. That's
Right.
what I thought.
Right.
Yeah, I guess you'd have to go back and look at how are those questions phrased?
Right.
Is it such a way that, yeah, I got paid. Yeah, it was my copyright, but I didn't physically deliver the video. That was the personal assistant. You know, that kind of routine.
Right. And the reason you have to be so careful for the chat, the reason you have to be so careful for that is perjury is really hard, especially in a civil matter between two people. They want candor to the court. They want people to show up and testify. They don't want people stonewalling with, I don't recall everything. And so they rarely ever charge perjury out, even when it's pretty obvious that it's happening. And perjury happens a lot.
Usually it's, enough vague. This would not be that vague if the question was asked right. If it
Right,
turns
if
out he's the one who gave it to TMZ, she sat there and lied to the court and the jury specifically about that issue. If she's the one who got paid, I mean, usually you get out of a perjury charge because it's an opinion thing, a memory issue, not like, like what Sussman's trial is like, where he said one thing, opposite was true, right in plain language. Yeah, this would be. I wouldn't. I don't know the politics of the local Virginia area, so I wouldn't anticipate a prosecution. But a smart political prosecutor that's ambitious might. But this would be. I mean, whatever was left of her case would be over if it turned out she so blatantly lied about this.
Oh,
It's
yeah,
just an
and
Do you
easy thing to
gentlemen
point to.
know how much a TMZ video, how much they'll buy it for?
It varies.
I-
It varies. What do you
I
think that was
threw
worth?
out
5
10
grand,
grand,
10
but what
grand?
do
Yeah, I expect
5
5,
to
10
10
grand.
grand's your guess?
I
Yeah,
have
it could
no
be more.
idea.
I mean, I know some that have
Um,
sold for 6
So the
figures.
video with Solange where she beat up Jay-Z in the elevator sold for $250,000. Okay.
Yeah, that doesn't
Jay-Z should
surprise
have
me.
paid them $300,000 to not air a video of him being beat up by a female.
Well,
So see, what
that
I
might
think this does, though, from a
that might
media
happen, by the
perspective,
way.
having been in media, I think, yes, TMZ obviously doesn't want to go on the stand because, they don't want somebody testifying. But I think it's also paying that much money for a video that's going to be blasted everywhere, not knowing the ramifications of it. It's going to show, and this is no offense, it's going to show their shady practices. Not that we haven't known that TMZ is a little bit shady, but it actually is going to put it into the record. And that's what I think, for me personally, as a media person, that's what I would be more afraid of rather than, having my photographer or producer who bought it or who they bought it
I
through.
mean,
That's just
they would
my
like a
angle.
reputation that they protect their sources, but their bigger risk is definitely that it's not a big secret that well, let's put it this way. It's alleged that TMZ is in the extortion business and that that TMZ often offers, they buy the copyright in order to go to the other guy who'd be embarrassed to get a higher price to not publish. There's rumors about their connection to various, how should I put it, trafficking activities going on in LA, so, and around the world. So there's a lot of stuff they would not like to somehow accidentally get out in questioning. But just if it is Amber Heard, the source, man, that was one brazen, bold lie from the stand.
According to the spider in the chat, the quote is, quote, "I didn't give or sell it to TMZ. I wouldn't even know how to do that."
Yeah.
That gets pretty
She
clear.
always adds more when she lies. She's got to quit doing that. It's like you're bad. It's like a 6-year-old liar. They always add an extra sentence. That's the giveaway that, okay, you were lying. I didn't know you were lying until you added that extra sentence. She always does that. She's a terrible liar.
You would think the justification for not enforcing perjury would not apply when you're dealing with a party, who's on the stand.
It was so blatant, and it's for the whole world to watch. It
Well,
kind
yeah,
of
that's
create pressure.
It's the recipe that could do it, but finding
Hey,
criminal
that's her
intent.
new role. She's going to be the new Orange is the New Black.
I
That would be,
kind of
that would
already
be
is.
popular, wouldn't it? Amber Heard, Orange is the New Black, the sequel.
The
With a reality
ACLU
TV component.
The ACLU can hire her as a representative, as an ambassador for perjury to Congress. It'll be perfect.
Yes. Yes.
The other thing, I mean, the likely culprits. There's two very likely culprits that aren't Amber Heard, but would be seen as at least as linkable as Adam Waldman, if not clearly more so, because
Whitney.
in this case, Amber would have had to transfer them. No, I wouldn't say Whitney. I would say the publicist or her divorce attorney. The divorce attorney is the one who advised her to go get the TRO, advised her likely to not wear makeup that day, or to, as many would suggest, wear makeup to make a bruise on your face. To do it in public, the paparazzi just showing up randomly is either the divorce attorney or the publicist who's there. Rocky Pennington is the one taking pictures of Amber Heard, the like photo session that she has waiting for her TRO. All of this is nonsensical, but I think, yeah, the publicist or the domestic relations attorney there in California, because they're trying to squeeze money out of Johnny Depp. We know that.
It could have been the domestic, and a smart lawyer would fall on their sword and say, we kept Amber in the dark about this now, and we just lied to TMZ that we had authority. TMZ would buy it because we're the lawyer to sell the copyright, that kind of thing. Fall on their sword to protect Heard. I could, there's lawyers that have done that in that context. It wouldn't surprise me if the divorce lawyers were managing all that. If they thought, hey, this will give us leverage here, this will give us leverage here, this will give us leverage. So much of the law in LA in these kind of cases is about the court of public opinion, not about the actual courtroom.
Right.
And if they
to the-
establish, I'm sorry, if they establish a reputation for falling on the sword, that only helps market them that much further. That people are like, oh wow, they're the type of firm
Exactly.
that's going to basically stand up for me if I really get caught screwing up. So
They'll even fall on the sword for
Yeah.
Amber Heard for
But-
someone like Amber.
But to even dispel all the media myths, as somebody who's been in those newsrooms before, there's absolutely, and I said this actually before when I was when you were on the stream with Joe and I, Rob, was when it was the whole testimony about how, you know, she didn't realize all the press was going to be there and all that. We all know that's a lie, but just from the inside of how the sausage is made in a newsroom, we get those, we do those FOIA requests, or we call, you know, the city manager or whatever, and we get a lot of that stuff every single morning. They wouldn't have known probably until 2 days later that she was that was filed. I mean, they were clearly tipped off, is what I'm
Yeah.
saying, because
Oh yeah.
the way
I
the
mean-
amount of time it takes for those ledgers to come down, they would have never been able to be there on time. Days
Yeah.
later,
Unless
Even
you
now.
had an inside source at the court
exactly.
itself.
Yeah,
Now
even
TMZ has sources at the police department. They have sources. I mean, they pay off Hollywood cop. Well, allegedly, I keep saying that. Allegedly, they pay off Hollywood cops. Allegedly, they pay off a lot of. They definitely do not want to deep dive into their modus operandi.
No, definitely not.
Yeah, but even in 2022, the electronic docketing and electronic filing systems that are out there now, there's still a day. Like you
Oh, God,
upload
yeah.
something.
Courthouse News is suing because a lot of courts have made it like 48 hours, 72 hours, 4 day. So unless you got a buddy or pal in the courthouse that's now TMZ does have that in parts of LA. They have court
Chicago
clerk
was 6 months behind because my brother, when he was practicing in Chicago, he's now in Phoenix, but they were like 6 months behind on stuff, and he was like,
Oh, yeah.
"Are you kidding me? We have court, like we have to appear before you, and you don't have this? It's
Yeah.
ridiculous, especially during COVID too."
But there's
And
no
granted, this was
chance
all before,
she doesn't
but-
show up with the photographer and the publicist unless her own people tipped them off to make sure they knew.
Absolutely.
The to the chat, people keep tagging me. Yes, I am aware that there was a school shooting in Texas. There's very little that we on a legal live stream chat can do. Obviously, condolences
And
to the
I'm-
families, and
I'm
and
for
we,
publicizing that as little as possible. All these, that's
Yeah.
what motivates these shooters. They want the
Mm-hmm.
publicity.
yeah. So I see you mentioning it. There's not much. First of all, we have no information. Second of all, there's nothing we can really do about it. So, what's up, Joe?
I just got to bust out of here. So I appreciate you sending me the link and everything. It was very an opportunity to spend some time with you. Great seeing you, Robert and Farron. I'll see you guys tomorrow.
See you, Joe.
Godspeed.
Take your birds with you.
I knew he wasn't going to stay long. I felt bad.
Okay. No, it's fine. I didn't know he was available. I would have sent him the link anyway.
So I stream with him a little bit during the day, and it's literally me throwing questions at Joe, and he's just, "You're not gonna believe this," and no, and he explains everything, and it's a blast because, like I said, you get a totally different view from like the news anchor perspective. But when I was like, "I'm going over to Ricada," and he was like, "I didn't get a link," and I was like, "Well, I did."
I do
I'm
not
just
mind
kidding.
having him on. I figured he was still streaming. So
No,
so
he's
there you go.
tired. We're both tired, but I actually got more sleep than he did.
Yeah, I think tonight might be a sleep night for me. Okay, so yeah, today's testimony, fair and balanced. What was your opinion on the testimony today from more of that media perspective?
Honestly, well, one thing that was interesting is I saw Court TV was in there the whole day today. I don't know if you saw that they're talking about now streaming. A little inside scoop. Court TV, at least a friend that I have there, has been seriously monitoring the law tubers and monitoring streams, seeing how people are really shifting over to this type of platform with lawyers that are looking at this objectively. And now they're thinking about doing it because for those that haven't watched Court TV, one, you're not missing anything, but two, one thing you are really missing is the commercials that they have. I mean, how they time out their commercials to me is insane. But when it comes down to today, though, meh. If I could give it a grade, meh. I mean, I thought the first witness, Walter Hamada, the president of film production, was pretty good, interesting.
Yep.
And then Morgan Knight was the only one that really stood out to me. And then Richard Marx I like just because, he has this illustrious CV, where he worked with Godfather and Scarface. And I'm just like, I'm listening to you just to hear stories,
Right.
Well, what stories do you have? But yeah, those were the only two that stuck out. And then I think Jennifer Howell, we know the Jennifer Howell story. The jury doesn't. So
Yep.
as the jury in there, I'm sure they're thinking like, okay, so she's trying to protect Whitney, but then they heard nothing. And that's how it ended, where she's like, I'm here because I know that Whitney's trying to protect her sister and I'm trying to protect her, fade to black. And it was like, what? Like, that's all we get. So from the jury perspective, I don't know if that had much of an impact, because it honestly, for this jury, who's, you got 4 out of the 5 nodding off, they need stuff that's really impactful, that's going to keep them awake. And I don't think Jennifer Howell did it.
Yeah, I don't think she did. I thought the hand surgeon was useless. I was hoping for more information about the injury, his opinion on the injury, to counter the previous expert, but it turned out to be more about, could he have grabbed Amber Heard? And I guess it goes to the Whitney story. Could he have hit her? Because if he's grabbing her and punching her, then the plaster cast would shatter. It would also severely injure his hand to do that. So that would be stupid. But that still fell really flat. I like Richard Marx. I really liked the thing that I took out of his testimony. I don't know if the jurors took anything, but the thing that I took out was he drew a distinction between these episodic superhero movies that are these major blockbusters. Like, she got one. Most people don't get 2. Like that.
Yeah.
You get this one option contract. He also explained the option part of it. And again, I hope the jury was listening, that the option is on the studio. The studio has the option to hire you at this price. They're buying you. They're buying your promise to perform if they call you. And you are not actually able to turn around and enforce that option on the studio itself. So that was really interesting testimony coming from him. And I think he did a decent job picking apart the worthlessness of the damages expert. The numbers guy got really numbery, and I thought his testimony was good, but it was also super boring and nerdy. So I think that was tune-out material. But yeah, I think it was still a decent day for Depp. I just don't think it was particularly super helpful. But I think they spent too much time, though. I mean, they 5-1 on hours spent seems like that's a bad trade. Even though they've got a time advantage, they had a 4-1 time advantage. They don't have a 5-1 time advantage. And so I think that's a mess that they'll have to clean up tomorrow.
And for the chat really quick, they're calling me a court TV insider. You have got to be kidding me. And then the other super chat that's like, because trust me, one of the things I do is I read the chat. I can read everything you guys are saying. The one that said, hang on,
God bless reading Nick Mercator's chat. That's all I gotta say.
Yeah.
Stealing your soul.
If they're asking about Fuda,
right now,
it's just about the Federal Unemployment Tax Act. They got a big obsession with the Federal Unemployment Tax Act.
But there was one where it was like, if Farron talks about her media expertise from her dad, I'm gonna puke. Well, guess what, bitches? I'm not. I'm the media. I was talking about it with my father yesterday and the expert witnesses and how awful they were. What was it, Dr. Bedhead and all them?
Oh, that guy was
the guy that
terrible.
looked like what's his name from Back to the Future. That
Yeah,
I mean,
looked like
at least
Christopher
if you're
Lloyd.
if you're gonna have your expert in there, at least do something with the hair, at least do something with the presentation. And then what was up with those mouth gestures? What was that?
Those were weird.
I think I got those off of some of your clips. I think they're either your clips or whoever's doing your clips for you who are doing a good job. Plus, is it Law Nerds? Well,
Law Nerd
Nerds
clips,
channel?
yeah.
Law Nerds does great clips too. Because I think that was is either your clip or one of those that had everybody's shock reaction to it was like in and out, like some sort of fish thing going on. I was like, this guy's, I mean, at least he's a character. He'll be a memorable character up there with Grambo from Rittenhouse and all the rest, but just not in a good way. He's definitely not testifying. I hope he got paid. Hope he got paid well. Some experts don't get paid
all
until
of us
after trial.
in the courtroom, at first, we all, at least I thought at first, that maybe like one of his dentures came out, or like some, because I don't know how it works. I don't have them.
Sure.
But I was like, oh my God, is something going on with his mouth and his dentures? Is he pulling like a Nancy Pelosi? But then all of a sudden, like he became like really pompous. And then we were like, oh wait, that was actually like he wanted to do that. And I think even the judge was like, I don't know how to respond to this.
Well, when the
You
judge
have
said,
spinach
yes,
in
you
your
have to
teeth?
answer
What's
the
going on?
questions, that guy was just a disaster from beginning to end. I don't know why they had someone do that. And my view is the judge should have even allowed that analysis. You're not supposed to give a psychological expert opinion without an individual evaluation. That should not have come in. That's what the Goldwater rule does have, an evidentiary aspect. And in order for you to have an expert opinion on someone else's psychological state, you have to examine him. He could get up and testify to generic principles. If someone behaves like this, it can mean that. If someone behaves, but can't say that's Johnny Depp. That's not permissible expert opinion in most courts.
Yeah.
But I mean, it's like the Rittenhouse case. We're seeing some state courts that today I was going a little half crazy at times. I mean, they're asking these like 2-paragraph questions that are from court orders, and it's like that's not an appropriate question, or from an they haven't even laid the foundation for trying to establish that. They're asking the medical expert questions about legal issues that are impermissible legal opinion questions. So but a lot of that stuff has got in because that's just state. Welcome to state court. There's crazier state courts out there, but people are seeing in live time. In federal court, 90% of this would never happen. The court is much more disciplined and strict and clean.
Well, you have a lot of lawyers that have the advocate complex, where you guys are advocates for, not when I say disenfranchised, or you're an advocate for your client. Whereas doctors, many of them out there, have a God complex. And when the two meet, you get a lot of fun.
Well, particularly brain surgeons. Brain surgeons are the worst. Like they actually have a psychological study for med students coming in.
My father's a neurosurgeon.
Yeah, I explained
I'm
it.
kidding.
Well, it's true. Like there was association with football and something else that brain surgeons were the most godlike in their mindset. The people with the least thinking they're God were kids doctors, people who wanted to become kids doctors. It was a fascinating little psychological survey. But I mean, they got stuck with this guy because who else is going to get up there and break all the ethics rules and give an impermissible opinion that's going to embarrass you on national TV? You're going to get the guy that looks like a hybrid from Scrooge and the professor from Back to the Future. That's what you're stuck with.
Yeah, I was really frustrated that the judge was allowing him to offer testimony specific to a fact witness rather than an expert witness with factual analysis of Johnny Depp. I mean, the moment he starts talking about his cognition and these observations, like, no, there was no evaluation. You could not do one. You can't make this assessment, and you can't represent to the jury that you somehow can make this assessment. And he did. I thought the shredding of him with the Goldwater rule was really, really effective. But I mean, personally, they should have just stricken his entire testimony in front of the jury.
My favorite one, though, is we actually had a scene from the ref replicate itself in court with the why did you call Johnny Depp an idiot? Which is, the people haven't seen it. The Ref, great movie. I consider it a Christmas movie. He's pretending to be a shrink in a certain part. He talks about he calls his patients idiots and they like it, but has to make up an explanation. But that guy was him trying to weasel out of that, why he called a guy an idiot, and that whole routine was just memeable. But he in 90% of courtrooms in America, definitely in federal courtrooms, what he had testified to, he would not have been allowed to testify to. That's not permissible psychiatric testimony, expert testimony.
And it should have been stricken. I mean, it should have been clearly stricken in front of the jury. And they should have been made very aware of that being improper testimony.
Is it just me? I've seen a lot of times where they'll object mid-answer, and it seems like the proper thing to do it at mid-answer is move to strike, Your Honor. Is it just me, or do they not do that often? Do they just keep saying objection,
rare.
hearsay, objection, whatever?
Yeah, it's rare. They have not moved to strike a lot of the testimony. If I'm backseat lawyer analyzing, which is what I do, I guess, I would think that they're doing that for the purpose of trying to not look evasive to information. I think that Depp's team in particular is trying to keep their objections hyper technical so that when they are made, it has the appearance that it's coming purely from the rule and not because they're afraid of the answer. And that's combined with the posture that Johnny Depp took on the stand right away. All I care about is the truth. I'm obsessed with the truth. And so if they come across as evasive, that discredits their whole posture in this case, that they want everything open to the whole world to see. And so I think that's why they're not moving to strike so often, if I had to guess, or they're just forgetting. I mean, one of those two.
Well, I mean, a lot of lawyers get accustomed to just objecting and not moving to strike. Like, I guess today, at the end, they did a proffer. I don't know why it had to be verbal. All that could have been in writing, but otherwise, but a lot of lawyers don't really do proffers really well. And also is a weird proffer. A proffer is for when you, like, if you ask for a certain deposition testimony to be introduced and it's not, you don't need to proffer that. That's already in the record. You need to proffer when there's no evidence of what the evidence was going to be. In other words, hey, judge, I'd like to go into this subject matter. And the judge says, no, you can't. Well, if there's no deposition or other testimony, you don't know what would the witness have testified to had he been allowed to. That's what a proffer is. A very underutilized process, in my experience, by a lot of lawyers, in the sense of whenever I pick up an appeal, there's almost no proffers in there, and when there should be, and you have to kind of guess what the evidence would have been or could have been. Also, it's a great way to screw with judges. Judges hate it when you go into a long, some judges, this judge is fine, but hate it when they want to keep evidence out really because they favor one side. And you say, here's what my proffer is. Because in a proffer, you can say a bunch of stuff that maybe wouldn't have happened, but it's what you reasonably believe could have happened. It's a great way to get, I would have said this. The witness would have said this. The witness would have said this. The witness would have said this. So it was interesting to see that. But yeah, I think Johnny Depp should win from a moral narrative perspective. Legally, I don't think it's the strongest case in the world because her statement was so vague. From what I've seen, better lawyering by her Depp's side than her side. Now, Depp's side has much better facts. It's always, you never look like a great lawyer when your facts suck and your witnesses
And I think
suck.
a better client.
Yeah. You bad client, bad facts, bad witnesses. That's really a bad combo. I would have been tempted to represent Amber Heard just because it would seem so impossible for her to win. Tempted. I didn't say I would do it. So
do you think their counter offer, like assume, let's take out the assumption that Amber Heard, not counteroffer, their counterclaim. Let's take out the assumption that Amber Heard is directing specifically that counterclaim. If that counterclaim was proposed by her lawyers, do you think there's a malpractice issue there? Because I think that counterclaim is the source of the overwhelming majority of her problems in this case.
Yeah, I mean, I think probably the biggest legal malpractice is still whoever advised her on writing that editorial. Because the language in
that guy's terrible.
Yeah, that was a complete disaster. That she has, I think, a very strong claim, because if it had been written a different way, it would have been impossible to sue her by Depp at that point. Because otherwise, she had done a good job of making sure anything she said was inside of a court pleading. Not otherwise. That's why it was tough for him to sue her. You can't sue for anything said in court.
Yeah.
So for the most part, there's malicious prosecution, but that's very tricky to bring. But I think her lawyers haven't helped her if they have failed to advise her to take settlements. That's usually one of the biggest screw ups by lawyers, is rejecting settlements that later on look reasonable if a reasonable lawyer would have recommended the settlement. Even though the client controls it, that's particularly in the insurance bad faith context. That's where it comes up most often, is a form of legal malpractice. But if they propose bringing a counterclaim, I mean, if they propose, it doesn't take long to talk to or look at Amber or interview her for 10 minutes. Like the behavior panel has broken down her body language to figure out she's nuts and she's not going to come across as a credible witness. And so it's legal malpractice to encourage someone like her to continue to pursue the case, in my view. Now, from a court perspective, they likely wouldn't consider that legal malpractice. They'll only consider failing to give what a competent lawyer would give. I think a competent lawyer would have told her not to bring the counterclaim. I think a competent lawyer would have told her not to take the stand and testify in the way she did. I think a competent lawyer would have advised her to settle and resolve the case. Now, I think in California, which is probably going to govern all of this, even though maybe Virginia governs, it's some of these cases are not easily assignable. So, like, let's say Johnny Depp wins a $50 million verdict. The question is, can he ask Amber to assign her legal malpractice claims to Johnny to prosecute on her behalf as a means of recovery of some of that? Because the lawyers with the insurance policies applicable probably have 10 million plus between all of them, at least available, collectible.
Yeah.
At least reimburse his legal fees. I mean, he's got at least 6-7 lawyers in court now on a rotating basis. So that he definitely probably did spend 6-7 mil on this.
He's got to be
Maybe
pushing close to 8.
yeah, and you add in the UK litigation, he might be over 10 because he a lot of these lawyers are expensive that he's hiring. I mean, you just look at it on a daily basis, he's paying what? Probably $100,000 a day between lawyers and paralegals time just per trial day when you add it up.
Really expensive. Yeah,
Yes.
because he's got 6 to 7 lawyers in there.
And some of these are going to be $1,000 an hour people.
Right. So even if you get down to an average of $600 an hour, if you count the associates that are testifying, so then you
They're
got
probably building 15-hour days.
yeah, you got 6 of them at $600 an hour, so it's $3,600 an hour, and then you start wrapping in 15-hour days. It gets really
So that's over
really
50,
expensive.
60 grand. And then it's however many paralegals, investigators, service providers, other people that are on call, plus
Yeah.
other ancillary services. If he's paying for cost, he's probably
And we
paying
know
for
they're
all the
watching.
meals.
They're watching these streams. So some
That's right.
researcher,
Some are. That's right. Some of the PR, some publicists.
some
Types,
yeah,
Amber Heard should
they're-
have hired a better lawyer. But it would have taken, if any lawyer that got her off, that's skill right there.
Mhm.
Because bad facts, bad witnesses, bad client. And not only that, on the other side, good client, good witnesses, good facts. I mean, it's just you couldn't be in a judge that really clearly kind of leans towards Johnny. I think she's a Johnny fan at heart. I think there might be a little Johnny Depp poster at home.
Well,
Just
she is
if
a
you-
big Game of Thrones fans, apparently. So she does like her some Jason Momoa. But I will say one other thing too that goes beyond the scope.
A lot of women like
of,
Jason Momoa.
of the client and the facts. I think the other thing too is Elaine is a terrible lawyer, and when you're in
That
person
lady,
and you
that lady
see her-
lawyer.
Yeah, she's.
I mean, all you had to do is hear her opening
Yeah.
statement. You're like, please don't talk. Please just don't quit talking.
Yeah.
Please. Her
Well,
redirect
even-
may have been the worst redirect in history of Amber Heard.
It'll go down
I
as
quit.
one of them,
I
yeah,
quit, and I'm
of
going to
what
sit down
not
now.
to do. But I think also too, when you're in the gallery and you see the two legal teams, and you're looking at them like, a football team, and here Ben Chu is the quarterback and Elaine is the quarterback for the other team, you can see Ben truly is a leader because he is not afraid to delegate authority to the other lawyers on his team. Whereas you can see, just even watching them, I was right behind them all day yesterday. They are always having to look to her for like Miss, may I? Can I, ma'am? Queen Elaine, may I? And you can
Ugh.
just see there's just a difference in the
Abusive-
way of their style. And I don't know if
abusive
it's
personalities hire those kind of lawyers that
Mhm.
are abusive personalities themselves at some level, authoritarian in a key structure. So they tend not to hire the really good criminals. Will hire good lawyers. The really good criminal abuse, whether they're abused or anything else, they know I got to get the best lawyer. I know how the system works. I'm going to get a lawyer who knows how to work the system or work a jury, etc. They're looking for the Lincoln lawyer types. That's who they're looking for. But your everyday abuser, it caught up in any kind of initial litigation. That's kind of what this is for Amber Heard. Overwhelmingly will hire a abusive authoritarian type lawyer. I used to know in my cases representing victims of domestic abuse, whether my client's story was likely true just by who the guy hired. It was almost always the guy. I didn't have any Amber Heards. I had a client that right in the middle of the deposition admitted that, she liked to take a knife and play psycho with her husband in the shower. Didn't know that until the deposition. I was like, I think we'll be resolving this case. And the lawyer did a great job of doing the deposition. He was like, you just wanted to scare him a little bit, right? And she's like, yes, that's right. And I was like, oh, this goes from bad to worse. But
Something you should have disclosed to me before the deposition.
Yeah, exactly. Well, the first ever client I ever had was a kind of client, unemployment assistance clinic. I don't know if they had those in Minnesota. It was the one thing your first year law student, you could have your own client, so to speak. I didn't know she was lying to me until the middle of the entire hearing. And I was like, one thing after the next thing. So I learned it early. Assume your client's scared to tell you the truth. Figure out what the truth really is. Anticipate it. I've had I've had every big case I've had, the client withheld something. And you just have to guess what it. Mostly they withhold it not because they're trying to lie to the court. It's because they're embarrassed or think you're going to judge them for it. And it's very hard to get around that. Now, your hardcore criminal people, they lied to you because they think it's necessary to win the case frequently. Your smart criminals don't. You're really smart. You're like your sociopath type criminal. They'll tell you the whole 9 yards, and because they expect you to weasel them out of it, so that they know the benefit of you knowing where all the traps may lay. But I think it's Amber Heard's psychology produced bad lawyering for her, and Johnny Depp ended up doing pretty solid. I mean, because sometimes celebrities pick wackos. Imagine if he picked Lynn Wood, what this would look like. It would not be good.
Yeah, especially nowadays, it'd be kind of scary. Well, let's see.
You got
trying
to do
think
some
if there's-
super chat.
I've got super chats to do, and then I need mega sleep.
Try to sleep.
But I'm trying to see if there's anything else I wanted to ask before I pop into those. I don't think so.
I did want to ask both of you gentlemen something.
Yeah.
Because I'm very interested on this. Do you bring Johnny Depp back to the stand?
Yes.
Oh, if I'm Johnny Depp's people?
Mm-hmm.
I mean, I think they won this case a long time ago. I think they probably won this case after opening statements, is my view. Just the nature of the facts and the situation. If they did a good job in jury selection, but at a minimum, they won it by the end of Amber Heard's cross. So my view is don't take a risk when you're already winning. So I think Johnny's a great witness. I think Johnny would probably close great. I wouldn't roll the dice just because I think they've already won it. Unless I knew something about the jury. If I was nervous about the jury because of something I knew or because of something my jury people said, hey, we got a problem here, then I would it would be worth the risk. Because I think normally Depp's a good, he's on the plus reward risk side. But I wouldn't recommend it because I think they're already home. I think they have more risk than reward simply because I think they're so far ahead.
Mm-hmm.
I would
Nick, you
I would
answered
do
that
it
pretty quick.
Yeah, I would do it for a couple reasons. And one big assumption is that they have a significant time advantage going into calling Johnny Depp still, to the point where the cross is effectively muted or limited to a meaningful amount of time, as we've kind of discussed, which is a couple minutes. If they have the ability to limit their cross through the timeline, then I think what you do is you get Johnny Depp up. He seems to have been eminently likable to the jury. He didn't seem to be too rattleable on cross, and whatever cross they'd be able to pull out in a couple minutes. You get him up there to remind the jury why they're here. And I think that's the powerful statement, bookending the whole thing with Johnny Depp at the end saying, this destroyed everything. These lies about me destroyed everything I've built, all the people I've tried to help, all the good I've done, everything I've tried to do. I had to sell my places. I had to do all this. I couldn't help my friends anymore. And it's all because of lies about me. And you let that be the mic drop at the end. That's why I would do it. And again, that's assuming that they haven't preserved like 3 hours that they could just cross him over and over. If they've got enough time to make a big cross, I think I agree with Robert that you don't call him. But if they're only going to get 5 to 10 minutes to cross him, and then you get to redirect after that, just say, Mr. Depp, what did you lose from this? Everything. And then let that be the last line that the jury hears before you go to closing argument. I like the sound of it personally. So,
oh yeah, I definitely like
for
closing
great
on a crescendo. Who do you
theater,
think
yeah.
they have, if not Depp, to finish on a crescendo? A lot of lawyers don't, honestly. They don't think to finish on a crescendo. But assuming they did, is there family member, daughter, kid, somebody that could add that emotional climax if it's not Johnny?
So the list that they have, let me see the list of witnesses they've named. They've called, they have Kimberly Collins, who that's a forensic pathologist. That's not a big one. Children's Hospital representative is going to be boring. Let's see. I mean, they got Kate Moss. They could end on Kate Moss, but she's not live in the courtroom. Oh, here's
They have the flight attendant from the Russian flight, right?
Yeah, but I think that's going to be a quick one. And it's also by video.
Okay.
The person you would end on, if not Johnny Depp, is Dr. Curry, Dr. Shannon Curry. Again, likable by the jury, knowledgeable, smart, pretty, put her on the stand, have her talk about what happened to Johnny Depp, have her rip apart the other expert witnesses, statements about her, that Dawn Hughes, that's some unanswered questions for his team. I mean, they need to call her anyway, and she's on the list. They're going to, but to have her talk about how she actually did the tests appropriately, Dawn Hughes did not, as we saw with her notes being incomplete, and then have her talk about the effects of intimate partner violence on a male victim who's in a perceived position of power or something like that, and really relay it home to Johnny Depp. I think that's the other closing option that I would go with. But I think Depp's the stronger one.
I was going to say, when you're in that courtroom and you see him walk in, I mean, yes, you're going to have your Johnny Depp fans and stuff. And as like DUI guys said, it's the Depp effect. But honestly, at first I was very much with Robert and saying, you don't want to risk it. But I kind of do agree with you, Nick. A trial is like a movie. It's like a theater. And I think if you don't have to cross him, end on the most powerful, most impact statement, and the guy definitely knows how to make an impact. At least on the stand, he's proven that.
Also, clearly his objective is more winning the court of public opinion than it is the trial itself, I think. It's if he were to lose the trial, it would undermine a lot of his gains that he made in the court of public opinion. But otherwise, I think his goal hasn't been actually collecting from Amber Heard. It's been, I'm going to leave a legacy and correct the record for the world to witness in live time. And I think he did that. And whether it's him or Dr. Muffins, but either one of those would be a decent finale.
Robert, I have a question for you on assuming Johnny Depp were to win. He's requested $50 million in damages. Now, I want to preface that I think Johnny Depp has sustained far more than $50 million in damages through the defamation, but I also don't think that a jury is likely to award $50 million in damages from an individual to an individual. What is your opinion on a potential damages award based on what you've seen from defamation? You've done high profile defamation cases and you've been witness to plenty more. What do you think's a reasonably possible damage award? In this
the
case?
only reason why he could even be in that ballpark is because he was making that kind of money. So but for that would be, like when Lynn Wood sues for some nutty amount, that it's a nutty amount. I'll give an example in Kentucky when I was researching it for the Covington's case, the biggest ever verdict in a case with frankly really egregious facts was the equivalent today of $100,000. So that gives you an idea of what juries typically do. It's only because Johnny Depp has a number, they can say that number because he actually makes it in movies. So that gives them a hook to hang their hat on. And if they really hate Amber Heard, then you might see a verdict like that. But I think the second problem for him is there's clearly from a legal perspective, I think the weakness in this case is legal, that her statement is really kind of vague. And I could see her meaning, or a jury interpreting her statement as not really meaning Johnny Depp is guilty of domestic abuse. There's clearly, or at least she thought she was saying that. I could see an interpretation in that way. It's a very vague statement that a lot of courts, by the way, would not have allowed to get to a jury trial because of how vague the statement was.
If this was in California, we wouldn't have a trial at all.
That's correct. That's why Heard's team was begging to try to get it moved to California, move somewhere else, move, et cetera. Though I think the moral narrative overwhelmingly favors Johnny Depp. But I think on the damages side, there is an attenuation on the legal side. I mean, why did he really not get these deals done? Was it because of statements Heard made, or was it because of his own lifestyle, or some of these other comments? There were some parts of the cross where his answers sounded like, I don't care if I ever get this movie deal, or I don't care if we ever do that again, or I have my own problems with Disney. Like, I know they kind of cleaned it up on redirect, but there were statements there.
I wouldn't do another Pirates movie for 300 million and 3,000 alpacas or whatever. It's a goofy statement. It's hyperbolic, but he is saying he would turn down a contract, and there may be an instruction on his duty to mitigate damages. And if there is,
I'm sure there will be.
Yeah,
historically there is in any defamation case, they include it within the pattern JIs. I haven't seen this set of jury instructions, but I think so from a legal perspective, I could see them saying, yeah, what she did was bad, but I'm not sure it's what caused Johnny all the damages. Now, my own view is jurors tend to make moral judgments. So they don't sit there and say legally, factually, does this connect? They say, do I feel good about issuing this amount of money to Johnny Depp? And you'll find out how much they dislike Amber Heard by how much the amount is. I think Johnny's going to win. I think she's going to lose. But if it's a big amount against her, it means they hate Amber Heard. And if they could, they would, draw and quarter her on the public square.
Either way, I think whatever amount he gets, I think he's going to donate it all.
Well, he's not going to donate anything because she's not going to pay him. And she doesn't have any money.
He'll pledge to donate it all.
Yeah, one little tidbit. Intentional defamation of a public figure is often not bankruptable.
Right.
So he could actually, make her work at Starbucks and give her the extra $2 an hour.
I
I wouldn't
dinner
imagine.
OnlyFans, honey.
The problem is,
she could make a lot of money on OnlyFans. That comes up in like the child support context, right? Like in child support context, they often force the man to do certain work, and they jail him if he doesn't. They say, hey, you can do this kind of employment, so you're going to owe this amount, and if you don't, we're going to jail you. And I've always wondered, what if the reverse was true? Could a husband come in and say, Judge, she'd make a lot of money on OnlyFans. She'd make a lot of money as a stripper. Make her work as a stripper and pay me accordingly.
Judge, you hear them selling farts in jars? Yeah, man, I've been around this chick for a while. She can fart in some jars.
He's gonna be like, I had to go to hospital because I was on a diet of beans and whatever it was.
Yeah,
if you're Amber Heard, if you almost have to Floyd Mayweather. If you're her PR team, come up with a way that she could still make money as a villain. But that's probably what you have to be. Like Floyd Mayweather made a lot of money by people paying tons of money just to see him get beat up. And then, of course, he didn't get beat up, which drove him crazier. So they would pay more money to watch the next fight where, once again, he didn't get beat up. But it was genius. He parlayed that exceptionally well. And that's her only possible path. Though I don't think Johnny cares that much.
Yeah.
Now, I do think Johnny would take some other additional roles. He may need to because, his business manager and some other things went a little bit sideways. But the cash-wise, I think he's not quite as wealthy. It's not clear to me how much wealth he has. I mean, there was talk that he was underwater 2 years ago. I don't know what happened to
that. I think his estimated net worth right now is $200 million because he did have significant
because of the royalties.
Yeah, and he's got the assets and he's got the royalty rights on Pirates,
right, all the
and
merchandising
and
owned free and clear mortgage.
But that will
fade
fade
with the government because rumor was Johnny wasn't paying a lot of tax.
Yeah, well, he blamed his business managers for the tax thing too. He won what was leaked as a $10 million settlement from them, sued them for $25 million, won a $10 million settlement. I've heard different numbers on the amount of tax that was in arrears. I've heard between 1 and 100 million. I have no idea what it was, but if you're 100 million, what was that?
I heard it was over 100 million. It was the biggest, one of the biggest tax debts ever.
Yeah. If you're over 100 million and you're only getting 10 out of the people who put you over 100 million, something's then
you would have had you have had a great bad debt deduction though. That's the advantage of fiduciary fraud is it creates a bad debt deduction. You can carry back 7 years, carry forward 20. You can erase a lot of tax with that.
That is a huge amount of tax. That would be beneficial if he gets another role. But he's got to get something big. Although the real deal, it won't happen, but the real deal would be is if Disney, if he wins the defamation, Disney calls and says, hey, Jerry Bruckheimer wants you to do the warm handoff to the new Jack Sparrow in the Pirates movie. I think they're doing like a female led Pirates movie coming up. So
Margot Robbie, I believe.
Are you serious? Another one? Well, if it's Margot Robbie, I'll watch. But I mean, it's like the Thor movie. I mean, why do they got to keep destroying these things by making men into women?
Yeah, I don't think it's they're not making Jack Sparrow into a female, but it is a new character or another character in the universe or something. But if he wins and Disney calls him back, gives him 20 million or 10 million in a royalty check to do that, he could make a significant amount of money. And I think whoever puts Johnny in the first major movie after this case makes a fortune.
Oh yeah.
And uncollectible judgments can, in certain circumstances, be a tax deduction. So that's where like the 50 million might save him 15 to 20 million, maybe even 25 to 30, depending on the circumstance. Now, Hollywood actors do that leasing agency structure, so they have creative taxes put it that way already.
Yeah.
But that's where even if you can't collect, there's probably real monetary value either in future films or in ways you can use that non-collectability to get rid of other debts.
And I think after this, Amber Heard won't even be able to get a spot as like a guest spot on Law and Order SVU after this. I mean, she's going to be
Not
able
unless
to get
she's a
nothing.
villain. Now, I think
Yeah.
she would draw ratings. That's where I think I would go the villain route somehow. I'm trying to think of who's like an actor that really everybody ended up hating that made a bounce back as a villain. I couldn't think of any, to be honest
Christian
with you.
Slater? Robert
Yeah, but
Downey
he was like a
Jr.?
likable villain. He could do a great Jack Nicholson.
RDJ became a hero, though. He didn't come back as a villain.
Yeah, exactly. But I was trying to think, but definitely a OnlyFans world for it and some other places, So
Yeah.
There's always
we'll see
OnlyFans.
how willing the Virginia courts are willing to enforce that judgment when the gender roles are flipped.
Well, after Hamada came out today, she's not getting Aquaman 3. That should be pretty clear. Like they're not going to exercise an option contract to have Mira played by Amber Heard in Aquaman 3. Not with the testimony he gave. That was a kiss of death. We release you and absolve you of any responsibilities you have to us.
She
Sort
needs
of
a
testimony.
The other possibility is a redemption arc somehow. Go rescue people somewhere. Maybe she'll go fight for Ukraine and they'll make her a hero and Zelensky in crowd, something like that. But she's got to have a redemption arc if it's not going to be the villain. Otherwise,
I'm guessing there's some lucrative Eastern European films she could star in.
Yes,
If I had to
exactly.
wager.
The last Azov or something.
Yeah, exactly.
Boy.
Crazy.
All right.
Nick, you need a pillow, some soup, and some sleep.
No kidding. No kidding. Well, thank you two for joining
Thank
me,
you
and
so much. It's been an honor.
we'll see you guys soon.
I appreciate it.
Adios.
Absolutely.
Take care.
Peace. Okay, guys, that was Fair and Balanced, who is a former news anchor turned independent journalist. Her channel's in the description. Joe's channel's in the description. Robert Barnes can be found on Viva Fry's YouTube channel, but you can most commonly find him on vivabarneslaw.locals.com, which is also in the description. If you like these people, these guests, please check out their independent work, because I appreciate them coming on here and adding value to my independent work. And I love to reciprocate when possible. And I try to bring on great guests with good insight and who are also personable. And I think those that everybody in the stream today certainly qualifies, and all of their links are there for you to click on nice and easily. With that said, I am going to finish up the $20 plus chats. And then I do have to probably go today. I don't know about it tonight, a show tonight. I have company coming for dinner, which is probably here now. So I'll have to cook and then and eat dinner and be sociable. And I'm really dragging. So I'm thinking a show tonight is unlikely, but stay glued to my locals and Twitter feeds for your notifications. That's where they'll most likely show up. They'll always show up on locals, and I'll always post it there, but it might be tomorrow before I see you guys again. Thank you for showing up tonight. I really, really do appreciate it. And with that, let's hit these chats. Eagles Talon, RIP the court stenographer fingers. This guy needs to slow down. Deep Surface, welcome to Lawyer Status. Mandrake, what is this? They're allowed to retry the case and get exceptions? WTF. No, the proffer, again, I knew there would be some confusion there. The proffer is a process by which you inform the court of some evidence that you believe should have come in but was excluded. And that is a preservation for appeal. It does not actually get it into the case. So it's a preservation for appeal. Amber Heard's team is anticipating the possibility that they will lose. And that does not, by the way, mean that they think that they will lose, that it's their duty to anticipate the possibility of a loss. And so they are making the proffer so that the record is clean and clear that these pieces of evidence they believe were critical and were excluded and could mount an error from the Court of Appeals. Matthew, self-breaking school shooting in Texas today. Horrible, 16 dead. Yes, very, very terrible news. It's always awful when we see these things happen. And yeah, I do not have kind words for the perpetrators of such horrific violence. Anthony Zink, this is for the cameras to help make it look like Johnny Depp has the court rigged or the court has a bias. No, again, I don't think the proffer was for the cameras. I'm not sure that the proffer could be done by written statement. Mr. Barnes indicated that it would, and I'll defer to his wisdom. I think it should be if it's not, but I'm just not familiar with the nuanced aspects of that courtroom's, local rules to know if proffers have to be made orally or something. But yeah, I'm not a big fan of the it's for the cameras thing when there is a legitimate court process. I called out Rottenborn for it during the motion to strike earlier. Tara Rayner, Amber Heard said in audio, people think I was A, in Fight Club, or B, planned this, took pictures and sent texts or similar. Another claim was I worked so hard to get the wedding. Johnny Depp said he was set up. Jeez. What's up, man? My son's trying to kill me. He's trying to give me a heart attack. Did you guys hear that? Good Lord. What's up, dude? Yes, I'll be up in just a few minutes. All right, thank you. No, you're okay. Just woo. So if you don't know, I broadcast from a literal vault. And so that was my son was knocking on the steel door to get my attention and didn't realize that it would sound like the drumbeat of the gods in my office. Oh my gosh. Whoo. So there you go. Johnny Depp said he was set up May 2016 in testimony. Thank you, Tara Rayner. Charles Bloomer, isn't a doctor supposed to report to authorities any claims of abuse? Mandated reporting of children is mandated reporting. Elsewhere, they have to get really careful. But I think one of the main things we saw is that there really weren't claims of abuse from the doctor's reports from either party throughout this case. There were some with the psychologists or psychiatrists that Amber Heard was seeing, the counselors or whatever. We kind of get some notes that there may have been allegations of some level of abuse, but we don't know that it's an ongoing pattern. And sometimes these people, they take some information and they make a determination. If they don't believe they're still in danger, then you don't make the report. Marnie Coffee, are they doing this so the audience outside of the court hears it all? I mean, this is stuff that we kind of half heard. It was just objected to. Allison Salerno, thank you for the donation. Chris Solheim, what happened to Miss Howell's testimony? Why did it end so abruptly? Can you speak to this more? Not really. I'm not 100% sure what happened to the testimony. It seems like maybe the juicy parts were excluded. And that exclusion was surprising and maybe even recent. And they had to do a quick edit to the video. And if that's the case, if they excluded the letter, then there's not much to bring Jennifer Howell for. So won't really know what happened there for a while, if ever. But it really did fizzle out. Just a normal bottle of mustard says, thanks for the entertainment for my 10-hour days, Nick. Hey, you're welcome. Thank you for joining at the paralegal level or being a member at the paralegal level. Courtney Lynn, your video day 18 timestamp 5 hours, 43 minutes, 25 is her answer to the TMZ video and her saying she had nothing to do with it and that she wouldn't know how to do that. Yeah, that's bad testimony, and they should be able to impeach her on it through TMZ. And that is something that the court should want to resolve, and it should overcome the First Amendment objections. Don't know if it will, but it should. Gonzalo Bergali, welcome to lawyer status. Very much appreciated. Kelly Little, novice question. And if there isn't time / this is old hat, feel free to skip it. Why is it that the prosecution/defense need to ask to approach the bench in order to deliver copies of what is being entered into evidence? It's a courtesy thing. You just ask permission to approach a witness or a judge, because otherwise, why are you going to a judge, right? Some lawyer may have a hostile intent or something like that. So you, out of courtesy and respect for the bench, you request permission to approach the judge. Out of respect for the witness and their time coming in and testifying and their honesty, you ask for permission to approach a witness. Also, so you're not intimidating witnesses or appearing to be bullying or puffing up to them. And that's the main reasons for that. Again, it comes down to controlling the courtroom and a general matter of respect and courtesy. Aki Yeps says, what's the likelihood of the judge allowing the former TMZ employee to testify? Thanks. I can't tell you a likelihood, like a percentage idea. I think that it's limited in scope enough to provide for the testimony. I think that is limited in scope, and so should pierce that First Amendment protection. Now, some states like Minnesota, for example, have journalistic shield laws that are specific, and those laws can provide extra protection. But just basic First Amendment, free speech and free association ideas, I think they lose on the idea that the government is allowed, even though I don't think it should be, to infringe upon fundamental rights so long as there is a sufficient level of scrutiny passed. And in this case, it'd be strict scrutiny, most likely. And that means it would be the narrowly tailored to achieve the objective. So that would be the enforcing a subpoena on just this journalist for just this purpose, and that it's the least restrictive means test, so that there's not some other less restrictive to other activities means. So having this person testify very briefly is probably not that big of a deal. Jerk off juggernaut, but Barnes, they hired a lawyer that snatched himself before he lied profusely. BYW, that was hilarious, and that's all I interpret that as a dumb. I'm not sure exactly what that means. Johnny Arbor 007 says, do this tomorrow. Go be with family and get some sleep. With that is the totality of the $20 plus chats. Thank you guys for participating and contributing and watching and chatting and all of those things. They make these very long shows doable on a regular basis. And, if you're here for Johnny, that's great. And I will miss you very much when Johnny is over, because I think many people won't have the ability to maintain the same level of time and investment. But if you're here for trials and stuff, we will have more trials coming as the year progresses. So to everybody who has newly subscribed to the channel, though, I really do appreciate it. You guys impress me and make me question life every single day. With that, thank you for watching. Let's play the outro. I'll see you guys later. Peace. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some lost-plaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitter and Erlang. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an art bag, a bow, more of love rug. Spirits flow as the ones who get unemployed. So pour out a glass for the tea, post on Twitter, as we hear Lost Planning tonight. From the white shores of Nam to the hills of Glenlivet, there's no one who explains the wrong better than Nick. So pour out a glass for the ones who have passed to make the law what we are now. Oh, the guests are all plentiful, from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Shores of Nan to the hills of Glenlivet, there's no one who explains the wrong better than Nick. So pour out a glass for the ones who have